Well, hello, everyone, and good morning from Uncivil Law. I hope everyone's having a great morning. I have had a nice sleep. I have had a nice shower. I washed off all the ugliness as much as is possible. And we are back with day 3 and the last day of the Senate confirmation hearing. So what we'll be doing this morning is we'll be hearing from the remainder of the senators. And then I believe we have statements or testimony from people who do or do not want her confirmed. And then I believe there's another round of questioning for all the senators for 20 minutes. So it could be a long day. It could be another long day. And they will be starting any minute now. They are just sitting down. So they're getting ready to start. Good morning to everyone. Good morning to Thomas, JMK, Lucentile, Verothium, Sky Queen, Darth Hideous, Carol Depp, Pam Ronning, Frithium, Noser San, Kyrie, Just Me, Bad Max, all that stuff. We are just waiting for the Senate to start. They are sitting down as we speak, so it looks like they're going to be starting just any minute now. So it doesn't look like they're that far behind. Now, on my end, it's showing 0 people watching, but I see your guys' chat, so I'm confused. It says there's 0 people watching my stream, but then you guys are chatting to me, so that's I'm not getting good information here. Showing the same to you? Oh, good. Good morning, Cheryl, Jay, Jack of the Dead, Purple AJ, Reddish Dog, Sea Cook, Snickers, Gently, Kiki, Michael. Good morning, everyone. Now it says 98. Now it says 103. Thank you to the 105 of you who are watching. Just waiting for this to get started, waiting for this party to get started. Move this mic down a little bit because I don't like it in shot. There we go. Super Deagle says, please remember to control audio and camera. Should be better because I'm within StreamYards now. So I shouldn't have the problems I did yesterday when I'm trying to do it within OBS, which requires more intelligent monitoring. Auto thumbs up. Appreciate it as always. Thank you. Now it says 0 watching again. So I went from 105 to 0. I'm sorry to have offended all 105 of you at the same time. Must have done something wrong. I'm feeling okay. I'm feeling okay this morning. I had a nice shower. Had a decent little sleep. I've taken some caffeine. So hopefully that will kick in at some point. Thank you for saying that I look nice. Stephanie recommended a whole bunch of skincare products, which I've started using recently. So when I was in the shower, I was using an exfoliant. And then I put on some serums that's supposed to help with my skin tone and color issues. So that seems to be working out okay. And she get me this eye depuffing gel, and that seems to be working out pretty well actually too. Forgot to put on the eye depuffing gel. I'll put it on at the break, I guess. How many green shirts do I own? I don't know. I haven't counted. Yesterday I was wearing red. Today I was wearing green. What do you want? Have I been able to squeeze an exercise? No, I wasn't able to squeeze an exercise yesterday, which was annoying because I was really looking forward to it. And then I lost the will to live. But no breakfast today. Breakfast today was 2 caffeine pills. That was breakfast so far today. And we're going to see if those work. Breakfast this morning was 400 milligrams of caffeine. Waiting for it to see if it kicks in. Looks like YouTube might be having some problems. Lost signal. Great. Just great. This is great. YouTube's having problems. That's just good news for my morning. That's what I wanted in my life. All right, they're sitting down. Let's add this to stream. There we go.
Senate Judiciary Committee will come to order. We have 2 senators, Senator Ossoff of Georgia, Senator Tillis of North Carolina, who will do their 30 minutes of questioning to complete the agenda from yesterday. And then each senator will be allowed 20 minutes to ask questions if they wish, but the chair is more than anxious to entertain efforts to yield back your time. I'm sure that the witness, Judge Jackson, would appreciate it as much as all of us in that respect. I'm going to make an opening statement. Senator Grassley is going to do the same, and then we will proceed with the questions by the 2 senators. First, I would say, Judge Jackson, that I thought that President Biden got it right yesterday. He tuned in and watched the proceedings and said you showed both grace and dignity. I've used the phrase grace under pressure, and it's been referred to by many people. This is a tough assignment, and many have risen to the challenge, but none as well as you did yesterday. Thank you for doing it so much. I would just say this, much of what we heard from
If I do this, can you still hear the audio or not? Just, I want to know, can you hear the audio of the stream or not? If
the
I do
overwhelming majority of senators on both sides, I thought,
let me know.
Asking appropriate questions and positive in their approach and respectful.
I assume the answer is no, but I want to double check.
Nominee before us. But for many of senators, yesterday was an opportunity to showcase.
You can still hear the audio when I did that, really?
The November
Excellent.
Election. For example, all Democrats are soft on crime. Therefore, this nominee must be soft on crime.
That means I can turn down my audio in my ear without impacting you, which is great news.
The endorsement of Fraternal Order of Police, the International Association of Chiefs of Police, just doesn't fit with their stereotype of a Harvard grad, black woman who is aspiring to the highest court in the land. But you earned it. Law enforcement is on your side because you've been on their side at critical moments. And your family has dedicated a big part of their lives to law enforcement. And you obviously
a little loud in my ear. I was worried by changing the system volume. I would
so the soft on crime charge, which leads all others, falls on its face.
Good news.
The second thing is that you are somehow out of the mainstream when it comes to child pornography cases. And of course, that gets down to the question of sentencing and your choices in sentencing. It is difficult, if not impossible, for each of us to put ourselves in your place when you are facing all the totality of facts concerning a certain defendant then looking at your requirements under the law as enacted.
So
by
Durbin's just going to do a
Congress
little
and trying to do
entry
the right
fluffing.
thing to keep America safe,
entry
but to
fluffing.
meet justice. You are in the same place as 80% of federal judges.
Some people will say, "Is the stream not started?" The
comes
stream has
to
started.
sentencing
People have to
on
refresh,
child
and then now it says 0 on my end
pornography
again.
80%.
This is going to be a thing, isn't it? It's going to be a thing all day on
And of
YouTube.
course, Congress
This is just a
is
thing
not
now.
without
This is our
fault.
lives.
We have failed to pick up the responsibility that was assigned to us some 17 years ago when the Supreme Court decided that the basic guidelines would not be mandatory on judges. We should have stepped in at that point, but it's a tough, hard, controversial subject, and we've stayed away from it. And what has happened is the judges have tried to make do with a fractured situation where they have guidelines that are advisory. They have opinions coming to them about sentencing from the government, as well as from probation office and others. So I would say that the bottom line is this. You have done what 80% of the judges have done. You're in the mainstream of sentencing when it comes to child pornography cases. I also think it's ironic that the senator from Missouri who unleashed this discredited attack refuses to acknowledge that his own choice for federal judge in the Eastern District of Missouri has done exactly what you did. You also have been criticized as having been wrong to be a public defender or even to be in a law firm representing a Guantanamo detainee. It's interesting that Republican judges, very conservative ones, don't see this as a blemish on your character. They understand, as we do, that the Sixth Amendment creates a responsibility that the people have a right to counsel. You have exercised that responsibility in your professional life. This, incidentally, yesterday, your nomination turned out to be a testing ground for conspiracy theories and culture war theories.
Oh, please.
The more bizarre the charges against you and your family, the more I understand the social media scoreboard lit up yesterday. I'm sorry that we have to go through this. These are not theories that are in the mainstream of America, but they have been presented here as such.
Really?
Finally, you are a respected,
Critical race theory,
successful
not in the
woman
mainstream.
of color. You've been approved 3 times by this committee for increasingly significant judicial assignments. Now the President of the United States has chosen you to serve on the highest court of the land. America is ready for this Supreme Court.
Just would like to once again offer my availability for federal judge if Biden is looking for somebody.
Mr. Chairman.
Please, somebody call the president.
Mr. Chairman,
please,
I think you've
please pick up your
in the
phones.
main provided both
Please
sides
pick up
an
your phones and
opportunity
dial
to be heard and
202
ask their questions.
456-1414.
I noticed that after every
That's the White House switchboard.
series of questioning
And let
on
them
this
know
side
that
of
you
the
want to
aisle,
talk
you
to someone
choose
about nominating Uncivil
editorialize
Law.
and contradict the points being made by this side of the aisle. I don't know whether we will have an equal opportunity to editorialize about the advocacy that you and your colleagues, the points that you're trying to make. I especially was concerned that after my questioning yesterday, I left the hearing room and you chose to come back after a break and raise with the judge a point that I had asked her about, and which I frankly think was misrepresenting my position and what the facts are with regard to whether the judge is accused.
I'm looking especially
President
pink
George
this
W.
morning.
Bush and Donald Rumsfeld of
Put on some
war
color
crimes.
correcting serum.
My language was,
Maybe that'll
I
kick
asked
in.
her whether she'd called them a war criminal, and she said under oath to you, no, I did not, although the record is plain as it can be that she accused them of war crimes. Now, I don't understand the difference between calling somebody a war criminal and accusing them of war crimes. Maybe in some other foreign language that I don't frankly understand, maybe that would make sense, but not in accordance with a common understanding of the English language. So I just want to lodge a protest and say that I don't think it's appropriate for the chairman, after every time somebody on this side of the aisle asks questions of the judge, you come back and you denigrate and you attack and you criticize the line of questioning. I think the judge is doing a pretty good job of defending her own position and answering questions. So thank you for giving me a chance to express my objection to the way that you've been editorializing after each time this side of the aisle asks questions.
Thanks, Senator.
Mr. Chairman.
Excuse me.
Chairman.
Excuse me. Thanks, Senator Cornyn. It's known as chairman's time.
Could I make my statement first?
You want to make your statement?
Yeah.
Well, may I respond to what Senator Cornyn said?
Well, if you want to speak before
May-
you're a
may I?
ranking member,
Thank you.
Tyler, you're right.
Mr. Chairman, I agree with Senator Cornyn. You and I have talked about this before. I have great respect for you. You know that. But I've had the same issue in normal hearings, non-Supreme Court hearings, where you make editorial comments after I question.
Yeah. So
I
what's happening
appreciate
today
your
is we got two
But
senators,
they're not offered in an even.
two senators
handed
this
way.
morning who get 30
And I
minutes
just don't
each.
think it's productive.
And then
I
I'm
mean, you just
unclear
referred by name to,
on whether or not that is
Senator
followed
Hawley.
by witness
I
testimony
think he should have a chance
or the witness
to
testimony comes
respond.
after.
You know, this is America. We
But
have
at some point,
the
okay,
right
two things are going to
express
happen.
Ourselves.
When so two senators are
You
going to
know,
give
you're
30
not
minutes
free
worth
if
of
you
time.
can't say what you think.
And then after that,
I
two
just-
things are going to happen.
I want to join
The
my
senators are going to get 20 minutes
colleague,
worth of time
Senator
each.
Cornyn. I just don't think it's
And
appropriate,
people are going to
Mr. Chairman.
testify. And I'm not
It's
sure which order
called
that happens
chairman's
in.
time. It is a tradition in this committee exercised by Senator Lindsey Graham as chairman and Senator Grassley in previous Supreme Court.
But they
No,
didn't
I'm
do it
gonna-
the way you do it,
I'm
Mr.
going to
Chairman.
allow you to be heard, but I want to be heard
Of course,
without interruption.
of course.
And so in the minority, we waited through chairman's time when we had Republican chairs. There will not be a separate set of rules for Democrats in control of this committee. That was used as a response time and again by both of those senators, and it was accepted. If what I said was somehow problematic or painful yesterday, I'm sorry, but the Democrats are going to use the same mechanisms that the Republicans have used in this committee.
And I appreciate that, Mr. Chairman. But I think if you're going to personalize it as to senators by name, you ought to give them a chance to respond.
Well, they will have a chance.
Mr. Chairman,
Each and every senator has 20 minutes today to respond if they wish.
Mr. Chairman,
Who's seeking? Senator Ossoff.
could we hear from Ranking Member Grassley? And then I'd like the opportunity to ask questions on behalf of the state of Georgia. I think the American public is now tuning into these proceedings, expecting a substantive discussion of matters of grave importance to the country with a nominee for the Supreme Court before us. I don't think we set an appropriate tone by bickering over time and process at the outset of our proceedings. Every senator deserves to be heard. I would like to humbly request that Ranking Member Grassley make a statement that I
What's
and
up with his
Senator Tillis
tie?
have our opportunity to question the nominee, and that then we can litigate balls and strikes from yesterday's hearing. Would that be acceptable to the committee?
I think in the name of your humility, we should do that.
Thank you, Mr.
Oh,
Chairman.
humility. Okay, sure.
Senator Grassley?
Senator Ossoff, my statement doesn't quite fit in with what you asked, but
It's not
I
20
feel
times
like
100,
I
it's
have to
20
say
times
it
the number of
anyway
the committee,
because of the conflict
think
that
is
happened late last night. But
13.
before I do, I want to somewhat
So,
tongue in cheek, but with some seriousness as well. When the chairman quoted Biden as saying that Justice Jackson or Judge Jackson handled herself with grace and dignity, I want to compliment the Democrats on this committee for using grace and dignity, unlike it was during the Kavanaugh hearing.
Is it?
Thank you all very
What
much
did-
for making this. I've heard a lot of compliments about how this is a way a hearing ought to be held. So I want to address that issue that was raised yesterday about records. Senator Cruz raised a very legitimate question about data related to U.S. probation obligations. The White House and members of this committee use that information to attempt to discredit information raised by Senator Hawley and others about the nominee's sentencing record as a
Yeah,
district
15 people,
judge.
including the chairman, something
No
like
one
that.
on our side of the
Yeah,
aisle had
something like that,
access
15
to
people,
this
13 people, something like
information.
that.
In fact, before this past week, I'm not sure anyone but the probation office and the court had access to this information. My understanding is that the probation office recommendations aren't part of any public record. The specific sentencing recommendations aren't always shared with prosecutors or defendants. Somehow it appears that the White House obtained this information. It was leaked in pieces to media outlets in order to cast doubt on legitimate members' questions, and then it was provided to only Democratic members of this committee without any of the underlying documentation. I'd like to add my name to the letters that are requesting at least, this is Senator Lee's letter request for at least the probation office recommendations so that we can be sure of the data handed out by Democratic staff last night. I'd also like to add my name and have added my name to Senator Cruz's follow-up request for access to any other data that might be shared with our colleagues on the other side. One last thing to suggest that all that we have to do is ask for information doesn't pass muster. You can't ask for information you don't know if it exists. I've asked for non-public records related to the judge's tenure on the Sentencing Commission. Those have not been produced, just like 48,000 pages of records withheld by the White House. How is the United States Senate supposed to review a record that we don't have? This process might be timely, but it's neither thorough nor fair to the American public. And I hope we can rectify that. I yield.
Thank you, Senator Grassley. Senator Ossoff.
Thank you, Mr. Chairman, Ranking Member Grassley. And Judge, good morning.
Good morning, Senator.
Welcome back.
Thank you.
We had a late night doing our job as senators and you as a nominee, and we're off to a morning start. I was considering asking you if you were a coffee or a tea drinker, but I thought that might be too personal and immaterial to the question of your nomination. I want to begin inspired by the presence of my
Okay, guys,
brother,
like
Senator
he had just
Reverend
given
Warnock,
that speech just
who's joined us
like
this
3
morning
minutes ago about how he wanted to
in the
get to
spirit
the
of
merits and be
national
serious on behalf of
unity,
the state of Georgia.
offering thanks
And now he's asking about tea and coffee,
for
man.
these proceedings,
Woof.
for our Constitution, for this opportunity to air in public before the American people a vital grappling with ideas core to our republic, questions of the role of branches of government, questions of the proper role of judges in our society, questions that keep the peace and ensure that this remains a nation of laws. As I noted in my opening statement a couple of days ago, democracy is the exception and not the norm in history or around the world. And this public exercise is a vital one. And so I'm thankful for it. I'm thankful that the American people have the opportunity to observe it. And I'm thankful for your presence, Judge, for your service to the country throughout your life as a district judge, as an appellate judge, as a member of the U.S. Sentencing Commission, as a nominee for the court. So thank you for being here. Thank you for subjecting yourself and your family to an intrusive, at times cruel and unfair,
Cruel.
but on the whole necessary and proper process of scrutiny as you are considered for this appointment.
Cruel.
The American people
Let's
who
talk
are
a
now
little bit about
tuning in
Kavanaugh
for the second day
and
of these
cruel.
proceedings are hearing about your approach to the law, to your role as a judge and as a potential Supreme Court justice, and they're also getting to know you personally. And we've had the opportunity to hear a bit about your family, your background. I think it's also appropriate that the American public hear a bit more about your brother's story.
Oh, good.
As
Let's
I
talk about your
understand it,
brother, who's definitely
served
important because
the
he's
Baltimore
being
Police
nominated to
Department.
something.
Served in the U.S. Army. Before we turn to matters of law, will you please help introduce yourself and your family
Oh,
to
yeah.
the
Will you tell us?
American public as
Will
you
you
seek
please
this
talk about
lifetime
your
appointment?
family and your
Tell us a bit about him and his story.
brother and how awesome he is and how much he
Thank you,
fought for our country,
Senator.
loves our country, because all those
My
things are
brother
totally relevant to
followed
you
in a long
and your
tradition
character
in my family of
and your
public
ability to
service.
serve, what he has
It
done with his
was
life.
a core family
Incidentally,
value.
this would, go the other
My
way too,
parents were
unless you can
both
show some
public
association
servants,
between them, right?
and my mother's
So,
two of my
like,
mother's
it's
brothers
different for Hunter because he
were
refers to the
career
big guy,
law
so it refers
enforcement.
to presumably
And
Biden.
my brother and I are
But
almost a decade
otherwise,
apart
like,
in age,
you're
and
not really.
he, I
There's also difference
think,
because Biden is his
looked
father,
up
so
to
just problems
my
and sort of,
uncles, who
maybe parenting issues.
were
But
often around in their uniforms,
otherwise, like,
keeping their
if your
weapons
brother's
away
a
from the
screw up,
kids
doesn't mean
by
you're a
putting
screw
them
up.
up on high shelves.
Well, I went to
and
Harvard and interned a couple
we
times.
looked
He's a
up to
crack
them,
addict,
and
so
we understood
we
through
picked our
their
paths, and
service what it
it worked
meant
out differently
to
for
give
us.
back
It's like,
to your
who
community.
cares?
My brother went to college, a historically Black college.
I'm just going to keep
Howard
talking over her
University
by
here
a
in
while,
Washington,
for a while,
DC,
by the way, because she's saying
after
nothing of
growing
any
up in
value.
Miami,
So if you're like,
and
talking over the nominee, well,
decided
at the moment she's
to
filleting
follow
herself
follow
vis-a-vis her
in
family
my
and their service.
uncle's
So I'll just tell you
footsteps.
what she's saying.
He could
Even
have
without
done
listening, I'll just
many
give
things
the
coming
answer.
out of college.
Well,
with a college
it's
degree,
my
but
brother and
decided
his
he wanted
service,
to
and
be a
he
police
wanted to fight
officer
for our country in
and
9/11,
went
and he
to
fought for
Baltimore,
the freedoms that I hold
which,
dear and
as many of you
freedoms that
know,
I want to defend
struggles
as a
like
judge.
many cities with
We each have our public
with
service, and
areas that are
as a
have a
judge,
lot
from
of
time to
crime.
time, I think about
And
his public service and the flag that
it
he
was a
fights for,
very
and how proud I am to
it
be
was
an
a very
American,
stressful period for
and
us
so
as a
forth and so
family,
on.
because
And everything
as
I said
proud
is
as
just
we
much value is
are
what she's
of his
saying.
service, as much as we know it's important, law enforcement is a dangerous profession. And as family members, you worry when you don't get the phone call, when you haven't heard for a couple of days, when you hear about things in the news, in the community, you worry.
Also, I'd like
And
to talk about
so
my other brother, or maybe it's the same
I
brother, I
grew up
forget, one of the two,
with
who
family
was
members
a
who
cop
put
in
their
Baltimore,
lives
and I
on the
want to talk
line.
about
I
his
understand
service to his
the
community
need for law enforcement, the
in defending our
importance
streets like he has defended
having
our
people
nation.
who are willing to do
I believe
that
in law
important
enforcement
work,
because I
the
have law
importance of
enforcement in my
holding people
family.
accountable
I believe in the rule of law,
for
as
their
I've
criminal
demonstrated through my
behavior.
practice as a judge.
I also,
And
as
we
a
all
lawyer
have
and
defended
a
our country in our
citizen,
own way. And also, while I'm at it, I'd like to
believe
talk about my
very
father,
strongly
and I'd like to talk
in
again
our
about how I was
Constitution
inspired by him
and the
reading his
rights that make
books at
us
the kitchen
free.
table when
And
I
what
was
that
a
means to
young
me
child,
is an
and how he led
understanding
through his
that although
examples
we need
that has inspired
accountability,
me
although
and
there
gotten
is
me to the point
crime,
where I
we
am today.
also have a society that ensures that people who have been accused of criminal behavior are treated fairly. That is what our Constitution requires. That is what makes our system so exceptional. My brother understood that as part of his work, and he also served in the military. He also decided, as many people did, to defend our country after 9/11, that he would go into the Army. And I remember when he made that decision, he had a college degree. He could have been an officer right away. He could have been a type of military officer that didn't have to actually be on the battlefield. And I remember saying, are you going to do something with, radio signals? Are you going to be behind the scenes? And he said, no, I'm going to be infantry, boots on the ground. He said, I believe strongly in the protection of our country. And if I'm going to be leading, I'm going to be out front. That's the kind of person my brother is. It's the kind of service that our family provides. And for me, what that meant was an understanding that to defend our country and its
I
values,
think I threw 9/11 in there somewhere.
we also needed to make
I
sure
think I threw 9/11 in there
that
somewhere.
when we responded as a country to the terrible attacks on 9/11, we were upholding our constitutional values, that we weren't allowing the terrorists to win by changing who we are. And so I joined with many lawyers during that time.
I could also put on the
were
closed captioning.
helping the
I'm gonna do
courts figure out the limits of executive authority, consistent with
There
what
we
the
go.
framers
That helps.
have told us is important.
That way
The
we can read our
limitations
words
on
in
government.
case you missed something.
I worked to protect our country. My brother worked on the front lines, and it was all because public service is important to us.
Thank you, Judge Jackson. And let's talk a bit about limitations on power. Our Constitution is a document that renounces monarchism and instead establishes a republic. You, in opinion that has been widely cited, made the observation that presidents are not kings. What does that mean, and what are some of the most
what does it mean that
important
presidents
bulwarks
aren't
in our
kings?
constitutional system against
Let
the abuse
me
of executive
explain
power,
to
against
you,
tyranny?
like a Schoolhouse Rock style,
Thank you, Senator.
why the concept
Our
of a republic or
constitutional
democracy is
scheme,
good
the
vis-a-vis
design of
a
our government
monarchy.
is
Wow, deep
erected
concepts.
to prevent
Let me ask this
tyranny.
Harvard grad
The
with the
framers
3
decided
clerkships
after
something a high schooler should be able to
experiencing
answer on an essay
monarchy,
question.
tyranny, and the like,
Why?
that they were going to
Why is
create a
republic?
government
What
that
are the
would
benefits of a
split
republic
the
vis-a-vis a
powers of
monarchy?
monarch
Is this 8th
in
grade social
several
studies,
different
or is this a
ways.
nominee for
One
the U.S. Supreme
was
Court?
federalism. It was vertical. They would split the powers between the federal government and states. Another was to prevent the federal government from itself becoming too powerful, from having all of the authorities, from having legislative, executive, and judicial authority concentrated in one place. So the Constitution, in its design, puts the legislative authority
Ossoff
in
rubs me
Article
the wrong
1
way.
and gives it to the
He
Congress.
rubs me the wrong
the
way
power
in
to
his
make
speaking.
laws.
Something about him, I don't.
It puts
just
the
rubs me the wrong
executive
way.
authority in Article 2 and gives it to the president, the power to execute the laws. And it puts the judicial authority, the power to interpret the laws, in Article 3 and gives it to the court. The separation of powers is crucial to liberty. It is what our country is founded on, and it's important, as consistent with my judicial methodology, for each branch to operate within their own sphere. That means for me that judges can't make law. Judges shouldn't be policymakers. That's a part of our constitutional design, and it prevents our government from being too powerful and encroaching
I'm
on
just a
individual
bill.
liberty.
Yes, I'm
Thank you,
only
Judge.
a
I
bill.
mentioned in my opening remarks that
Sitting here
the
on
court
Capitol Hill.
has played a vital role, constrained
Nate the
within
lawyer wants
its
to join.
proper
Let's let in Nate the
constitutional
lawyer.
boundaries
Hello, Nate the lawyer.
in the national
Hey, what's up,
of
Kurt?
making
We
America
were
Hello here,
learning. We were
too.
learning what the difference between a republic
what
and a
America
monarchy
is
was.
in text.
Oh wow.
Reflecting on your experience as a public defender, a vital role.
We're also
in our
learning why her
justice
family
system.
is just the best. That was the
Let's
first
talk a little
question.
bit about the
Why is your
Sixth
family
Amendment
just the greatest family?
and the role
Question
Just,
that
Why is
Hey,
a
good man.
republic better than a
ensuring
monarchy?
that the Sixth Amendment
This is the great Democrat from Georgia.
Uh-huh.
in the
I
Gideon
think your
v.
volume is a little
Wainwright
low.
decision.
by
Can
the way.
you
At least it is in my
help
ear.
all those who are
Oh,
tuned in
oh,
right now
hold
to
on.
reflect upon that
Turn
decision,
myself up.
what
Better?
it means, what it
Yeah,
says about
thanks.
the
Is that
role of the
better?
court?
Yeah, that's better for me.
Woo!
Yes, Senator. Prior to Gideon versus Wainwright, people who
Gideon
could
versus
not
Wainwright. I haven't heard
afford
that case in a while.
lawyers were not entitled to lawyers
Great case.
under our system. So a person
Excuse me.
could be accused by the
Gideon
government
wrote
of
his-
criminal
Gideon
behavior
wrote his
and would have to
petition for
fend for
certiorari
themselves in court.
on,
They would have to make
prison
their own
stationery.
arguments. Someone
You
who's
didn't,
not
didn't.
a
and sent it
lawyer
into the U.S.
would
Supreme Court, and they
still
granted cert.
be responsible
And won.
for defending
And won.
him or
And
herself
won.
in front of a
You don't need to
judge
be a lawyer to
if
win.
the
Apparently.
government brought charges.
Apparently.
Earl Gideon was a criminal defendant from Florida, my home
It
state.
basically showed every lawyer up ever,
who
this
had a
this
handwritten
non-lawyer
He
criminal
complained
writes.
that
I
it
think it was
wasn't
like 5
fair
pages too. It wasn't
under
very
our
long.
constitutional
5 or 6
scheme
pages.
that
Writ
protects
for
and
certiorari at
requires
prison
people to be
stationary,
tried.
and they grant his certiorari.
He
So what are the
said,
rest of us
"I
doing
need
wrong with our
help.
lives?
I'm not a lawyer. I can't make these arguments. I think it's important for the protection of liberty to ensure that people are able to have counsel." And that handwritten petition
Please tell us
made
why
its
it's
way
important
to
for
the
people to have
Supreme
lawyers.
Court. And the justices read it, and they determined to take his case, and in the end decided that the protections of the Sixth Amendment, the right to trial,
Like
includes the
some of
right
the questions are
to
getting silly. Like
appointed
define
counsel,
what the word woman
so
is.
that everybody
Like,
who
we
is
I thought that was a
can
good
do that
question.
again.
accused
I'd
of
press her on
criminal
it.
behavior
It's
now
like
has the
feeling-
right
I'd be like, hey,
Yeah,
to
like-
an attorney.
I'd
What's
ask
the definition
you,
of the
I'd
word
ask her something
word?
like,
Very
I'd
important.
say,
I mean,
are
one
you
of the
proud
things
to
that I
be the
see
first
or
black
saw as a
woman
trial judge
nominee? This would
is
be
that
me
it
as
was
Republican. Like, are you
crucial
proud to be the first
for
black
our
woman
justice
nominee
system to
Yes.
have
to the U.S. Supreme Court? Then I don't care
representation
what her answer is.
from both sides.
And because then my next question is,
It was
well,
the
Define
only
the
this is
way
word.
going to be
that
some
a
version of yes.
judge-
I know
it is
that.
the only way that a
Mhm.
judge
And then,
can
of course, my next
really
question is,
make
well, I hear that you say
fair
that you're proud to be the first
determinations.
black
And
woman
in
nominee. So
cases,
let me
and,
just
you know, we've
ask you
heard
the
a lot
question:
about my criminal
what is a
cases.
woman?
In every case,
and see what
I'm
she does with
getting,
this.
as
Like,
a
but you
judge,
agreed to that
arguments
you were proud to
from
be
the
the first Black woman
prosecution.
nominee.
I'm
So
getting
woman must mean
arguments
something to you.
from
Shit,
the
That could be
defense
fun.
counsel.
I could do that for
I'm getting
20 minutes. That
arguments
could be a
from
fun
it's a-
exercise.
probation.
again, it's a
from
political.
witnesses,
This is a political
and the
theater. So
work of a
it's
judge
just
is
a
to
silly
look
question.
at
I
the
think would have
facts
never
and
been asked. Well,
circumstances,
not
hear the
to
arguments of the parties,
her. I think to
apply
Kavanaugh.
the
I think
law,
now
and make a fair
the questions
determination.
are more
And so
trying to,
having
these are,
lawyers
let's
for
just try to
criminal
get you on a
defendants
gotcha sub
aids in
question
that
than
process
anything substantive.
and
I
benefits
don't
of
really
Defining what a
think
woman
define
is,
woman
like,
should be a
I
gotcha
gotcha.
question, to be quite
I would
honest.
just-
I really
I-
don't.
I could
the
define
public
it,
to note
a
at
female
this
human
time,
being, right?
Judge Jackson, that
That's
it
what I
so
would have said, a
happens to
female,
be
Yeah,
female
this
human
I,
being.
I,
that
That's
Georgia
if
is one
you're
of just
saying
easy for me.
that
three
define woman is a
federal
gotcha question,
districts
I don't know what to
without
tell
a
you,
federal
Nate.
defender's office. And
No, I'm
I've
saying,
sponsored
I think they're
legislation
trying to get a
to
gotcha
establish
question.
one,
That,
and
that
I'll
was
be
definitely true. Let me see if I can
seeking
get a
support
gotcha.
from my
And I
Republican
think she
colleagues to
played
try to
into
make
it.
that
She should have just
bipartisan
answered
to
a
ensure there
female
is
human being. That's what a woman
access
is.
to counsel for
Let's Google it.
defendants
Google what's
in my
the
state.
definition of the word woman.
Let's talk a bit about
But
the
I
First
do
Amendment,
think, though, on the opposite end,
freedoms of
it would be
speech,
concerning to me that she couldn't
publication,
clearly define it. Like that
assembly.
was so, it did its job, because I'm like, if you can't define what a woman
There's
is,
a
then who the fuck are
well-known
putting up
Supreme
there,
Court
right?
case,
Like,
Brandenburg
really,
v. Ohio, which
Are you
establishes
that?
certain
Are you,
facts
Come
are
on.
you,
to
are you
ensure
proud to be
that
the first
the
Black
government
woman
is
nominee? Define
constrained
woman. Define Black.
in any effort
Yeah, it's like
may be
at that
made
point, I'm thinking we're
to
getting up, even though, but I do
punish
think
speech.
she
Define
kinda
Black
got
is actually
caught up
harder.
with
The
the-
impulse to censorship
I think she got caught up with the woman
is
thing, though.
something
But the
that
define
can
Black,
emerge from time
That's
to
hard,
time
actually.
across the
I
ideological
don't know what the answer to that question
and
is. Do
political
you?
spectrum,
like God forbid they
particularly in
ask
times of great
Kavanaugh
controversy or in
define
times of
define
national
beer.
security
What is
crisis.
beer? Like,
Oh,
really?
well, that
Can
one.
you-
I mean, I don't know the
that's
answer
like
necessarily off the
even
top
they
of my head,
asked
but
them,
I'm sure it's
broader
defined
do
on
you
the
like-
CFR somewhere.
watching now from
like
afar,
they
Right?
asked
And it's
them,
like,
do
oh,
you like
define beer. Well, it's like,
through
well, I'm sure it's in the Code of
that
Federal
decision
Regulations. We could go look it up
and how
together.
you will
Yeah.
approach
Yeah,
these
exactly. No,
vital
the same thing with the word woman. I
for
think
speech,
when you start getting a
publication,
devolving, and
should you be
I'm
confronted.
not saying what they're doing is wrong, right? The question
you,
they're asking, I think
Senator.
it's all grist for the mill.
freedom
They
of
asked
speech,
Kavanaugh, what do you like
publication,
beer? And
assembly,
all these
I like
stupid
beer.
is in the
questions too.
First Amendment
So,
of the
I like beer.
It's
I'm
like
not a fan of
I just
sour.
wish the
Is,
questions were more substantive instead
a
of these.
core
Let me see if I can just get a
foundational
moment.
protection
All right, great.
against censorship. It is important in our
Censorship is bad. Is that what we're
constitutional
doing now?
scheme
Okay.
that people
Censorship is
be
bad.
allowed
Okay.
to express
So
themselves.
how do you feel about, like, for
that
example,
ideas
the
be exchanged.
New York Post
That
being
is
kicked off the Twitters
groundwork
in response to the Hunter
for,
Biden story, which has now been acknowledged
a
as true?
vigorous and
Do you view
vital
that as censorship?
democracy.
To which, of course, the answer
There
is
are,
Twitter is a non-governmental actor,
many
and I was speaking of the
tests,
government.
many cases
You know, it's
in
frustrating when
the
I can ask
Supreme
all the questions
Court's,
and give all the answers
jurisprudence that
because these things are so predictable.
discuss various disputes.
It's like I could ask all the
about,
questions and give all the answers. And just do my own
circumstances in
interview for
which
10
the
hours.
You know,
government
I
can
like back in the day when there were really no
restrain or
questions. They weren't
regulate
coming in front of the committee. Like,
and
this is a
that
whole new phenomenon.
Well, this is true,
back
right?
in the, what,
Because
the
as they
50s?
pointed out,
establishes to a
I
certain
remember which
extent
justice it
that,
was, but as they point out, back in the long ago, the far, far
if there
away,
is speech
there was a
that is
time
an
when at least
incitement to
once a president
violence,
appointed someone to the
that's
Supreme Court,
one
and they were
circumstance in
confirmed the
which
very next
government
day.
might be able to
And
prevent
even
it.
in
But other than that,
up
short
to
of
early
that,
20th century,
um,
there were
free
no
speech is
hearings.
supposed
No
to be
committee
allowed to
hearings.
happen.
Well, no committee hearings. Yeah, they
And
didn't do the whole committee
there
hearings.
are,
and like that.
again, various tests and circumstances that the
Just as a
court has
reminder,
applied
like Scalia
in
was
deciding whether the
Scalia
government
was
can-
confirmed
can
by a vote of
regulate the
what was it,
content
Like
like
98
98 to
or
0 or
97,
98 to
yeah,
1 or something?
But the
And Ginsburg is about the
Republican-
same. 90,
But it was a
Yeah.
Republican
99.
president and a Democratic Senate.
thrive
So, it was,
because the government
both this just shows you
restrained
where
and
we are in our
cannot
country, right?
censor, its
Both
citizens.
always
Scalia
changed. Yeah.
I
and
think in the same
Ginsburg were
spirit of
confirmed with
thanks,
95
with
plus
which I
votes.
open these questions,
Who
I
thinks
also want to
that
just
she's
take a
gonna
moment
get
and recognize
95
the
votes?
members of the press who are
Nobody.
here, the reporters and photographers who
To be honest
ensure
with you, if
that
I'm a Republican, that
these
whole
proceedings are
woman question
truly
would have
accessible to
kind
the
of
public.
shook me a little bit. I'm like,
And,
you can't define. Come on,
ask
that's a
you to
softball here.
describe your
That's
approach to press
ridiculous.
freedom.
Come on,
Um,
So I do think it exposed a
the
little that
question
liberal
of
mindset because
prior restraint
that shouldn't be
has
controversial.
been
But the
litigated.
same thing with Amy Coney Barrett with the whole
famous case in the context of the Pentagon papers
when what's her name got it?
in the latter years of
What's
the
the VP?
Vietnam War.
Harris. When Harris got it with the
I
whole
know, I believe for
with the
all
question
of us,
about
we
oh, you
we
believe, you know,
recognize
she
the
was
vital
when
role
she cornered
press freedom,
Barrett when she was like,
and
science,
ensuring the
science, I
free
believe in
exchange of
science. Yeah,
ideas,
smoking
access
is
to truth and
judicial
debate,
notice. Everything's judicial notice.
democracy. How will you
98% of scientists
approach
believe. They're like, oh, what about
cases
climate
to
change?
implicate press freedom?
Well, you see, it was
Thank
a
you,
great catch.
Senator.
She made it look like she
This
was
is another area in which there
inconsistent. And that's the
is
same thing what's going on with this woman.
well-established case law.
You know, I'm a black woman.
um,
It's great to be a black.
that
What's a woman?
The
But
current question on the
see,
table is, do you
the
think press freedom is
to be
good?
able to
That's the current question on the table.
write
the press is the
report,
fourth
Do you
branch
think
of the
freedom of
government,
press is a
baby.
good
is
thing?
a general obligation of truth in terms
I'll
of
just
This is not a
simplify the question.
softball
That's the
question.
current question on the table.
This is not a
that
softball question at all. This is a
sometimes,
deep philosophical
sometimes
question.
there may
You know,
be
is that
things
constitutional guarantee a
published
good thing?
that aren't exactly
She's
accurate.
got to say
And so
no
the
and
court
then
in,
defend her position.
New York Times versus Sullivan
I believe it was Jefferson who
determined
once wrote
a higher
that
standard
if he had to choose
liability
between a free
for
government and free press, he'd choose the free
um,
press. That's how important the
things that
free
are
press
put
is,
out
would be
in
the
the
start of
press
my
have to
answer.
be knowingly
Isn't it the
false.
fourth?
I'm going
The
to
fourth
just state
branch,
the
right?
importance of free press so we all feel better.
Because the
The
court
fourth
was
branch.
balancing
Fourth estate, yeah.
concerns about libel, people claiming that they have been misrepresented in the press, with the need to allow the press to do their job.
C-SPAN's stream is loud. I can
The
turn it down a little bit if
overall
it's too loud.
understanding
Let's
is
turn it
that
to
press
80%.
freedom, again, is one of the First Amendment freedoms that are undergird our democracy.
But I do think the Republicans
Something I
do
just
have a
want to take
beef.
a
They're like,
moment
look at the
and
way we're
observe
questioning her on
Judge
real
Jackson,
shit. You guys
is,
had Kavanaugh's out here looking like a
this is my first
goddamn
such proceeding.
rapist.
So I'm
And
How's the
this
volume
like
now,
for-
guys?
Chairman for
Is this
opening
balanced? I turned it down to
today's ceremonies at
80%.
the
Did
end
it?
of the
First of all, did it make a
days, but,
difference? Second of all, is it balanced or I need to change
something
it
that
more? Let me know in the
studied and I'm
comments.
aware of is that there's been a range over time of
Welcome to StreamYards and
how
audio
willing
management.
nominees are
Yeah.
to candidly and openly and forthrightly discuss these core matters of constitutional principle in proceedings like this one, and a tendency over time.
It's like I don't
to
really
allow
care about the
less,
Democrats'
discuss
questions. I know
less,
it's all going to be fluff
a,
and you're the greatest ever, blah
more
blah
restrictive
blah. I really want to
approach.
see the
And I wanna
Republicans.
thank
That's
you
where I want to see
because,
those hits. Those are going to be questions.
While you have prudently and disciplined in a disciplined way refrained from
What does the
commenting
word
inappropriately
black
on
mean?
potential pending case law, you have been willing to engage in a forthright and expansive discussion of these vital principles.
I hate StreamYards and
in
audio
a way that I
management
think
so
stands
much.
out among
I hate
some
it
recent
so,
nominees. That's not a criticism of
so
recent
very
nominees.
much.
It's
Because
an
what it
observation
sounds like
about your
in my
performance. And I
ear
think that
and what it sounds
having
like
an
to you
open
guys are
and
two
honest,
very, very
and
different
forthright
things.
dialogue about
They're
these
probably
matters.
saying,
This is just a
I'm-
problem in
is
you
part of the
StreamYards
vital
as a
role
tool.
that
It sounds
these
fine
proceedings
in my ear.
serve.
And
I
then
wanna
it doesn't sound
turn
anything
now
like what
to,
you're hearing.
the Fourth
I
Amendment.
hate it so much. Why can't it just be what you
Want
see
to
is what you
discuss with
get?
you
I don't know.
the protections against unreasonable search and seizure. We discussed how the Constitution was a renunciation of monarchism and tyranny. It establishes core civil liberties, one of which is the protection against unreasonable search and seizure. How will you approach Fourth Amendment case law, and can you
Please tell us
help
why.
those tuned in across
Please
the country
tell us why
remind them
rampant
of
search and
what, for
seizure
example, the
without
principle of a
cause is
reasonable
bad.
expectation
Please-
of privacy means?
Please
in the
tell us
context
why
of
the Fourth
Supreme Court
Amendment is a good
jurisprudence.
thing.
Thank you, Senator. The Fourth Amendment is one of the amendments in the Constitution that protects individual liberty by limiting what the government can do with respect to criminal processes.
Mm.
It restrains the government from engaging in unreasonable searches and seizures. And the Supreme Court has developed a series of tests and ways of evaluating whether any particular act by an officer in a case qualifies as an unreasonable search or seizure. Let me just say that this is the kind of area.
There seems to be
of,
problems on YouTube on
Supreme
streaming
Court
today, by the way, as well.
and,
I need a reason.
Yeah.
He says I'm
review
refreshed my
that
page
is
and get the
very
stream starting
fast,
screen and can't get
specific,
back.
because
Yeah,
that's
we're having
what I
all
was-
kinds of problems with
in
YouTube
order
today.
to stay
My
in
counter shows
our
0 people watching.
appropriate role,
Yeah, the
People are
counter
saying
shows
that
one
their
person.
stream isn't working on their end.
make policy
It's
about
true. It's saying waiting for
police
uncivil law.
behavior writ
Do you
large.
have OBS
You
open?
can't just sort of look
Do I have
out into
OBS
the
open? No.
universe and say we
All
have
right,
a
yeah, 'cause sometimes
constitution that
you
says
maybe
unreasonable
stream
searches
may
and
be
seizures.
active.
So let us tell you all what that means. That's not the way that courts operate. Under Article 3, courts can only hear individual cases and controversies and decide them. So every court, including the Supreme Court, is looking at unreasonable search and seizures in the context of a particular dispute where someone has had something searched by an officer in their house, they've been seized under a particular set of facts, and they claim in the context of a lawsuit or in the context of defending themselves that there has been an unreasonable search or seizure. And so the court, case by case by case, looks at the facts and circumstances and decides. And
Essentially, what she's saying
I
is
would
judicial.
say that this
The
is-
judiciary
this
look
the
is a means
kind
test.
of
They look at the means
analysis that
and
takes
determine if the
into
means were
account
appropriate.
a
It
number
doesn't
of
take into the
things. but
conclusion
one
or
of the
whatever. It's the
things,
means. How did it
in
happen?
addition to understanding the facts and circumstances, is understanding what is meant in the Constitution by unreasonable search and seizure. There is case law that the Supreme Court has developed that looks at whether or not something is an unreasonable search and seizure, in part by analyzing whether there was a reasonable expectation of privacy in that item, in that area. Is there a reasonable expectation of privacy in your house, for example? If a police officer were to come into your house, you would not be able to claim Fourth Amendment protection unless, says the Supreme
And I'm waiting
Court,
for
there was a
the
reasonable
decisions for the last
expectation
term
of
to come up.
privacy
They
in
still
your
haven't
house.
published any of them.
And the Supreme Court has determined whether there's
Wonder what's
a
going on.
reasonable expectation of privacy, for example, in your house, by looking at what areas were protected at the time of the founding when the words unreasonable searches and seizures were written into the Constitution. Lo and behold, something like your house, the court has determined there is a reasonable expectation of privacy because that's what those terms meant back then. And so if a police officer were to come without a warrant, the court has said, in areas where there is a reasonable expectation of privacy, that would be an unlawful search.
But see, this is where I think the originalism
This is an
sometimes
area
fails
where
because
the emergence of new
true,
technologies
the original meaning of the
makes
Fourth
it
Amendment
likely,
was
I believe,
you know,
that
personal
should you be
personal
confirmed,
effects, things of
you
those
will have
natures.
to
But there was no
consider
cell phones.
Fourth
And
Amendment claims
then Roberts comes
in
and
light of
says, "Hey, cell
circumstances
phones are now
that couldn't
covered
have been
too."
anticipated
Yeah,
at the time
you know,
of the drafting of the
originalism.
Constitution. And indeed,
Could you make the
constitutional
inference?
interpretation
Yes,
has
because
already
technology's
evolved
changed.
over
But then you
time
have the argument that
to
hey,
adapt to the
there were no
reality
cell
of new
phones. This
technologies,
obviously didn't mean cell phones. This
from phone
obviously didn't
booths,
mean a lot of different things like GPS
classic
location and
case in
stuff.
the late
That the court has
1960s
now
of whether
applied
a
it to. So
closed phone booth door demonstrates an expectation of privacy, to more recent case law involving geolocation data from cell phones.
yeah,
And I want to urge you, should you be confirmed, to remain vigilant about how the emergence of new technologies, the way that they become ubiquitous in our lives, the way that virtual spaces are increasingly akin to physical spaces, will require the court to consider very complex questions and to seek technical advice, because these are technologically complex questions. What is your view on how the court should seek such technical expertise, which may be, with all due respect,
It's in the briefs. It's in the amicus.
training or
I mean,
experience
that's
of a
the answer. How
justice
do they
or
seek
the
it?
clerk?
They don't have to.
If, for
People just tell
example,
them.
People
one
give it to
such
them, yeah.
method of seeking advice is through amici, what's the importance of understanding the provenance and origin and funding source of such briefs submitted to the court? So this is a two-part question.
Dark
I wanna
money.
restate
Those
it.
are two very
First
different
is,
questions.
yeah.
What's the
Again,
importance
I
of
wanna
understanding the
urge
funding of the
you,
briefs?
should
It
you be
shouldn't
confirmed,
really matter because the briefs are either good or
as I'm
not, right?
confident you will,
I think he's talking about the
to
motivations. You know,
vigorously
getting a brief
I mean, yeah.
on abortion.
defend
If I get a brief from
constitutional rights of
amicus from
American
Planned Parenthood,
citizens
you
against
want to take
unreasonable
that
search and seizure
a
in the
lot
context
differently
of
than
new
I'll take one
technologies.
from the
I'd like
Catholic
to hear
charities,
how
for
you'll
instance,
approach seeking
because you know
technical
their
Can you go
motivations
into
for the
expertise
YouTube
to
and
briefing.
can I
inform
pin a
that
comment from
decision
here?
making.
But I'm
And then
thinking
the
he's also
question
talking
of
about dark
I'm going to
money, right?
YouTube and pin a comment about
of
this because
briefs
people are
filed
having
before the
problems
court,
loading the
something
stream.
that Justice Scalia noted in some campaign finance case laws, that it's important for the public to know who's funding electioneering communications in the context of political campaigns. I think it's important for the court to know who's briefing them. what the motive and funding source of such briefs might be. Could
I wonder
you
how he got on this
please,
committee though.
with my
He's on the
remaining time, and then
Judiciary
I'll yield,
committee,
we'll
and,
have some
and
more
he's
time later
really
to
just a
discuss
part timer
war
because
powers.
he's about to he's got to going up for
Please
election this
comment on
cycle,
those matters.
which
Those
he's
would be my
probably going
final
to be
questions.
voted
Please,
out
Sharon.
in
Thank
Ruby Red,
you.
Georgia.
Senator, one of the ways in which the court receives information other than directly from the parties in a case
Oh no, he's on for the
is
full term.
through
It's
a
the other guy,
practice, an established
um,
practice
Warnock.
of
That's up for reelection.
receiving amicus briefs. Amicus is a term for friend of the court briefs. These are people who are not parties to the case, who don't have that kind of interest in the case, but may have expertise or information or arguments that they wish the court to hear. And I think that that would be the primary mechanism by which, if the court were to decide to hear a case concerning a matter that involved some technical expertise, I would think that there might be amicus briefs related to the technology, for example. I have not looked at the court's rules. I would certainly want to discuss with the court's other justices the ways in which determinations are made about which amicus briefs
Well,
are
Warnock
received
is winning pretty
and
big
what
down in the polls right
disclosures
now.
are related
Polls are looking good
to
for him.
them. But the court does receive amicus
He's losing
briefs
against Herschel Walker
in
though. Herschel
cases
Walker's got a nice
in
little
order
edge.
to inform itself so that it can make a decision related to the issues in a case.
Thank you, Judge Jackson. Thank you for your courage and your grace, your forthrightness in answering my questions. I look forward to the opportunity to ask a few more later, and I yield, Mr. Chairman.
Thanks, Senator Ossoff. Senator Tillis.
Thank you, Mr. Chairman. Judge Jackson, thank you for being here. I hope you got some rest last night, and congratulations.
Very little, Senator, but that's all right.
Me too. But thank you for being here, and congratulations to your family and your husband, who has an impressive medical list of accomplishments that he should be proud of. I'm sure that you are too. And thank you to your family, the public servants, serving in the military, serving in law enforcement, educating our children. You're a role model family. I do want to go back. This morning, I ended up turning to a channel that I never watch.
Uncivil Law?
Just to see what was being said about the proceedings. I thought it was interesting that they were ridiculing some of my colleagues on this side of the aisle for bringing up the behavior of past Supreme Court hearings. This is really the appropriate venue to do it. I guess we could talk about it when we're reviewing intellectual property or something else, but contextually, this is the time to do that. And I think we all have to agree that the behavior in the Kavanaugh hearing was inappropriate. I hope we never get back to it. And I hope we can all agree that many of the behavior or the positions that some of my colleagues.
I ordered a bird feeder and some bird seed. It's arriving today. I'm gonna put it on my balcony. I'm gonna get some bird friends.
I'm so glad that for the most part,
I'm just sharing this information for no particular reason.
This is the one thing that does piss me off is that I was watching some of the coverage last night on the news, and they were like, "Oh my God, they're treating us so bad." I'm like, "What the? Did they not see what happened to Kavanaugh? Like, what the fuck? Like, what were they watching?
Like the Kavanaugh hearings, it's like you're gonna.
Yeah, did they not see Kavanaugh's?
To be honest, they didn't see it. I guarantee you, they didn't see it.
A couple of rough questions to her, like, "Oh, they asked her what a woman is. Oh, how disgraceful." I'm like, "What the? Did you? They're asking Kavanaugh if he drinks beer."
Did you continue to
they
do
ask
that?
her, "Well, can you define a woman for me?" Now it's so disrespectful.
Did you continue to do debate
It's,
competition?
the media is totally in the tank.
Continue
for
in
I mean, were you doing
college?
that in school?
Which is so
college?
shameful.
I did not do it in college. No, I did it from middle school through high school.
I missed debate
stopped
competition
when I graduated high school.
I did too, and I recall with that we would get assigned a topic that wouldn't necessarily be one that we agreed with, but we had to argue it.
Tillis is pretty good
Were you
too.
ever in a situation, or did you get?
He's
to
not
pick
as
a
good as
topic and only argue
how many
this
more
topic?
senators they got to go
So
today?
I didn't do what.
Or what
it
do they
sounds
get
like
one
you're
round of questions and 2 to 3?
referencing
Like,
is,
what is it, 11 hours every day
contemporaneous
now?
speaking.
No, that's
going
not
on?
extemp.
I think I did that once.
That's
in one
LD.
competition. I did original oratory, which is where I wrote my own speech.
Okay, you've had an opportunity to debate a
It's
lot.
either
as
LD
a
or
defense,
cross-ex. That is
counsel,
not
I would
extemp.
assume. In the court of law when you're debating a position. And the reason I ask that question is that yesterday when Senator Kennedy was asking you about the expanding the court, or what we call court packing. You said, I haven't really thought about it, but I hear the arguments on both sides. And I hear the argument on both sides. So could you briefly describe to me your perception of the arguments on both sides?
My understanding of the argument is about whether or not to expand the court beyond the 9 justices that are on the court right now, the 9 seats that are there. And
if you were to view, I mean, right now,
YouTube is currently suppressing
9
me.
is fine. 4 or
Yeah,
more.
John O'Brien has it right.
jump
Stamp is
into
30
that.
minutes to prepare
2 arguments.
7-minute
So do you
speech
understand, or have you heard any
on
of the
unknown
arguments
Yeah, I've been-
for or
competition.
against
That's
either
exactly
I've
right.
been
That's the way I
trying
did
to-
it.
I've been trying to check
I'm
it out
not even
too. It's
sure
just
about
been
the
acting
4.
up.
I've
I
just
don't know what the
heard
hell's going
people
on.
talking about putting more justices on the court.
At least when I did
expressing
extemp, you got your choice of 3
concerns
topics.
That the court has become politicized,
That's
that
right. 30 minutes
the
to
court
prepare a
has become
7-minute speech.
unbalanced in terms of
Preferably that
what
you will
people
do from
perceive to
memory
be views
with sources.
of the majority
That's
of
how
the
I rolled.
justices. And so
Boom.
I've
So
heard
yeah, 30 minutes to write a 7-minute
arguments
speech
about
and
rebalancing
memorize it
the
with
court
citations.
on that side. And then
Fun.
there's the argument that many
I miss it though.
on the dais have stated about the inappropriateness of doing so, the concern that it might lead to some kind of a war of
Which
every
is
time,
distinguishable from
there's a new
impromptu, by the
president
way,
adding
because at least when I did
justices to the
impromptu,
court.
impromptu
The,
was 7 minutes to write
Actually,
and deliver
yesterday
the
was,
speech.
Senator
So you got 7
Whitehouse,
minutes
I think it was
total
Senator Booker who
to write and
observed
deliver the speech.
Senator
So it became an
Whitehouse's,
exercise basically of
presentation, made
how
a comment
fast could
about
you write the
how
speech, because
Rhode Island,
at least
uh,
when people were judging me, they
Jersey
seemed to
being
be
a bit
impressed
bigger,
by your
have
ability
a
to give
bigger
more speech
graphic
and less prep.
to display.
So
I
I
went
was
back,
down
I
to
think
like
that New
a
Jersey
minute
is
prep and 6-minute
6 times the
speech.
size of Rhode Island.
So like a
by
minute and a
square
half
miles.
prep, and
North
then you give the rest
Carolina
of
is
the time in speech.
36 times the size of
It's
Rhode
fun to
Island.
try to race the
And
clock
before
and
my
try
friends
to
from
do it in less
Texas
time and give more
chime
speech.
in, I would let them know that if Alaska were 2 states, they'd be the 3rd largest state. So I'm decided to use
If Alaska were 2
the
states,
White House format
it'd be the 3rd
for
largest state.
dark money, so that we have a
It depends how
balanced
they were split into
understanding
states.
of the fact that our proceedings here, the aspirations for the court, there is an ecosystem.
I think a lot of people don't
out
realize
there.
how large
As a
Alaska
matter of
is.
fact, we
Alaska
had a
like dwarfs
judicial
every
nominee
state
who actually
in
participated
landmass by
in
like
this.
Very big.
You
crazy
could
amounts.
reasonably
Yeah.
assume if they participated in that ecosystem, that they probably would have been an activist judge.
But it's weird. It's the most
the
populous.
point that
It's
I
the
make
most.
here
It's the biggest state in landmass,
that
but the least
we've
amount of
seen
people.
John
this
O'Brien says when they did
ecosystem
impromptu, they
mobilize
did
to
no prep.
support you, and I think
We called it
Judge
something
Jackson,
different
you
in our
said you
competition. We
haven't
called
had
that
any,
expert
uh,
with no prep.
encounter with demand justice.
That was a
I don't
different
know
kind
if
of
you've had
competition. I
any
didn't do
encounter with
expert.
some of these that are abbreviated, or I'm
But
sorry,
yeah, impromptu
yeah,
was
either acronyms or abbreviated. So I wouldn't
7
expect
minutes to
you
write
to.
and
It would
prep.
be interesting if we
Write,
could,
prep,
for
and
the
speak.
record,
So
determine if you have had any
but
interactions.
yeah, there was a
but
format called
with
expert
I have
where you
not,
did no
Senator.
prep
I've
and just
never
had to
seen
start speaking off the cuff.
most of those.
That's good enough for me. I wouldn't expect you to.
Yeah,
to be
on the
honest,
YouTube thing, it keeps
sitting up
saying
there.
it's saying
But,
waiting for Uncivil Law.
I
And
know.
I
That's
go,
why I
they
have
are
the
out
pinned
there,
comment,
and they have a
because
specific plan.
yeah,
And
I
their
know this is a
specific
problem
plan,
where my
as a matter of
viewer
fact, I
count
was
keeps dropping to
inspired by,
0. People are having all kinds of
Senator
problems. My
Whitehouse's
life
seat,
sucks.
so I went out to
no,
demand
there's
justice.
like 200 something people watching, but then
They
it's
have a
like on one
specific
stream
plan.
it says nothing, then the
Step
next one
one,
it says waiting for
4
Uncivil Law.
seats on the Supreme Court. We must add 4
But when I
seats
go
on the
to
Supreme Court to restore
what's it
balance,
called?
which by their opinion is a majority with
I
their
go to
view and their
what's it
judicial
called?
philosophy.
I forget the name of that
Uh,
fucking thing. Hold
They're
on.
thrilled that President Biden has
Incognito
promised
window.
to appoint a commission. In fact, they're
It
so
comes up
thrilled
like
that they want to make sure
regular.
that they
I don't
can
know, maybe
influence
it's
the
maybe like
outside of
cookies. Am I seeing it? I don't know.
the commission by
YouTube's
endorsing
having
their
problems.
4-seat
Tubes is having problems this
strategy.
morning.
They want to recruit 25,000 volunteers. This is on their website, their strategy, to influence the commission's recommendation. And then they want to nuke the filibuster, 51 votes to make a decision that could ultimately be to pack the courts. This is their stated goal. They're proud of it.
No, wasn't that what
Senator
Trump
Whitehouse
said
was
too?
talking
He wanted to
about
kill the
how
filibuster
prior
too. Like
presidents
each side
were
wants to kill the
influenced by an
filibuster when they got the
organization.
power.
When
I
it's
would-
yeah,
I
when
would
it's
say
convenient.
Yeah,
that
like Trump was like, we need to end the filibuster,
and
and now
almost
it's like, oh my
everybody
God, these people are so
president
evil. They're
vetted
saying in the
before
filibuster.
Trump,
Yeah,
Judge
yeah.
Jackson, are on this
Both
list.
sides have been begging for him.
So I think it's intellectually dishonest to say that the administration, that my colleagues on the other side of the aisle are not influenced by this organization. We've tracked some of the fundraising and support in re-elections. They're engaged and they're influenced by it. But let me tell you what I'm
Now both sides
really
are talking
worried
about
about
the
with the court packing
crazies.
Dark money.
Yeah.
risk that we have today. We're talking about the ultimate destruction of two institutions.
But why are we talking about?
Back in January,
There's no court packing. We're just
Senator
replacing one
Schumer
of the
laid a
9
vote
seats.
down on the floor that
There will be no
ultimately
court
I don't know.
packing.
There's
reduced
lots of
the
discussions
majority
happening
of
that
60,
aren't
the
particularly relevant
filibuster
to the
limit of
immediate
60
issue.
to 51.
Do you think they're going to pack the court?
He was doing it.
If they pack
as
the court,
a-
then
as
in
a
a couple of
way to
months,
pass
the
a
Republicans are
single
going to have
bill.
all the
But we
power,
all
and
know
then
what
they're
happened
going to start packing the court,
when
right? It's like
Senator
it'll be a
Reid
never-ending
nuked the executive
ridiculousness.
calendar for
Yep.
circuit court
You can
judges.
pack it now,
led
but in a couple of months, when
you only being
we all know the
subject to
Democrats are going
51
down in
votes
flames in
to
the
be confirmed.
midterms. Republicans are
That
going to get the
nuked the
gavels.
executive
Only thing
calendar.
they won't have is the
In
presidency. As
January,
soon as you get a Republican
Senator
president,
Schumer was
let's
laying the
pack the court
groundwork for
again.
the same thing. Now,
Especially once you got rid of that filibuster,
I
right?
worry that's the destruction of the Senate
Makes it really easy.
institution as far as I'm concerned. I
If
think
I'm the
we have to be a
president, right? I'll just give you a
consensus-based
whole damn list of
organization. We don't
nominees.
need to be a 100-member House of Representatives.
Vote on them
And
all.
that vote
And without a
happened. What
filibuster,
disappointed me
I can
most
just
about
do
that
the
vote
entire court basically in a
is
day.
back when President Trump was
I
calling
could fill
on
every
us
damn
and
position in the federal
pressuring
judiciary.
us to nuke the filibuster
He's talking about Trump.
when we had control of Congress. I signed on to a letter with more than 60 members to say that I would never do that in the face of in the face of a Republican president whose policies I supported. I did that to send a very clear message. I respect this institution and I respect the court, which almost certainly would have been, we would have had pressure from our side of the aisle.
But this
to
makes
pack
no
the court
sense.
a
There
little
is
bit
no
more.
filibuster. Nobody's
Now,
talking about
every
packing
member
the
who
court
was
now.
there
They
back
nuked
when we sent
didn't
that
they nuke
letter who's
that?
on this committee
They
We're
said it's
talking
not.
about a
It
lot of
doesn't
things
make
that don't
sense.
matter.
and voted.
Yeah, you missed the whole,
to
I don't know if you missed it or
potentially nuke
not,
the
with the whole
filibuster
exchange yesterday
just 2
from
months
Lindsay and
ago.
whatever about
See, I
Guantanamo
hope
and
you
whether
can understand
Guantanamo
my
is good or
concern
not.
about the political wins and the potential damage that it could do to the Senate and do to the Supreme Court. I think it was Federalist Paper 78, where Hamilton talked about
This
the
is Barnes loves the
vulnerability,
Federalist.
or I think the feebleness. Now, he was
Even
arguing
though I don't think he knows
pleading
that
the case for
Scalia,
lifetime appointments.
was
But I do think
actually the person who started
that
the whole
the
thing.
Supreme Court is a fragile institution. And I do believe that if we think it's politicized now, think about how it would be if we destroy the institution of the Senate so that a strict party line partisan vote, we expand.
Justice
the court.
Thomas croaks, I'm going to go in and have a week.
That's why court packing is important.
Oh,
And
it's-
that's
it
why
would
we're
just-
asking
black for a while.
questions that I know you're not
You know
gonna
what? It'll
answer,
just be just
but I know that
desserts.
Justice Breyer
It'll be
and
just
Justice
it's the
Ginsburg did.
same great thing
And if
happened
there's any
when
Supreme
what's
Court
her
justice
name
listening
passed
right
away, and
now,
it was a
I wish
Republican
that they would
president.
speak
If
up,
he passes away and a
because I
Democratic
think the
president,
institution is in peril.
I
and
I
accelerating
actually
into a
appreciate
truly
a
political body
5-4 court
is
with
only one
swing
successful
voters.
nuking of the
'Cause
filibuster vote
I just
away
think
from
both
the US
sides
Senate.
sometimes have
This is serious
hugely
stuff.
horrible
I was at Price
philosophies when it comes to
Waterhouse. I was
certain
a partner
things.
at Price
So I think
Waterhouse.
I think that having them having to argue
I
about
saw
particular
about
things and get themselves
100-year-old top
in the right
tier
senses,
Big
the way
Five
the better way to go.
consulting firm cease to exist because their reputation suffered. If we pack the court, the only thing that you all have, that the Supreme Court has, is its integrity and the esteem that the American people and the trust that they put into it. Packing the court could cause the Supreme Court to lose the trust of the American people. And I think.
But who is
if we
packing the
want to
court? They
expand the
they don't
court,
have the votes to
let's
pack the
do it
court.
for the
Matter of
only
fact, even
valid
Democrats aren't voting.
Maybe the
They're not
justices
voting for
come
packing
to
the
us
court.
and the Chief Justice come to us.
Like this
and
is just
say,
all BS
workload
scare
too
tactics.
is too
Yes,
great.
yes. You
The
had
times
like
have
7
changed.
Democratic
And
senators
then
that come out and
convince
said
60
we're not
members of this
voting
body
to
to
kill the
consider it.
filibuster. We're not
But when
packing the
you've got a
court.
partisan organization here that's putting a pipeline of people in there that they think like them and have a judicial philosophy like them, how can any reasonable person think that this is just kind of fixing the mechanics? It's a partisan decision that even some of my colleagues on the other side of the aisle have taken the bait. So much so that they would reverse a commitment that they made with me when they signed that letter to say they would never nuke the filibuster and then nuke it. President Biden's on that list too. Back in 1983, he gave a rousing speech in a Judiciary Committee hearing saying, don't pack the court. He gave a rousing speech on the Senate floor saying, don't
Pack the
nuke
court
the
since the 80s.
filibuster. But now we're in this posture
And they've
where
never
we
had
can
packed it
destroy
in what,
two
40 years?
institutions
Yeah,
if we're
this
not
is-
careful.
He's doing this. Is
So I actually hope that you can at some point study the issue thoroughly and understand the risk to this institution that you're likely to be confirmed to. It's serious. And you could end up being there. You'll have a lifetime appointment. You could actually be there and witness its demise real time if we allow it, the court to be packed. Now, I want to talk a little bit about I think you were a part of a case in Massachusetts that some people are casting as a pro-life versus pro-choice issue. Now, to be clear, I am Catholic and I am pro-life, and I'm proud to have signed and ratified pro-life bills in North Carolina when I was Speaker of the House that have withstood judicial scrutiny. But I don't really think that case was about
apparently it's
pro-life.
gone.
I think it was about free speech. So I want to ask you a few questions about
Lol.
it. And maybe you could describe it to me if your memory serves you. But it seems to me that the argument that you were a part of, I think that you joined with a couple of others. It seemed as if the argument was because the pro-life protesters were threatening and dangerous to women, attempting to enter the clinic. I'm not necessarily saying you put those words in the brief, but they were in there, and they were a hostile, noisy crowd in the face of protesters. Now, am I correct that a part of the argument was because they were noisy, in-your-face protesters, they needed to be a little bit further away than people who were pro-choice advocates? Because as I understand it, I think the underlying law in Massachusetts was ultimately struck down unanimously by the Supreme Court. Is that correct?
Thank you, Senator. The brief that you.
Oh, by the way, I didn't expect you to respond to my riff on packing the court.
Yes.
Just to net it out, it's a bad idea. But back on this.
I understand. The brief that you are referencing was a brief that I worked on right after finishing my Supreme Court clerkship when I joined a big law firm in Massachusetts. This is maybe 2000.
Welcome back,
the end
Nate.
of my clerkship.
Yay!
And it is a First Amendment free speech
I clicked the
set of
the
arguments
X button by
that
accident.
the
I was like,
lawyers
no!
at my firm, I was a part of a team representing clients who wanted to make an argument about buffer zones, which at that time had not yet been litigated all the way up to the Supreme Court.
Was it a buffer zone that put pro-life and pro-choice people in the same buffer, or one that argued that pro-life people were in your face and perhaps needed a bit bigger buffer than the pro-choice? I was just trying to understand the facts of the case.
I believe that it was viewpoint neutral, meaning it wasn't about what the people were saying. It was about clearing a path to allow people to enter the clinic. The laws at the time were about how far did people have to be kept back, whether they were pro-life or pro-choice, because if they were blocking the entrance.
Do you understand why the underlying law was ultimately deemed unconstitutional by the Supreme Court?
I didn't follow the jurisprudence at that time. It had not been. And the First Circuit, this was a First Circuit brief. I don't remember what happened in the district court, but my clients wanted to argue in the First Circuit that the laws that allowed for the clearing of the path so that people could enter the clinic and have people stand back were constitutional and important, and the First Circuit agreed. I think ultimately, I don't know exactly, but I think ultimately, as you say, there was some litigation that went all the way to the Supreme Court, and the court had other jurisprudence about the extent to which buffer zones are constitutional.
Yeah. Well, it looked at, I'm not an attorney. I watch Law and Order from time to time, and I'm not going to get into a debate, but on its face, it almost looked as if there was this notion that there was bad speech and good speech, that somehow, and look, I'm somebody who's had protesters come to my house, get in my face, and be very nasty, 4 times by land and 2 times by sea. I live on a lake. Okay with them doing it as long as they stay off my lawn. In the last case, they didn't. But it almost felt like to me that those protesters who didn't like me needed to be a little bit further away than the protesters that maybe I would allow to be a little bit closer. It may not be right, but I'll make sure that I get my facts right before this afternoon in the second round. I want to go to sentencing. I'm not going to cover any of the ground that my colleagues have. I'm sympathetic to some of it, not necessarily all of it, because I think the details are something that we don't have possession of. I'm sure we're going to talk a little bit more about that, but I want to talk more about a pattern. I know, and I was really impacted by your description of family dinners and your uncles coming in uniforms and putting their guns up on the cupboard and having a sense of pride that you had family that served in law enforcement. There are a couple of cases. I'm very focused on law enforcement and backing the blue. I think that law enforcement, I talk with a lot of them, their morale is low. They feel like defund the police and some of these other efforts are already making a very difficult and dangerous job more difficult, more dangerous.
Yeah, defund police was so horrible. That's
I mean,
like, how dumb can you get?
I love it when people say things like they don't think about it 1 second.
Even I
It's like
think
defund
the
police.
defense
You
attorneys
haven't thought
have,
this through like even a little bit.
but I'm sure that if I were
Yeah,
you and
I like the
observing
reallocation
yesterday,
of
you would
resources
probably
argument,
point
but
to
defund
some
the police. It's like,
mitigating
people just don't live in
My
reality.
personal favorite has to be the Chaz Chop.
for doing that. I think in one
It's got to
Oh
be
my
my
God,
favorite,
that
like
was
the
another
Chaz Chop,
idiotic
where they
stuff.
kick out,
recommended
they
a
kick out all the
31
police,
sentence,
and they kick
the
out all the things. They
defense
create their own little
recommended
autonomous zone. What do they
21
do
months,
immediately?
and you gave
Set
them
up
18
borders
They
months
said
and
border
police
checkpoints.
force.
conviction for assaulting an
They set up
officer.
their
There
own
was another
security,
one.
right? It's
They
like
set up a
it's like they believe in
police
strong
That was a
borders. I mean,
lower
they even had the
sentence
signs.
for,
You were now entering
there
Seattle.
were
You were now
officer
entering the
assaults.
Chaz
It seemed
Chop,
like it
right?
went
They
lower,
They
but
had
I don't
borders
immigration,
get into
with
those.
border
immigration.
checkpoints
They have
and police and everything.
factors
I'm like, geez,
that,
wow.
that
Dude,
you would
it's so
Immediately.
point to that would
hilarious.
justify the decision. I've got a
That
question
is
about,
so
see,
funny.
that's at an atomic level. I mean, you're looking at the facts of the case, you're looking at the defendant, and as you
And people now
described in
saying your
some of the
mic
other
is too
cases here,
hot, so
you made a
I
judgment
guess maybe
that
it was
you
just
thought
me.
was
So
Yeah,
I
I'll
guess
turn
maybe
it
I
down.
just gained some
bounds
more, and
Turn
we'll
it
try to find the
with,
happy
down.
medium.
peer group. But
All right, I should
back
be down now.
at the
Let me see
beginning
if I
of
can
the
hear the
COVID pandemic,
stream. The stream just is not coming through for
I
me.
believe you made this
Oh, yes,
statement, and I'll
it's
give
back
you
now.
time to provide context if it's out of context. But in the interest of time, I'm only going to read the most
Yeah, it came
striking.
through loud on the stream.
You
This
said
sounds
the
better.
obvious increased risk of harm that the COVID-19 pandemic poses to individuals who have been detained in the districts, that's the District of Columbia's correctional facilities, reasonably suggests that each and every, and I think that means everyone, every defendant who is currently in the DC Department of Corrections custody and who thus cannot take independent measures to control their own hygiene and distance themselves from others should be released. I checked in April of 2020. I think that's when you made the statement that there were 12.
She said that
or
everyone in detention should be
1,600,
released
let's
because
call
of
it 1,200,
COVID.
I'll be conservative.
Okay.
People
She said
in
that?
the Department of
Apparently.
Corrections. Do I read that statement to say that you felt, given the circumstances of the time, they should all be released? Because that's broad. That's not looking at their individual cases.
No,
That's
Senator,
true.
you don't read it correctly.
Okay.
It was not a statement. It was a line in an opinion. And
What?
The beginning of the COVID-19 pandemic was a really, obviously,
I was there.
horrible and difficult time
It's
for
not a
all
statement,
of
it's
us.
a line and opinion. That makes it
Um,
worse.
And what was happening at the beginning in the prisons, which
Well,
was
obviously
part of
she's
the
gonna
criminal
try to add some
justice
context
system
to it
that
to
as
us, too.
judges we were involved
I
in.
tracked it quick. I want,
Yeah.
because I do not want to go over. I don't go
Can I
over.
just-
But
w-
let me
yeah.
just give you a little bit more context. I've actually written letters to the Department of Justice encouraging the release of nonviolent offenders in North Carolina at a federal correctional facility. I've also supported early release programs. I voted and supported the First Step Act. I, as Speaker of the House, was
Yeah, like the
first
crack cocaine
speaker
distinction
in
on a federal
probably
level was
2
stupid. That should have
decades
always
that
that should have been
actually
overturned.
did
Yeah.
the Justice Reinvestment
And it's
Act
funny because
early
Trump was the one that
release
overturned it. It
nonviolent,
wasn't fucking Obama should have overturned that
prisoners. But
shit. That was like so
how can I
stupid.
not read this to say that perhaps they should be released irrespective of the crime for which they've been charged?
Senator, if you read 2 more sentences down, that is precisely what I focus on. This is a case, United States versus Wiggins, where I was setting up my analysis as to why I would not be releasing Mr. Wiggins in this case. He was arguing essentially what I said in that statement. He was arguing
So now it is a
that
statement.
the circumstances of COVID-19, which at that point was rampant in the prisons, we had not had a vaccine. There were very difficult circumstances for prisoners who could not be separated from each other in the context of our jails. And as I say at the beginning of that opinion, at that point, COVID was ravaging the jail. And the question for courts under the statute that Congress has enacted for compassionate release was whether COVID-19, a pandemic in the jail, was an extraordinary and exceptional circumstance or extraordinary and compelling circumstance that should warrant release. What I said in that statement that you read was it would seem as though something like a deadly pandemic rampant in the jails would justify releasing everyone. But I go on to say in that very opinion, Congress has indicated that we have to take each case individually. We have to look at the harm to the community that might be caused by the release of individual people. We can't just release everybody, I said in that opinion. And so
I wanted to give you, I'm sorry to interrupt you, but I'm on,
that's all right.
on 4 minutes. But I feel like I also had my staff provide me this morning in very, very small type, recidivism and federal sentencing outcomes. I've said, I'm on record as saying that I want people out. I want them to have them an opportunity to reenter society, become productive members. And I've got a track record for ratifying bills to that effect and supporting similar measures since I've been here in the Senate. I'm going to continue to work on it. But tell me why the numbers that I'm looking here, we have recidivism rate, the most recent one that I have before me, and I'd be happy to share it. I'll ask with to have this submitted to the record. But I think an 8-year look back says that 49% of the people incarcerated are rearrested within 8 years. If you take a look at the types that are most likely to be reoffending, it's firearms offenders, robbery offenders, violent offenders reoffended at a higher rate than nonviolent offenders. And so if I look at this and I look at your philosophy with respect, and it's admirable. I said that the content of your character would be demonstrated this week in my opening statement, and it has been. And one of the things that are first among them are your compassion and your belief that people can redeem themselves. But if you look at some of the cases that my colleagues have brought up, and if you look at even with the context that you provided on the last statement about the Department of Corrections statement in Wiggins,
All right,
Can you
talk amongst
understand
yourselves for a
how
minute. I'll
some
be
of us
right
may
back.
think that your
Cool.
passion could lead to bad results based on the numbers that we have here with recidivism, that Congress may need to work more on that to make sure that we get it right? Can you understand how somebody who from our side of the aisle could see that maybe there is some pattern to give the benefit of the doubt to someone who has been incarcerated, in some cases with very serious crimes?
Thank you, Senator. I don't recall saying anything about compassion in the way that you're describing it.
No.
What
I'm just saying that if I take a look at your responses to some of my colleagues' questions and your statements to some of the defendants, it seems as though you're a very kind person and that there's at least a level of empathy that enters into your treatment of a defendant that some could view as a maybe beyond what some of us would be comfortable with respect to administering justice.
Thank you for letting me clarify. The statements that I made about my practices as a trial judge, which I'm no longer a trial judge, but were intended to explain how trial judges operate and how they impose sentences within the framework that Congress has provided. The statute that applies to us tells us to look at all of the various factors that Congress has set forward, including the nature and circumstances of the offense, the history of the characteristics of the defendant, and it tells us that we should be imposing a sentence sufficient but not greater than necessary to promote the purposes of punishment. Congress also tells us that one of the purposes of punishment is rehabilitation. My attempts to communicate directly with defendants is about public safety, because most of the people who are incarcerated via the federal system and even via the state system will come out, will be a part of our communities again. And so it is to our entire benefit, as Congress has recognized, to ensure that people who come out stop committing crimes. And so what I convey or did when I was a trial judge, as I sentenced people to very lengthy periods of incarceration, was you are getting your day in court. You are able to say what you want to say, but you have to sit here and listen to my reading into the record the victim statements in this case. You have to go away understanding that I am imposing consequences for your decision to engage in criminal behavior. And the reason why I did that, I've said, is because I recognized as a defender that there were lots of people in our system who, instead of taking responsibility for what they had done and then ultimately understanding the harm and potentially not doing it again, instead of that, those people were bitter, they were angry, they were feeling victimized because they didn't get a chance to say what they wanted to say, because nobody explained to them that drug crimes are really serious crimes. Nobody said to them, do you understand that there are children who will never have normal lives because you sold crack to their parents and now they're in a vortex of addiction? Do you understand that, Mr. Defendant? I was the one in my sentencing practices who explained those things in an interest of furthering Congress's direction that we're supposed to be sentencing people so that they can ultimately be rehabilitated to the benefit of society as a whole.
I appreciate that, Judge Sachs. I just still note that virtually half of those people, statistically speaking, that you gave that speech to within 8 years were back in prison, and in some cases for more serious offenses than the first incarceration. Thank you, Mr. Chair.
Thanks, Senator, for that line of questioning. And I've noted that you joined a letter with Senator Grassley and myself in March of 2020 at the earliest stages of this, talking about release under these similar circumstances. And of course, we all said at the same time, low risk inmates would be considered, but
Only low-risk inmates.
yes.
Yep.
And I wanted to make that note for the record. We're going to start the second round of questions, 20 minutes each, and I'll kick it off. This is an unusual document.
Okay,
This
kids. So we
Constitution of
just
ours,
finished the first
which has
round
taken up so much time
with 30
in
minutes
the hearing,
each.
the
Remember
conversation about
yesterday? Remember how much
And
fun that was?
it is
Okay, so we're going to
really
do
at the
all that
core
again.
of public
Only
service.
20
I
minutes
don't
each
know
this
that
time
there's
instead of 30
a
minutes each this
place
time.
that you can
But if you
take a
liked
job
yesterday,
at the
good
federal
news.
level,
It's more of
in
yesterday.
any branch of government without taking
Yay.
an oath to defend this document. I don't know about other countries and the oaths that might be required, but we even within the Constitution spell out the oath to be taken by the President of the United States, and it's to uphold and defend this document. And there's great debate about just what this document means in today's context. We understand the wisdom, the inherent wisdom of the document, and the fact that we're still here some 230 years later with the design of a government that has endured longer than virtually any other democracy, which of course speaks to the wisdom of the founding fathers
baby.
and their plan for
Do
this
you
nation.
like Senator question
But we
time?
also understand,
Oh,
taking an
yeah.
honest look at it,
Because I got
that you
Senator
barely get
question
into
time
this
for you.
document, Article
All
1, Section 2,
day
and you run
long.
into a problem.
All right.
Because in Article 1, Section 2, the article that relates to Congress, they talk about who will be counted for apportionment among the states. And there is that awful reference to 3/5 of all other persons, which, though the document never mentions the word slavery or slaves, what was being spelled out here by the founding fathers was, how are we going to count these slaves? And for apportionment purposes, they were to be counted as 3/5 of a person, which is a horrible notion by any standard, but the wise founding fathers included it, trying to deal with the reality of their day. I hear debates back and forth of originalists, textualists, and others, and you've been asked as often as any nominee what your thought is. You've talked about stay in your own lane, judiciary, and methodology and like. But I'd like to explore for just a moment, without asking you to get in any particular fact pattern, the reality of a couple things. First, when the Bill of Rights was written, the First Amendment to it made certain to guarantee freedom of press. Freedom of the press in 1790 was, of course, referring to a piece of paper, a newspaper, and saying that there would be freedom to engage in that process in this democracy of America. Now that freedom of press is referring to this, and things have changed an awful lot. We have a circumstance now where people no longer have just a handful of television networks or known publications, Washington Post, New York Times, and such, but turn for their sources of information to places like Facebook and Twitter and beyond. And we have a real serious question about what is a publication in America? What does it take to be a publication and be press? Is my blog that I publish tomorrow the press, guaranteed with a constitutional right that I have a right to publish it as I wish, say what I want to say with certain boundaries? And I guess my question to you as we look at this is, how do you move from the language of 1789, 1790?
Well, for me, the answer is easy because I interpret freedom of press as referring to technology.
And make sure it's relevant.
So
if more people
for me, freedom of press refers literally to the printing press, the device. That's the freedom.
Common sources of television and
newspapers. So then it just becomes a question of being freedom of all devices. Like it's the freedom to use any particular device. What you can say with that device is controlled by freedom of speech, not freedom of press.
So how do you reconcile?
That's how I look at it.
The changing times, the dramatic changes in technology, what the founding fathers envisioned and what we face today.
Thank you, Senator. the challenges that you identify are the types of things that the Supreme Court is now dealing with. We have a foundational document that has
DJ Gotti says the
text,
press
and it
doesn't mean the
has
literal printing press.
principles.
I think it does.
It establishes
I think that's exactly what it
freedoms
means.
and foundational important concepts that are intended to govern us.
Freedom of speech refers to
and
what
that
you can
we are
say. Freedom of
bound
press
by
refers to the
as,
mechanisms in which you can say it.
as a
The
society.
technology to make it public.
There's modern technologies,
yeah, that's
as
how
you
I view
say,
it.
that have not, that the framers, the founders could not have imagined the cell phone and all the other things that we now rely upon. And as I mentioned earlier, the Supreme Court and every court deals with individual cases, disputes about issues, and when the court gets an issue that requires constitutional interpretation, it looks at the facts and circumstances of the particular case and the text and principles of the Constitution in light of the times in which they were written, and analogizes to present day. So the Supreme Court, for example, has considered the cell phone issue with respect to the constitutional principle of unreasonable searches and seizures, which is a protection from government intrusion that the framers called an unreasonable search. The
How'd you get
text,
from freedom of press to the
search,
Fourth Amendment?
does not have an inherent definition. What the Supreme Court has done is looked back at the time of the founding to determine what kinds of
Freedom of press is the
intrusion
right to distribute
would have
information.
been
Yeah, we're on the same
covered
page, Dirk.
when those words
We're on
were
the same
written
page.
into the Constitution.
Yeah.
And to the extent that at the time
Freedom
of
of
the
press
founding,
refers
those
to
words
distribution
covered
methods.
things like police officer intruding
Freedom of speech
into
refers
your
to what you can do with
home
those
and
methods.
looking into your
So,
papers and
from
affairs.
my point of view, New York Times doesn't have
then
any more freedom of
The
press than I
Supreme
do.
Court analogizes that circumstance
Way more freedom of speech than I do.
to
They're
the
not special,
modern day
in my humble
circumstance of
opinion.
a cell phone.
In the First
which
Amendment
now
analysis.
is in all respects, says the court, like rifling through your papers and affairs. So it's a process of understanding what the core foundational principles are in the Constitution as captured by the text, as originally intended, and then applying those principles to modern day.
I'll just give you two illustrations of my thinking on this and my frustration, or at least understanding of the challenge, let's put it that way. Senator Feinstein and I joined in legislation.
So they're now doing a whole nother round. It's
confidentiality.
Yep, 20 minutes
Oh my
each.
God.
It's like if you liked yesterday, I got more of your yesterday for you.
and
Did you
whether
like
or not a
yesterday?
person could,
I've got so much
reporter
more
could be
yesterday.
compelled to disclose those sources.
Now, since this is a 50-50
The effort
Senate,
really drew some of
it's
the best and brightest. in the
if you
news
get
business to
all
come
votes
testify
for
before the committee.
yay and all votes
The
like
effort
equal divided
failed
vote, it
and
automatically goes to the
faltered
floor, right?
over
Tie votes go to
what
the
is a
floor still,
publication,
right?
Who is
Out
a
of committee?
publisher?
Well, I mean, there's
Yeah.
there's
Who
not a
is
Tie
number on
votes
the
out of
committee.
committee goes to the
business
floor.
of dispensing news?
I think there's 15 on
Does it
committee.
involve,
So
I
it will
thought-
be approved by the
has to
committee. If it's 50-50 on the
pass
floor, then
between them for
Harris
this to
breaks the
be
tie. But I think it's
official
going to be
publication?
55 or 60
Or
votes.
can I just put up on my blog what I wish and
I think the
and
over-under is
resist any
55 at
efforts
this point.
to discover my
Yeah,
sources?
I think she's
That was
she's a
one of
solid
the
pick, but
serious issues that we faced.
she's gonna get through. I think she
We,
gets through. If
also
she
took a look,
was,
I took a
if
look
she's
at,
another gender or
where this is
another
going
race,
in
then I think it
terms
might be a
of,
little bit more.
the
But
future
I think she's
and our
she's getting
entities
through no
that we
matter what.
rely on for news.
She
so
has to have
often.
like a big mess up
and
for her not to get through.
I'm going to leave it at that because I think you've addressed the general and don't want to get into more specifics, nor should you. But when people pledge that, they are originalists, we're sticking with the
This whole
original
thing-
words, you better have your mind open to the reality that this world is changing and changed. And
Yeah.
many of those principles are sound today, but the challenges of interpreting them with the reality of today's technology is a challenge.
See, that's why I like
very
that's why I
difficult
like my
which
First
we'll be
Amendment
facing in
analysis,
court.
because if you
I'm
refer to
gonna
if
try
you
to
think
set
freedom
an
of press
example
just
here.
refers to the
We have
freedom
20 minutes.
to
and
use
I'm gonna try to
technology,
yield
then
back
the
some
fact there's
part
new
of it.
technology is
I see
irrelevant.
that Senator Cornyn is
Yeah,
here.
so
I'm glad
it
he
doesn't
is
matter.
because I'm going to address an issue which he raised yesterday and again this morning.
What do you think
There's
about the
there's a new
While
printing
he's
press now.
physically
It's Twitter.
present,
Oh,
so
okay.
that when he gets his turn, he can address it.
Fine.
I'm
what do you
sure he
what do you
will.
think about the
Yesterday,
TPO
Senator Graham
now
said
that they're
you
thinking
had
about
gone
making
too
the
far in calling
Second
the
Amendment
government, quote,
analysis a
a
time,
war
place, and
criminal
manner
and pursuing
analysis?
charges against a terrorist.
So,
Well,
for
I think
instance,
there's
you
some
can't bring a
merits to
gun
that.
to.
Judge
I think there's merit to
Jackson,
that
quote,
in
you
parts.
referred to the Secretary
I
of
actually
State
like
as
it a
the
lot.
The First
President of the United
Amendment
States is war
analysis
criminals. Why would you do something
is a
like
very
that?
good mechanism.
As I noted
I've said that as
yesterday
well,
and
and
repeat
the
this morning,
courts have
these
said that as
charges
well.
don't hold up.
Unfortunately, they've been much
CNN
less good
fact
about
check said,
actually doing
quote,
that, in
both
my
Graham and
opinion.
Cornyn left out
And to the
important
point where now
context.
they have to like
Specifically, neither mentioned that
distinguish
Jackson's
the
allegation
First
of
Amendment
war
and Second
crimes was
Amendment
about
because they're so
torture.
embarrassed
Also,
by
Jackson
the
did
fact that they're not
explicitly
actually
use the
adhering to
phrase
First
war
Amendment
criminal.
principles.
The
So
New
I don't
York
really
Times
necessarily have
noted
any
the
objection
allegation, quote, is
to
a
like a time,
distortion
place,
and
manner
lacks
analysis
context.
in a Second Amendment
The New York
context.
Times went on to
I
say
just think that
Judge Jackson did
it
not
should be
specifically call the former
parallel
president and defense secretary war
in
criminals.
the
She
respects
was
of
one of
the
several lawyers
First
in
Amendment.
2005
And
Yeah, I
signing
agree.
4 essentially
It should be. It
boilerplate
should. I
habeas
think it should almost
corpus
be identical.
petitions on behalf
yeah,
of
so
Time,
detainees.
time,
I think
time, place,
the
and manner
First Amendment
restrictions
analysis,
Claimed the
makes
U.S.
sense.
Second
government
Amendment.
had
I mean,
tortured
if
men
it were
and such
if it were
acts
me,
constitute war
if it were me,
crimes. That's in
my
quotes.
baseline would just be
Petitions each
grafting
named Mr.
the First
Bush
Amendment
and
analysis
Mr.
onto the Second
Rumsfeld,
Amendment analysis, and
along
then
with
make
2
any
senior military
modifications from there. But
officers
that'd
who
be my starting
oversaw the
point.
Guantanamo detention operation in their official capacities as respondents. Washington Post noted, and I quote, "One key thing to note, as law professor Stephen Vladeck does, is that Bush and Rumsfeld are named in petitions because they have to be, to clear procedural hurdles. Indeed, those petitions later named
Yeah,
Barack
and
Obama
what's the
after the
young case?
administration changed.
I'd also
Another is that they
be
are
a little
named
bit
in their
more, because I
official
think the
capacities,
problem,
not because of
one of the
actions
problems
they
in the Second
personally
Amendment
took as
analysis as it
individuals.
currently
They
exists is in the
contend
first
that
half
larger
where you're talking
problem is
about
that
the importance of
Jackson
the
was
interest.
acting as a detainee's
Because
lawyer
the way
in a
that
role as
the
public
courts are
defender.
currently looking
And one
at
of the
it
underpinnings
seems
of
to
the
be
American
like
justice
basically
system
you're automatically at
is
compelling
even
interest,
the most
basically, almost by
reviled
definition.
alleged criminals have
Gun
the right
violence
to
is
a
bad,
vigorous defense.
murder is bad,
Would you
right?
like to
So
comment
anything that
on
restricts that is going to be a compelling
statements
interest.
that I just made?
So you're not only at
Well,
intermediate
Senator,
scrutiny, you're at strict scrutiny,
I
like
would just
basically
say
automatically.
that
So for my
um,
money, you couldn't
public
do that
defenders
because that would
don't
swallow
choose their
the entire
clients,
analysis,
and
and you're
yet
automatically there.
they
You need to
have
show
to
something
provide
a more.
vigorous
You need to show a more
advocacy.
specific
That's the duty
interest
of
than
a
just a
lawyer.
generalized
And as
concern
a
about,
judge now,
I
I
crime or
see
something
the
to,
importance
for my
of
money, to
having
trigger the
lawyers
the
who
analysis. It's one of the
make
reasons I
trigger the
don't have a problem
who
with the time, place, manner analysis,
make
because I would
allegations
view
in
the
the
substantial
context of a
government
habeas
interest
petition,
as
especially
having to be
early
more specifically
in
defined than it
the
currently is under the
process
current law.
of the response to the
Yeah, I
horrible
think nobody's ever.
attacks
I
of
think hopefully that
9/11.
New York case will then,
Lawyers were
because in the New
helping
York
the
case that
courts
hopefully
to
they'll be
assess
telling us how they came
the
out. They
permissible
essentially were
extent
making
of
that argument in
executive
the arguments that,
authority
hey, TP, after you
by
get past the initial hurdle,
making
whether this is strict
arguments.
scrutiny or not,
And
the time, place,
Yeah.
and
we're
analysis
assigned
makes
as
sense.
public
You can't bring a
defenders.
gun to the White
We
House,
had
right? You
very
can't bring a
little
gun,
information
to certain places.
because
So,
of
and I think that just makes sense, and I think that would
confidentiality or
do two
classified
things.
nature
It'll
of a
align
lot
the
of
Second
the
Amendment, because that's why
record.
Thomas calls it disfavored
And
right.
as
It'll take that
an
right and now
appellate
make it,
lawyer,
on par with
it was
all
my
these other
obligation
rights treated the same.
to
And like the White
file
House is a good
habeas
example, because if you're
petitions
looking
on
for a
behalf of
substantial
my
or even
clients.
compelling governmental interest, and you're
Thank
looking
you,
for a more
Judge. I'm gonna
specific
try to
reason
set an
for the
example
White
by
House
yielding
versus
back
an
about
other
7 minutes
place,
of my
it's
time. I
not
invite my
particularly hard,
colleagues to
right? The
follow that
protection of the
example if they
president
wish.
is
Senator
a
Grassley, you're next.
substantial interest, but it's more specific
Uh,
than a generalized
Before
interest in
I
reducing
start,
gun
I'd
crime
like to
in
make a
general,
brief
right?
point.
So
Yesterday,
it's more
Senator
specifically defined,
Durbin
which is why I think
referenced
that the
Congress's effort
analysis
to
works.
stop child pornography and the exploitation protection of minors. I've worked on this issue for decades. In 1983, I supported the Protection of Children Against Sexual Exploitation Act. In 2012, I sent a letter to the Sentencing Commission while Judge Jackson was vice chair. In the letter, I encouraged the Sentencing Commission not to lower sentences for child pornography. I said that, quote,
Hey, did you hear about the
would be a
Santos?
disservice
He
to
just
the
named
American
the
people
other
to have
swimmer. He
the
said Leah
commission
Thompson
issue
didn't win.
a report
The other
that
swimmer from
advocates
Florida is
for
the
the
true
reduction in
NCAA
sentencing
champion.
for a class
Who
of
said that?
criminals who cause
DeSantos. I love
profound and
DeSantos.
lasting
DeSantos,
Oh
he
yeah,
loves the
no,
kids of the house,
DeSantis is
man.
to their
fun.
victims. End of
DeSantos is
quote.
my man, yeah.
I'd like
Even
to
though
have
I wouldn't have
that,
voted for him, but my God, would I love him
put
if
in
he was
the
my
record.
governor. He's
Without
a good
objection.
guy, man. I love DeSantos.
Yesterday, you referred to your record of decisions as the best thing to look at when explaining and evaluating your nomination. But you also said that you haven't had enough cases involving constitutional law to develop a judicial philosophy. If you haven't had to develop a philosophy for deciding cases yet, what else do you think would be helpful for us to look at?
So respectfully, Senator, I do have a philosophy. The philosophy is my methodology. It is a philosophy that I
So
have
are you
developed from
arguing for like a
practice.
product by process?
Unlike some
Which
judges
is,
who
I
come
can't
to
define-
appellate work from academia
I can't
and who
define
have
what
some
is good, but I
overarching
can define how to
theory
get
of the
there.
law,
Which is something
I
that
approach cases
is a concept in
from
patent law, for example.
experience,
One of the
from
ways
practice,
in my field of patent law,
and
for example, one of the ways that you can claim an
consistent with
invention
my
is
constitutional
by describing the
obligations.
process to create the
So
invention. Like, so,
my philosophy
you can
is one
you
in
can
which
claim the invention
I
if you can
look at
describe the
cases
invention. But
impartially,
if you can't describe the
consistent
invention,
with
another way
my
you can go about it
independence as a
is by
judicial
describing the
officer.
process to make the invention. It's like, I don't know exactly what this is. I can't describe it.
Understand
But I
my
know I can tell you
limited
how to
role
make it.
in the
And if you follow this
constitutional
process,
scheme,
it
and
produces
therefore take
the
very
substance X.
seriously all
And
of
if
the
you do that, it
constraints
gives
on
you
the
the patent in
exercise of my
substance X.
authority that
So maybe
exist
that's what she's trying to argue
in
is product by
our
process. Like, I can't
system.
tell you
What that means is that at the
what
beginning of every case,
is
I am setting
good
aside
in
my
sort of a
personal
constitutional
views. I
sense,
am
but I can tell you how to
Three
get there.
steps you gave us.
Is that what
Yes,
she's
sir.
trying to do? I don't know.
Yes.
So you don't have to go into that. Let me go on then. Should the Supreme Court overrule a precedent when it is clear to the justices that the precedent was wrongly decided?
Thank you, Senator. Stare decisis, which is the principle that the Supreme Court uses at the outset. It's the sort of background rule of judicial maintenance of precedents in order to have predictability, stability in the law, is the kind of principle that the court begins with when it is asked to overrule or revisit a precedent. And the court has developed certain factors that it looks at before it actually undertakes to reverse a precedent. One of those factors is the view that the precedent it's reconsidering is wrong, but that's not the only factor. The court also determines, in addition to whether or not the prior precedent was egregiously wrong, the court has said, the court looks at whether there's been reliance on that prior precedent, whether the precedent is workable or has proven workable over time, whether the cases in the area of the precedent have shifted such that the precedent itself is no longer on firm foundation, and whether there have been either new facts or a new understanding of the facts that give rise to a need to revisit the precedent. So it's not just a look at whether or not it's wrong, and it's important that the court take into account all of those factors, because stare decisis, meaning letting the precedent stand, is a very important pillar of the rule of law.
When is it appropriate for a judge to impose a sentence enhancement under the guidelines?
Thank you, Senator. The federal sentencing guidelines are crafted to assist courts in making sentencing determinations within the broad range that Congress prescribes for cases, for crimes. So in the typical case, a defendant is convicted of some crime. In the federal system, they're usually
breakfast.
very serious crimes. And Congress will say, Judge, you can give that person a sentence anywhere between 0 and 20 years, for example. The sentencing guidelines are designed to set out a series of factors that judges should be looking at when they decide what they're going to sentence that particular person to. And those factors will be things like, if this is a violent crime, does the person have a weapon? If this is a violent crime, was there any injury? And so the judge is looking at these facts, in many cases horrible facts, and calculating
Burroughs
the
breakfast
guidelines
burrito.
based on what we call
Sounds good.
enhancements. Each one of those different characteristics or conditions is an enhancement. So you ask, when is it important to when it's appropriate? Well, the judge has to calculate the guidelines in every case. That's how we start the process. But under the statutes, in addition to calculating the guidelines with all of those enhancements, the way our system now works is you determine what the guideline range of punishment is going to be. And then Congress says you look at a series of other factors in addition to the guideline range. And at the end of the day, the judges in the system now are choosing sentences based on both the consideration of the guidelines and also the consideration of the statutory factors that Congress has put forward.
Have you ever declined to impose an enhanced sentence on a defendant because you disagreed with the enhancement as a policy matter?
Thank you,
That's a
Senator.
damn good question.
Yes, and the reason is because of Supreme Court case law concerning the way in which the guideline system operates. The Supreme Court has determined in a case we discussed yesterday that the guidelines are no longer binding on judges, meaning the guidelines you calculate, but you don't have to stay in the guideline range anymore. That was the Supreme Court's Booker case. And I can't remember if it's in that case or in subsequent case law, but the Supreme Court has also made clear that when you are calculating the guideline range in the new system that we're in right now, judges are free.
But hold on, Kurt, I want to ask you a question because you'd probably be better in this.
Decide in
So
particular cases
so
whether
the
as
guidelines are
a
guidelines, but
quote,
what about
unquote,
mandatory
policy
minimums?
matter,
Mandatory minimums, you have
they
no
disagree
discretion.
with a
But in the
particular
Supreme
enhancement.
Court's
That
case,
is the
though,
state of
and
the
that
law. That is what the
there,
Supreme Court has said.
my understanding is that
judges
sentencing
are
is
permitted
a
to
constitutional
do
right of the
in
judiciary,
cases.
right?
And so I have
Punishment.
in
So
certain cases,
a judge
given
could
the way in which the
theoretically go
guidelines are
against the mandatory
operating,
minimum, right? They
the
can say, well, the
disparities
mandatory
that are
minimum is just a
created in
suggestion.
cases,
Or
I have
is that
at
not
times
accurate?
identified various
Because on one
enhancements
end, they'll say
that
the
I
mandatory minimums you
disagreed
can't
with
go under, but
as
then all
a
other these sentencing
policy
guidelines you
matter
can,
because the
because they
Supreme
before they were
Court has
mandatory, but now they're
said
not. So I'm
that
just
that's
trying to
the
figure out the
authority of
difference
a
between the two.
sentencing judge in our system.
Are nationwide
question. I'm thinking about the
injunctions
answer.
constitutional?
I'll get back to you.
Well, Senator,
You've issued them.
thank you for letting me address that circumstance. The reason why I paused is because what I have issued is not technically a nationwide injunction. People call it that, but in a particular set of cases, administrative agency cases that are brought under the Administrative Procedure Act,
Yeah.
these are challenges.
You enjoin the
to
agency, and it just
agency
happens to enjoin
actions,
it
like
nationally. But
agency rules
and for
that
those of you
they
who don't know
have
that's what happened with a lot of the
promulgated.
COVID cases when
And
the
if
Fifth
the
Circuit
challenge
enjoined
is to
the whatever
procedures that the
agency that was.
undertook,
then that agency
create
was
the
enjoined
rule,
nationwide. It was
the
enjoined by a federal
statute
court.
that applies, the Administrative Procedure Act, tells the court that if you agree with the plaintiff that the agency rule is faulty procedurally, the remedy in the statute is to invalidate the rule. That's what Congress tells judges to do. Now, technically, that's not a nationwide injunction. That is invalidating a rule that the
It has a
agency has
procedural
enacted.
defect. Yeah.
It may have nationwide effects because the agency may have implemented its rule nationwide. But what the court is doing is not reaching out and touching everyone in the country. The court is directing the government.
I don't
that
really buy
has
this distinction personally.
promulgated that
Like,
rule,
because in principle,
that the rule
in
is
principle,
invalid.
if you are
And
enjoining
that's
the
what
agency, the question would be,
statute
what is
tells
the
us
nature of
we
your
have to
injunction?
do in those
And
cases.
so if you are a district court or a
That's
court of
different than a
appeals with a limited
nationwide
jurisdictional
injunction,
reach,
because a nationwide
then your
injunction
injunction
would be
might
a
only reach as far as your
situation
jurisdiction,
in which
even
we're
though it
not
applies
dealing
to
with
the
the
agency,
rule,
right?
we're
Because you
not
only can
dealing
give
with
as
the
much
Administrative Procedure
relief as
Act.
you are authorized
We're
in your
dealing
lane,
with
right?
a
So
particular
you come to me with a
case in which
complaint as a
something has
district
happened
judge
between the
against an
plaintiff and the
agency. I
defendant.
find the agency's in
And the
violation of
court
law.
says,
I
based
issue an
on what
injunction,
happened in
but
this case,
my
I'm going to
jurisdiction
tell
isn't
everybody in the
everywhere.
country
My
that you
jurisdiction
can't,
is,
the defendant,
you
you
know,
can't
the district
operate
that
in
I'm
this
in.
way anymore. I'm
And
going to
so the scope
find
of
on
my
the basis
injunction
of
would
this
only
particular
apply within my
case,
district.
I'm going
So
to
the agency would
enjoin
still be free
everyone in the
to
country not to
implement
do
it
that
everywhere
anymore.
else,
That's a nationwide
at
So
least
injunction.
in principle, right?
It's
uh,
not
So that's,
that
I mean,
done
that's the
in,
alternative, right?
I think the
it
cases that you're
Opposed
depends
to me
talking
on
enjoining the agency and applying
How
everywhere.
can
So
the-
I don't
it
buy
depends
this
on the
distinction. That's a
concerns
nationwide
about
injunction.
I disagree with what you're
given the
saying
rise
is
of
because it
nationwide
depends on the
injunctions?
question being asked of the court. If the court is being asked to look at a
Well,
particular rule that agency's passed, whether it
forum
was done
shopping
in a procedural manner,
is
it
um,
conformed with the
the
APA, the
concern
Administrative
that
Procedures Act,
arises
and that judge
when
finds that it does not, that federal
litigants
judge says you didn't follow the
to
APA, you didn't go through notice and
um,
comment rulemaking, for instance,
go to
that
I think
different
court
in answer
could
to your
enjoin
question,
that
maybe during a
rule and
break
say
or
that
something, we
think
could
that
pull
they
Booker
may
and
get
see,
a
and we
better
could read
result.
Booker because it's been forever
And
since I
it's
read Booker
something
and
that
see how the
Congress
logic
Because
tracks.
can address.
Because
because
I'm
I'm
not sure I
saying,
can
well,
answer
hold
your
on.
Congress
question.
has
So
the
Well,
maybe
no,
we
I'm
could
saying
reread
in this
Booker during
point,
a break.
in this
Determine
point, I'm disagreeing with is
various
that I think because
aspects of
if
judicial
the
process.
judge is ruling that rule wasn't properly done, then
Explain
that rule is
political
enjoined.
question
And yes, the
doctrine,
agency itself
and
can't then
then what
continue to enforce
standards
a rule
would you
that the
apply
court
to
has said
determine
is you didn't
whether a
properly go
claim
into
before
effect.
you
So that in that sense, I
implicates a
think
political
yes, the district court, even though it's at one particular
So the
circuit,
political
can have that
question
national, and
doctrine
it's happened many times.
is
It
a
happened multiple
doctrine that
times. Well, I think with the
relates
last COVID
I'm
case
to
when the
not
district
arguing
court
that
did
it
it.
doesn't
jurisdiction
happen.
of the
I'm
court.
just pointing out that
As
I
I
don't buy the
mentioned,
distinction. It's like if you're
the
issuing an
courts are
injunction and by the
in
nature of its injunction it applies
a
nationwide,
particular
that's a
branch of
nationwide
government,
injunction.
the judicial
I just don't buy the
branch that
distinction.
is limited
If you think
in
that's a good
its
thing,
power.
that's if you think
The
nationwide
courts
injunctions in this sense are
can't
good, then fine.
make
Like
policy.
maybe, I
They
mean, I
can't
don't know,
reach
maybe
out
a
into the
district, maybe
world
one
and
district judge
decide
should
that
be able
certain
to issue an
things
injunction
are
against an
good or
agency.
bad and then
And even though
address
that
them.
even though
They
that
have to
district
wait
judge has
for
a limited
cases to
jurisdiction
come and
and
decide them.
it doesn't have
And
nationwide
when a case
jurisdiction, he has
comes,
jurisdiction in that limited area. So
it
maybe it
has
should
to
be
be
the case that it
presenting a
would apply
question of law
nationwide. I don't
for
know.
the
I just
court
don't buy
to
the
answer
distinction. It's
it.
not a nationwide
If a
injunction.
person comes to the court
But no,
and they
I think she
ask
said it
the
is a
court to
nationwide
answer
injunction. It's
something that
just
is
it's like
properly
the
in the
court
province of
is
Congress,
not making.
they
I
ask a
understand what she's. I
political
understand what she's
question,
trying to make the distinction. There are certain
Hmm.
then the
times where your
court has
injunction would
to
just be
say, I'm
localized, like you're
sorry,
saying,
that's
and
not
there are other
my
times
role.
where the injunction would
So
be
I had, for
nationalized,
example,
but
a
it would just be
case
the
that
type of relief the plaintiff
involved
is asking for. If they're
um,
asking for to enjoin this rule
Yemeni
because it was made incorrectly,
citizens
you have a nationwide
who,
injunction, even though it's localized. And then in
I'm
other
trying to
cases,
get the
you
facts
could have an
exactly right,
injunction,
but
but it would
they
just enjoin that. Like I
had
think the
relatives.
Medicare
I
injunction
think they were
was
resident
just
in
in
the
the Fifth
United
Circuit,
States,
so
and
it
they had
wasn't nationwide because it
relatives
was like
in
some issues
Yemen,
with the Fifth Circuit. So
a
so I
war-torn
think you're right.
area.
There's a distinction
a
between the
few
types of injunctions,
years
but I
ago,
think they were asking her about
and
this injunction that
they
was
came to
nationalized, and they were
court,
saying, well,
Hmm.
what
me,
you did that on purpose. She's
asking
like, no, it's
if
just
I
the type
could
of
direct the administration to
Yeah,
extract
I think I
their
understand
relatives
everything you're
from
saying.
Yemen.
I think I just disagree with
That
it.
they wanted me to order
Yeah. Well, that's what we do.
um,
We disagree all the time.
executive branch to send in troops and get their relatives out because it was obviously dangerous for their relatives to be in that country. And what I said in that circumstance is essentially, I don't have jurisdiction to do that because what you're asking me to do is a political question. That the question of when and where troops can be sent and who can be extracted from foreign governments belongs with the executive branch.
Yeah, that's a
And so
full.
you
Yeah,
have to
that's
ask
way
them.
outside that period.
And so I said, I have no jurisdiction. That's a political question doctrine. And it's well established in our law.
Yesterday, in response to a question from Senator Durbin, you said that as a judge, you are, quote, trying in every case to stay in your lane, and end of quote. That's the same time you gave us the 3 steps you go through as you work yourself through a case. You also described the text of law as a constraint on your authority. But in several cases, I'll list Make the Road New York, AFL-CIO versus
AFL-CIO.
Trump, Watervale Marine Companies, and others, the DC Circuit reversed your decision or criticized your reasoning for failing to follow a clear and unambiguous text. Why didn't the clear text of the law constrain your authority in these cases?
Thank you, Senator. You mentioned 3 cases. Certainly with respect to the second one, the DC
You know, I got to pull that
Circuit
case down to read it to
didn't
see why
say
she
that
was
the
slapped
text
up
was
by the
clear, and in
appeals
fact,
court,
that,
especially the DC
um,
circuit.
what
That's
happens
gonna be
in
interesting.
cases that judges at the trial level do their best to make interpretations. In that case, it involved a channeling provision. This is AFG versus Trump. It involved a provision, a statute that was designed to channel the judicial authority into an agency. And I interpreted the statute, and I thought that the arguments that were being made, the claims that were being made, were not ones that Congress had intended to channel. And I went
gotta
through the
say,
analysis,
these questions are
and I
some really
explained
good
my
questions.
reasoning as to why
I
I
mean,
Like
he's
thought
asking
I
like
still
actual
had
questions, which is
jurisdiction,
nice.
These are like
Nice for
really good
change.
questions.
to address
This is
the
not the
mayor
Kavanaugh. Have you
duty
drunk
of
beer
This is
before?
actually
These are
asking
they determine
questions.
they do have
these are real,
jurisdiction.
real substance
These are actual
questions.
questions.
too.
Wow.
DC Circuit
What a
disagreed.
strange
They
idea.
wrote an opinion that interpreted the statute differently with respect to those claims, but it was a case of first impression as to what those claims meant and whether they were supposed to be channeled or not. And that happens. The district judges do their best, and sometimes the Court of Appeals and the Supreme Court haven't spoken to the issue, and the parties disagree. In
I'll
Make
be
the
back.
Road,
I got a call.
I explained that what I was attempting to do in light of Congress's enactments, not only the particular immigration provision, but also the Administrative Procedure Act, was reconcile the statutes of Congress, which is something that the courts also are supposed to do. That there are statutory interpretation canons that make clear that courts are supposed to understand that Congress intends for statutes to work together. And to the
Excuse
extent
me.
that you are interpreting and the claim is made that allows you to do that, that's the sort of way in which interpretation is done. I can go through my actual analysis. I did it yesterday as we talked, but there was a good faith disagreement between me and the Court of Appeals, which gets to decide as to what the language meant and whether or not Congress actually intended to exclude the APA using that language under those circumstances.
Thank you very much.
Senator Leahy.
Thank you, Chair. And welcome back, Judge Jackson. I know yesterday was a grueling day of questions. I commend you for your poise, your endurance, your thoughtful answers. I felt privileged to be here for hours of that, and you had even more hours. But I want you to know the reaction in my own state of Vermont. I've gotten all kinds of emails and calls and from friends across the political spectrum. They're all been praising you. And they fortunately aiming for what a soundbite that they might be able to put on a political website where it now is. For example, we heard some overheated claims yesterday that your representation of Guantanamo detainees somehow signaled your policy preference with how the United States has dealt with those detainees. Every single member of this committee, especially those of us who have been assigned as counsel in cases, should know better than to conflate a nominee's past representation with their policy positions, or to argue that a nominee espoused their client's viewpoint simply by choosing to represent them. So your policy views aside, can you reiterate why it's so important for our courts to have the benefit of the best possible legal representation on both sides of any case, and especially in cases where we are in uncharted legal and constitutional waters?
Yes, thank you, Senator. So I've been a judge for almost a decade, and what I've learned is that as part of my duty to render decisions consistent with my judicial oath in support of our Constitution and the rule of law, I need to consider all of the arguments related to the dispute that is being brought in my courtroom. I need to hear from not only the parties who are prosecuting a case, for example, a crime, but also from the defense. And some of these crimes are terrible crimes. Our Constitution is designed to ensure that the government affords due process to people who are being accused of crimes. And one might think it's even more important in a way in a case in which someone is so reviled. It's kind of like the First Amendment. It's a protection for unpopular views. It's needed when there's a chance that the government will suppress or do something that's untoward. And so in the criminal justice system, we have many, many amendments that are designed to make sure that unpopular people who are accused of doing terrible things, are still treated fairly by the government. And that's a limitation on government power, which is the framework of our Constitution. It is about limiting government overreach. And so in the criminal justice system, you can imagine, and the framers imagined, a world in which the government would use its authority to deprive people of their liberty, to throw people in jail, to lock them up and throw away the key, to not give people the opportunity to make arguments about their freedom. That would be a real exercise of government power, government overreach. And so the framers said, what we're going to do is we are going to put in our foundational documents a protection for people that the government is accusing of crime. And that's not to say that the people are innocent. That's not to say that they haven't done terrible things. What it's about is ensuring that the government does what is required in order to ensure all of our liberty. It protects all of us because there might be someone who is innocent, and if the government is able to just do whatever it wants in criminal process, we are all at risk.
Well, and I think we've all seen cases where that happened. I mentioned to you yesterday that I spent nearly a decade as a prosecutor. Especially when I had serious cases, I wanted the best defense attorney possible on the other side. I wanted a case that if I won, it usually went up on appeal automatically if it carried a heavy penalty. I wanted the court, the appellate court, to look at it and say, okay, there were not errors of counsel on either side. But I also, as a strong proponent of our Constitution, I think what you're saying is something I totally agree with. We have to have the individual's rights protected. It doesn't mean the defense counsel is in favor of murder or rape or armed robbery, but the rights have to be protected. And let me tell you about another area. I've authored and I've long championed the bipartisan John Lewis Voting Rights Advancement Act. I think it would help curtail the growing wave of voter suppression sweeping across our country. Again, something we don't have to worry about in Vermont, but unfortunately do in other states. I'm passionate about this legislation. I've always believed that our democracy is stronger when we expand, not shrink, the ranks of our citizens who fully participated. I believe our democracy goes stronger with your historic nomination and your presence before us today. And I've told you privately how my family members feel about that. Why is it important for our democracy's institutions, courts and all others, to reflect the rich diversity of our nation's citizenry?
Thank you, Senator. One of the things we've been talking about is the difference between the judicial branch and the other branches of government. We have 3 branches in our federal system, and the legislative branch has certain powers and it can do certain things to ensure that its prerogatives are achieved. And the executive branch has the power of might. The president controls the military. The judicial branch, its force in our system is the protection of the rule of law, which can only be done by essentially the consent of the governed. It can only be done if people in our society believe, decide, and agree that they're going to follow what it is that courts decide. And so one of the reasons why having a diverse judicial branch is important is because it lends and bolsters public confidence in our system. We have a diverse society in the United States. There are people from all over who come to this great nation and make their lives. And when people see that the judicial branch is comprised of a variety of people who have taken the oath to protect the Constitution and who are doing their best to interpret the laws consistent with that oath, it lends confidence that the rulings that the judge that the court is handing down are fair and just, that everything has been considered, that no one is being excluded because of a characteristic like race or gender or anything else. And that's important. I would also say that that it's important from the standpoint of role modeling, that I have been so touched by the numbers of people who've reached out to me in this period of time to say how much it has meant to their daughters, to their sons, to the next generation, that I've been appointed, to nominated and hopefully confirmed.
Well, I agree with you. certainly seen that within my own family. You know, we do have areas where we agree on things on this committee. Senators Grassley and Senator Cornyn, myself and others believe in transparency as part of our democracy. We've done this with the Freedom of Information Act when we've updated it a number of years. Senator Cornyn and I have been the key sponsors of legislation, joined by Senator Grassley and Senator Durbin and others to improve the Freedom of Information Act. You've talked about the detailed opinions you've written to try to do the same thing. I think it's safe to say you believe transparency is central to the duties of a judge. Do you intend to carry that attitude and you will become a member of the U.S. Supreme Court?
Thank you, Senator. The value of public confidence, which I was just discussing, I think is enhanced when the public understands the reasons that a judge renders his or her ruling. One of my mentors used to say, people think the judicial branch is so secretive, but in fact, the judicial branch is the only branch that actually has to tell everyone, that actually has to write their opinions and explain why it is that they did what they did. And so I've tried in the nearly 10 years that I've been on the bench to make my rulings transparent, to explain all of the inputs that I have considered with respect to the case, to lay out the law as I see it in interpreting what Congress, for example, has done in with respect to a particular case, and what legal provisions that I think are relevant to the dispute, and then to explain my analysis. Why am I granting this motion or denying this claim? And my hope is that it will help people to be confident in my reasoning, and even if they disagree with it, they will understand what it is that I think, and I think that's important for public confidence in promoting the rule of law.
Well, you know, you had talked about your clerking for justice prior, how it opened up doors of opportunity. I remember so well our conversation in my office, in the President Pro Tem's office, talking before these hearings began. You told me what you thought it meant to your parents and your family, your husband, your daughters, your parents who have been here throughout this, and what it would have meant to your grandparents. You said you were the lucky first inheritor of Dr. King's civil rights legacy. I keep a daily journal. I wrote that down. It means a lot. So let me do this sort of an open-ended question. You patiently answered our questions this week. I told you the reaction in Vermont was disappointment in some that were obviously political. I heard that from both Republicans and Democrats, because they think it should be your legal thoughts in the Supreme Court. So I'd like to give you an opportunity to speak directly to the American people, including our little state of Vermont. Is there anything you want to convey to them about what kind of Supreme Court justice you would be if and when you're confirmed? It's all yours, Your Honor.
Thank you, Senator. Well, first, let me just address my comments to you in your office, which is something that I've said in speeches, because it speaks to who I am and what I value. My parents grew up in Florida under lawful segregation. And what that means is that when they were coming through middle school and high school, they were not allowed to go to school with white students. This is in the era before and right after the Brown versus the Board decision. There was lawful segregation in places in this country. And it was after that time that Dr. King made his famous comments that people mention about having a dream where people can be judged by not by the color of their skin, but by the content of their character. And I then was born in 1970, and the contrast between my reality growing up in Florida and my parents' reality growing up in Florida, like night and day in terms of the opportunities that were available to me that weren't available to Judge Motley, who is one of my role models in the law. And so what my being here, I think, is about at some level is about the progress that we've made in this country in a very short period of time, I would say. It seems like a long time, but one generation, we've gone from the reality of my parents' upbringing to the reality of mine. And I do consider myself, having been born in 1970, to be the first generation to benefit from the civil rights movement, from the legacy of all of the work of so many people that went into changing the laws in this country so that people like me could have an opportunity to be sitting here before you today. What I would hope to bring to the Supreme Court is very similar to what 115 other justices have brought, which is their life experiences, their perspectives. And mine include being a trial judge, being an appellate judge, being a public defender, being a member of the Sentencing Commission, in addition to my being a Black woman, lucky inheritor of the civil rights dream. And in my capacity as a justice, I would do what I've done for the past decade, which is to rule from a position of neutrality, to look carefully at the facts and the circumstances of every case without any agendas, without any attempt to push the law in one direction or the other, to look only at the facts and the circumstances, interpreting the law consistent with the Constitution and precedents, and to render rulings that I believe and that I hope that people would have confidence in.
Thank you. And Chair Durbin, I've had the opportunity to be here. The first justice I got to vote on was John Paul Stevens, nominated by President Gerald Ford. Proud to vote for him. And it's a long arc, Judge Jackson, but I am so proud of your answers and I appreciate you yield back.
Thank you, Senator Lee. Let's take a break for about 15 minutes.
Thank you.
Thank you very much, Judge.
Okay. I've been eating breakfast for a little bit here, by the way. Yeah, the stream was taken down on a copyright claim. So, yeah. I'd like to point out that there is no copyright in this by law, because this is a work produced by the United States government. there is no copyright in this by law. See 17 USC 105. There's no copyright because it is a work of the U.S. government. The U.S. government doesn't get copyright. It's right in the law. And so our fair use analysis is really easy because I don't even have to go to 107. I'll just go to 105. Makes it easier. C-SPAN can eat me. I guess I could get this. I guess I could get it straight from the U.S. Senate site. I think they have a streaming thing too, but it would be it's based on an audio match, right? So I mean, like, okay, if they because it's the same camera. It's the same camera. C-SPAN is just using the same camera. It's not copyrighted. It's the same exact feed that's on the U.S. Senate site. I know there's no sound. They're not in the hearing right now. This is from the past. They're on break. Yeah. I mean, so there's not really nothing to listen to right now. But we can do something productive with our time. Let's see. YouTube is still thinking, by the way, behind the scenes. But we can do something productive in time. Because Nate asked me a question, and I didn't know the answer. So let's figure out the answer. Right? That'll be productive. So let's do that. YouTube is still trying to talk to me, by the way, at the same time. All right. So this is U.S. Supreme Court, U.S. versus Booker. This is the case that said that the sentencing guidelines, which were previously mandatory, were now not mandatory. Nate asked me, if this is true, then are mandatory minimums still a thing? I'm like, okay, that's a good question because the sentencing guidelines were published by Congress. The mandatory minimums are published by Congress. If this is if the sentencing guidelines are unconstitutional because they unduly restrain the judiciary, the question might be, are mandatory minimums unconstitutional because they unduly restrain the judiciary? And so I thought what we might do is we could go through this and we could try to figure out, what's going on there. And I do prefer this in PDF form. I prefer this in PDF form. It makes it a little bit easier for me. So I'm used to seeing it that way. No. All right, let's do this. All right. We'll read the executive opinion, or we'll read the you guys can't see this, can you? Because it opened in a new window. It's one of the things about StreamYards is it makes it a little bit hard because you have to stop the screen. Every time you want to change the window, you have to remove it. You have to stop it. You have to restart it. It's a little bit hard in StreamYards with the Windows thing. That's okay though. We will press through together. Where is my window? Okay, great. All right, so we'll read this in PDF form because it's a little bit easier for me. And we'll start with the syllabus. Under the federal, so this is U.S. v. Booker again, which dealt with mandatory, dealt with the sentencing guidelines being mandatory or not. Under the federal sentencing guidelines, the sentence authorized by the jury verdict in Respondent Booker's drug case was 210 to 262 months in prison. At the sentencing hearing, the judge found additional facts by preponderance of the evidence. Because these findings mandated a sentence between 360 months and life, the judge gave Booker a 30-year sentence instead of the 21-year, 10-month sentence he could have imposed based on the facts proven to the jury beyond a reasonable doubt. The Seventh Circuit held that this application of guidelines conflicted with apprendi, okay. YouTube is not being particularly helpful. The Seventh Circuit held this conflict with apprendi, holding that other than the fact of a prior conviction, any fact that increases the penalty beyond the prescribed statutory maximum must be submitted to the jury and proven beyond a reasonable doubt. That sounds right. Relying on Blakely, the court held that the sentence violated the Sixth Amendment and instructed the district court to either sentence Booker within the sentencing range supported by the jury's findings or hold a separate sentencing hearing before the jury. Sounds right. In Respondent Fanfan's case, the maximum sentence authorized by the jury verdict under the guidelines was 78 months in prison. After the sentencing hearing, the district judge found by preponderance of the evidence additional facts authorizing the sentence in the 188 to 235 month range, which would have required him to impose a 15 or 16-year sentence instead of the 5 to 6 authorized by the jury verdict. Relying on the Blakely majority statements in its dissenting opinions and Solicitor General's brief in Blakely, the judge concluded he could not follow the guidelines and imposed a sentence based solely upon the guilty verdict in the case. Sounds right. The government filed a notice of appeal in the First Circuit and petition for certiorari. Hell, the judgment of the First Circuit is affirmed. Okay. Judge Stevens delivers the opinion of the court in part, concluding that Sixth Amendment as construed in Blakely applies to federal sentencing guidelines. In addressing Washington State's determinate sentencing scheme, I continue to work with Google behind the scenes. In addressing the sentencing scheme, the Blakely court found that Jones v. United States and apprendi and Ring made clear that statutory maximum for apprendi purposes is the maximum sentence a judge may impose solely based on the facts as reflected in a jury verdict or admitted by the defendant. Okay. As Blakely dissenting opinions recognize, there's no constitutionally significant distinction between the guidelines and Washington's procedure at issue in this case. The conclusion rests on the premise, common to both systems, the relevant sentencing rules are mandatory and impose binding requirements on all sentencing judges. Were the guidelines merely advisory, recommending but not requiring the selection of particular sentences in responding to differing sets of facts, the use would not implicate the Sixth Amendment. However, that is not the case. Title 18 U.S. Code 3553 directs the court shall impose a sentence of the kind and within the range established by the guidelines, subject to departures in specific limited cases. Because they're binding on all judges, this court has consistently held the guidelines have force and effect of laws. Yeah, that makes sense. It appears to be a law in the U.S. Code, but yes, I mean, fair, sure. Further, the availability of departure where the judge finds an aggravating or mitigating circumstances of any kind or degree not adequately taken into consideration by the Sentencing Commission in formulating the guidelines should result in a sentence different from described. The section does not avoid the constitutional issue. Departures are unavailable in most cases because the Commission will have adequately taken all relevant factors into account and no departure will be legally permissible. Okay. In those instances, the judge is legally bound to impose a sentence within the guidelines range. Booker's illustrates the point. The jury found him guilty of possession of at least 50 grams of crack cocaine based on evidence that he held 92.5 grams, which would be at least 50. Under those facts, the guidelines required a possible 210 to 260 month sentence. To reach the actual sentence, which was almost 10 years longer, the judge found, by preponderance of the evidence, mind you, that he possessed an additional 566 grams of crack. Although the jury never heard any such evidence, the judge found it to be true by preponderance of the evidence. Yeah, so I have no particular problem with this part of the conclusion, right? It's like if you want to, everything that's held against you should be proven beyond a reasonable doubt. which was not the law before, right? The law before was you could find additional things in the sentencing by preponderance of the evidence. That was the law at one point, and the U.S. Supreme Court changed that. I have no problem with that, right? If they're going to use it against you, you should prove it beyond a reasonable doubt. Judge shouldn't just be allowed to say, oh, it's more likely than not, right? That seems odd. So that's fine. Although the jury never heard such evidence, the judge found to be true by preponderance of the evidence, which is distinctly not beyond a reasonable doubt. Thus, as in Blakely, the jury's verdict alone does not authorize the sentence. The judge acquires that authority only upon finding some additional fact. This is deeply problematic. Finally, because there were no factors in the sentencing commission failed to adequately consider, the judge was required to impose a sentence within the higher guideline range. Okay, yeah, that's bullshit as to that much, right? So that's bullshit. I can get behind that. The government's arguments for position in Blakely reasoning should not be applied to the sentencing guidelines are unpersuasive. Okay, why? This is where the rubber meets the road, right? So Blakely stands for the proposition that if they're going to sentence you to something, probably, would be good if they proved it beyond a reasonable doubt. That might be nice. Then the government argues that should not apply to the sentencing guidelines. Okay, but that doesn't work. Okay, why doesn't it work? Convince me, Stevens. I'm willing to be convinced. I really am. The fact that guidelines are promulgated by a sentencing commission rather than by Congress is constitutionally irrelevant. Okay. The court has not previously considered the question, but the same Sixth Amendment principles apply to sentencing guidelines. Okay. Further, the court's pre-apprendi cases considering the guidelines are inapplicable as they did not consider the application of apprendi to the sentencing guidelines. Finally, separation of powers concerns are not present here and were rejected in Mistretta. In Mistretta, the court concluded that even though the commissions performed a political rather than adjudicatory function, Congress did not exceed the limitations to create a commission. This is probably correct, right? This would get into the issue of delegation of legislative authority, which is a tough trigger to pull and probably isn't true here. So I think that's fine. And Google just tells me I'm out of luck, by the way. Their final analysis is I'm out of luck as long as the stream is live streaming. So as long as it's live streaming, I can't protest. That was Google's answer, by the way. So they told me to go stuff it. Moving back to the Supreme Court. Okay. All right. This conclusion remains true whether the factors are labeled sentencing factors or elements. I'm on board with that much. Justice Breyer delivers the opinion of the part, concluding that 18 U.S.C. 3553, which makes the sentencing guidelines mandatory, is incompatible with today's Sixth Amendment jury trial holding, and therefore must be severed and excised from the Sentencing Reform Act. Okay, why? Section 3742, which depends upon the guidelines' mandatory nature, also must be severed and excised. So modified, the Act makes the guidelines effectively advisory, rendering a sentencing court to consider the guidelines range, but bringing a tailored sense in light of the other concerns. Okay, but why are we severing it? This is the question. Why isn't it good? Answering the remedial question requires determination of what Congress would have entitled in light of the court's holding. Right. So then once we sever it, then we have to determine what to do about it, right? And that gets into a whole issue, but I don't really care about that issue for the moment because my question is, and then okay, so they get into what they're going to do about it, blah, 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 blah. All right, so that didn't really help me that much. Whether or not the whole act has to be invalidated, I don't care that much right now. Other remedies, parties, blah, 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 blah. Okay, I don't care about any of that. I need to know why it was severed. This is just the syllabus? Oh, Lord. I don't want this. I want the opinion. From Breyer, I guess. You're killing me right now, by the way. You're killing me. You're killing me. All right, fine. We'll do it the older way. Other way. Fine, we'll do it this way. I don't like this format as much. I'm not used to seeing it this way. Okay, let me see if I can find the operative part. Is this just the remedy issues? Okay. So Breyer is just doing the what to do about it problem. I don't care. Let's go to Stephen's opinion. The question presented in each of these cases whether application of the federal sentencing guideline violated the Sixth Amendment. In each case, the court below held that binding rules set forth in the guidelines limit the severity of the sentences that the judge could lawfully impose on the defendant based on facts found at the jury's trial. In both cases, the court rejected on the basis of our decision in Blakely. The government recommended application of sentencing guidelines because proposed sentences were based on additional facts the sentencing judge found by preponderance of the evidence. I'm with you as to that much. I'm on the board. We hold that both courts correctly conclude the Sixth Amendment as construed by Blakely does apply to the sentencing guidelines. Why? In a separate opinion authorized by Justice Breyer, they conclude what to do about it. All right, we can skip. It's been settled through our history the Constitution protects every criminal defendant against conviction except upon proof beyond a reasonable doubt. It's equally clear the Constitution gives a criminal defendant the right to demand a jury to find him guilty of all the elements of a crime. These precepts have provided the basis for our interpretations. Okay. In Jones, we consider the federal carjacking statute, which provides 3 different maximum sentences dependent on the extent of the harm. Okay. In spite of the fact the statute at first glance makes it look like these are sentencing provisions, we conclude that harm to the victim was an element of the crime. Fine. This conclusion was supported by statutory text, blah, blah, blah. I'm okay with all that. An apprehended defendant pleaded guilty to second-degree possession of a firearm for an unlawful purpose, which carried this term. Thereafter, the trial court found this was a hate crime, but that wasn't proven to the jury. I don't care. In Ring, we reaffirmed our conclusion that the trial judge alone should do that. Fine. In Blakely, we determined with determinant sentencing schemes similar to the federal sentencing guidelines. There, the defendant pleaded guilty to kidnapping, a Class B felony, punishable by a term of not more than 10 years. Other provisions of Washington law, comparable to the federal sentencing guidelines, mandated a standard sentence of 49 to 53 months, unless the judge found aggravating factors justifying an extended sentence. Although the prosecutors recommended the sentence in the standard range, the judge found it acted with deliberate cruelty and sentenced him to 90 months. These are all problematic because the judge is finding additional facts, right? These are all problematic because the judge is finding additional facts that were not proven to the jury. I have no problem with that part of the conclusion. Okay, so the jury has to find any operative fact. Great, I'm on board. As the dissent opinions in Blakely recognize, there's no distinction of constitutional significance between the federal sentencing guidelines and Washington procedures in that case. This conclusion rests on the premise common in both systems that relevant sentencing rules are mandatory and impose binding requirements on all judges. Okay. If the guidelines as currently written could be read as merely advisory provisions that recommend that rather than require the selection of particular sentences and respond to differing sets of facts, their use would not implicate the Sixth Amendment. We have never doubted the authority of a judge to exercise broad discretion in imposing sentencing within a range. Indeed, everyone agrees the constitutional issues presented by these cases would have been avoided entirely if Congress had omitted from the Sentencing Reform Act the provisions that make the guidelines binding. But why is it bad if the makes them binding? As long as those facts are found by the jury, why is it bad? It's the circumstances that makes the court's answer a second question possible. For when a trial judge exercises discretion to select a specific sentence within a defined range, the defendant has no right to a jury determination of the facts the judge deems relevant. That doesn't seem right. I'm thinking, by the way, in case you're wondering why I'm pausing. It might be right. I'm thinking. Okay. So here's what I think they're saying. and I'm going to read more, but I want to see if I'm right. So I'm going to, explain it to myself for a little bit. Then I'll read some more and see if I'm right. But here's what I think they're saying. All right. So we are determining that a judge cannot sentence you based on facts that they find that are not presented to a jury. Okay. I'm on board with this conclusion. The sentencing guidelines themselves give a range. So let's say it's 60 to 72 months. Okay, is our number. We have to sentence you to something between 60 and 72 months. Okay. Is the problem that the judge is making a factual determination as to what that number should be? Because it seems like that's not quite right, because all the facts are proven to the jury by the implication of guilt, right? So by operation of law, if you have a guilty verdict, you can conclude the jury relied on any fact that would lead to that conclusion. So how do you know what facts the jury found? It's easy, as a matter of law. If you have a guilty verdict, you can assume, as a matter of law, the jury found each and every fact that would lead to that conclusion. They have to have been presented to the jury, so it has to be somewhere in the evidentiary record. So you can't just make it out of nothing. Right? So it has to be facts presented to the jury, witness testimony or otherwise. But once you have a guilty verdict, you can assume the jury found each and every fact that would lead to that conclusion. And you can also find that they discarded every fact that would go against that conclusion. That's just operation of law. The jury found every single fact that would lead to the conclusion and disagreed with every single fact that would lead away from that conclusion. So all those facts are now proven beyond a reasonable doubt. That's my point, right? So I'm not sure what the problem is necessarily. All right, let's continue reading. Lindsay's questioning right now. Well, Lindsay can wait. I'm in the middle of a constitutional law analysis, and I need to finish this thought. So Lindsay can wait. We're doing this now. We're doing a constitutional law analysis because I want to answer Nate's question. Lindsay can wait. You want to watch Lindsay go to C-SPAN or something? I don't know what to tell you. Madison says they've been back. What the F? Well, what the F is, we're doing constitutional law analysis at the moment because I want to understand something. Nate asked me a question and I don't know the answer and I want to know the answer. So I'm going to read something so I become less stupid. So I will know the answer to the question. That's what we're doing now. Uncivil law is becoming smarter before your very eyes. It's nice. Okay. The guidelines as written are advisory. They're not advisory. They're mandatory. While subsection A of 3553 of the sentencing statute lists the sentencing guidelines as one factor to be considered, imposing sentence. Subsection B directs the court shall impose the sentence within the range established by guidelines, subject to departures in specific limited cases. Because they're binding on judge, we've consistently held the guidelines have the force and effect of law. I don't have any problem with that conclusion. They have the force and effect of law. Fine. The availability of departure in specific circumstances does not avoid the issue, just as it did not in Blakely. The guidelines permit departures from the sentencing range in cases in which the judge finds there exists aggravating or mitigating circumstances of a kind or to degree not accurately taken into consideration by a sentencing commission in formulating the guidelines that should result in a sentence different from described. Well, fine. I don't see that as a problem, though, because, again, like the factors, maybe the sentencing guideline didn't think of everything, or maybe they did. So this is just like an escape clause. This is an escape clause, right? Because because the sentencing commission is smart enough to know that they can't think of everything in advance, because of course they can't, because they're not God. So they wrote an escape clause and just be like, hey, by the way, in case you find something that we didn't bring into the analysis for some reason, just to let you know, you can depart from our guidelines. We tried to think of everything. We sure gave it our best shot. But in the event that we didn't find something and that's relevant, you can obviously add that into the equation, right? But if we thought of everything, then you're done, which makes sense, right? It's okay. I mean, fine. At first glance, one might believe the ability of the district judge to depart from guidelines means that they're only bound by statutory maximum. Were that case, there would be no apprehendee problem. Importantly, however, departure is not available in every case, and in fact are unavailable in most. Well, one would kind of hope actually that would be true, because hopefully the sentencing commission is, reasonably competent. And so it should be the case that in the most situations, there wouldn't be a deviation, because the sentencing commission isn't an idiot, one would hope. So, okay. In those instances, the judge is bound to impose a sentence within the range. It was for this reason we rejected a similar argument in Blakely, holding although the Washington statute allowed the judge to impose a sentence outside the range for substantial and compelling reasons, that exception was not available to Blakely himself. Maybe we need to go back to Blakely. We're not going to do that now. I'll finish this analysis, and then we'll go back to the stream, and we'll listen to that. And then if I'm still confused, we'll then do Blakely in the next break. More constitutional analysis until I understand the answer. Booker's case illustrates the mandatory nature of the guidelines. Okay. Blah, blah, blah. Okay. To reach the sentence that found facts beyond the jury. Okay, I'm fine. That's fine. I understand that. Okay, so yeah, they have to be facts found before a jury. Fine. It's quite true that once determining sentence had fallen from favor, American judges commonly determined facts based on the manner in which particular acts acted. However, in 1986, our own case recognized a new trend of legislative authority when we consider significance of facts selected by legislatures. They're not only authorized or even mandated heavier sentences that otherwise would have been imposed, but increase the ranges of possibilities for those crimes. I'm not sure I understand the problem. The legislature would be saying, if you find this fact, then increase the sentence. The fact would still have to be done by the judge. It just tells you what to do if you do find it. Provisions for enhancements of permissible sentencing range reflect growing and wholly justified legislative concern about proliferation of varied drugs crimes. The effect of increasing emphasis on facts that enhance sentencing range, however, was to increase the judge's power and diminish that as the jury. It became the judge, not the jury, that determined the upper limits of sentencing, and facts determined were not required to be raised before a trial. Again, to the extent that they're talking about facts proven at the trial, I'm on board. I'm on board with all this. Right? If the issue is the judge is finding facts by themselves, by preponderance of the evidence, and you don't have the right to a jury trial, I'm on board. I get it. My question is, why are facts determined by the jury not enough? As enhancement became greater, the jury's finding for underlying crimes became less significant. That doesn't make sense. And the enhancements are very serious. As it thus became sentencing was no longer taking place in the tradition that Justice Breyer invokes, the court was faced with the issue of preserving an ancient guarantee under a new set of circumstances. The new sentencing practice forced the court to address the question of how the right to a jury trial could be preserved in a meaningful way, guaranteeing a jury would still sit between the individual and the government under the new sentencing regime. As long as all the facts are found by the jury, I am not sure I see the problem. As the new circumstances nor a tradition of practice that new circumstances is supersedis, that led us to the answer first considered in Jones and developed in apprendi in significant cases. What am I missing here? The fact that it's the commission versus the legislature, I agree that's irrelevant. I'm on board with that. Provisions of the guideline that require sentencing enhancement if the judge determines the defendant committed perjury do not violate the privilege of the accused to testify on their behalf. Yeah. Double jeopardy clause do not bar prosecution for conduct that provide the basis for enhancement in a prior case. Sure, that I'm good, right? Because your prior conduct is going to your criminal history score, so it's not a double jeopardy issue. Fine. I don't understand this. I don't get it. What am I missing? I don't get it. I don't get it. It doesn't flow. Am I missing something? Because it doesn't flow. Well, while I continue to ponder that, I'll put the stream back on so we can enjoy that. But I don't get it.
Sexual images of children, and the most disgusting way is to supervise their computer habits versus putting them in jail?
No, Senator, I didn't say
That's
versus.
exactly what you said. I think the best way to deter people from getting on a computer and viewing thousands and hundreds and over time, maybe millions, the population as a whole, of children being exploited and abused every time somebody clicks on is to put their ass in jail, not supervise their computer usage.
Senator, I wasn't talking about versus.
You just said you thought it was a deterrent to supervise them. I don't think it's a deterrent. I think the deterrent is putting them in jail.
Senator,
Does
would you let
sentencing
her
have a
respond?
deterrent component?
Senator, would you let her respond?
Yes. Does sentencing have a deterrent component?
Yes, Senator, deterrence is one of the purposes of punishment, and Congress has directed courts to consider various means of achieving deterrence. One of them, as you said, is incarceration. Another, as I tried to mention, was substantial periods of supervision once the person.
So if I could may ask you, in your view, it's more of a deterrent to have somebody substantially supervised in terms of their computer use who's looking at child pornography than it is to put them in jail?
Senator, I'm not saying it's more or
That's
less.
exactly what you're saying.
What I'd like to point out is that if we're going to, let me say it this way. Congress has authorized courts to use a number of different means to achieve the purposes of punishment.
And one of
and
them is an enhanced punishment by using a computer.
The enhancement with respect to using a computer relates to the penalty in terms of incarceration.
And you would choose not to apply that in these cases. You've said that. I'll read you the quote, but you've decided not to apply the use of a computer as an enhancement. You've also said you're not going to hold the number of images that the person has looked at as a sentencing enhancement factor. Is that true?
No, Senator, it's not the number of images that the person has looked at because we don't have that information.
Well,
It is the number of images that they've either received or distributed
well,
that are.
whether we don't know if they looked at them, but you're not going to hold it against them that they received 10,000 images versus 100.
That's not what I've said, Senator.
Well, here's what you said. I've decided to apply my general policy disagreement with respect to those enhancements, at least that is the computers and the number of images. Folks, what she is saying, the reason she's always below the recommendation, I think, is because she doesn't use the enhancements available to her. She takes them off the table. And I think that's a big mistake, Judge. I think that every federal judge out there should make it harder for somebody to go on a computer and view this filth. That if you use that venue, which is the venue of choice for all these child pornography cases, that you use it against them. I think the more you download, like drugs, the more you have, the more you should go to jail. You've made a conscious decision to disregard those two enhancement sentencing factors, and I think that is a wrong way to go in terms of deterrent. To me, putting somebody in jail for using a computer is more of a deterrent than supervising their activity of watching the computer. That's just a difference that we have. I know I'm out of time, and listen, you've lived an incredible life, but here's one thing that won't happen to you as we wrap this up. How would you feel that if I'd had a letter from somebody accusing you of something, a crime or misconduct, for weeks, and I give it to Senator Durbin just before this hearing's over, and not allow you to comment on the accusation? How would you feel about that?
Senator, I'm not sure. I don't understand the context of the
Sure you
question.
do.
Well, let me.
Of
did
course you understand the
watch
context. You're
Kavanaugh
not an
hearings?
idiot.
No, sir.
Are you familiar with what happened in the Kavanaugh hearings?
Generally.
Senator, your time is.
Well, please, Mr. Chairman. So to be honest, it's a minute and 47 seconds. She filibustered every question I had, and she has a right to give an answer, but I'm trying to make a point in 20 minutes. You were here for Kavanaugh. If she's confused about what happened, some people on the other side had an accusation against Judge Kavanaugh that during high school, he sexually assaulted somebody. And the rest is
She
history.
didn't even see like those
That was
segments on the news or
known
something. I
to
mean,
the
you know.
people on the other side and never revealed during the meetings they had with Judge Kavanaugh. It was literally ambushed. He was ambushed. How would you feel if we did that to you?
Senator, I've appreciated the kindness that each of you has shown me to see me in your offices, to talk with me about my approach.
But my question is, what if it, during our 15-minute exchange, it was very pleasant? You're a very nice person. You have a lot to be proud of. I would never do that to you. If I had some information that's sketchy at best, that somehow you've done something wrong, I promise you, just from human decency, I would share it with you. I would not disclose it at the last minute of the last day of the hearing, and I've already given it to a newspaper so the whole country can read about it before you ever said a word.
Senator, she's had nothing to do with the cause.
No, but
Kavanaugh
I'm
hearing.
asking her about
You won't even let her
how
finish your
she may
response.
feel about what y'all did.
We have order,
Senator, your
Mr.
time
Chairman.
has expired, and I'm going to give her an opportunity to finally complete an answer.
So if I could
Just
address
answer the question.
Senator, I don't have any comment on what procedures took place in this body regarding
What'd you think about the
Justice
Kavanaugh hearing?
Kavanaugh.
you
What
let
I'd
her
like to
finish?
answer is
I
your
bet you'd like to answer something
points
different.
about my sentencings in child pornography cases. The point of the guidelines is to assist judges in determining what punishment to provide in cases. And there are horrible cases, but the idea is that between the range of punishment that Congress has prescribed, judges are supposed to be providing proportional punishment based on what a person has done. The sentencing scheme doesn't place everybody at the same level. The point of judging and the guidelines is to look at what has happened in a case, compare defendants to each other in terms of what they've done, and give proportional penalties
Mr.
based.
Chairman, this
Wait,
is she has said, Mr. Chairman, she does not use sentence enhancements in the area of somebody using a computer for everybody.
Can I explain why, sir?
I'm going to give the witness an opportunity to respond to you, Senator.
Finally.
At
Why?
the time that the guidelines were created for child pornography, this crime was primarily being committed by people who were literally mailing 1, 2, 5, 10, 100 photos at a time.
How's it being committed now?
Would she please
Go
let
ahead.
her complete her answer?
Go ahead.
As a result, the commission determined in the guidelines that it was a substantial aggravating factor if the facts of the case demonstrated that someone had been distributing hundreds of images, because what that meant was over this long, maybe it was a long period of time, they had collected one photo at a time, they had amassed it, they had potentially mailed one at a time, and that showed really aggravated, terrible conduct. I'm not saying as a baseline it's not terrible, it's all terrible. But what we're doing is we're differentiating among defendants. So in a world in which the mail is used for the purpose of distribution, it really matters whether the person has distributed 1 or 5 or 1,000. And so the guideline says, you know what? We are going to treat a person who's distributed 1,000 a lot worse, because that shows that this person is really engaged in this really horrible behavior. In comes the internet. On the internet, with one click, you can receive, you can distribute tens of thousands. You can be doing this for 15 minutes, and all of a sudden, you are looking at 30, 40, 50 years in prison.
Good.
Cut.
Good.
I understand.
Absolutely
Senator, but what
good. I
we're
hope you
trying
are.
to do
Good.
Allow her to finish, please.
I hope you go to jail for 50 years if you're on the internet trolling for images of
Please.
children in sexual exploitation. So you don't think that's a bad thing? I think that's a horrible
That's not
thing.
what the witness said, and she should be allowed to answer this question once and for all.
Senator, all I'm trying to explain is that our sentencing system, the system that Congress has created, the system that the Sentencing Commission is the steward of, is a rational one. It's a system that is designed to help judges do justice in these terrible circumstances by eliminating unwarranted disparities, by ensuring that the most serious defendants get the longest periods of time. And when modes of commission of the crime change, such that in 2 seconds, someone can receive or distribute thousands of images, that's no longer and this is what the commission found in their studies, an indicator of a person who, relative to other people, has committed this crime in a more aggravated way.
Well,
And so what we're trying to do is be rational in our dealing with some of the most horrible kinds of behavior. This is what our justice system is about. It's about judges making determinations in meting out penalties to people who have done terrible things.
It is not rational to take the venue of choice of child pornographers, the computer that have 85 million images on it, and not consider that feeding the beast. We're trying to get people to stop this crap. So when you troll on the internet and you pull down thousands of images of children from the internet, I want you to stop that. I want people to go to jail who do that, because you're feeding the beast. We have a bill here, the Earn It Act, that would allow the victims who are on the internet over and over again to sue the media companies that provide these images. We have a fundamental differences of how you deter crime. I think the best way you deter crime when it comes to child pornography is you lower the bloom on anybody who goes on the internet and pulls out these images for their pleasure.
Senator, every person in all of these charts and documents, I sent to jail because I know how serious this crime is.
For 3 months,
Every
sure.
person I discussed
Technically correct is the best kind of
harm
correct.
of these terrible, terrible images to the victims who are portrayed in them. I talked about what this crime does to the children who are being abused in these photos, and on the other side of their terms of imprisonment, I ensured that they were facing lengthy periods of supervision and restrictions on their computer use so they could not do this sort of thing again. That's what Congress has required of judges, and that's what I did in every case.
You always were under the recommendation of the prosecutor, many times the parole people. And to be honest with you, Judge, a 32-year-old man who sent an image of his own 10-year-old daughter, you substantially reduced the not only the guidelines, but the recommendation. And all I can say is that your view of how to deter child pornography is not my view. I think you're doing it wrong, and every judge who does what you're doing is making it easier for the children to be exploited. If you're on a computer right now looking at a kid in a sexually compromising situation and you get caught, I hope nobody gives you a break because you used the computer.
The conduct that's been described is reprehensible, and I think everyone in this room agrees. And the fact of the matter is that I'm co-sponsor of your bill, the Earn It Act, and I believe that we should be doing our job here. But part of our job, we have failed in responding to the changing circumstances that face this crime. What has it been, 15 or 16 years? She is currently not an outlier in sentencing. 70% of the federal judges face the same dilemma and wonder why Congress has failed to act and when it will act.
This is our fault.
Partially it is, Senator. To be honest with you, it is. We have to upgrade these guidelines and decide whether we're going to stick with the Supreme Court decision that they're not mandatory. Senator Feinstein.
Thank you very much, Mr. Chairman.
That was a lot.
I would like to compliment the witness. You've been answering, I think, close to 15 hours worth of questions. And I know how difficult this is and hard it is. But I just want you to say in this senator, know that in this senator's eyes, you've handled it very, very well. So
Thank you, Senator.
And I'll move on to my questions. Congress has recognized how important it is for crime victims to participate in the legal process. And one example is the Crime Victims' Rights Act, which I authored with Senator John Kyle in 2004. That law provides certain rights for victims at critical stages of the legal process. The right to be notified, to be present, to be heard, among others. And I understand that in your 8 years as a district court judge, you would carefully consider victim impact statements when imposing criminal sentences. Could you tell us a little bit about this and how you considered crime victims in making your sentencing decisions as a judge?
Thank you, Senator. As you say, the law provides for victims to have an opportunity to address the judge, to address the court, to explain the harms that happen as a result of criminal behavior. And in the time that I was a trial judge, I found it to be a very important part of our criminal justice process because my sentencings were about handing down consequences for the behavior that defendants had engaged in and making sure that the defendants who received those consequences understood that they were getting those consequences because of the harm that they had caused. And so what I felt was important for promoting the purposes of punishment, which is what Congress has required of judges to do, is to ensure that the harms were made clear to the defendant in every case. So I had, for example, a case involving robbery. There were two, it was a single defendant who committed two robberies, one in April and one in September of the same small pharmacy in DuPont Circle, which is not far from here. It's a small independent pharmacy selling pharmaceuticals, and this person decided that he was going to rob the pharmacy of their oxycodone and other kinds of prescription drugs for sale. that's a sort of standard scenario that we see in the federal system. But what was so particularly egregious in this case is that this defendant was so bold in his robberies. He came in April with a gun. He held the employees hostage, essentially, forcing them to open the safe with the drugs in it at gunpoint, stole the drugs, not masked, not hiding his identity.
Not masked.
This is pre-COVID,
Wasn't respecting
so
the
we're not
COVID
talking
restrictions.
about having to have a mask. He was a robber, plain and simple, with no fear of people identifying him. And then in the period between April and September, he would come back to the pharmacy. He would loiter outside on the street. This is according to the victims. They would see him looking in the window. Once or twice he came inside looking like he was going to buy something and staring them down. And they knew who he was, and they called the police, and they weren't able to, apprehend him because he hadn't really done anything at that point. And the people who worked in the pharmacy were terrified, and they were terrified by that behavior, the menacing nature of it. By the time we get to September, he actually comes in, and they think maybe this is another time when he's just loitering, but no, he pulls out a gun. He hops over the counter. He assaults one of the people who are working there and steals the drugs again. And that time they were able to call the police in enough time for them to come and apprehend him. So at his trial, he did not try. He didn't go to trial.
You're the judge.
I'm the judge. He pled guilty to this behavior, which was well documented. There was no defense that it wasn't him. But the guidelines in the case and the statutes that applied said because he used the gun, he was supposed to get something like 7 years. And I used the victim statements to, first of all, explain to him how he had terrorized the people. Their statements said one woman said, "I can't work at the pharmacy anymore because I am
You
fearful
explained it to him, so you
that
chided
this guy
him.
will come back. It's
Is
changed
that
my whole life."
Is that the chiding?
It
Is
was
that
a
what?
whole
Is that the extent of it?
set of really horrible circumstances that I read to him at his sentencing so that he could understand what he'd actually done. And then I sentenced him above the requirement
Okay.
of the law because I thought it was warranted to make clear to him that this was a terrible, terrible thing that he had done to these people. So the victim statements were really important because they explained to me and to him the consequences of his behavior, but beyond just how many drugs he stole or the fact that he used a gun. They were the real life circumstances that resulted from his behavior, and it was important for him to understand that.
I've listened to most all of this testimony, which I think now you've gone on for over 15 hours. And I just want to say that I think you have a stamina and a very good brain and a real sense of empathy has been communicated to me in these 15 hours. And I want you to know that. One of the things that I'm concerned about is that the public perception of the Supreme Court has turned increasingly negative over the last few years. A recent Pew Research survey found that 44% of adults have an unfavorable view of the Supreme Court. Less than 3 years ago, that number was 30% of adults that held that view. And I understand that as a judge on the DC bench, you have frequently accepted invitations to speak at public events in the hopes of giving the public more information about the judicial process and more confidence in the outcome. So here's the question. Why do you think there's been a decline in the public's perception of the court? And if you are confirmed, how would you strive to improve the public's confidence in the court and its decisions?
Thank you, Senator. I think that public confidence in the court is very important. It is it's crucial to the rule of law that the public believe in the judicial process, and therefore choose to accept the rulings of the courts, not just the Supreme Court, but all of the courts. It's part of the way our process works. And I think that I have taken that to mean, in terms of my role as a judge, that outreach to the public to explain what it is that we do, to inspire, hopefully, law school students and high school students, young lawyers in law firms and elsewhere, to think about careers in the judicial branch or think about careers in law, as one of the ways that I have attempted to try to shore up public confidence. And if I'm confirmed, I would plan to continue as best as I can to do that kind of thing, because, as you say, it's very important for the public to understand the work of the court and to follow its pronouncements concerning the law.
Earlier, when you and I spoke in my office, we discussed some of the people who have mentored you throughout your career. And one of those was Judge Patty Saris. You served as a law clerk for her on the Massachusetts District Court, I believe, early in your career. And you've spoken publicly about the role she has played as a mentor in your legal career. You have described her as, quote, a consensus builder, a good listener, a careful speaker, the essence of judicial temperament, end quote. So would you share with all of the members here more about how Judge Saris's approach to judging and her mentorship have shaped you and your career? If you give some of the specifics,
yes,
I think everybody would be interested.
Thank you, Senator. As I reflect on her mentorship and also the mentorship of my other two judges, it's very interesting because I think I learned maybe different things from each of them. Judge Saris, who was my first clerkship, you're correct. She's serves on the District Court of Massachusetts, which is the trial level court. I learned how to look at the facts in a case from Judge Saris. That's part of what the trial court level does. We, as trial judges, develop the record in a case, take testimony, have trials, and she is extraordinary at developing a record and making sure that all of the relevant facts are adduced from the witnesses and considered in the context of her trial and record responsibilities. And so that I think is something that I learned from her in terms of the law, and her warmth and care for her law clerks meant that she has been a lifelong mentor to me. And ironically, she became the chair of the Sentencing Commission after I had been on the Sentencing Commission. So we worked together later in my career. So I often use that story to tell young people, you know, you never know what's going to happen. Someone who you worked for at some point might be your colleague down the line.
Well, let me just one more. You've handled a large number of cases during your career, both as an advocate and a judge. As an advocate, you've worked on a very wide variety of cases, from work for corporate clients during your time in private practice to your work for low-income clients during your service as a federal public defender. And during your 9 years as a federal judge, you've written nearly 600 opinions. I think that's really quite a sterling record. And I imagine that some of the cases have really stuck with you. And so I would like you, if you can, to talk a little bit about some of the cases, maybe one or two, that you've had that have made a deep impression and have really enabled you to progress as you have?
Thank you, Senator. Well, as you say, I have handled a lot of cases in my time, nearly decade on the bench, and you learn something in almost every case in some respect. If you're doing your job right and you're looking into all of the issues, I think there might be, I'd mention one from sort of a few years into my service as a trial judge. I handled a case, Yakai versus Napper. And the case involved trademark infringement. And you would ordinarily think that trademark infringement charges are dry and technical. And what I learned from this case is that even areas of the law that you might think apply only to businesses and impact real people at times. So this case involved a small community, a cultural community of people who believe in vegan lifestyles. They call themselves the African Hebrew Israelites, but it's not a religious community. It's a cultural community around healthy living. And they have created a restaurant and a series of restaurants here in the Washington, D.C. area with menus involving really, I'm told, terrific vegan foods. And in this community, there was a member who was the one who created the recipes and who was responsible for the restaurant. The whole community had other aspects to it. He ended up falling out with the community, and the dispute involved his actions essentially taking over the restaurant and reopening it by himself using the same name. The restaurant was called Everlasting Life, which was a important phrase for this community. And he essentially ejected the other members because he was the leaseholder, or he had signed the lease on behalf of the community. And he kicked them out for a day, and then he reopened the restaurant using the same name. And so the question was, under the Lanham Act, which is the statute for trademark violations, the question is whether there is a potential for confusion in that sort of circumstance. But ordinarily,
this is a weird way
I
to
see Senator
characterize
Coons
the
nodding.
Black
Ordinarily,
as
when you have
Israelites.
a
I'm just
trademark
saying.
infringement, you're talking about two different businesses who have very similar products. And the question is, are they similar enough to cause confusion? Because the idea of the law is that people should be able to have products that are identified with them, and you shouldn't be confused.
She remembers this case in extreme
And
detail,
in this
but
case,
not the.
we had a bench trial about it, but
Yeah.
it was pretty clear. I was the fact finder as the judge. It was pretty clear that when you open the same business with the same name, using the same recipes and food, that you have created this kind of problem that is a trademark violation. But what was so interesting to me about the case, in addition to the fact that I got to be the fact finder,
Why are you so happy about this case?
was that we had witnesses.
Why are you so
come
happy
in
and smiley
who
about this case?
Testified.
I love
about
this case, man. This
their-
is the
the
greatest case of my career,
circumstances.
man.
This
Let me
was a
tell you about
very
this case,
small
man. I was so
community,
happy for these
and they
people,
all
man.
knew each other. And the
Black Hebrew Israelites, man. I was all about that
testimony
case. I
what
was
it
into
meant
that
to them
shit.
to have one of their members ejected
I don't know, man.
in
It's a
this
strange thing
way
to get
and
all
then have
excited
him
about, but
turn on
okay.
them was very, very moving in the courtroom. So even though we were talking about this kind of arcane area of the law, it was real circumstances that were happening.
Well, stop for a minute.
Is that sort of
because-
true in
Yeah,
trademark law?
I
Just
think you're a
generally, it's
very
real
important addition
circumstances
to the
happening. I
court.
mean, like, what?
And
Okay.
what I'm trying to fathom out from the hearing is, what kind of judge will she be? How will we
I mean,
look
from the
at
trademark
her
law
in
analysis, it sounds
5 or
pretty
6
easy.
years? And
All right,
so
two
what I really
businesses with
wanna
the same name.
ascertain is
serving the same
what kind
food
of
in the
a
same
judge
place. Sounds like a
you will
trademark
be.
problem.
What will be the
So
principles you
it sounds,
hold
I mean, the
dear,
analysis
and
sounds
how will you
right.
function in
I
this
just weird thing to
capacity?
be super
If
excited
you could
about. I mean,
just answer that one
yeah.
question. I've been waiting for it
Yes.
for about 15 hours, so I'd appreciate it. Thank you.
Well, I would hope to be the kind
Maybe
of
she missed her
judge that
calling
I
as a
have
trademark lawyer.
been, during
It's
this
not too
last
late.
decade.
It's not too late.
have been
Judge
the
Jackson,
kind of judge
you could be a trademark
who
lawyer. If that's where your
understands
passion is.
that it's
You
my
know, we could always use
responsibility
some more
to
trademark
rule
lawyers.
neutrally, to not have any agenda when I'm looking at a case. I've been the kind of judge who understands that facts matter, facts like the ones that I was just describing, and that it's important for a judge to take into account and be able to understand the arguments of all of the different parties and participants. And I've been the kind of judge who takes my responsibility to not be a policymaker, to try to understand and ascertain the will of Congress if it's a statute, or to adhere to my own, I've been saying stay in my lane, to not
My
exert my
lane is the
authority
trademark law.
beyond what the
That's my lane.
Constitution requires when I'm interpreting and applying the law. I think I've been the kind of judge who lives up to the oath in terms of being fair and impartial, ruling without fear or favor, and ruling consistent with Article 3.
Thank you. Thank you, Mr. Chairman.
Thank you, Senator Feinstein. Senator Cornyn?
Good afternoon, Judge. I understand I'm the last one, maybe before lunch, so if
Oh, good
your
news.
blood sugar is getting a little low, you can think about having a little break. But just because the chairman keeps bringing this topic up, let me just ask you one question. When you accuse somebody of a crime, are you calling them a criminal?
Yeah, a little bit.
Oh,
Yeah.
Senator, I haven't accused anybody of a crime.
That's not my question. When in common understanding and in plain English, if you accuse someone of a crime, are you accusing them of being a criminal?
It depends on the context. It depends on what else you say about them.
She knows what the
It
question
depends
is.
on the circumstances.
It depends on the circumstances.
Yes.
So you put this in the same category as defining what a biological woman is.
No, I'm
You're
just,
really not sure.
I didn't say I wasn't sure. I said it depends on the
So
circumstances.
you are sure.
No, I said it depends on the circumstances that you're positing as to whether or not you're calling someone a criminal.
I just don't think that's credible, Judge. Let me ask you another question. You talk about the public confidence in the courts, in our institutions, which I agree are very, very important, that the public has confidence in our judiciary. Would you agree with me that to the extent that people perceive that judges, unelected, lifetime tenured judges, are making policy pronouncements or political decisions, that it undermines public confidence?
I do.
Thank you. Yesterday, we talked a little bit about precedent. And I know Senator Feinstein, as she does in these hearings, talked about super precedent, and in particular, Roe versus Wade. And I want to talk a little bit about that. But first, let me just ask you, do you think there's any good reason for the Supreme Court not to overrule a previous decision when they've concluded that that decision was wrong?
Thank you, Senator. Again, it's hard for me to answer that question in the abstract. What I'll say is that the Supreme Court has laid out factors beyond just the precedent being wrong as a reason to overturn it.
Well, we talked a little bit about this yesterday. The Supreme Court revisited the issue of separate but equal, which was the law, the constitutional interpretation of the Supreme Court under Plessy versus Ferguson. And and overruled that precedent because
Yes.
it concluded it was wrong, right?
I haven't looked carefully at whether all of the different factors that the Supreme Court now uses to overturn were discussed in the opinion. But now the Supreme Court's precedent is to overturn on the basis of a number of different factors and not just whether or not it's wrong.
So are you suggesting that the Supreme Court could not or would not overrule a precedent that it determined was wrongly decided?
No, I'm suggesting that the Supreme Court's case law indicates that it looks at multiple factors.
No, I understand. You go through the stare decisis analysis,
Yes.
right?
Yes,
But if it's wrong, that's one of the factors that you consider, right?
yes, but it's not the only one.
So are you suggesting that there may be circumstances under which the court determines its previous decision is wrong, but it will not overrule it?
The fact that there are multiple factors indicates that the court looks at more than whether or not it's wrong.
Okay, so so you would say, if I'm interpreting you correctly, that if the court concludes its previous decision is wrong, it won't necessarily overrule that. It applies a multi-point analysis.
Yes, I think that's
Okay.
accurate.
Back when Roe versus Wade was decided in 1973, generally speaking, the court said that the states may not limit access to abortion pre-viability.
That wasn't
But
Roe, that was Casey, but
post-viability, there could be some restriction on the right to abortion. Is that generally
As a general matter, yes.
that's
Okay,
Casey,
thank you.
not
Okay.
Roe.
Well, and then I think it's since 1973, the question of viability has risen again, what that actually
Not
means.
really, because it wasn't
Because now,
viability wasn't the standard until Casey.
Viability was around 28 weeks.
It wouldn't
That
happen
is, the
until
fetus could live outside the
1992.
womb, but
I think
today,
it was.
because of the advances in medical science, the fetus can live outside the womb after about 23 weeks. Is that your understanding?
Senator, I haven't studied this, so I don't know a number of weeks in the way that you're
Okay.
saying.
Well, let's talk a little bit about viability. The line that was drawn for pre-viability and post-viability analysis by the courts. What does viability mean when it comes to an unborn child, in your understanding?
Senator, I hesitate to speculate. I know that it is a point in time that the court has identified in terms of when the standards that apply to regulation of the right.
Justice Brennan, at a later point in his career on the Supreme Court, admitted that the viability line was an arbitrary line. Do you agree with him?
Senator, I'm not able to comment on viability. There's a case pending in the Supreme Court right now concerning the issues.
I'm asking you about previous decisions, but I hear you. No one suggests that a 20-week-old fetus can live independently outside the mother's womb. Do they?
I don't know.
I mean, the child will need to be fed or sheltered and all the other essentials to sustain human life. So there's no suggestion that after 20 weeks that a child can live independently, correct?
Senator, I'm not a biologist. I haven't studied this. I don't know.
You don't know
What-
whether an unborn child could live outside the womb at 20 weeks gestation?
What I know is that the Supreme Court
No, she probably
has,
doesn't.
Tests and standards that it's
20
applied
weeks is, yeah, 20
when it
weeks is,
evaluates regulation.
I mean,
of
the best
right
answer is probably
of a
no,
woman to terminate
to
their
be honest.
pregnancy.
20 weeks?
They have a.
You could try harder,
the-
like maybe
the
25
court
would be
has
better for your
announced,
question.
That there is a right to terminate up to the point of viability, subject to the framework in Roe and Casey. And there's a pending case right now that
Right.
is addressing.
Or you could go
these
30
issues.
weeks and like just eliminate the problem, right? So him saying 20 weeks is confusing
The
the issue.
Constitution doesn't mention the word abortion, correct?
That's correct.
Just like it doesn't mention the word marriage, correct?
That is correct.
And so as you and I discussed, perhaps ad nauseum yesterday, when we were talking about substantive due process, this is one of those unenumerated rights that the court has created, court-made doctrine or law, and creating a constitutional right, even though it's not explicitly mentioned in the Constitution itself. Correct?
The court has interpreted the due process clause of the 14th Amendment to include.
Right. We talked about substantive due process yesterday. And that's what this is, right? The Supreme Court cases that deal with the right of abortion is a result of substantive due process analysis like you and I talked about yesterday.
Yes.
Okay. In the, you remember when you were confirmed for the Court of Appeals, in that process, we had a hearing and then we sent you questions for the record, what we call QFRs around here.
Yes.
And one of those, question number 10 was, does the Constitution protect rights that are not expressly enumerated in the Constitution?
The Ninth Amendment says so,
As
yes.
part of your answer, you said, you mentioned Roe versus Wade and Planned Parenthood versus Casey. And you've said this, and I'll quote, they articulate a limited right to terminate a pregnancy. What is the limitation that you understand that was
And not
pronounced
interested. The
in
salary
Roe
for the
versus
U.S.
Wade and
Supreme Court
Casey
isn't
when it
that great.
comes to
It's, I'm
a
trying to
right
remember.
to terminate an abortion? What are the
I
limitations?
think it's like
under current law?
230,000 a year. But
Under current law, as I
you
understand
know,
it,
with her credentials, she could make
there
far more
are,
than that in private practice. So you don't take the Supreme Court gig for the
limitations
pay.
in so far as
I'd take the Supreme Court
there
gig for the pay,
can
but that's
be
me.
regulation
Yeah,
of
for some,
that
for it's a
right
pay cut for everyone who takes the position.
pre-viability, unless the regulation imposes an undue burden on the exercise of the right. And there can be regulation after viability, as long as there's exception for the health and I think maybe life of the mother. So it's the limitations are about whether and to what extent the government can regulate.
Just by way of
The right.
illustration, Judge Judy makes like
Is
$8
it your
million a
understanding
year.
under the
So
current precedent of the Supreme
$8 million
Court
a year
that,
versus 230,000. I'm just saying.
there is a right to abortion up to and including the time of delivery of the child?
Senator, I don't know, actually. I mean, the Supreme Court in every case is looking at individual regulations of the government related to individual rights. And I am not aware of the court having made a pronouncement about whether or not regulation can extend all the way up until.
Can we nominate
birth. I'm
Judge
just
Judy to the
not
Supreme Court? I mean,
aware
you
of
could
that.
do worse, right? Judge Judy before she served her
And
current
it's because the
25
court
years
is
plus now. I think it might
looking at
actually be
individual
30 years at this
cases
point.
and
Before she
making its
became Judge
rulings in the
Judy, as you know her
context of
lover, for
individual
25 years
cases and
before
not
that,
making
she was Judge Judith Scheinlin
sort
So-
of pronouncements
of the
in
family
general.
courts
So
of New
you are
York. So, I
suggesting
mean, you
that
could do
in
worse than
some
Judge Judy.
individual case.
She served 25 years as a family
the
court
right
judge.
to
You know,
abortion
she's
could
got some
extend
credentials.
through the entire pregnancy up until the time the child is delivered.
No, Senator, I'm suggesting that I'm not aware of any case that's handled the issue.
You told us that you think that you believe Roe versus Wade and Casey are precedents, and we talked a little bit about some of the questions about whether it's a super precedent and the like. Are you familiar with the Supreme Court's decision in the Heller case?
I am.
And that was a decision by the United States Supreme Court that recognized the individual right to keep and bear arms under the Second Amendment, correct?
Yes,
Is that a precedent of the court?
it is.
And you would respect that precedent?
Yes, Senator. All precedents of the Supreme Court have to be respected.
Is it equivalent in terms of its precedence to Roe versus Wade, or would you evaluate it differently?
I'm not aware of any ranking or grading of precedents. All precedents of the Supreme Court are entitled to respect on an equal basis.
I agree with you. That's why it kind of blows my mind when people talk about super precedents, as if somehow one precedent was different in terms of its significance or priority and under the Constitution than others. In the short period of time I have remaining, let me just revisit with you some of the questions we talked about yesterday with regard to free exercise of religion. And of course, that's recognized explicitly under the United States Constitution, the First Amendment, correct?
Yes.
Okay. Are you familiar with the cases that have been litigated before the Supreme Court of the United States involving the Little Sisters of the Poor with regard to the Affordable Care Act mandate on contraception coverage?
Yes.
Now, the Little Sisters of the Poor are a benevolent group of nuns. I think there are about 300 of them that take care of elderly and infirm individuals. And of course, as a matter of their religious beliefs, as documented in the court's opinions, they don't believe in either contraception or abortion. Do you agree with that?
I believe that was described in the case that you're talking about.
I think that's right, too.
Yes.
Yeah. And so when the Affordable Care Act mandated that every health insurance policy contain coverage for contraception or chemically induced abortions, they objected and said that this violated their conscience and their free exercise of religion rights under the First Amendment, right?
I believe so, yes.
Well, after the Obama administration, during the Trump administration expanded the regulations to allow not only churches, but also religious organizations like the Little Sisters of the Poor a waiver from that contraception and abortion-inducing drug mandate. Do you recall that?
Yes.
Are you familiar with the fact that President Biden has said he would restore the previous regulation and that was promulgated under the Obama administration and exclude
So if they go to break or
organizations like the
something,
Little
I'll try to
Sisters
come
of the
back
Poor
before they go to
from that
break.
waiver
But I can't promise.
potential
I'll be right back.
for abortion drugs or contraception coverage?
I am not aware of that, Senator.
Well, I guess what all this boils down to, Congress passed a bill called the Religious Freedom Restoration Act, which tried to make sure that people's sincerely held religious beliefs could be accommodated under their First Amendment rights, as opposed to Congress mandating things that would violate their conscience and violate their religious beliefs. Do you agree with me that it's important to accommodate the sincerely held religious beliefs of all Americans when it comes to legislation that the Congress may pass?
Thank you, Senator. Religious freedom is a core foundational constitutional right. It's in the First Amendment of the Constitution and reflects the founding fathers' understanding of this country as being one that is based on in large part, the idea of pluralism, the idea that people can come and have sincerely held religious beliefs and practice them without persecution. That's part of the foundational foundation of our government and the amendment that you're discussing. And as a result, that right is protected in many ways. You mentioned the Religious Freedom Restoration Act.
Right.
Congress has enacted a statute that, when it comes to federal regulation, if there's a substantial burden placed on religion, then the strict scrutiny standard applies.
I agree. I have 1 minute, so I have one more
Yes.
question. I agree with what you just said.
Yes.
So since I have asked this question or made this point of some of your predecessors who sat in the same chair and expressed my concern about some of the court's establishment law, establishment jurisprudence, I don't want to leave you out of that concern. When I was Attorney General of Texas, I had a chance to argue a case in front of the United States Supreme Court and called Santa Fe Independent School District versus Doe. This was a lawsuit brought by the ACLU, which sought to enjoin or prevent a student-led prayer before football games at the Santa Fe Independent School District right outside of Houston. In the end, 5 judges said that that violated the Establishment Clause of the Constitution, causing Chief Justice Rehnquist to write in his dissent that the Constitution mandates neutrality toward religion, not hostility, but that the court's decision evidenced hostility towards religious expression, leaving me to conclude that the public square, we can talk about everything from violence to misogyny to sex, you name it, but we can't talk about sincerely held religious beliefs. I would just footnote that for you and plant the seed for what it's worth. Thank you very much.
Thank you.
Thank you, Senator Cornyn. Welcome to Majority Leader Schumer. Glad you're with us. And he would report, if he could, that we have a challenge to finish our hearing today at a time when we can go to the floor for a series of votes, which will end the day. So we want to stick to the schedule as much as we possibly can. I will just say that Senator Cornyn's suggestion of lunch was aspirational.
Okay.
It was an unenumerated right.
You're in charge of the agenda, Mr. Chairman.
What we had hoped to do was to take 3 more senators before we have an actual lunch.
Oh.
But it's up to you. Is that all right?
Oh, whatever you want to do. I'm open in here, happy to answer whoever would like to ask me a question.
Thank you. I appreciate that. Senator Whitehouse.
Thank you, Chairman. Judge Jackson, you can relax for a bit.
You can relax because I don't have any serious questions.
When you appeared as a potential nominee, we started doing work looking at your record and your story. We met with the president to discuss his process and his goals. When your nomination was announced, we obviously brought the work on your record more into focus. And now I've had the chance over 15, 16 hours to see your performance in this hearing, which I think sets the gold standard for patience and courtesy.
Really?
So
Really?
I'm
everyone's forgotten
prepared to
Kavanaugh,
not
I
only
guess.
support you, but to let you know that I will be very proud and very honored and very excited to support you. There are 2 things that have come up during the course of the hearing, Mr. Chairman, that I'd like to take my time to have a chance to respond to. And the first has been a question, I've been through a bunch of these now. I don't think I've ever heard it come up so much. Questions about the nominee's judicial philosophy.
Really? That's pretty
I didn't know you
standard.
needed to have one.
What?
I actually thought that when you're dealing with the Constitution,
What?
your oath of office, the constitutional precedents and the Constitution itself kind of gave you your guide path.
What?
And when you're construing statutes, the law and the conventions of the language and your logic gave you that path. So the fact that Judge Jackson has said, I don't have a judicial philosophy, I've got a judicial methodology, doesn't bother me a bit. In fact, it kind of bothers me, the expectation that a nominee to the Supreme Court should have a judicial philosophy. Because a judicial philosophy can be a screen for a predisposition.
What?
That judges, frankly, should not have, but that folks and powers and interests influential in the process may very well want them to have.
What is he talking about?
So, you know, when I think about judicial philosophy, one of them that's come up a lot has been originalism. And one of the problems with the judicial philosophy is occasional adherence, selective adherence, which in my mind makes it less of a judicial philosophy and more of a doctrine of convenience to be trotted out when it helps the people that you want to help. And originalism strikes me as being that kind of a doctrine. And the place where I think we have the biggest gap between philosophy and practice in all of this has been with respect to what I've witnessed with respect to corporate power in our democracy in the time that I have been in the Senate.
Okay, sell
If you
me.
go back to the founding days, there was no expectation that corporations would have any role in American democracy. Nil. Doesn't turn up in the constitutional debates. Doesn't turn up in the arguments leading up to the approval of the Constitution. It's only when corporations became big and powerful many decades later that they began to intrude in our politics.
The East
and they
India Company would
corrupted
like to
our
have a word
politics
right
in a
about now.
terrible way, history shows. And that led to the movement by muckrakers, whose probably best leader was Teddy Roosevelt, to knock down the grasping political power of corporations and rein them in. And we had some real victories at that time, but ambitions of those of great wealth and power do not go away, and they have continually crept forward. It's an age-old story. And right now, we have corporate power controlling this Congress in a way that is really remarkable. We have a complete inability to address the climate havoc that fossil fuel emissions are creating.
Havoc.
Because half of Congress has been disarmed and disabled by political influence of the fossil fuel industry. We can't even have a reasonable,
As opposed to
sensible
the political
discussion on it,
influence on you? I
because
mean,
the power of that industry is so great.
you have political influence
And
on
we've
you,
seen that
but you're,
manifested first
I
with
mean,
Republican justices on the
you're
Supreme
subject to
Court
influence.
letting corporations into politics.
How's their influence different than your influence?
That was an interesting invention. And then once they were in, they let them spend money in politics. And then once they let them spend money in politics, they let them spend unlimited money in politics.
Right.
And now we are looking at a court whose majority is in the process of building a right for corporations, the biggest and most powerful corporations that we have, to not only get into politics, spend money in politics, and spend unlimited money in politics, but to spend unlimited money in politics anonymously, to hide from the real vote,
Anonymous
the we the
speech
people, who
has
they
been
actually
protected
are
since,
when they're
forever.
intervening in our politics, and to play this game through phony front groups with ridiculous names. Rhode Island is for peace and puppies and prosperity, sort of the quality of the name that's involved. So let's not get too excited about judicial philosophy if it's nothing more than a screen for a predisposition that will benefit certain players in the arena. And let's certainly not take judicial philosophy too seriously when it evaporates.
You do realize that
face
originalists rule
of
against
the
corporations too, right? I could find you decisions from
that have pushed the
Scalia ruling
philosophy.
against corporations.
And I think
It's
originalism
or
qualifies
Thomas.
that way.
Take
I
your
just wanted
pick.
to
It's
say
not like
that. I
Scalia and
don't
Thomas
think
ruled for corporations
you
every
have to
single
have
time.
a judicial
They're
philosophy.
corporatists.
I think you have to have integrity. I think you have to have a judicial temperament. But a philosophy?
Yeah, philosophy
Where
is
does that
good.
come from? The second thing I want to say has to do with
Where's what? I know it says resume playback, but I'm pausing. What? Where does it come from? Thinking through issues so you can come up with an a priori philosophy. It's something that is completely independent. Yeah, like you have to have axiomatic beliefs, kind of almost definitionally. I don't know how you could have a system without axiomatic beliefs. So you have to have beliefs that are kind of at level zero, that don't have to be buttressed by anything. And the way you get those beliefs is by thinking through the issues and trying to apply them evenly. And I guess Senator Whitehouse is implying that he doesn't have a philosophy either. But he does, of course, whether he knows it or not. He has certain a priori beliefs. That's how he judges, for example, whether legislation is good or not. Right? He how does he decide if a bill is good or not? He has a priori beliefs that exist before the bill, and he bases his conclusions based on those a priori beliefs, presumably. And okay.
is that the picking of the justices has been handed to special interests. And we know that's the case because, as I showed yesterday, everybody involved admitted it. The President of the United States said so. The co-founder of the Federalist Society said so. A former chairman of this committee said so. And the President's legal counsel said so. And what happened in that process by which the justices were picked over at the Federalist Society? We don't know. There wasn't a poll that was taken of Federalist Society members saying, give us your recommendations. I don't know that there was any meeting of the board. Let's take this up. Let's go through a proper agenda. What appears to have happened is that people went into a back room.
Yeah, probably.
And there was wheeling and dealing. And millions of dark money dollars flowed into the Federalist Society during this period.
I don't believe that for a second.
And what came out were names.
I don't really believe that.
And those went straight to the president and straight to here. But the picking appears to have been done in the confines of a private organization by anonymous special interests. There is no country in the world that does that by way of how you pick judges. If we went to some banana republic to try to educate them in democracy,
he does understand that
and
the
that was
Federal
the way
Society
they
has
pick
no
their
power to
judges,
pick
we'd have a
judges,
lot
right?
to say about it.
The
That is the
president
way
has the power to nominate,
that recent justices have,
and he can
been
look to
picked.
any group that
Court
he thinks
packing
might help him. And the
by
Federal
court
Society is a good group to
picking.
look to, in my opinion. It might not be the end all
And
be all. There's some
deputizing
other
this to
groups
the
that I can
Federalist
name that would
Society
be
is
good.
very unusual.
Cato
Them
Institute
having no
comes to
process,
mind.
no public process.
A little bit more
implementing that
libertarian minded
deputization
than my
is
taste,
very
to be
unusual.
honest. But
Provenance
I
of
think
these
they're a good
mysterious
organization to look
lists
to.
that were produced and how people got on and off
And
them.
you could look to these groups and be
That
like, well, who do you guys
is
think are
very
good? Because
unusual,
I know what your
unprecedented in our
philosophies
history.
are, and
And it's surrounded by
you'll
lots
be
and lots
more
of dark
familiar.
money.
And so you can
$400
give me some
million,
names so that I can
think,
vet
is
from
a
there.
lot
Seems
of
like a
anonymous
reasonable
money
approach
that has
to the
been
thing.
chronicled being spent to control.
Hey guys who
gets
have
put
a
on
philosophy
court.
that makes sense to me. Can you pick some
And
guys
controlling
that
who
would be
gets
emblematic
put
of your philosophy
on a
and save me a little bit of
governmental body is how
time?
you
Give
capture
me some names
a governmental
so I
body,
can
and a
take a
captured
closer look at
governmental
them.
body is
Maybe
a
pick one of
wrong
them.
thing. Whether it's a
Is this
railroad
bad?
commission
I don't know.
or the United States Supreme Court, there is in that method of judicial selection not just the prospect of impropriety, but indeed the likelihood of impropriety.
How?
If it's pay to play and checks for millions anonymously delivered will get you into the room to decide who is going to be on the Supreme Court, we got a problem. And that's what
The
happened.
Federalist Society, again, has absolutely no power.
And the thing that makes it even worse, in my view, is that as
The
you
president
pursue
nominates
this
and
play
the
it out,
Senate
you see
confirms.
the decisions of the court line
If
up
the president wants to
in
listen
an
to the Federalist
astonishingly
Society
clear pattern with the interests
versus any other group, I mean, you know.
of big Republican dark money donors.
And
that is my concern.
I think that it's pretty typical
That,
for
I think, is a legitimate
Democratic
concern. If you
administrations to
disagree
point
with
out
me,
when
disagree with
various
me. But that is the
organizations
concern. And I
support
wanted
their
to lay it
nominee,
out here,
right?
because it's not about
They'll say,
court
like,
hacking. It's about
these
the integrity of
organizations
the
support this.
court.
I mean, that's what we've been
and it's
hearing about,
about
right? These organizations support this
The
person.
unfortunate
So
comparison that
is
can be made
is
now
Biden wrong? Because
between the
he
captured
and
agencies
are you guys implicitly wrong?
delivered
Because
through
you guys, a lot of you
picking
guys, for
of their
example, have been taking
membership
note that she's supported by
and what looks
the
more and more
International
like a
Federation of Police
captured
or whatever,
court
which is a
delivered
private
by the
organization,
picking of
an
its
international
membership
one at that,
in secret
mind you,
with a very,
international
very
private
high
organization
ticket
who supports her,
price
and you've been
to
noting
be
that
in
as
the
a good
room where the
thing.
picking took
How's that
place.
different?
So,
I mean,
like I said,
you want to talk about
colleagues
dark?
can
I mean,
agree,
that's
colleagues can
international dark.
disagree with. We all have our shots to
Who's
make our
apparently having a
cases.
hand in
Because
choosing our
this has
nominee.
Come up tangentially in multiple different ways.
Is that bad?
I wanted to take this moment and lay
Is
out
it wrong
what
for
my
Biden
case
to
is
do
and
that?
explain it as clearly and simply as I can. And I thank the chairman for allowing me that opportunity. And I yield back my remaining 7 minutes. And I
Okay,
congratulate
I'm
Your Honor,
confused.
you for the patience that you've shown with all of us. It's not over, but it's close.
Thank you, Senator.
Thank you, Senator Whitehouse. And of course, you've joined the Hall of Fame, yielding back 7 minutes. Senator Lee?
That was
Thank you,
weird
Mr.
attack
Chairman.
for me.
Thank you, Judge.
It wasn't even really an attack. It was just,
Talk
I mean,
next
it was weird
A
speeches.
little bit about a case that you were involved in, a case called Coal River Mountain Watch versus United States Department of the Interior. It was decided a ruling that you issued in 2015 while in the federal district court. I know you've handled a lot of cases.
I have.
I can't imagine that by merely triggering the case name that would necessarily bring it back. But this case involved a challenge to an administrative action within the Department of Interior on some issues bearing on coal mining within the state of West Virginia. There were 2 parallel challenges brought against that administrative action. One in a federal district court in West Virginia, where the land in question was located, and another in the U.S. District Court for the District of Columbia, where you sat. The government defending itself against that action brought by some environmental groups asked that you dismiss the DC case so that the matter could be litigated in West Virginia. You denied that. Can you, based on my description of the facts, does that ring any bells? And can you tell me why you might have denied it?
Thank you, Senator. It actually doesn't. It sounds like, dozens of cases that I handled with similar issues and requests. Something like a motion to dismiss is early in the
Sure.
action.
Sure.
And so denying a motion to dismiss is pretty routine.
No,
District of Columbia.
I understand, and I'm sure you handled a lot of those all the time as a district judge. The reason I raise it is just because it relates indirectly to some concerns that I've got that are somewhat unique to the Western United States. We have a lot of cases that involve the U.S. Department of the Interior and agency actions taken relative to the public land that we have. In every state east of Colorado, the federal government owns less than 15% of the land. In most of those, it's much less than 15%, in the single digits or low single digits. In every state, Colorado and west of Colorado, the federal government owns more than 15% of the land, and most of the time, it's a lot more. In my state, it happens to be about 2/3 of the land that's owned by the federal government. As a result, it complicates our ability to do just about everything we do, whether it's recreation, construction, oil and gas development, whether it's just accessing people's farms and ranches, or even something as
I don't know why you're
simple
bringing
as,
this up to
trying
the
to fund
attention of
local
her. This is a
fire,
problem for
police,
Congress.
search and rescue
It's
operations.
national
All
land. You
these
guys
things
can divest
are
it
affected
anytime you want.
by the excessive
You guys
ownership
can't get the
of
votes. I
federal
don't know what to
land
tell you
by the
why you're
federal
making this her
government
problem.
and the way it's often managed. Sometimes decisions made at the federal level are challenged in parallel actions like these. One in the forum state, in the host state to where the action is happening, another in DC. And I'm always concerned about forum shopping. And I'm sure that's something you watched out for as a judge and saw forum shopping from time to time. It's also something that, touches on an issue that involves statutory interpretation. There's something called the Antiquities Act, passed 110 years ago or so, designed to give presidents of the United States the authority to designate parcels of federal land as national monuments.
Right.
The text of the statute states that the limits of the parcels in question should be, quote, confined to the smallest area compatible with the proper care and management of the objects to be protected. Now, given that these presidential proclamations tend to be broad, it's sometimes the objects to be protected are also broad. And as a result of that, it's difficult to tell what the limits are. Do you have any reaction as to how?
Sounds like you wrote a shit law 110 years ago to me.
Define any meaning out of that?
I don't know why you're
It's got
making
to
this her
mean
problem.
something. The text of the statute.
Sounds to me like you wrote a shit law
try
110
not
years
to
ago.
leave language,
And if
simply
you're upset about your
unaddressed
state
or
not having
meaningless
land, sounds to
in a
me like
statute.
you're
Do you have any
upset that
thoughts on
Congress
how
not being
a
able to give
statute
you
like
your
that,
land
saying
back.
that it should be confined to the
Sounds to
smallest
me
area
like,
compatible with the proper
Congress
care and
made some shit
management of the
decisions. That
objects to
sounds
be
suspiciously like a Congress
Any
problem,
thoughts
though.
briefly on that?
Well, Senator, if I were presented with a case with that statute in that circumstance, I would proceed as I always have. You would have to understand the parties' arguments about the particulars in the case. What does the presidential proclamation say? To what does it relate? Whether there are any precedents in this area that further define or further address what Congress intended with respect to the statute at issue.
And I would assume that it would also matter if the government's lawyers defending the president's action made an argument that would leave the interpretation open-ended and meaningless.
Well, as part of your interpretive exercise, as you're considering the parties' various arguments, one that did not account for all the words in a statute would be one that you would
Excellent.
might
Excellent.
not
It-
might not agree with.
No, I get it. And this is one of the things that I've appreciated about what you've told us in these hearings. I really like the way you've described the fact it's important to construe the text that you're asked to interpret. And in interpreting that, you look at the language and you're endeavoring to figure out the original public meaning. And I think that is a very helpful thing. All right, let's move to a different issue a moment ago. Now, you clerked on the U.S. Supreme Court for Justice Breyer in October term 1999. Is that right?
That is right.
That was the same, and you clerked for Justice Breyer.
I did.
And that was the same year that the Supreme Court issued its decision in a case called Stenberg versus Carhart. This is the case where the Supreme Court of the United States struck down a Nebraska law prohibiting partial birth abortion. And in the absence of circumstances where the baby posed a threat to the life of the mother. Now, to be clear, the law prohibited a procedure where the abortionist causes an unborn baby to be partially delivered by the mother. And then the abortionist intentionally kills the baby outside the womb by puncturing its skull with scissors and then collapsing the skull. This is gruesome, and I don't like having to quote this, but it is relevant to the topic we're covering here. Justice Kennedy described it this way in chilling terms when in his dissent, when he describes the fact that when scissors are inserted into the back of the head, the fetus's body, wholly outside the woman's body and alive, reacts as though startled and then goes limp. Justice Scalia, in his great eloquence, expressed
lamented the ruling, but also expressed optimism for the fact that future courts would get it right, saying, quote, "I'm optimistic enough to believe that one day Stenberg versus Carhart will be assigned to its rightful place in the history of this court's jurisprudence beside Korematsu and Dred Scott. This method of killing a human child, one cannot even accurately say an entirely unborn human child, prescribed by this statute is so horrible that the most clinical description of it evokes a shudder of revulsion." We then saw a few years later the Supreme Court of the United States issue a different ruling. The Supreme Court issued a different ruling in a case called Gonzalez v. Carhart. Gonzalez v. Carhart upheld a different statute. This one was federal rather than state, but it was a different federal statute that also prohibited partial birth abortion. Judge Jackson, can you distinguish these cases for me? What was the difference between Gonzalez v. Carhart, where the partial birth abortion ban in question was upheld, whereas in Stenberg v. Carhart, it was invalidated?
Thank you, Senator. I don't have the opinions in front of me. I think it had to do with the method of extraction, the fact finding related to the procedure. In one case, the district court had made some findings and the court felt bound by them. And another, there was considerations beyond those that were previously relied upon. So there were distinctions that the court looked at and considered in the cases, but yes.
Let's talk about court packing for a minute.
Yes.
One of the reasons court packing concerns me, one of the many reasons, is because it's not prohibited in the first instance. It's not prohibited by the Constitution. There's nothing in the Constitution that says that Congress may not change the size of the Supreme Court. There's no limitation on that. We have, for 152 years, stuck with the number 9. It has worked, and in the absence of an argument saying that that number is too
Rackets is stream
low,
sniping me.
the court is too small. From
Hello,
a
Rackets. How are you
standpoint,
doing?
we need to expand it.
You know, you could just
It's difficult
join.
to imagine
You have the link.
why it would be
Just
a good
saying.
idea to change it, particularly because if you increase the size of the court in
Just
one
saying,
fell
you
swoop,
could join the
swoop,
stream.
and you do that for partisan political purposes, allowing one president, the current president, to have a disproportionately impact on the court and to change its rulings. That portion of the court's docket that tends to be more politically contentious, it can turn the court into a political football of sorts. Given the fact that our Supreme Court justices serve for life, once you do that, it becomes something of a one-way ratchet, always expanding, never contracting. Before long, you could see an increasingly larger court, with the court expanding each time a different party secures the coveted circumstance of a majority in the House, majority in the Senate, and controlled by the same party of the White House. And so this is why it concerns me. I understand.
So Nick says he's not joining me because he
why
doesn't
it
have the
is
time.
that, the canons of judicial ethics don't
Noted.
allow you to comment on matters that might come before you. This is one that could not come before you as a justice. This is a non-justiciable political question. It's committed to the two political branches of government. There's not even a constitutional challenge that could lie to it, even though it would undermine the separation of powers in the Constitution, as I see it. It's not unconstitutional. So it couldn't and it would never come before you. Last night when you were asked a question by my colleague, Senator Kennedy, on this, you acknowledged that you have.
Rackets is now
I understand that,
streaming
right?
this
You have an
himself
opinion
separately on
court
his own
packing.
channel.
Senator, I have a
I
lot
cannot
of
believe
opinions.
this.
I have opinions
Hold
on.
on.
I'm
No,
a human
this
being.
is not. This will not
and I have
stand.
an
Hold
opinion
on.
a lot of
No, no, we are not doing this. There's only one thing for it, guys. There's only one thing for it. You know what's happening next, right? You know what's happening next, right? Yeah.
This maxed out. I thought it was loud enough, but I'll turn it up a little more. She is so fucking mad immediately. immediately.
That stems back decades and that is concerning.
Okay, hold on. We're gonna crank up a little bit more. Alta Man is not on Odyssey today.
Fix
I am
the
on
audio
Odyssey
issues,
today.
Nick.
On Odyssey right now.
Why can't you
The
fix the
Odyssey
audio? Make
chat
it louder,
is-
Nick.
Is talking. They're live.
Nick, fix
Hey, what's
the
up,
audio
Odyssey
issues.
chat? How you guys doing?
Damn it.
Let me just crank this up. I'm going to crank it all the way up to 600, and then if I have to turn it down on the back end,
Nick!
I will. Prepare for ear rape.
You wrote your note
Not
on the
so
Harvard
bad.
Law Review on sex crimes.
Ketanji Brown
Your
Jackson would give
note
us a
is your
minor
major
sentence for that.
academic
Why are you
work on
watching
the
it
law
live,
review,
Nick?
And yours is
We already saw
entitled
this part.
Prevention versus Punishment towards a principled distinction in the restraint of released sex offenders.
Okay, so real quick, she writes a law review article about going soft on sex offenders.
For not joining
She's
my
going to
stream
spend the rest
and
of this time
streaming
talking
some old
about how
stuff,
she
man.
doesn't go
What
soft
a-
on sex offenders. But her law review article was on it. All of her sentences are light on sex offenders. This is
good times. Back to Michael Lee.
Commerce Clause, the one we discussed yesterday, prior to 1937, you had the Supreme Court agreeing as far as the channels and instrumentalities of interstate commerce that we talked about yesterday. You had the court more or less in agreement over time as to the impact of the Dormant Commerce Clause. But as to the substantial effects test, that didn't exist yet. It required something much closer to an interstate commercial transaction in order for Congress's Commerce Clause authority to kick in.
Man, my name is Nick Rackets. Man,
There
join
were
me on
the
the
so-called
Rackets
four
review.
horsemen of the apocalypse, as FDR affectionately called them. Four conservatives who were consistently pushing for limits on Congress's authority. And then you had other justices who would sometimes join with them. Usually that included Justice Owen Roberts, who had stood
My
with
name
them
is Nick
in
Rackets.
maintaining
I have Drexel on
narrower
tonight.
authority for Congress under the Commerce Clause. All that changed when on April
The worst
12th,
impression of Nick
1937,
ever.
2 weeks to
Ever.
the day when the case often associated with the so-called switching.
I need to
time
work on my
for
Nick. I need to
Change
work on my
9,
Nick Ricada impression
West
a
Coast
lot.
Hotel versus Parrish, where they undid the Lochner precedent. April 12, 1937, the Supreme Court decided a case, NLRB versus Jones and Laughlin Steel, that forever changed and magnified, expanded the Commerce Clause in a way that, had it been through a constitutional amendment, it would be among the most significant, impactful constitutional amendments ever adopted, and yet it's rarely discussed. This case resulted from one vote, one person on the Supreme Court who changed his vote, Associate Justice Owen Roberts. It's widely believed, and I believe it based on what I've researched on it, he was influenced heavily by FDR's
We're
court
in
packing
fake
plan.
news.
He didn't want to be on a court that was packed. He didn't want, he convinced
I'm Nick
himself that he
Rackets. Look at my
made that
nose.
switch in order to save the court as it was. And that has changed everything. It's led to a much bigger, more expensive, more intrusive.
Remember,
intrusive
friends.
federal
We
government.
only
can
roast the
disagree
ones we love.
as
That's
to
the theory we're going
policy
with.
merits of that, but it
Like
did
the
change
Friars Club.
Constitution. That's why I worry about that. So I hope, I understand you don't want to answer it. I hope that between now and the end of the day, you'll see fit to tell us what your opinion is. I do think it's worth discussing. Let's talk for a minute. Got just moments left. I want to get back to your sentencing approach. Now, when you approach these child pornography cases, what you're describing in many circumstances is an overall concern that you've got with the sentencing guidelines, and particularly that portion of the sentencing guidelines that deals with child pornography cases. This showed up in the.
I am also listening to Nick at the same time I'm listening to this, by the
some
way.
of your sentencing
In the back of my ear, he
hearings,
just
including
says he's not competing if anyone. And on a
the
practical
transcript of
level,
your
he's
sentencing
right
hearing in the-
because he's
the
got
Hawkins
literally
case.
10 times more
I
viewers
turned
than I
to
have.
that,
I got
page
328. He's got 3,373.
17 to 24 of that transcript.
So he's got 10 to 1 on
Here's
me,
something you
man.
say
He's
in that
definitely not
Hawkins
competing with
case.
me. He's kicking my
I believe
ass.
this was the 18-year-old defendant that you sentenced to
Kicking
3
my
months in
ass.
prison when the lower end of the guidelines.
But for the
would have
330 of
been
you who are
97.
here,
I think
you're
higher
the
end would
real
have been in the
people because
120s
you know
or
where to
something
actually
like
find
that.
some good law
You said, and
content.
in your case, this is you speaking to Mr. Hawkins, In your case in particular, I don't feel that it is appropriate necessarily to increase the penalty on the basis of your use of a computer or the number of images or prepubescent victims.
Thank
as
you.
the guidelines require, because
Thank
these
you.
circumstances exist in
Appreciate
many
it.
cases, if not most, and don't signal an especially heinous or egregious child pornography offense. I've got a couple of questions about that. Were those, you start out that paragraph sounding like you're making a determination as to him, but then the observations you make in that paragraph seem to apply broadly. Is that right? So that would.
Senator, I don't have the transcript of Mr. Hawkins' case. I recall that I found that case, like all child pornography cases, to be
I'm now going to
difficult,
shitpost
really
in Nick
difficult.
Ricci's channel because that sounds
And
like
his
fun.
case,
I'm going to
I
shitpost his stream
recall,
while listening to this stream at the exact same
in
time
many ways
and doing
an
intelligent commentary.
outlier
I'm going to do three
in
things at once
terms
because that's
of
how I roll.
the various
I'm going to listen to this,
considerations
comment on it,
that
and shitpost his
Congress
chat all at the same
required
time.
me to take into account.
But there were prepubescent victims that were at stake in that.
I don't remember how many. I don't remember the circumstances of his actual crime. What I will say is that, consistent with Supreme Court case law and Congress's statute in this area, judges have to take into account a number of factors and the guidelines, which are no longer, I won't say not mandatory. You have to calculate the guidelines. They're no longer binding. And the Supreme Court has said that under the statutory scheme, judges have discretion.
But I'm almost out of time.
Yes.
Here. I want to make a point.
Yes.
Hawkins, as I recall, and as Senator Hawley discussed yesterday, he specifically asked for images.
Because
of
we're going
11 to
into this Hawkins
17-year-olds.
issue again.
So I don't understand how that can be an instance where that shouldn't matter, and where the fact that he did it with a computer.
So at least we're getting to something that matters again, right? So it's like talking about Hawkins. During the lunch break, whenever that's going to be, I'm going to call Senator Hawley's office and see if I can get a copy of whatever he's referring to. I assume the answer is no. I'm not going to be able to get it.
Over time,
but I'd love to have it.
Transmit and receive and store because of computers. I actually think it cuts in precisely the opposite direction that you described. It makes it more severe, not less. I see this as an aggravating factor, and that is of great concern to me. I see I've exceeded my time. Thank you.
You may respond.
Senator, as in every child pornography case that I sentenced, I considered all of the evidence, all of the relevant factors. It is
you
not
considered
the
all the
same
things, and what you concluded
exercise
was 3 months.
to look at a
This raises questions in our
transcript,
mind,
to
like why and
think
how.
about guidelines, to not have in front of you the individuals, the victims, the pictures, the circumstances that trial judges have to review in these cases or any cases. I understand, Senator, that there are some questions about records, et cetera. Courts have all of the evidence, and courts have all of the recommendations of various parties, and courts have, under Congress's authority, the responsibility of using our judgment to make determinations that
Correct. This is the problem. This is the problem.
are sufficient
Yes,
but
you
not
have
greater than
you have the
necessary
ability to make a judgment.
comply
We're
with the
wondering how
purposes
you
or
got to that
promote the
judgment. This
purposes
is
of
the issue.
punishment, taking into account things like unwarranted sentencing disparities. And it may seem like an easy exercise. It may seem, in retrospect, when you look back at a few pieces of data, that courts have not done what it is that they're supposed to do. But what I can assure you
3 months
is that I took every one of these cases seriously in my duty and responsibility as a judge. And I made my determinations in light of the seriousness of the offense, the nature and circumstances of the offense, the history and characteristics of the defendant, the need for the sentence imposed to promote various purposes of punishment, and all of the other
And
factors.
having
that
considered
Congress
these
prescribed.
factors,
Okay, but you
you
keep
came up with
resetting that
3 months as
standard,
the answer?
and yet you specifically excluded from consideration the fact that he had requested and obtained images, prepubescent child pornography images.
Senator, I didn't exclude it. I didn't exclude it. What I did was I looked at the guidelines, which is what the Supreme Court requires, and
You looked at the
I was
guidelines,
making
which said 8
policy
to 10 years.
determinations as the Supreme Court says that judges are to do.
Look at
in
page
these
38
situations.
of your transcript. It looks to
Where's
me
the
like you
transcript?
excluded it, and
I want this
you're
transcript.
actually
Where is it?
sentencing him to 3 months. for
Someone
one of the
find me
most
the transcript
heinous
for this,
offenses
please. I'm
imaginable.
begging
Keep
you.
in mind, because these are transmitted
Senator,
electronically.
I have to
they're
call
there
Mike
for
Lee's
years.
office
They
too. Where's this
re-victimize these
transcript? I want this
victims
transcript.
The rest of their lives.
We're asking everyone to try to stick with the 20 minutes, please.
I want
Next
the
is Senator
transcript.
Klobuchar, but before recognizing
Where's
her,
the
I'd like
transcript?
to
Someone get me
ask
the
consent
transcript.
To enter into the record a support
U.S.
letter
v.
for
Hawkins,
Judge
go.
Jackson from 48 former federal prosecutors in South
Someone
Florida.
call Mike Lee's
Without
office,
objection. Senator
and someone
Klobuchar.
call
Thank you very much,
Senator
Chairman Durbin. Welcome back,
Hawley's office,
Judge
and
Jackson.
ask them where this transcript is, so I
Yesterday,
can get a
you and I
copy.
discussed the court's increasing reliance on issuing
Just
unsigned
ask them.
orders on its
Hey,
shadow
you guys
docket.
seem to be
And
reading
less than
from
an
a
hour
transcript
ago,
of the
court
judge's
once
remarks
again
during the
used the shadow
sentencing.
docket,
Where is the transcript?
to
Can I get
throw
a
out
copy?
Wisconsin's redistricting maps. And because this decision just came out, I don't expect you to have immediately reviewed it. But
JMK, you are now
I
my
just wanna
secretary.
make this point
Congratulations.
That in
Did you
her
make some calls for me?
dissent, Justice Sotomayor, joined by Justice Kagan, called the court's move.
Holly has a thread of it on Twitter.
She
If it's on Twitter,
noted
that'd be
that
fine.
in an emergency posture, the court summarily overturned
I'll take Twitter
Wisconsin Supreme
as long as I
Court
can get
decision
access to the
resolving a
underlying materials. That'd be
conflict
great.
over the state's
I'd prefer not to do it like by
redistricting, a
isolated
decision
pages.
that was
I
rendered
let the
after
ability to
a
determine for myself what is and is not
process
important.
involving all interested stakeholders based on an obligation that is, these are her words, hazy at best, even though summary reversals are generally reserved for decisions in violation of settled law. And again, I don't expect you to be familiar with this case, but I do want to point out that this underscores the point that I made yesterday, that the court's increasing practice of using the shadow docket to decide cases that have grave consequences for our democracy, including the right to vote, that you and many other nominees have said is fundamental, is incredibly troubling. You had in the other case I mentioned yesterday where Justice Roberts dissented, the Texas abortion bounty hunter case, that should not have been done on the shadow docket. And while I'm not going to ask you about this because you couldn't possibly have read it, just your record of writing decisions that are thorough and listening to litigants in cases, could you just generally talk about the importance of
Shadow
having
docket. B-Man
full
asks, what is the
briefings
shadow
on the
docket?
merits,
Okay, so shadow
as well
docket
as
is
public
this
oral
nickname
argument,
for
if
something.
you
So
believe
the
in
Supreme Court gets a
transparency.
whole bunch of petitions for a whole
Thank
bunch
you,
of things.
Senator.
And
As
the shadow docket
as a
refers to
judge
decisions that are
in
made
my work over the
without
last
the full
decade,
briefing. They're
I've
almost
seen
always
that it is
relating to the
very
nature of
important,
injunctions.
at least
So
to
the Supreme
me,
Court gets a
in
whole bunch
my
of petitions
time as a
to
judge
issue
to
injunctions
date,
or to
to
quash
hear
injunctions.
arguments from
And
all
so the shadow
sides in a
docket
case.
is
The duty of a
this
judge in,
thing that
in
exists outside of the normal procedures
is to make
with the full briefing,
determinations
full
and,
argument, and full fat decisions,
under our
where they
system
render
of
decisions almost
adversarial,
always with respect to
proceedings, you make determinations
injunction issues.
Based
And
on
the idea, at
arguments.
least, is that the Supreme Court has been doing a lot more of
And
this, and that is bad.
and it's important
So
to
that's
do
the shadow
so.
docket.
I know that with respect to the emergency docket, you haven't asked me the question about it.
I'm not sure where we came up with the name
because
shadow
I
docket,
would
but
say
it
what I
seemed
said
to have
before,
stuck.
which is
So that is
I
a name that I
would
would recognize in the legal
benefit
community.
from being able to speak with
It's like eggshell
the
skull doctrine. I
justices.
don't know where we came up with
understand that
eggshell
there's a
skull.
need
It's a
to
thing.
balance,
I don't
getting
know
full
where it came from. It's just a
briefing
thing now.
emergency circumstances, and
Eh.
the court has long had
I'm not sure how we
its,
decided on it, but we did
in
apparently.
its procedures, the
Kind of like law
ability
too, for that
to
matter. I'm not quite sure
rule,
how we decided that
quickly
LawTube
on
was the
various
official name, but we
cases.
apparently
It's
did.
also
I don't remember taking a vote or
um,
anything, but apparently we've collectively
my
decided that is
understanding
the
from
official
my
name
time clerking on
somehow.
the court
So that's the
that
thing.
the court
Yeah.
does recognize the value of allowing things to what we call percolate, meaning lower courts to hear issues. And
All right, let's take a look
my
at this thing
understanding
from
is that at
Karen,
least
see if
in
this
some
has the answers to our
of the
questions.
recent cases, the justices have
Maybe it does.
have had oral
That'll be
arguments
awesome.
related to
If
some
so,
emergency
she wins a cookie.
matters. But from my perspective as a judge in the work that I've been doing, I know that it's important to hear from the parties.
Another hallmark of your work
Does
has
Karen
been
win a
taking
cookie?
complex issues and
Let's
making them
find out.
accessible to the public. So much so that I actually referred to one of your opinions from a debate stage in Los Angeles, saying, as a wise judge said, those were my words, I guess I was ahead of my time, the president is not king in America, the law is king. I paraphrased it. That was a written opinion that you wrote that was over 65 pages long, relied extensively on Supreme Court and circuit precedent. It was Committee on the Judiciary v. McGahn. And could you talk about really two things? The importance of having
Well, I
the
see
law
little images from a
written in
transcript on
terms
his
that
Twitter.
are easy to understand by people. And
Where are
then
these coming from? That's
secondly,
what I want to know.
your opinion was actually a narrow one. It required
No cookie
Ms.
for
McGahn
Karen.
to
Although
appear
she's
to
the closest to
testify,
cookiedom
but
that we've achieved
that
so
said
far.
he remained free to
So,
assert any legally applicable privilege in
you've
response to
won
the questions
points
asked.
towards a future
So
cookie.
what you did there was a narrow opinion. What role do you think that narrow rulings play in helping to maintain the legitimacy of the court? Why is it important to have plain language in orders?
Thank you,
I
Senator.
mean, you came the closest, at least on his
well, I'll
Twitter.
start with the
He
second
has
first.
excerpts from
I
the
think
transcript, which is more than we had
that,
before.
you
So
know, as
Karen is
we've
by
been
far and away the leader of the
discussing,
pack. All you, the
we
rest of you, should be
have a
shamed
rule of
for
law
your
in this
failure
country
your failure
which
to do the bidding of the Uncivil Law
requires a
master
certain
and
amount
find the
of
stuff I need to do my
predictability
stuff.
and stability in the law.
You're my minions.
If there are big
Help me.
shifts in terms of legal principles and doctrines and whatnot, it could lead to people not understanding that judges are ruling on legal principles. It could lead to undermining public confidence, thinking that judges are injecting their own policy preferences rather than following the law in terms of their rulings. And so to further predictability, stability, there are many doctrines in judicial practice. There's stare decisis, which is the principle that if something has already been decided, very similarly, you at least if it may be binding on you if you're a lower court, but at least you have to contend with it because that is the law that existed before you got the case, and you don't want to make a big shift. And then there's also the principle that the understanding that when you are announcing rulings, you are building on what exists before. And so you don't want to make a big shift if you don't have to, because if you can find a way to rule incrementally in a more narrow way, it keeps the law stable as a part of the proposition that I mentioned before. In McGahn in particular,
Maybe I can put you guys on mute or something while I just call his
it was a
office
case
now.
in which there was a precedent
Why
directly on
not?
point.
I'm still
from
waiting
my
for the break
district.
when I'm
It
going
was
to have
not
to probably
binding
vamp.
on me, but
I probably
the
should, because we'll do
exact
some
same set of
analysis. So I'll
circumstances
call his
and
office now.
arguments
I'll get back
had
to you.
been presented to another judge in my district. I believe it was something like 10 years prior to my case. And so we had law that governed the circumstance. And I looked
Does
at
Bulk
that,
get a
determined
cookie?
it was persuasive, and that I should continue.
Does Bulk get a cookie, or does
the
Bulk get the shame?
principles that had been laid
Does
down
Bulk get cookie or does
by-
Bulk
in
get
the prior
shame?
case.
Where is it?
In accordance with those principles,
Just a reminder what we're
prior
looking
judge
for.
and I
We're
made
looking
the
for the judge's
determination that
comments,
when the
right?
president,
So this would either be in the this would either be in a transcript,
absolute immunity,
or it would be in the
the
judge's sentencing
argument
memorandum.
was that
This is what we're looking for.
the person who
judge's
had been
comments.
subpoenaed by the legislature, a former employee of the White House,
No, you just teasing me?
could
Shame. Shame for getting
could
your uncivil law friend
say that they had
his hopes up. That was just mean.
immunity of some sort. In other words, it could have invoke executive privilege in response to particular questions.
Yeah, document 21 is not
but
what
they
I need.
couldn't say,
Melvin,
I don't
document
have to
21
show
is
up at
either
all.
the
And so the argument that
defense's
was being
memorandum or the
made
government's
was
memorandum.
when the House
I
of
remember because we looked it up
Representatives
yesterday.
issues a subpoena and says, show up on this day at
If you
this
take a look
time
at
to
it,
answer
document 21 is
questions,
either the government's memorandum or
does that
or the
person-
defense memorandum.
can
What
that
we need
person
is the
just
judge's
ignore
words,
and say,
which
I
is
have
document number
immunity, I
28,
don't
which
have
is not
to
available.
follow,
So yeah,
the law, in other words, respond to the subpoena? Or do I have to show up and sit there and listen to the questions?
it's
and if
Hawkins.
there are things
Melvin
that I
has the right
believe I can't
citation.
answer because
Melvin
they're
has the right
privileged, then
citation.
you
That's the right
invoke
citation for the right
privilege.
case.
And the prior case had said in this narrow way,
2013. That's the right
you
case.
have to show up.
U.S. v.
You don't
Hawkins.
necessarily have to give the information. That's determined on a question by question basis, but you have to show up. And that's what I held in that case as well. And it's important to be clear in your rulings so that people understand that judges are ruling consistent with the law and not their own.
2013 D.C.
Right. And
Court of District of
speaking of
D.C.
being clear and being careful in your rulings, some of my colleagues have, I think, given not a necessarily true view of your whole record, because when it comes to your rulings being upheld, the numbers show that out of over 550 cases, your district court cases, you were reversed less than 3% of the time. And in some of the instances, you were reversed only to have your decision later upheld. I noticed one case, Territory of Guam, the United States, in which you were initially reversed, but then a unanimous Supreme Court reversed that decision, then siding with you in an opinion written by Justice Thomas and aligned with your view. Do you want to quickly talk about that case?
Well, that case is kind of legally complicated. It was a CERCLA case, which is a Superfund cleanup kind of case where the country of Guam, which has a dump site on it that was used by both the citizens of Guam and the United States before the 1950s, when the United States was stationed there. Military operations happened out of Guam, and there was a lot of dumping into this site. And over time, the site got contaminated, and Guam was charged with having to clean it up, which is millions and millions of dollars. And there are statutes, very complicated statutes about the circumstances under which you can seek contribution, under which a country like that can ask for the United States to pay some of that cost, or other countries to pay some of that cost. And that was sort of the nature of the dispute. And I did a statutory interpretation about whether or not Guam's action could proceed. The United States filed a motion to dismiss, saying that all of the technical requirements of the law weren't met and that the action had to be dismissed. And I denied the motion to dismiss after interpreting the statute, saying that the action could continue. The DC Circuit reversed my view, had a different reading of the statute, saying that the motion to dismiss should have been granted, and dismissed the case. And then it was appealed to the Supreme Court. And as you say, the Supreme Court reinstated the action, saying it could proceed.
Very good. Thank you. In 1972, in Brandsburg v. Hayes, a 5-4 court did not recognize the reporter's privilege in the context of criminal grand jury testimony. I spoke with you earlier at length about Times v. Sullivan and First Amendment issues, so this will be my last question on this. Since the court's decision, my state, like many other states, enacted strong reporters' privilege laws to protect journalists from having to divulge unpublished materials, confidential sources. How would you approach balancing the need to protect journalists and the role they play in informing the public against the need for law enforcement officers to gather information?
I would apply the precedents of the Supreme Court in this area. It would depend on the circumstances. As I mentioned, press freedoms is one of the fundamental First Amendment rights. The court has a number of precedents in terms of expressive freedom, press freedom, and in every case, there'll be a specific set of circumstances regarding an alleged violation of the right, and the court would need to look at the facts and circumstances, the prior precedent, in order to determine whether that particular regulation could be upheld.
Okay, thank you. This is my very last question, Chair, before all of us get to eat lunch, including you. And that is really the important role of dissenting opinions. Justice Ginsburg once said this. She said, dissents speak to a future age. It's not simply to say my colleagues are wrong and I would do it this way. But the greatest dissents do become court opinions, and gradually over time, their views sometimes become the dominant view. When Justice Ginsburg's rabbi gave a eulogy at her memorial service here in the Capitol, and some of us were fortunate enough to be there, they said, Justice Ginsburg's dissents were not cries of defeat. They were blueprints for the future. What do you think is the purpose of a dissent? And do you want to talk just a little bit about that, this idea that they can be blueprints for the future?
Thank you, Senator. On the Supreme Court, there are 9 justices, and in every case, they're all sitting together to hear the issues in a case. And one hopes, and it often happens, that the justices agree as to issues in cases. That I believe that the vast majority of cases that the justices hear are actually not. There is no dissent, that they agree to the outcome. But there are cases in which, after deliberation and collaboration and consideration, the justices may disagree about how the case should be resolved, and there's a mechanism for every justice to decide whether they're going to join others, either in the majority, whether they're going to write a separate opinion that might agree with the majority but wants to make a different point, or whether they want to dissent. And sometimes more than one justice might dissent or join a dissent. It's a way of expressing one's own view that may differ from your colleagues. And with respect to the point that you made, there are actually many justices in history who have used the dissent mechanism to discuss the law in ways that others find over time to be more persuasive. And so I'm thinking of the first Justice Harlan, who dissented famously in Plessy versus Ferguson. He dissented alone. All of the other justices agreed with the proposition of separate but equal, and he said no in a dissent. And his dissent, generations later, became, according to Justice Thurgood Marshall, became the blueprint for Justice Marshall to make arguments that led to Brown versus the board. So there is the opportunity for justices to describe their views in ways that become persuasive to others in the future.
Thank you for all you've given us the last few days. We look forward to working with you. Thank you.
Thanks, Senator Klobuchar. And we're going to break now for a 30-minute lunch. I'd say to everyone that when we return, if we stick to 20-minute rounds and don't yield back time, we'll be finishing in something around 4.5 hours, which would take us to about 7 o'clock. So that doesn't include a break, but we'll consider that later on. Thank you, Judge, again.
And then a shooting skill that are well, so that all right, see you later.
Are not exactly productive, but I give Judge Jackson a tremendous amount of credit for keeping her poise, for the clarity and intellect in her responses, and just the temperament she continues to demonstrate just is convincing members more and more that she's ready for the Supreme Court. Thank you. I gotta go.
Wow. Oh, so you think slow.
Well, we'll continue to attempt to bring you remarks from senators at that podium that is just outside the hearing room. The Senate Judiciary Committee now taking a recess for lunch. It'll be about 30 minutes. And when they return, questioning will continue with Senator Ted Cruz on this, the last day of testimony from Judge Ketanji Brown Jackson. While this break continues, we'll review some of the back and forth between Senate committee members and Judge Jackson.
Do you guys miss me? Yeah. So I was on the phone with the senator's office for 12 minutes. Their staff gave me quite a lot of time, given the constraints of their time. So, I mean, he was very nice. Whoever talked to me on the phone at their office, I was on the phone with Senator Hawley's staff for 12 minutes. So first of all, Senator Hawley, your staff is very nice. They gave me quite a lot of time, and they tried very diligently to answer my question, which was very, very appreciated. even though they weren't able to answer my question, but they tried really, really hard. So, props. Yeah. And so it's like, at 12 minutes, he's like, I do the volume of calls. I need to go to the next one. I'm like, okay, fine. Can you take down my number? He's like, sure. So I gave him my name and number. It's like, ask him and get back to me. So I'll call you if I can find it. I'm like, great. Now, I don't think he's ever going to call me back, but, he was courteous. It was nice. I appreciated it. It was nice. I appreciate it. He was trying desperately to respond to my question with due attention and care, and good for him. Good for the staff. And I'm sure they're very, very busy, so 12 minutes was a lot of time. He was trying to dig around in Westlaw, and I was trying to dig around in Pacer and stuff, but yeah, we couldn't find it. Is the short of it. At least we couldn't find it yet. So I don't know what's going on. Yeah. All right. Great. Yeah. Yeah. They don't know how they're going to contact him and find out. Great. Yeah. So yeah, let's see if we can find these comments, see what he was basing his question on. That'd be great. Because, I'd like the ability to look at and so would you guys, presumably, right? You guys want to look at the primary material. The question seems very reasonable. The answers don't seem particularly reasonable, which suggests that, at least it's suggestive that the question's more reasonable than the answer. But still, all things being considered, I'd like to make an independent determination for myself. Because I don't know, maybe the judge was right. Maybe 3 months for the 18-year-old with the prepubescent videos. Maybe 3 months is the right answer. Somehow. I'm open to possibilities. So we could review that and we can try to make that determination together. Maybe we'll read it and we'll just be blown away with the brilliance, and we'll be like, wow, I can't believe we ever saw it any other way. 3 months was definitely the right answer. Way to go, judge. I mean, stranger things have happened, to be honest. So it's not completely ridiculous. But it could be. It could be. Maybe 3 months is the right answer somehow. Maybe. Probably not. But no. Yeah. Yeah. So anyways, back to what we were talking about before the break, or before whatever at this point. We're talking about this case, U.S. v. Booker, in the sentencing guidelines. So while you guys were listening to the stream, I was also doing legal research in the background, because I'm just that good, right? I was doing some more legal research about this case, U.S. v. Booker, because I wanted to figure out what the answer was. And so here's how I understand the case now, okay, on terms of the sentencing guideline thing, all right? So the Supreme Court appears, and this seems to be right, but the Supreme Court appears to have read the sentencing guidelines law to require that the judge consider information out that was not proven to the jury. That seems to be like the baseline premise of the Supreme Court's argument, right? The sentencing guidelines law required the judge to consider evidence not proven to the jury. That seems to be the baseline conclusion. Okay. So from there, the sentencing guidelines law would be unconstitutional. Fine. Then the next question is what to do about it. And there was some dissent on this issue in the opinion, because there was a minority opinion which suggested the remedy that first came to my mind, and I'm not sure it's still wrong, but it's the first remedy that came to my mind. It's like, okay, how do we fix this problem? It's like, okay, well, we just conform it, right? It's like, well, they didn't, we'll just make it so that they can only consider the constitutional information, right? The law says consider all information. The Constitution says only consider information proven to a jury. So the statute must bend to the law, or statute must bend to the Constitution. Therefore, when they said all information, what they really meant to say, or at least the way we're going to construe it, is all information posed to a jury, right? that would solve the problem. That would solve the problem, right? That would be one way to fix it, which was the solution that came to my mind. But the majority opinion in this case, in Booker, said no, that is not the right remedy, because the question is, among other things, the question is, what would Congress have done, right? What would Congress have done if they knew what we were going to do? Like, if we're going to remediate the statute, remediate the statute, then one of the things we can try to do is try to figure out what Congress would have done, right? So the minority says, well, Congress would have just said, consider the information that's proven to the jury. The majority says, no, that's not right. Here's their argument. They said it wasn't right because it would make it harder to consider evidence that would enhance than would be a downward departure, that would mitigate was the alternative, right? It'd be easier. It would be harder to find evidence that enhances than mitigates. And the reason for that, by the way, is because it wouldn't be a prejudice to the defendant to bring in evidence from outside it, right? So the statute said consider all the things. That would be also information the defendant would be able to bring in. So if we just bar the government from bringing stuff in after trial, then the government has to bring everything in a trial, which means it's harder for the government to bring stuff in than for the defendant. And Congress probably wouldn't have done that because it makes it harder to enhance than it would be to decrease. And Congress probably wouldn't have done that. Okay. And the other thing that they said, which I wasn't quite persuaded on, but the other thing they said is the other reason it doesn't make sense is because to the extent that you have these extenuating factors, how would a defendant properly defend themselves? So the hypothetical that the case talks about is, like, suppose you have a person who has been charged with armed robbery with a firearm. Okay. Armed robbery with a firearm. All right. So they want to plead not guilty. Right. So, and they want to argue they didn't do it. Okay. They want to argue it wasn't them at all. Right. Their defense is it wasn't me. Shaggy style, right? Their defense was it wasn't me. It was somebody else. Okay, fine. So the question becomes, how can this hypothetical defendant effectively defend themselves with the theory it wasn't me and also defend themselves from the enhancement? How can they do that? Because it becomes, well, it wasn't me, but if it was me, it wasn't with a gun. And that doesn't quite work, right? Logically, it doesn't quite work. So how is a defendant supposed to be able to effectively defend himself against the enhancement in at least some of these cases? Okay. So that presents a problem. So the majority's decision says, okay, well, we're going to fix this by striking the mandate of it down and striking down the appeal relative to that. And we're going to make the entire thing an optional system, which is another way of fixing the problem, right? It also fixes the problem by just making it advisory, because now it's just a guideline. And now it doesn't violate the rights, because the problem was, how to sentence you within the range and all the stuff. And so now that fixes the problem. Well, that is a solution to the problem. I mean, I can't deny that. It is definitely a solution to the problem. I'm not so sure it's better than the alternative of just make it so it's only the evidence brought in at trial. And maybe that does make it harder for the government to bring in enhancements than the defendants, but maybe that's okay. Maybe that's okay. Maybe it's okay that the defense could bring in stuff after the trial, after the jury's verdict is back. They could bring in new facts, but maybe that the government can't bring in new facts. So everything that the government would want to use to enhance would have to be offered at trial, but not everything that would mitigate. And this makes perfect logical sense, incidentally, by the way, because the defense, of course, doesn't have to offer any defense, period, right? The defense doesn't have to do anything at trial if they want to. So, but that does, just because they didn't do something in the guilt phase doesn't mean that they shouldn't be allowed to do something in the sentencing phase. So it makes perfect logical sense, by the way. It's like, okay, the defense doesn't want to offer any evidence. The defense doesn't want to offer any evidence. They just don't think the state has it, and they just want to put this burden to proof. They just want to put the state to the burden of proof. Okay, fine. So their defense strategy is how about the no witnesses? How about the no witnesses? How about we just, challenge the state's evidence? Okay, I mean, that's a valid strategy to use, right? So that means that the defense doesn't have to bring in any mitigating evidence because they don't have to do anything. But we could still allow the defense to turn right around and in sentencing be like, hey, by the way, I'd like to bring in some new additional facts now that I've been convicted. But not allow that opportunity for the government. That's right, because the government has the burden of proof, right? They're the ones with the burden of proof and burden of production. So it's like, look, if you want to hold this against this guy, you got to prove it beyond a reasonable doubt. But if the defense wants to bring some stuff in to mitigate all this, maybe it's enough that they can bring it in, and the judge can find those things by preponderance of the evidence. And if he finds them by preponderance of the evidence, because it's only beneficial to the defendant, right? So you're finding mitigating factors by preponderance of the evidence, no prejudice to the defendant. So it only is a downward enhancement. Maybe that's a better remedy. So I haven't thought this all the way through, obviously, in the last 5 seconds, but that seems to be the decision in this case in terms of why they did what they did. So the thing is, so the reason that Nate's question didn't work, now that I know the answer, now that I've done my research, going back to Nate's much, much earlier question from the long, long ago and the far, far away when Nate was on the channel and asked me the question in the first place, I now have an answer. The reason that the logic of this case, Brooker, doesn't read on mandatory minimums is because unlike the sentencing enhancement statute, which required the government to prove all the things, or allowed the government to present all the things, including stuff after trial, right? If it's in the underlying statute, so if it's in the armed criminal statute, whatever, right? It sets out all the elements of the crime, right? And those all have to be obviously proven at trial. And you'll even see that on jury forms. You'll even see it in kind of ridiculous situations, to be honest. You'll see the jury asked, like, the whole entire theory of the crime is like he shot him with a gun. And you'll see the testimony. It's all about the gun. Here's the gun. Here's the gun being fired. Here's the pictures of the bullet wounds. Here's the guy from the medical examiners who's telling you he was shot, totally shot. Here's the bullet, right? We got it on video and witnesses, and we got the actual bullet and the gun and all the rest of it. And they'll still ask the jury, for example, if this is a murder case, they'll ask them, do you find them guilty of murder? Question 2, was a firearm used in this commission of this act? Right? Which, it's the only way it could be, really, but they'll still ask the jury separately because it's now a separate element of the crime, right? Well, if he committed the murder, that's one thing, but the statute provides this enhancement if it's with a firearm. So we still have to prove it's with a firearm. So the jury has to conclude it's with a firearm. So we're going to ask him this question anyway. And you'll see that on jury forms, even where it's a little bit ridiculous because the jury still has to find that fact. So that's why it doesn't prevent a problem for mandatory minimums. Because in the case of those situations, the jury is finding every single fact. They're finding every single fact. That's the whole point. And so the judge being constrained to within the guidelines provided by that statute doesn't pose any problems. So that's why the one case doesn't read on the other. So now I know the answer to Nate's question. And now I've explained the answer to Nate's question, and we're all smarter. We have all learned a thing. How fun. How fun. Right? Yeah. That is the answer. That is the answer. Yeah. Mark asks, what about aggravations that would prejudice the defendants during the guilt phase? Yeah, that's exactly the problem. That was the problem the Supreme Court was pointing out, right? What about aggravations during the guilt phase? Yeah, that's kind of exactly the problem. Now, you could solve this problem another way, incidentally. There is another way to solve this problem. So there's a third solution to this problem. You could have the guilt phase in 2 different parts. Or you could basically have the sentence, you could have the jury as part of the sentencing procedure. That would also incidentally solve the problem. So another way you could solve this problem is that you have the jury do what they normally do, and the defense doesn't have to offer any evidence or do anything during this guilt phase. So the defense doesn't do anything. They find them guilty. Another solution to this problem is you can keep the jury around and be like, okay, jury, now that you found him guilty, we're on to phase 2. We want you to determine whether these additional facts are true. And now the defense can offer those facts in mitigation if they want. And the government, of course, can offer their stuff in aggravation. So that's another solution to the problem, right? You have the jury provide a second verdict with respect to the facts that are the facts that would be in aggravation and mitigation, and have them check off the ones that they find accordingly. That'd be another solution to the problem. But the government, the Supreme Court went with the strike down the statute solution, which is a solution. I'm not sure it's the best solution, but that's what they went with. So all that stuff. There were 2 super chats from anti-commie. Even Skelton's had enough of that. And here's some money for not being Nick. Thank you for your super chats. So since we have a minute to kill, is there anything else you want to know? Now that I've solved that problem, what other questions can I answer for you? This can be Ask Me Anything Law time, or it could just be Ask Me Anything for that matter. I just might not answer your questions depending on what they are, but sure, ask me anything. Ask me anything law. Ask me anything. I reserve the right to answer the question and answer or not answer questions. You already know one of the questions I won't answer. You already know what it is. I know you know what it is. I'm not going to tell you what it is because you know what it is. And everyone who's thinking about asking the question, you should be ashamed because you already know what it is. Stop wasting everyone's time. But we'll wait for someone to ask it anyway. What's the meaning of life? 42, man. You know that. All right. How's peanut butter get made? Mashing up peanuts, man. Enjoy the Stargate series? Yes, for the most part. I enjoyed SG-1. And that's about it. Stargate Atlantis, And then there was the one on the ship, which... But yeah, Stargate SG-1 was good. Where do babies come from? Ask the left is my answer to that question on that one, right? Maybe they know the answer. Favorite band? Oh, favorite video game? Like of all time? Well, I'm a bit of a sucker for Final Fantasy II on the SNES, which I think was Final Fantasy IV in the international system. It doesn't really hold up these days, but I really, really enjoyed it at the time. Final Fantasy VII, of course, is great. What else? In terms of, I played a lot of Prison Architect, but I'm not into that very much anymore because I kind of exhausted the game. But I played a lot of Prison Architect. That was fun. What else? I was thinking about trying to get into like Mario and do like Mario speedrunning shit and try to play with those guys, but that would require a lot of time and effort, and I'm not sure about that. Who was the first man in space? The Russian. Yuri, right? What's his name? The first man in space was the Russian whose name was... I don't remember. What was the Russian guy? Favorite band? Probably Nirvana. Probably Nirvana is my favorite band. I'm a bit of a fan of this rapper. I guess we'll call him a rapper named Forrest Day. Forrestday. Forrest Day. I'm a fan of his work. Never seen him live. I think he's kind of a regional thing. He never seems to tour outside of like the California area in the West Coast. But I like his work. Let's see. Is there anyone else that really comes to mind for favorite band? Those are the two that come to mind. Which senator had the best line of questioning? I think Hawley did, because he stayed the most on point and was most pressing. and he was the most relevant. And then there was one senator today who was really good in the morning, who was asking a lot of questions. Was that Senator? I don't think it was Lee. There was someone else today who was pretty good and remaining on point, but I can't remember who right now. Fallout's okay. Final Fantasy 4 on the SNES is amazing. Yeah, I agree. RimWorld, I've been playing RimWorld too. The thing with RimWorld that I never quite figured out, and I've watched YouTube videos trying to explain it to me, but I never really figured out how to effectively set up a defense against, the raids and such. I've tried different strategies, and I just don't seem to do very well at the defense. So my games end because I can't effectively defend my base, which is very, very frustrating, despite my play. So RimWorld and I can't quite figure out how to effectively set up a defense. So Uncivil Law, can you point out how wanting to force one particular religion through force of government and law on everyone might run afoul of the First Amendment? I mean, seems kind of inherently obvious. Freedom of religion, which necessarily, yeah, I don't know where that's complicated, but forcing everyone by governmental law to, have a particular religion would be kind of difficult to square with the freedom of religion, I would think. Justices can be impeached. That is true, and only one was impeached, but it failed. Samuel Chase. That's correct. How's it know that 650 people are staring at your face? Well, to 250 people staring at my face, I hope at least that you're appreciating that I'm trying to take better care of my skin to look better on camera. And I'm seeing results. Like the bags under my eyes are looking better, I'll tell you what. And I think my skin tone and overall is improving. So, hey, all those products I bought seem to be doing something. Yuri Gagarin. Yeah, I came up with Yugi, and I know that wasn't quite right. Yuri Gagarin. Yeah, so I was vaguely in the ballpark. Yeah, I came with Yugi. I'm like, it's not quite right. But Yuri, yeah, instead of Yugi. So I kind of conflated his last name a little bit somewhere in there. Do I D&D or Warhammer? I played a lot of D&D in college, and I haven't since, but I really enjoyed it. Which is better, Nevermind or Bleach? Nevermind is better. Nevermind is better. Pepsi or Coke? Coca-Cola. Graham did pretty good today, yes. Civilization is okay. Never a huge fan of Civilization, but it's okay. Thank you for saying that my skin looks better. Buy razors. I do have razors. I just don't shave very much. I guess I could go back to shaving every day. But yeah, I use a traditional safety razor. So I use a traditional safety razor, and then the blades I use are who are the blades I use by now? I forget. I was using Feather for a while, but they're so sharp, man. You got to be careful with that shit. So I went with a slightly duller blade because Feather is will get your attention, and I don't need to bleed everywhere. But yeah, I use a traditional safety razor, old school. Kurt, I can take a lot of things, but you liking Coke better can only mean one thing. You're a communist. Okay. Did I ever listen to Porcupine Tree? That name does sound familiar. Bobbert says Feather? Oh, yes. Yeah. Safety razors. Yeah. So you're like, what's Feather? Yeah. In a traditional safety razor, these are the kinds of blades that you see in the movies, right? The actual, when you see a razor blade by itself, right? You just see a razor blade, right? In like a movie. That goes in the safety razor, right? So that you can use lots of different blades in the safety razors. And Feather is a company out of Japan that makes blades for the safety razors, which they are considered to be the sharpest in the world, which I would tend to agree with. They're a little bit much for my skin. So I went with a slightly duller blade so I don't, cut myself 8,000 places. Yeah, there you go. Thoughts on nuclear energy versus wind/solar? I think nuclear energy, particularly as technology has developed, has gone really good. People seem to think that we're stuck with 3 Mile Island, but 3 Mile Island was built, quite a while ago at this point, and technology has, of course, improved. So I think nuclear energy is fine. Of course, one of the major problems is what to do with the spent stuff, which we still don't have a good solution for. But there are reactors that are better about that than others. But nuclear is a good technology. The biggest problem is just what to do about the stuff. But that's a problem that can be solved. At least it seems to me. I think solar has very good long-term implications. The biggest problem with solar is just producing enough solar panels. There's two big problems. The energy storage problem is one. Like the batteries are a problem. I mean, it's not great solutions. Tesla's Powerwall is as good as any out there, but yeah, that's one problem. And then just producing enough solar panels. Like we can easily, you can easily power the entire United States by putting a solar farm in the middle of the Midwest desert. That would be about what? I forget the exact dimensions of how big it would have to be. I think it's like 10 miles by 10 miles, something like that. Which in the middle of the nowhere desert is totally doable. Maybe it's bigger than that, but yeah. In either case, it's a totally solvable problem. Maybe it's 100 by 100, which is still nothing in the middle of the desert. Either way, the problem is producing enough panels. You don't have a dad teach you to shave? Yeah. Yeah. Like they have a slot for on the plane. Yeah, exactly. Yeah, they have a slot for on the planes. Yeah, exactly. So you use a barber blade? Technically not. Right? Well, it depends what you mean. A barber traditionally uses a straight edge razor. And that's hardcore. Right? That's a hardcore blade. So yeah, a barber traditionally uses a straight edge, which is just a blade. It's just a blade. It basically looks like a pocket knife, kind of. You open the pocket knife and it's just a big ass blade. That obviously not so safe because you could just cut someone's throat with that pretty effectively. Safety razors, much safer. So it's the blade and it goes inside a housing, so only a very tiny amount of the blade is exposed, and not so much with the cutting the throat. Cutting with a straight edge is hardcore. That's hardcore. I'm not up for that, man. Entire state of Texas would have to cover it in panels to power the country. I don't think that's even close to true. No, I don't think it's even close to true. I think, it's not even close to correct. I don't think. No. I think you'd have to take the little top off, that little square part of the top of the T, the top of Texas, about that much. It's nowhere close to the whole state of Texas. Yeah, I do not have steady hands. I do not have steady hands, as anyone sees, because I have a tremor. So not so much with the straight razor. Not so much with the straight razor. Are they getting back into session? What's going on over here? Are they back? Let me check. No, they're just musing around. Beta blockers. I've used beta blockers before. I'm not sure what the question is. We can talk about razor blades, though. We'll talk about razor blades some more. Let's talk about razor blades. So this is what I use. Merkur, the German brand, safety razor. right? So the top screws off. You put the blade under that cap. A little bit of the blade sticks out. And you got yourself a shaver. Just like that. And then here's the blades I'm currently using. Derby are the blades I'm using. I bought 100 count, so they last forever. I bought 100 razor blades for $9. That's the benefit of the safety razor. That's the benefit of the safety razor. The blades are cheap. I bought 100 blades for $9. Yeah. So, yeah, that makes them a little bit more accessible. Yeah. And this is what a blade for a safety razor looks like. You might see that, you know what that looks like, right? So there's that. And then the ones I used to use, which are a bit much for me, in my opinion. Then there's this hardcore nightmare. Feather. Japanese blades. 50 for $21. So a bit more expensive. They're 4 times more expensive, but still cheap. And they are very, very, very sharp. Very, very sharp. So maybe not what you want to do. You know, yeah. So feather was a bit much for me. It's a bit much for me. So I use Derby, which seems to do the job just fine. Astra is a fine blade. Excellent. Excellent. Yeah, finding the right blade for you is a whole thing. But they're cheap, so you know you can try different kinds, and then you can even buy like sample packs of different kinds. So, you know, is there any truth in lore about sharpening the blades in a glass pyramid? I don't even know what you're talking about, to be honest. You got me. You got me, man. They're still musing around somewhere. Yeah, the blades are so cheap you replace them like every day. Exactly right. Yeah. Yeah, I usually replace them like every 2 shaves. Right. So the blades don't quite last as long as the ones in the multi-blade, but they last fucking, I mean, the blades are so cheap that, you know, whatever. I mean, you could use a new blade every single time and you'd still be cheaper. I mean, 100 of them for, what did it say, $13 or something, for $9. There's 100 of them for $9. I mean, that's a year of shaving for $30. You know, so yeah, you can use a different blade every day. It's fine. Do I do the brush and proper soap or can? I use the can. I use the can. It's a bit of a cheat. So if you want to look down on me because I don't have the fancy brush and don't do the soap thing and lather old school. Yeah, I just use the stuff in the can. It works fine. You're allowed to say that I'm not welcome at your club meetings. I understand. I'm not sufficiently pure. In fact, I'm a heretic. I understand. Yeah, I understand. What lather do I use? I think at the moment I'm just using like the Gillette Edge stuff, just like the gel. It works fine. Yeah, I use like I use the gel. I think it's Edge. It's pretty good. Yeah, the brush makes it more of a ceremony. Yeah, I agree. Yeah. Have I ever had facial exfoliation via hot wax? No, I've never done that. Can't say that one. No, you got me there. How to find a good lawyer when you want to, that you're going up in the United States. My best recommendation for how to find a good lawyer is, well, there's two different ways to go about it, in my opinion. Well, okay, there's really one way to go about it. The best way to find a lawyer is to use Martindale-Hubbell and AVVO. Martindale-Hubbell and AVVO, they do attorney ratings, and they're as good as anything. So I look up attorneys for that practice area on those two websites, and I look for one that has a good rating on both. That's how I've picked lawyers in the past when I've had to use them. So yeah, AVVO and Martindale-Hubbell are probably your best solutions to finding a good lawyer. Do I have a P.O. box? Not at the moment, no. I've had one in the past, but yeah. I've never had a significant other wax my back. Never had that one happen. Didn't come up, I guess. For the 230 of you who are currently watching, thank you for being here. Remember to like, comment, subscribe, and all the YouTubey things. Oh, and yeah, and then I cut myself like crazy when I shave. I have a very nasty habit of cutting myself when I shave, which brings us to a tool that I can't go without. Which I use pretty much every time I shave, because yeah, it's a thing. The Humble Styptic Pencil. This cost me $4. I think I bought it 2 years ago, and I still have it. It hasn't run out. It doesn't take much, but this works very good for stopping small bleeds. This stuff works like crazy. So you just get it wet. You just run it under some water or something, get it wet, and then you put it on the bleed, and it burns a little bit. I'm not gonna lie, it burns a little bit, but it works great. Me and the pencil have a notable relationship. I use it every time I shave. So if you cut yourself when shaving, this is your answer, right? Don't do the toilet paper thing. This is the way to go. Just, put it in the water, put it on your skin. It will burn. It will get your attention. You will know it's working, and the blood will stop. It's great. It's absolutely great. Get that. Yeah. Allen Block. It's the same thing. Yeah, Allen Block is the same thing. Yeah. Yeah, don't do the tiny bits of TP thing. This thing works. What thing works much better? This thing will work much better. And they're still doing whatever they're doing. Stephanie says she has a case for me. What you got? Use super glue? You could do that too. I mean, that's a solution. All right, let's take a look at this interesting one. This is interesting. Let's take a quick look at this for Stephanie. And then maybe we'll do a fuller video on it. We'll redo it, but this will be interesting. Let's take a look while we're waiting around. See what we got. Okay. As nurse faces prison for deadly error, her colleagues wonder, could I be next? 4 years ago, inside the most prestigious hospital in Tennessee, nurse Rodonda Vaught withdrew a vial from an electronic medicine cabinet, administered the drug to a patient, and somehow overlooked signs of a terrible and deadly mistake. The patient was supposed to get versed, a sedative intended to calm her before being scanned in a large MRI-like machine. But Vaught accidentally grabbed Vesceronium, a powerful paralyzer, which stopped the patient's breathing and left her brain dead before the error was discovered. The fact these two drugs are kept side by side is not particularly encouraging, I have to say. But okay. Vaught, 38, admitted her mistake to the Tennessee Board of Nursing last year, saying she became complacent in her job and distracted by a trainee while operating the computer medicine cabinet. She shook responsibility for the error, but said the blame was not hers alone. I know the reason is the patient is no longer here is because of me. There won't ever be a day that goes by I don't think about what I did. If Vaught's story had followed the path of most medical errors, it would have been over hours later, when the Tennessee Board of Nursing revoked her license and ending her career. But Vaught's case is different. This week, she goes on trial in Nashville on criminal charges of reckless homicide and felony abuse of an impaired adult for the killing of Charlene Murphy, the 75-year-old patient who died at Vanderbilt University Medical Center. If convicted on charges of reckless homicide, she faces up to 12 years in prison. Wow. I mean, reckless homicide, that's wow. Yeah, normally that's like if you're impaired. For a doctor, prosecutors do not allege in their court filings that Vaught intended to hurt Murphy, which is good because that would make it not reckless, or was impaired by any substance, which is much more typical for these things, when she made the mistake. So her prosecution is a rare example of a healthcare worker facing years in prison for a medical error. Fatal errors are usually handled by licensed sports and civil courts. Yeah. And experts say prosecutions like Vaught loom large for a profession terrified of criminalization of such mistakes, especially because her cases hinges on an automated system for dispensing drugs that nurses use every day. Yeah, this seems problematic. The Nashville District Attorney's Office declined to discuss the trial. Vaught's lawyer did not respond to requests. Vanderbilt Medical Center has declined to comment. Vaught's trial will be watched by many nurses nationwide, many of whom worry conviction may set a precedent. Yeah, I'd be worried about that too. We might watch that trial too, because that sounds like some bullshit. But as always, we do have to at least open ourselves up to the possibility that this article may be full of shit. Maybe there's more here than meets the eye, but at least based on the description, it seems problematic. Janie Garner, a registered nurse and founder of Show Me Your Stethoscope, with more than 600,000 members on Facebook, said the group has closely watched the case out of concern for her fate and their own. Garner says many nurses know all too well the pressures that contribute to such an error. Long hours, crowded hospitals, imperfect protocols, inevitable creep of complacency in a job with deadly life or death stakes. Garner said that once she switched powerful medications just as Vaught did and caught her mistake only in a last-minute triple check. And I'm sympathetic to that too, by the way, because I've done double checks before and not caught a mistake. So, you know, I understand. In responses to a nurse story like this one, there are two types of nurses. You usually have the nurses who assume they'll never make a mistake like that, and usually it's because they don't realize they could. You definitely can. And second kind are ones who know this could happen any day, no matter how careful they are. That could be me. I could be her. Yeah, that seems more plausible. As the trial begins, Nashville prosecutors will argue the error was anything but a common mistake any nurse can make. I hope so. I hope they've got something. Prosecutors will say she ignored a cascade of warnings that led to deadly error. Okay. The case hinges on the nurse's use of electronic medicine cabinet, a computerized device that dispenses a range of drugs. According to documents filed in the case, and so there's some documents, that's some good news, so something for us to analyze in the future. Vaught initially tried to withdraw a verse from a cabinet by typing VE into a search function, without realizing she should have been looking for its generic name. Midazolam. When the cabinet did not produce Verst, Vought triggered an override that unlocked a much larger swath of medications, then searched for VE again. This time, the cabinet offered Versonium. Vought then overlooked or bypassed at least 5 warnings or pop-ups saying she was withdrawing a paralyzing medications. That does seem like a lot of warnings, to be fair. I mean, but then again, like, I could see you missing that, to be honest. But will a jury understand that? I don't know. She also did not recognize that Verst is a liquid, but Versonium is a powder that must be mixed into a liquid. Finally, just before injecting the Versonium, Vought stuck a syringe into the vial, which would have required to look directly at the bottle cap that read, "Warning, paralyzing agents." I bet you she can withdraw from that vial without looking at it. I bet she can do it blindfolded with her offhand. The DA's office points this override as central to the reckless homicide. Vought acknowledges she performed an override on the cabinet, but she and many others say overrides are a normal operating procedure, which raises a whole set of other problems, but yeah. When testifying before the nurses board last year, foreshadowing her defense in the upcoming trial, Vought said at the time of Murphy's death, Vanderbilt was instructing nurses to use override to overcome cabinet delays and constant technical problems caused by an ongoing overhaul of electronic health records. This I believe. I totally believe this. Bypass all the warnings. Super Iron Bob, $5, says that system sounds like one that creates pop-up blindness, a known problem in UI design and reason to be judicious about their use. Respect. Absolutely. I agree. I agree completely. It didn't pop to mind because it wasn't first on my mind, but when you say it, you're like, yeah, I know that. I mean, yeah, you're right. Yeah. It's the boy who cried wolf thing, right? Michael Cohen, President Emeritus of Institute for Safe Medical Practices, and Lori Brown, past President of American Association of Nurse Attorneys, each year say it's common for nurses to use override to obtain medication. But Cohen and Brown stress that even with override, it should not have been so easy to access Versonium. This is a medication you should never, ever be able to override to. It's probably the most dangerous medication out there. Okay. Cohen said in response to the case, manufacturers of medicine cabinets modify the devices requiring up to 5 letters to be typed when searching for drugs. But not all hospitals have implemented this safeguard. 2 years after the error, Cohen organization documented a strikingly similar incident, which another nurse swapped Verst with another drug, Vermapil, while using override and searching with just the first few letters. That incident did not result in death or prosecution. Well, that's definitely something we're going to have to follow up on and do a stream on in more detail, because that sounds like some very questionable bullshit by the prosecutor to my mind. And, you know, so that sounds like a problem to me. The Senate's not back. They're carousing. They're musing around. Madeleine Albright died. She was pretty old, man. Drug pronunciation. Verst is Versad. Versade. Verst is Versade. Okay. Versonium is Vecuronium. Okay, well, I tried. I failed, but I tried. I gave the college try on the pronunciation. Verst is Versade? Versus Versad? Said? Versed? Versed. Verst is Versed. Okay. All right, fine. Okay, apparently. Why don't they just call the drug like Paralatastic or something? That'd be good. Name the drug after its function. Reach for the Paralysium. I'm a nurse. It's versed. Versed. Okay. That thing. That drug. That one. The Versed one. We'll name it Omicron. There you go. That's good. Now try to decipher those names from a handwritten prescription. I feel you. My handwriting sucks too. It's probably one of the ways I could be a doctor. My handwriting is atrocious. So I got that going for me. My handwriting sucks. What else can we talk about while we're killing a little time for the Senate to get back? Pronunciation guide for said vec your vec your ononium. Vec your ononium. For sad and vec your ononium. It doesn't quite roll off my tongue, but maybe you get used to it. Maybe you get used to it. I don't know how you memorize all these drug names because there seems like so many of them and they're not obvious, but I guess you get used to it. Yeah, let me message Stephanie back too. So we might do another video about that later where we reread the article or something to prime people to the issue. But you guys got a preview, so you guys feel special, right? I'm going to pronounce it super chat. I'm pronouncing it super chat. Have you given the patient super chat yet? The patient needs some super chats. Is it working yet? Is it working? Eh? Can I suggest 1,000 milligrams? Okay, good times. Or I guess 10 grams really. Can I suggest 10 grams of the super chat? Oh man. All right, what else? They're still musing around, man. They're never going to come back, are they? What's Rackets doing? Is Racket still streaming? Is Racket still streaming? I thought Racket said he didn't have that much time. Racket said he wasn't joining my channel because he didn't have the time. He's been streaming for an hour. Rackets lied. Rackets lied. Uncivil died. Disrespect from the Rackets. Disrespect. See if he sees my $5 super chat. Disrespect. Oh, I have to look at my own security card for my. I have to remember my security code for my card. Shit. Oh, it's right here. Thank God. It's like I did not want to get up for this. It's not the right card, is it? That's definitely not the right card. What card is YouTube trying to charge me against? I'll give Nick $5 to make him feel guilty. My card has declined my payment. Oh, Christ. Did I forget the... Hold on. That's the wrong card too. No wonder it denied my payment. All right. Where's my actual valid card? Damn it, as I try to super chat him. My this one. This is the right one. Why won't you let me pick this? I hate you. Save. Bill. Finally, Jesus.
To understand.
Like how she's trying to sound tough with that. I sent this 18-year-old to 3 months in federal prison. You gave him 90 days. The stuff people get 90 days for. There was a lady in Albert Lee, Minnesota, who opened her restaurant during COVID against the governor's order. Got 90 days. 90 days. The governor said you can't open your restaurant.
Disrespect.
And then 90 days in jail.
That's what's happening right now. Let me tell you what.
90 days. Okay. Sure. All right.
And that what he had done was harmful, that what he had done was unlawful, that what he had done.
Are they back? Are they
violated
live?
the law and
Looks like they're live.
needed to
Okay.
be
Well, that's enough of
punished,
rackets, I guess, because we have to
not
actually go
only
back
by
to this actual
prison.
testimony. Now it's actually happening. So that's enough of that. Let's go back to the committee hearing.
And in my view, egregious policy of discriminating against Asian Americans. Even though I think that policy is egregious, I, as an individual plaintiff, could not bring a lawsuit challenging it because I am not Asian American. Is that right?
If you brought a lawsuit, the court would have to evaluate whether you had an actual injury in order to be able to determine whether it had subject matter jurisdiction to hear the suit.
But if I'm not in the class being discriminated against, then I don't have the ability to bring the lawsuit. Is that right?
I think you'd have to have an actual injury. Certainly people, I think, who are in the class could claim that they had an injury for that purpose.
So now you're on the board of overseers of Harvard. If you're confirmed, do you intend to recuse from this lawsuit?
That is my plan, Senator.
Okay. We discussed yesterday how the standard for race discrimination was strict scrutiny. The court has laid out a different standard for gender discrimination. What is the constitutional standard that applies to gender discrimination?
Gender discrimination, the court has held.
She should correct him and say sex
intermediate
discrimination,
scrutiny
not gender.
applies, which is that the government has to have an important interest, and the tailoring doesn't have to be as narrow.
Right. So yesterday, under questioning from Senator Blackburn, you told her that you couldn't define what a woman is, that you were not a biologist, which I think you're the only Supreme Court nominee in history who's been unable to answer the question, what is a woman? Let me ask you, as a judge, how would you determine if a plaintiff had Article 3 standing to challenge a gender-based rule, regulation, policy without being able to determine what a woman was?
So, Senator, I know that I'm a woman. I know that.
How do you know that?
Senator Blackburn
How do you
is
know
a
you're a
woman, and the
woman?
woman who
How do you know that?
admire most.
How
in the
do you
world
know
is in
you're a
the room
woman?
today? My
What is a
mother.
woman? How do
It
you know
sounded
that?
as though
But
the question.
but
How
let
do
me
you know
ask,
that?
under the modern
Tell
leftist
me.
sensibilities, if
You know you're a woman. What is that?
I
I have this strange
decide
word,
right
woman. What is
now
it that you know that
I'm a
you are?
woman,
Please tell me.
then apparently I'm a woman. Does that mean that I would have Article 3 standing to challenge a gender-based restriction?
Senator, to the extent that you are asking me about who has the ability to bring lawsuits based on gender, those
Just
kinds of
ask her.
issues are
You
working
just
their way
said
through the
you're
courts,
that
and
you
I'm
know
not
you're a
able to
woman.
comment
How
on
do you know that?
Okay, if I can
How do you know you're a woman?
change my gender, if I can be a woman, and then an hour later, if I decide I'm not a woman anymore, I guess I would lose Article 3 standing. Tell me, does that same principle apply to other protected characteristics? For example, I'm an Hispanic man. Could I decide I was an Asian man? Would I have the ability to be an Asian man and challenge Harvard's discrimination because I made that decision?
Senator, I'm not able to answer your question. You're asking me about hypotheticals and
I'm asking
kinds
you
of
how you would assess standing if I came in and said I have decided I identify as an Asian man.
You're a judge.
I would
Let me
assess
ask you, am I Asian?
standing the way I
How about that?
assess other legal issues, which is to listen to the arguments made by the parties, consider the relevant precedents, and the constitutional principles involved, and make a
No,
determination.
No. Absolutely
back to
not.
your favorite
No,
topic of this
no,
hearing.
this is just absolutely the wrong answer.
Which
Super
is
Iron
the
Bob. This is
criminal law
about maybe the
cases
most wrong
you
answer
had
you
as a
could
district
possibly
judge,
have.
and in
This
particular,
is the most
cases
wrong answer you
involving
could
child
have.
pornography.
Woman is like now it's
Now,
like
your
obscenity. You
defenders,
know it
both
when
on
you
the
see it.
Democratic
Oh
side of
really?
the
Oh
dais
really? You
and
can
also
tell
in
what
the
a woman
press
is by seeing it.
have
Oh
suggested
really?
that the
Try that
criticism
one
that
with
has
the
been
left. Let
raised,
me know how it
has
works
been
out
somehow
for you.
cherry-picked, that it's only some specific examples. So I'm going to give you
Let
an
me know how that
opportunity
works out for you.
to discuss each and every case you've had. Because looking at your cases, and I've now examined all of the child porn cases you've had as a federal district judge, there is a very consistent pattern. So let's start, and by the way, I'm excluding the cases. So Senator Durbin and Senator Coons focused on the Nickerson case, the Fife case, the Nguyen case, and the Hilly case. I'm excluding those because those are not child porn cases. Those are actual sexual assault of a child, which is markedly different. And I will concede when you're dealing with sexual assault, you have been willing to impose stricter penalties. So let's focus on actual child
I
pornography.
mean, I at least agree with him. It's
And
different
let's
enough
go
to
through
my
each of
mind
them,
to
because
split
if
it.
it's right that we're cherry picking, then you should be able to explain quite powerfully. Now, your justification is that you're following the statute. And as you know, 18 USC section 3553 lays out the factors that as a district judge you had to consider in sentencing. And let's start with the Hess case, United States versus Hess. Now, in that case, a man sent 6 pictures of a prepubescent girl that he claimed was his daughter to an undercover law enforcement officer. Officers found over 600 images of child pornography,
600 feels like a number that's
including
notable.
images of sexual acts being performed on prepubescent children.
Seems like that
The
could be
defendant
bad.
pled guilty, and I believe in all of these cases the defendant pled guilty. So there's no question about guilt. They came in and pled guilty in your courtroom. The charge carried a mandatory minimum sentence of 5 years and a mandatory maximum sentence of 20 years. The sentencing guidelines recommended 151 to 188 months sentence. The government, as part of a
If she
plea
answers these questions
deal,
with any
agreed
kind of
to
specificity,
argue for
I'll be
60
amazed.
months, but didn't agree that that would be the sentence, simply that they would advocate it. And you, in turn, sentenced Hess to 60 months. So under the terms of the statute, why did you choose to sentence Hess to the absolute lowest possible sentence you were allowed to sentence under law?
Thank you, Senator. I have spoken at length throughout this hearing about these cases. I've said what I'm going to say, which is I've taken every case seriously. These are
Do you have anything to
very
say about the Hess case?
horrible
I'm asking you specifically
crimes,
about the Hess
and
case.
I've taken every case seriously.
So you're not going to answer that?
These are very horrible crimes, as was that one. And as a mother, having to look at these
She said, "Mother,
having
drink."
to follow Congress's directive.
Also, how do you know you're a
having
mother and
to
not a father?
listen
Just out of
to
raw curiosity.
recommendations like the government in that case, which argued for 60 months, I imposed the sentence that I believed was the sentence that was required by law.
So I believe you, and I've read your sentencing hearing in each one of these cases for which we have transcripts, and there's several of which we don't have transcripts. So in each of these cases, you read from the same script. So in each of these cases, you say that
I don't have
the
transcripts
distribution
for
of
any of
child
them, I don't
pornography
think.
is an extremely serious federal crime.
If anyone can
And
find
you point out
transcripts
that the
for
crime
any of
involves
them,
people who are taking
let me
pictures
know.
and videos of real children while the children are being sexually abused. In Hess, you pointed out that he had hundreds of images of children in sexually compromised positions.
How do you have transcripts?
Some of them
Maybe I could call Senator Ted Cruz's office.
All of this I'm reading from you on the bench. And most importantly, the children in these pictures are not knowing and willing participants in the degrading conduct that was being depicted. They were being forced by someone off screen to commit unspeakable acts of sexual violence.
Yeah. I see you. Where's the window?
But you also, and in Hess, you said, I have to say that what I found particularly disturbing about your offense.
You said some transcripts they don't even have yet, but at the moment I don't have any of
You
them.
apparently concocted a story about having
So I'll take some as
photographed
opposed to
your
the
own
none I
daughter,
have. That'd be
who you
great.
purportedly were willing to take pictures of to trade with other people. I know from your comments and from those who know you that you are unlikely to ever harm a child, which I find remarkable that you've got a child predator in your court who says, I'm unlikely to harm a child. And you say, well, you told me that, so clearly you're unlikely. But you say, but in the context of the crime, you represented that you would. That in and of itself is astonishing. So you talk about it as astonishing. You nonetheless sentenced him to the very lowest possible sentence allowed under law. And what's striking is in these cases, and half of them in 5, you sentenced the defendant to the absolute lowest sentence under law. Let's look at another case. Let's look at United States versus Chazen. Now, Chazen is a particularly nasty case. In Chazen, the defendant was accessed a Dropbox that contained 35 videos and 13 partially downloaded files of prepubescent minor females engaging in sexually explicit conduct. At least 3 of the instances of prepubescent female children were engaged in sexual activity with adult men. The images included the sexual abuse of children, including those as young as toddlers. And several of these cases that you had involved the sexual abuse of toddlers, which is truly horrifying.
Which then they filmed,
In this
which I'm not sure
instance,
which part is
Chazen
more
pleaded
horrifying.
guilty.
That's, yeah.
The guidelines recommended a
And then
sentence
other
of
people
78
downloaded them to
97
watch, which
months.
still not sure which
The
part is more horrifying.
prosecution
It's pretty
argued
horrifying.
That should be what the sentence was. And you sentenced Chazen to just 28 months. Why did you sentence someone who had child pornography of toddlers being sexually abused to 28 months, 64% below what the prosecutors asked for?
Thank you, Senator.
Say it. Say the line.
You've picked out, I don't know, 7, 8 cases. I've sentenced more than 100 people.
but not to child pornography.
And in
These
every
are your child
case,
porn cases.
in every case, Senator, I look at the evidence, I look at the recommendations of
She's not
not
going to answer with
just
any
the
specificity.
government, because my duty as a judge is to consider all of the arguments that are made in a case. I look at the evidence. I talk to the defendants about the harms that they have.
I'm sure that helps a lot with the chiding.
Engaged in. Many of these defendants are people who.
Okay, Judge, with respect, you're not answering my question. You're right. You talked to them about the harms. Let me read you again from what you said at the bench. You said in this instance with Mr. Chazen, you said among the defendants nationwide who received a below guideline sentence on the basis of a downward variance as opposed to a departure, the average sentences ranged from 84 to 92 months. So that's what you lay out as the average. Our Democratic colleagues say, well, other federal judges sentence below the guidelines. That is true. A number of federal judges do. Our Democratic colleagues have not pointed to a single federal judge in the country who 100% of the time sentences child porn defendants to markedly below what the prosecution has recommended, unless you have a mandatory minimum and no ability to do so. In this case, you say comparable defendants are sentenced to 84 to 92 months. Sentencing guidelines by statute require you to have similarly situated defendants sentenced to similar sentences, but you don't sentence Chazen to 84 to 92 months. You sentenced him to 28 months. Why?
Senator, I've said what I'm going to say about these cases. No one case can stand in for a judge's entire record.
Okay, but I'm discussing
And
every one of your cases. So if you're not going to explain it, then I'm
Senator,
gonna-
would you please let her respond?
No, not if she's not going to answer my
Well, if
question.
you're just going to give a speech, then you shouldn't engage in questions.
you are not taking my time. If you want to filibuster, you're welcome to do so, but do it
I
on your
would
own
at least
time.
give you an opportunity to speak, and you should give her an opportunity to respond.
If she wants to answer the question, I asked her why.
Please
she
allow
sentenced-
her to answer the
I
question.
asked her why she sentenced Chazen to 28 months when comparable defendants, in
So
her
let's
own
hear the
words,
answer.
were sentenced to substantially higher, and she said she's not going to answer. Did you? I mean, I would welcome your
I didn't hear
answer,
that.
please.
Senator, I didn't say I'm not going to answer.
Okay, well,
I
then
said
please
my
tell us
answer.
in this case, Chazen, why did you sentence him to just 28 months?
Senator, you're looking at the record. I don't have the record here. What I will say is that in every case, I looked at
So you
the
don't know?
recommendations
You don't
of
remember that
not only the
case?
government,
But you
but
you remember the
also
trademark
probation
case
office,
with the
the
black
defendant,
Hebrew
the
Israelites. You remember
record,
that
the
case
evidence.
real
I
well.
took into account
The trademark
seriousness
case.
of the offense.
But you don't remember this
and
case.
By the way, you know, one
you
of the
don't
striking
not
things
sure about
in
that
Chazen,
one.
the prosecutor comes
Okie
in front of
dokie.
you and says, this is the prosecutor's argument at this point. And the prosecutor says, I understand from my experience before Your Honor's objection, policy objections to the 2G2.2 sentencing guidelines. And he goes on to say, however, in this case in particular, the 4-point specific offense characteristic is justified because it contains
Ted Cruz, tell me your secret. What are you reading from?
images
Damn
of
it.
infants and toddlers. I'm trying to understand how you see someone that possesses images of infants and toddlers.
Yeah. This questioning brought to you by Dr. Pepper.
Them to 64% below what the prosecutor is asking for. You don't provide a justification other than a generic concern that the guidelines are too high. You don't provide a justification as required by statute. So I'm asking you to take the opportunity to explain to this committee and the American people why in 100% of the cases, you have people with vile crimes, and you have language saying they're vile crimes. But then you sentence them to very, very low sentences. And why do you consistently 100% of the time choose to do that?
Senator, no one case can stand in for a judge's entire sentencing record. I've sentenced
How
more
about
than
7
100
cases?
people. You have 8 or 9 cases in that chart.
Okay, Judge, you said that before. These are the 8 or 9 child porn cases. I will say to correct the record.
I just say to the judge, there's no point in responding. He's going to interrupt you.
Thank you.
Look, I appreciate the chairman trying to filibuster, and if you don't like your witness's answers, you're welcome to provide your own. She is declining to answer the question, and Chairman Durbin, if you want to join her on the bench, you can. But Chairman Durbin,
my job is to make
Chairman
sure
Durbin, I'm not
questions are
interrupting your questioning.
I'm asking you to give her a chance to answer.
But
You
she's
refuse to do it.
consistently said she's not going to answer. I want to clarify for the record, by the way, the case I was discussing was Cooper and not Chazen. But Chazen is the case that I was reading from the transcript.
The chairman's getting a little spicy. Let her answer the question. Ted Cruz, I have to say I'm more with him on this one, right?
Chazen
I
is
love her
equally
to answer the
horrifying,
question,
and
but
you
she's
say in
not doing it.
Chazen,
She's
it's
giving me
something
these
Senator
generic
Graham asked
bullshit
you.
answers.
So the guidelines
It's not an
lay
answer.
out different enhancements, and you say repeatedly, and this is true in all your cases, you say you disagree with the guidelines, you think they're wrong. And the two guidelines you disagree with is one, there's an enhancement for use of a computer, and you say the world has changed, and now all of these are on a computer. And I understand that. I don't agree with you, but I understand that. That is a understandable thing to say. But the second thing you say over and over again is there's an enhancement for the number of images. And you say repeatedly, for example, in Chazen, you say, whatever the state of the law and technology at the time of the guidelines were first adapted, neither the use of the computer nor the number of images are especially aggravating factors today. Now, I find that bizarre.
Where
And
is
you
he
say
reading
in
from?
every case, you say the number of
Give
images
me the
is not an aggravating
documents.
factor, it doesn't matter, and you won't apply
Uncivil
the
Law wants
enhancement.
to talk about it.
Do you really believe that a predator that has hundreds or thousands of images of hundreds or thousands of children being sexually violated has not
He is
committed
technically
an
my
offense
senator, so I could
is
call him as a
more
constituent.
serious than someone that has a single picture of a single child? A single picture of a single child is
All right,
horrifying.
Uncivil Law's calling Ted
But
Cruz's
hundreds
office.
of
Hold
children that
on.
have been violated, do you really believe that is not a more serious offense?
Senator, I did not have any cases involving hundreds of thousands of pictures.
No, I said hundreds or thousands. You had cases involving hundreds and you had cases involving thousands. You're right, you didn't have hundreds of thousands.
And I also applied an enhancement, just not to the degree of the guidelines.
You're
So I-
right. It's a 5-point enhancement under the guidelines. You provide 2.
Yes, so not 0,
Okay, you're right,
not the
but-
suggestion
But,
that I
but
did.
are you suggesting the number of images doesn't matter? Because you say it in court over and over again that the number of images doesn't reflect that it's a more serious crime. Do you really believe that?
Senator, as I said to Senator Graham, the court is taking into account a number of circumstances. The commission has done a report about the operation of the guidelines, which enhancements actually reflect different levels of culpability with
So
respect.
let me ask you this, Judge. You've said the purpose of sentencing is to distinguish between crimes that are not as serious from truly egregious crimes. Is that right?
No, Senator.
So what is the purpose of sentencing if it's not to distinguish from less serious crimes from truly egregious crimes?
It is to assign proportional punishment. It is to do justice in cases where you have defendants who are convicted of the same conduct, but have differing levels of culpability.
Well, I will point out that you have a pattern. It doesn't matter how egregious the case is. Senator Hawley talked about the Hawkins case where you had an 18-year-old with pictures of boys as young as 8 being sexually assaulted and raped, and you sentenced him to just 3 months in jail. And I will point out the Stewart case, the last one on this list, because we're running out of time. The Stewart case, you describe that he had over 6,700 images and videos. So that's a lot, 6,700. That's a lot of kids
Time
being
expired,
sexually
Senator.
assaulted. You have taken over a minute of my time, Mr. Chairman. So
You've been given extra time. You usually ask for it. You're given it.
okay, I know you want to interrupt. I know you don't
I
like
just
this
want you
line
to
of
play by the
questioning.
rules.
I know you like to interrupt, but
I
you've
like you
consumed a
play by the
substantial
rules.
question of my time of my questioning, and I'm going to ask my questions, and you can, if you
Senator-
want to testify, you're welcome to.
Senator,
Judge,
you play by the same rules as
in
every
the
other
Stu-
senator.
in the Stewart case, you said from the bench, thus, although this is not necessarily an atypical case, your child pornography possession crime was egregious in the court's view. Okay, so this is a bad one. If you're actually sentencing defendants, you said this was egregious. What did you sentence Stewart for? The guidelines said 97, 121 months. Prosecutor said 97 months. You said it's egregious. 6,700 images. You come in with 57
Time
months.
has expired.
Why
Senators
did
use
you
2
sentence
minutes
him to
over the
just
allotted.
57 months in the Stewart case? Do you want to address that? Because you're claiming it's cherry picking. In fact, you're welcome to explain any of these cases, but let's take the Stewart case.
Senator
Why
Coons,
did you sentence him for half the amount?
you're not recognized, Senator. Senator
If you,
Coons,
you don't want her to answer that question?
you wouldn't allow her any.
Mr. Chairman, she may answer the question. I've asked her why she sentenced Stewart
You've
an
gone over the
egregious.
time, Senator, by 2 minutes.
Why she,
and a half.
because you've interrupted me for 2 minutes, Mr. Chairman. Will you allow her to answer the question, or do you not want the American people to hear why, with someone she described as an
There
egregious.
comes a point, Senator, where you get a little bit.
Chairman Durbin, will you allow her to answer the question?
You won't allow her to answer.
I will happily allow her to. The question is
Senator
why
Coons, you may
Thank
you
proceed.
sentenced Stewart, an egregious child pornography possessor,
So,
to
Judge Jackson.
half of the amount
Please, Senator.
requested by the prosecutor.
Please, Senator.
Will you allow her to answer the question, Chairman Durbin?
Senator Coons.
Thank you.
Why are you not allowing her to answer the question? There's
You're
not
over the
another
time
senator
by
here
2
that
and a
you've
half
not allowed her to answer the question.
You're
I'm
finished.
not asking another question, but allow her to answer the question, Chairman Durbin.
Thank you, Chairman.
Why
Durbin.
do you not want the American people to know what happened in the Stewart case or any of these cases? Chairman Durbin, I've never seen the chairman refuse to allow a witness to answer a question. You can bang it as loud as you want.
Well, I can just tell you, at some point, you have to follow the rules.
Okay, will you let her answer the question? You've been interrupting, and by the way, with Senator Graham, it went 10 minutes over. You've
sure
taken a
did.
big chunk of the time. Will you allow her to answer the question?
You've given her.
Why
no
are you afraid of her?
opportunity to
She's
answer.
welcome to answer it right now. Will you let her?
Senator Coons.
Will you let? So no, you don't want her to answer the question?
Senator Coons.
Will you let her answer the question?
Chairman Durbin,
Apparently,
Judge
you are very afraid of the American people hearing the answer to that question.
we here in the Senate, in this committee today, are in the middle of a policy fight. It's my understanding that across this nation, more than 70% of district court judges who impose sentences in cases such as the ones that have been so vigorously debated here depart downwards from the sentencing guidelines, from the requests of the prosecutors. And as you've explained repeatedly and in detail, that's because a sentencing judge is required to weigh a whole series of factors. How many opinions have you written as a judge, Your Honor?
I've written it.
All right, so Ted Cruz's office, who I'd like to
And
remind
in how many
you,
cases have you imposed sentences?
Ted Cruz's
as a
office,
federal
who I'd
judge?
like to remind
More
you,
than 100 cases.
is my
And across
senator,
all of those,
was a bit of a dick
we've
to
just
me.
heard very forcefully assertions made about you and your character.
Senator
and your
Hawley's
capabilities,
office was
your
really,
background,
really nice to me.
narrowing in on just
They
a
spent
few.
12 minutes on the
And I
phone
would
with
simply
me.
put for those who are
Senator
watching
Hawley's
and trying to
office.
understand what all of this is about.
They didn't even ask me if I was a
that in an
constituent.
attempt to distract
Senator Cruz,
from
who is my senator,
your broad support,
their staff
your
was a
deep
dick to me.
record, your outstanding
I
intellectual
was like,
and
do
legal
you, I
credentials.
was asked, so I was like, do you know where I
that
can find this
we
material?
are taking what is a policy
She
dispute
says,
that should be
no.
decided by members of the Senate.
It's like, if you have an
If
opinion,
we
I'd be
want
happy to forward it
change the
on.
sentencing guidelines
I'm
to
like,
make
I
them
don't have an
mandatory
opinion. I
rather
just
than
want the underlying
advisory.
material.
If we want to change
Well, I don't know
the
where I could find that,
structure
but thank you for
within
calling.
which
She
a
tries to
federal
hang up on me.
judge
I'm like,
imposes
could you
sentences, we could do
perhaps
that.
ask and get back to me?
But to
She's like,
demand
sure,
that you be
I'll
held
get back to you.
accountable
Thank
for
you
this
for calling.
practice
I'm
that
like,
is
do you want to
nationwide
take down my
and is years
contact
old,
information
I
so
view
you can
as
get
an
back to
unfair
me?
misrepresentation of your record.
She's like, is it the number
So
on the
if I
caller
could,
ID?
Let's
Okay,
go
well, we'll
to
get back to
something
you.
that you did as the
She
vice
totally is
chair of
ignoring
the
me.
Sentencing Commission.
Senator
an
Ted Cruz's
important
office
vote
was a
that you
dick
took
to me.
in 2014. Because in my view, it shows how
And
fundamentally
he represents me.
misguided are the
Unlike Senator
attacks that
Hawley.
try to characterize
Jerk.
you as someone who, at all costs, will do what you can to help criminal defendants. Let me just lay out the context for a moment. In 2010, Congress, enacting a policy choice, unanimously passed the Fair Sentencing Act, a bill that reduced the disparity in sentences between crack cocaine and powdered cocaine from 101 to 18 to 1. And the Sentencing Commission unanimously concluded this law meant those currently in prison on crack offenses could seek to shorten their sentences. 4 years later, the commission further concluded that individuals who provided substantial assistance to the government, people who cooperated, who helped out the prosecution, could use this law to shorten their sentence retroactively beyond any break they might have gotten for their cooperation. But you disagreed. In your public remarks at the time, you explained that although given your prior service as a federal public defender, it might seem logical you'd support this direction, you could not do so because you concluded it was manifestly inconsistent with the law and would create unfair disparities between those previously sentenced cooperators and those sentenced today. Essentially, if I understand your view, it was that the sentence of a cooperator shouldn't be understood to be based on the sentencing ranges modified by the Fair Sentencing Act,
but was best understood as a fixed discount of the mandatory minimum that a Fair Sentencing Act had not changed. I know this is technical, but I just wanted to make sure I'm characterizing this correctly before reaching a conclusion. Do I understand the context correctly in which you made this decision?
Yes, Senator, perfectly. It was debate among the commission, one of the very few in which we couldn't reach agreement about the retroactive application of the Fair Sentencing Act reduction.
And so just to finish the framing, the Sentencing Commission, which often decides things unanimously, was sharply divided. And here's who was on each side. You voted to deny relief to cooperators, to deny them a pathway towards reducing their prison sentences. And you were joined by two conservatives well known to us, Judge William Pryor and now Judge Dabney Friedrich. And the three of you were outvoted by four commissioners, which
Maybe we should
included
call my
Judge
other senator.
Hinojosa,
He's
an
also on this
individual
committee. See if he
nominated
can
by
help.
President Reagan and described as a hard-nosed, no-nonsense judicial conservative, who was on the other side of the argument from you. So you've got four commissioners, including an outstanding conservative Reagan nominee, and they thought the law could
Well, I've
be
sent him an
interpreted
email
to
for all
give
the good it will do
a
me.
break on sentencing. And you were on the other side of that argument. If, as someone has tried to paint you, you simply were determined to give every break you could to criminal defendants, all you had to do was join the majority and this would have passed. But that's not what you did. Help me understand why not.
Thank you, Senator. As you say, this is a sort of technical kind of in the weeds discussion, but the top line is that when I looked at the issues and I looked at the law, it was my opinion that the law did not provide for the further reduction that was being considered.
So across an incredibly broad range of sentences you've had to impose and cases on which you've had to opine, I'm picking this one in part because it's not getting any attention in this confirmation process. But for folks who'd like some insight into how you make decisions and how you explain those decisions.
all I asked for is
there
what
was a
is the
video
underlying
publicly
material? Can I
available
get it?
Of your April
And she didn't
2014
even ask if I was
public
a
meeting of the
constituent. I
Sentencing
mentioned it in the
Commission, where
end
you
as she
laid
was hanging
out,
up on me.
your position. So I
I'm
encourage
like,
folks to just
by the way, I'm a
watch that.
constituent. She's like,
And
bye.
they'll see a jurist who
Jerk.
understands that her commitment above all is to determine what the law requires and then follow it. In my view, that's an individual who belongs on the Supreme Court. By the way, your position that the law required that there not be further
Let me
breaks
check out the
given in
Senate
this
Judiciary
context
Committee
ultimately
and
won
see if
the
it's
day.
like there now
My
or
colleague
something.
from New Jersey made a point of mentioning a relevant case, United States versus Booker, yesterday. I have to say that in this case, it was decided in Coons versus United States with a K, not a C. Look, we all have our judicial record from which we work. But the Supreme Court ruled for exactly the same reasons you did in this argument that was made public. So
No.
I just think, Your Honor, this is an example of you looking hard at the law, making a tough decision, ultimately being vindicated in that decision, but taking a position that is not the caricature that's been proffered by some of you. Yesterday, I ran through a number of the letters and statements that debunk some of the attacks that have been levied based on a handful of sentencing decisions. There was the National Review piece by a conservative former prosecutor who calls out the smear on your sentencing practices in cases involving child pornography. The statement by the Fraternal Order of Police and the International Association of Chiefs of Police endorsing your even-handed and judicious approach to the law. The glowing letter from 24 prominent conservative attorneys and the resounding recommendation we heard in person.
Nick is
from
still
Judge
streaming, by the
Griffin.
way. He
There's
is
also
still
been
streaming. Nick
received
is still
here a
streaming.
Letter from a number of retired federal judges, including two Republican nominees, rejecting this mischaracterization of your sentencing record. As I've said, this is a policy dispute that we should be deciding, not an appropriate basis on which to mischaracterize your record or your character. We have letters from the National Coalition of Domestic Violence, in addition to these law enforcement leaders, from survivors, advocates, crime victims. The breadth of your support from the very communities my colleagues have suggested you're making less safe shows just how off base these attacks are, and in my view is a testament to your qualities and qualifications. So we all agree, all of us, that it's critical to protect our children and prevent the kinds of heinous crimes we've heard about in some detail earlier today. It's why I'm introducing a bipartisan reauthorization of the Victims of Child Abuse Act,
Not
something that
a
we could act on as a
chance.
committee to do our
Not
job,
a
which is set
chance.
policy and pass laws.
You are looking
But I
at the
also
next
frankly
Supreme
think we
Court
need
justice.
to be mindful that we are asking of you to get engaged in that policy dispute in front of this committee, which is not the role of a judge, something you well understand. Let me turn, if I could, to another reason I think you're deeply qualified and that you will bring something important to the Supreme Court. Brian Stevenson, one of America's leading civil rights lawyers and by happy coincidence, a Delaware native.
What's going on?
Has spoken about how achieving justice requires being proximate.
What's happening now?
To the people most impacted by the criminal justice system.
Don't mess
and
with
you've
me
done
about that.
As a public
Don't mess
defender,
with
you've
me. I
represented
will ban your
individuals in the
ass.
criminal justice system. As a district court judge, you have
That is
looked
not
individuals
funny.
in the eye and told them that for their crimes against society, they will spend years or decades in prison. You have met with, fought for, and advocated for victims. You've also studied the big picture. As an effective and engaged member of the Sentencing Commission, you've pored over data, reviewed thousands of letters, and thought hard about the appropriate national approach to just punishment in a more policy-oriented role. You've also thought about the big picture as a judge when considering the precedent that your opinions set. I'd be interested briefly in how your experience on the Sentencing Commission shaped your approach as a district court judge and how the interplay of all these factors might shape or contribute to your decisions as a Supreme Court justice.
Thank you, Senator. One of the things district judges, sentencing judges often say when asked about the task is that sentencing is the hardest thing that a judge has to do. And it's in part for the reasons that you have articulated, that it's one thing to understand the law, to read it in a book. It's one thing to look at data and numbers and make policy based on that. It's quite another to have someone in the courtroom, whether as a victim of crime or a defendant who's perpetrated a crime, and have to decide how to proceed and pronounce sentence on that individual. The work that I did on the Sentencing Commission, which was prior to my becoming a district judge, I think enabled me to understand unwarranted sentencing disparities, to understand some of the policy reasons behind the guidelines, and to make the kinds of evaluations that the law now requires since the guidelines are no longer mandatory. And I felt better in a sense about the task of calculating the guidelines, which is what courts have to do at the beginning of a sentence. They can be a little complex, and having been on the Sentencing Commission, I think that helped. And some of these cases do make their way to the Supreme Court. So I think that I am prepared to handle the cases that involve sentencing that do go
Man,
to
you
the
got
court.
me.
In
You got me in
preparing
a
for
tizzy,
this
man.
Confirmation, I went back and read a lecture you gave, but it was later published in the Harvard Law Review about the balance, the challenge of sentencing, about that moment. I had the joy, the blessing of clerking for a judge on the Third Circuit. My legal skills and talents did not allow me the opportunity to clerk for the Supreme Court as you did, and also the District Court and also the Circuit Court. But I clerked for a judge who I first met when she was a district court judge and imposing a sentence on someone who was a crack dealer. And she did a remarkable job of speaking to the victims, speaking to the community, speaking to the prosecutor and the defense attorney, and then speaking directly to the defendant in imposing a very long sentence. And as I got to know her later, I recognized that, as a member of our community and as someone who saw the importance of that moment, that public moment of helping the defendant understand what they'd done so that they might somehow change, but also helping the victims understand what had happened, that she took that very seriously, incredibly seriously. In the Harvard Law Review publication of your remarks, you said that you're persuaded by the theories of punishment that accept all human beings are responsible moral agents, and you view punishment as a necessary consequence of the defendant's decision to engage in criminal behavior. You also went on to say that the challenge is balancing the acknowledgement all of us are more than just the worst thing we've ever done, but there is a need to ensure the defendant is adequately addressed and punished. What I think you say in that lecture, what you've shown across the arc of your public service, reveals someone who understands the appropriate need for punishment in our society, but who is also striving to follow the balance of recommendations, guidelines, statute, and the context and facts. And I trust that as members of this committee and the Senate as a whole and the general public take the time, which they should do, to give a fair reading to the whole scope and arc and reach of your service, that they'll see you as someone.
I would love
who
to
cares
give a
deeply
full
about our
reading. I would love
Constitution
so
and the
very,
rights
very
that make
much
us
to
free.
give a full
As
reading
you
to these
said
cases. You have
in
no
your opening
idea how
statement.
much I want to give a full reading to
Your
these
career in
cases.
the law,
I'd
your
love
service on the
to.
bench,
I'd
your
love to.
thoughtful
Please,
responses to
someone tell me
questions
where it
put to
is.
you, the way you've maintained your composure, all impress me. As I
Maybe Senator
mentioned,
Coons knows. Maybe he'll give it to me.
I don't think labels such as a judicial philosophy are always that meaningful or dispositive. I think in your case, a deep admiration for the Constitution and an understanding that the role of a judge is a limited one are critical and qualifying. You opened yesterday by referencing how your parents were educated in racially segregated schools in Florida, but how you, just one generation later, were raised in integrated schools and had far greater opportunities to put your evident God-given talents to work in
Nick has
service
it?
to our nation. You cited this one generation change as an example of the greatness of America. Of course, the Supreme Court played a central role in more correctly interpreting the Constitution and applying it in a manner that allowed this reversal of unjust law to occur. I think the experiences of your own family and your connection to the experiences of trailblazers who came before you, on whose shoulders you stand, has meaningfully shaped what kind of a justice you will be. I think you know in your bones how important our Constitution and the rule of law is. And I think as someone who served on the Sentencing Commission, a public defender on the trial court, and appellate court judge, you have the ability to see across the whole scope and reach of how the law impacts families, communities, and our nation. Last, in some ways, I think most importantly, I've learned that as a person and a judge, you have humility. Judge Griffith, who came before this committee to introduce you, and scores of others we've heard from, I've just referenced,
Do I really have to
lauded
enter
your
my credit
practice
card
of
again?
judicial
God damn it.
restraint. And you've said a core component of your philosophy is your understanding that the judge's role is a limited one. Well, I think restraint is a core part of your approach to decision-making, partly because you are a judge who is humble enough to know that the Constitution and the laws passed by Congress say what the law is. The judge has a limited role in deciding questions of law based on facts presented. Penn Law Professor Lisa Fairfax, your other introducer, your dear friend, explained that since college at Harvard and then through law school, you've been a mentor and a role model. She praised your warmth and intelligence, your devotion to friends and family, but she also mentioned your humility. She knew you were honored and humbled by the significance of this moment, not what it means for you, but what it means for our nation. I remember thinking about this on Monday, and I had a chance to talk to your brother Ketanji, and he mentioned that he knew you were destined for this moment your whole life. I am sure he would say you've been exceptional since you were student body president at Palmetto High School. I suspect your wonderful family upbringing is partly responsible for this facet of your character. I suspect your faith has played a role in sustaining you, as mine does, and so does many others in this room. I've often found instruction and comfort in the verse, "What does the Lord require of you but to do justice, love mercy, and walk humbly with your God?" Now, I'm not going to ask you to reflect on that verse, Your Honor, but I wouldn't be surprised if it's one of your favorites that sustains you. Let me close by returning to what Judge Griffith said when he told us in his heartfelt introduction of you on Monday, and something you've also shown in the hours you've been grilled by this body. He'd already written a letter to this committee delivering his endorsement. He took the extra step to then amplify it in person. And he did so because of confidence in you and because he was delivering a message to us as a committee that Supreme Court confirmations should be more than just exercises in partisan tribalism. He said there should be nothing unusual about a judge who just happened to be appointed by a Republican president and who holds conservative legal views coming forward to support a nominee with your impeccable qualifications and character, especially a nominee whose legal opinions, whose actions and decisions as a judge, he was in a position to review for years, given that you were a district court judge and he was a circuit court judge. Look, our confirmation hearings for justices have sadly been devolving over many years into longer and longer exercises of partisan politics, punctuated by just brief glimpses and occasional thoughtful examinations of a nominee's judicial decision-making and views on the Constitution, which should properly be our main focus. I have to believe this sad state of affairs troubles my colleagues of both sides and all who watch this. But as I reflect on these hearings, I'm hopeful that your gracious, thoughtful exchanges with some members will be remembered as just one more service you've rendered to our nation. And I hope some watching these hearings will be reminded that even though we disagree with the policy preferences or opinions of a nominee, we should all recognize when a nominee is fundamentally qualified, deeply committed to the Constitution, rule of law, and a person of great character. Judge Griffith reminded us at the outset of this week, and I quote, "As Justice Scalia taught us for so long, an indispensable feature of the republic the Constitution created is an independent judiciary of judges who've taken an oath not to a president or party, but to the American people and to God that they will be impartial." I couldn't agree more with Judge Griffith. You've demonstrated your unwavering commitment to that oath and your impartiality, and your abundant qualifications. It'll be my honor to support your confirmation for Associate Justice. With that, Mr. Chair, I yield.
Thank you, Senator Coons. The senator from Nebraska, Senator Sass.
Thanks, Chairman Durbin. Judge, welcome back. I'd like to associate myself with parts of what Chris said there in his closing. I would differ with him about whether or not getting to precision on judicial philosophy matters, but you know that. You and I have been wrestling about it for a couple of weeks. But I'd like to affirm Chris's point about the beauty of the hymn to America you told, and through the eyes of your parents and the changes, the growth in the country over the course of the last 2 generations. And the Wall Street Journal had an editorial this morning that said pretty much the same thing as Chris just said, which is that the hymn to America that you gave in your opening on Monday afternoon and some of your comments yesterday were inspiring and beautiful. So I associate myself with Senator Coons on that. I'd like to talk a little bit about your time as a judge and particularly how you see development and growth and change over that time. So take us back 9 years and then maybe 5 years ago and then today. How has your approach to being a judge changed from year 1 to year 5 to today?
Thank you, Senator. I do think there was a little bit of growth. I hope there was a little bit of growth. Certainly in year 1 and year 5, I was still a district judge, and both of those years differed dramatically from my work as an appellate judge, which is where I'm currently stationed. In every job, in year 1, you're new, you're trying to figure things out. I don't know that I had quite pinned down at the very beginning exactly how I would approach cases, but by the time I got to year 5, I think I had a really good sense of this judging thing and was able to demonstrate in my opinions, the many, many opinions that I've written, the way in which I go about making my decisions. I was able to demonstrate clearly, I think, that the particular parties in the case, the issues in the case, what it's about from a standpoint of personal preference is not an issue. I'm setting those things aside. I am ruling from a position of neutrality and trying to determine in every case what the law requires. I am looking at only the facts and the law in the case. I'm evaluating the arguments of the parties, and if it's statutory interpretation, I'm trying to ascertain what Congress has intended. I am committed, I think my record shows, to the understanding that that is the role and the only appropriate role for a judge.
I'd like to talk a little bit about the troubling pattern we see on law school campuses and across higher education more broadly, especially in the last 5 years. There's obviously a trend toward shouting down and canceling opinions that are outside the left-leaning mainstream. Calls for firing professors, canceling professors, shouting down and sometimes threatening speakers who bring diverse opinions, calls to discipline fellow students. These tactics are increasingly commonplace, particularly against conservative speakers and professors and students, but also increasingly against traditional liberals. I'm a former college president, and one of the sort of oddities that doesn't fit inside the tribalism of how a lot of times media covers things in DC. One of the oddities for me is how often I have liberal professors reaching out to me saying that their experience on campus is becoming much less interesting, that the divide on American political campuses is less
I'm
and
sure we'll get a
less,
non-answer to this, but this
conservative
is a good
policy
question.
leaning versus liberal or progressive policy leaning, but more and more liberal versus illiberal. And I think these campaigns are obviously deeply problematic. They shut down debate rather than teaching students how to engage ideas that they might not have encountered before, which is also a pretty decent definition of education. If you already knew everything before you ever encountered a new idea, you wouldn't need to write checks or take time off of productive life. So there's obviously a tendency in response for students to self-censor rather than learn from each other. And this robs students of the chance to engage with ideas from across the political spectrum, but in particular in law schools.
Liberal is a word,
it
yeah.
robs students of the opportunity to learn how to consider an alternate position and argue a different point of view than they might have had. So given that you're a debate champion in earlier days as well, I'd like to ask if you agree that law students should be engaging with ideas from across the political spectrum, even those they disagree with, rather than trying to shun those different ideas.
Thank you, Senator. Let me just say, in part because these issues are things that could implicate matters that come before the courts, I will just say that as a general matter, law school, like many schools, is a place where ideas and perspectives are considered. And in the law, as I've said, it's important for the judge who's making the decision to have different arguments. And so one of the things that traditionally happens in law schools is that you are trained in law to make arguments that are at times not even the arguments that you personally agree with, because the understanding is that in litigation, in disputes that come before the court is going to want to hear from different viewpoints. So in that sense, the essence of legal instruction is to have different arguments being made, because that models in great part what happens in a courtroom.
I really am not trying to ask any kind of gotcha question here. I
Yes.
suspect we highly agree, so I don't understand the qualification you put at the beginning. There's no sort of second order fork on my question. It is better to debate ideas that you disagree with than shout them down, isn't it?
It is better in law schools to make sure that there are ideas from all perspectives, and in order to have that happen, they can't be suppressed.
So you don't want students shouting down other students or visiting professors, right? I mean, I'm honestly, I didn't think there was any chance we would differ on this. So I'm not.
Yes, no, I'm not.
Okay.
I'm not suggesting
You're
that we do
against
differ.
canceling people, I assume.
I'm not suggesting that we differ. What I'm saying is that these issues about speech.
Why is
on
Branko having a
campus
stream?
and the
Why isn't
like are
Branko
the
on
kinds
my
of
stream?
things
That's a
that
good
are
question,
issues
right?
that are working their way, in different formats and different ways.
All
through the
disrespect.
courts. And so
You
I'm
get
just being
nothing but
careful
disrespect from my
in
fellow
terms
law
of
students today.
my answers.
Okay, I'm
gonna try not to take
lead
it
you
too
because I
personally.
want to, because I think American civic health will be better off. You're going to be a hero. You are already a hero to lots and lots of kids, students, maybe some bound for the law, but more broadly, students across the country. And I think it's in America's public interest for them to hear you as an advocate
He's got a
for the
stream
full,
in
vigorous,
20 minutes.
strong kid debate of different views.
So much
And
disrespect.
I suspect you are an advocate for vigorous and robust debate. I don't see how you might be constrained against saying that because of future cases, but I'm going to just assume we're mostly aligned on this.
I think that's a fair assumption.
Thank you. I do want to make, before I move on, just because we've had a number of members of this committee comment on cameras in the court. I've made my position on this clear a lot of times, but if I can give a tiny bit of friend of the court brief in advance, because I think when you're on the court and you all continue to debate this issue, I think it should be a decision for the Supreme Court.
When
to
you're
make
on the court,
about
Ben
whether or not
Sass
there are
knows the
cameras
truth.
in the courtroom.
This is
Not
happening.
a decision for the Article 1
This is
branch
absolutely
to make
happening.
for Article 3.
It's just a question of how many
But
votes, man.
I think it's incredibly important for us
This is
to
absolutely a thing
recognize,
that's
'cause
happening.
I think I differ from a lot of my colleagues on this who are advocates for cameras in the courtroom. I get their position. That transparency is a virtue. Transparency is a good thing. I also believe that pen and pad can facilitate a whole heck of a lot of transparency just fine. And it's healthy for Americans to recognize the second.
I think this is a fair point. I think the Supreme Court is in some ways the most transparent
institution
branch.
doesn't work well is because we have
Because they have to
cameras
explain everything. A senator doesn't have to
cameras
explain their
change human
things,
behavior.
right? They don't
We
have
know
to
this.
explain their
You don't have
reasoning.
the same kinds of conversation.
Like
over the dinner
everything
table,
that's submitted to them
with your
isn't
family
submitted
when
in
you're
the
wrestling
open.
through issues,
Right?
and
Senators get all kinds of
apologizing for
stuff that
something
they
and
don't
saying, I said this
necessarily
before,
talk
but maybe I
about.
should modify
Supreme
what
Court,
I
everything's
said.
in the open,
My
man.
tone was jerky. My substance didn't account for your position. There's a whole bunch of things that humans
No
can
way,
do
Kurt, you're
if they're
wrong.
not immediately
Wow.
mindful of
I
some
feel
distant
unloved.
camera audience
I
that
feel
they
so
might be trying
unloved.
to create a soundbite for. And Instagram can be useful for some small things, but for intellectual discourse, it is not a friend. And I think we should
Looking
recognize
for
that
love in all the wrong
jackassery
places.
we often
Looking
see
for
around
love.
here is partly because of people mugging for short-term camera opportunities. And it is definitely a second and third and fourth order effect that the court should
Supreme
think
Court
through,
didn't explain shit in
before it
regards
has
to election fraud
advocates
yesterday.
in
They just
there
didn't provide
who are
the
not
explanation
only
you
trying
wanted.
to persuade you 9 justices, but also trying to get on cable that night
There was they
or
made
create
this,
a viral video. So for what it's worth, I hope that the court doesn't respond
and so did every
to
court that touched those cases.
some
They were all
well-meaning,
explained.
impulses from the Congress to push for cameras in the courtroom, but also some bullying. And there are ways that you can get to a lot of transparency. Audio recordings are increasingly released from the Supreme Court in timelier
I don't think that
fashion over
happened
the
at the
past few
U.S.
decades.
Supreme
So
Court.
for what it's worth, I'm glad that you
I-
are
that might have
making that
happened
decision, and I hope it isn't made for you
in
by
some
the,
other
by the
court. I don't think
Congress.
it's ever
I want
happened
to
in
go
the
back to the
Supreme Court.
legitimacy of the Supreme Court. That term has been used a few times over the last
But I
3
could
days.
imagine that
Do
happening
you
in
think the
some
Supreme Court is legitimate?
situation that might be rare.
I do, Senator.
And so some of the ways that the court has been derided and called illegitimate by members of this Senate include, over the course of recent days and weeks, quote, leans into extreme partisanship, leans into extremism, twists the law, threatens basic liberties, has been hijacked by Republicans. These kinds of attacks undermine the public's trust in the court. We need the public to believe
Yeah,
in the
Nick
legitimacy
was reviewing
of its
yesterday's
government,
stuff
including all
when
three
she had on the red.
branches.
That was yesterday.
So I would
Today is
ask
blue.
you, do you
Yesterday was
agree
red.
with
Today's
these
blue.
characterizations of the court that have been levied in this room?
I forget what
over
day
the
one
last few
was.
days?
My memory doesn't go that
Senator,
far
I have
back right
nothing
now.
but respect for my former judicial colleagues, my current judicial colleagues, and hopefully my
Am I
future
being petty?
judicial colleagues. I do
Was I
believe
being
that
petty?
we need legitimacy. I've said
Yeah,
that
I
that's
didn't. I didn't
the
think I was being
currency
petty,
of the
but I
court,
apologize
and
if I
I
was.
look
I'm sorry.
forward, if I'm confirmed, to joining the institution.
So do you think there could be any opinion that would be handed down this term that could undermine the legitimacy of the court?
Senator, I think the Supreme Court makes its determinations, and all of them are precedents, and they are entitled to respect.
I'd like to come back to our conversation from yesterday. You pointed out a number of times that as both a district and now a circuit court judge, you were constrained and bound by the Supreme Court's holdings. You mentioned a couple of times that you haven't had a chance to do much constitutional interpretation for yourself. I largely agree with the way you framed most of that for the lower courts. But I think you would also agree with me that the job of a Supreme Court justice is different than a district court judge, and in certain ways from a circuit judge as well. When you serve on the Supreme Court, you'll have to interpret what the Constitution means. And based on what you told us about the constrained role on the lower courts, lower court decisions would then not be able to answer how you would approach the new job you would have of the highest court. And so that's why I thought our conversation on judicial philosophy yesterday was somewhat helpful. I'm not a lawyer, but I think you took a lot of us to law school yesterday in ways that were helpful. And in particular, you walked us through some different schools of constitutional and statutory interpretation in ways that I think were good for the committee, were good for the court, and were good for the public more broadly. So I guess I would ask you if you could take us to law school one more time and walk us through some of the different approaches to substantive due process and unenumerated rights. What are the different ideas
among the many stupid ideas? Is let's get her LSAT. It doesn't fucking matter.
Thank
It doesn't
you,
matter in
Senator.
any possible way. Who
am,
cares what her LSAT was?
Not
No one
mostly
cares. It's a
familiar with
stupid thing
the
to ask for. It's a
Supreme
totally
Court's
stupid thing to ask for.
precedents in this area.
Who cares? It doesn't matter.
It's
What a stupid thing to
been
ask
a
for at
while
this point.
now
You know,
that the Supreme Court has determined
whoever's like, let's get her
that,
LSAT. Yeah, that was Tucker Carlson's thing, wasn't it?
the 14th
Tucker
Amendment,
Carlson's like, why can't we get her
which,
LSAT? I'm like, Tucker, you're being an idiot. That's such a
guarantees
stupid thing
due
to ask
process,
for. Who cares?
includes
No one
a
cares.
substantive component in addition
No one
to
cares. Tucker, what are
procedure.
you even doing?
The term due process, one would think, is just about the
They cared about Kavanaugh's yearbook.
procedures
Yeah, that was
the
equally
government
stupid,
has
though.
to afford you
That was so
before
stupid,
it,
too.
affects your
stupid.
life, liberty, or property. But the Supreme Court has also said that that protection extends to certain personal, individual rights that relate to dignity and autonomy.
Her net worth is 23 million.
And that are deeply
that's a
rooted in
lot.
our nation's
Unless her
history
husband
in
has picked up that
traditions
somehow,
or
but-
implicit in the
Yeah.
concept of ordered liberty. And the kinds of things the court has recognized pursuant to that line of jurisprudence are things like marriage.
I'm sure she did great on the LSAT.
Interracial marriage.
Again, to Harvard, I'm sure she did great.
The access
She
to
probably did a 170
contraception,
plus.
a woman's right to terminate her
Who cares?
pregnancy, abortion, pursuant to or subject.
I'm trying to remember what
the-
I did.
the
I think it was
framework
158 or
established in,
163. I don't
Roe and
remember.
Casey.
It's one of those.
Travel. There.
So I'm sure she kicked my
child
ass.
rearing, the ability to direct your children. Those are some of the rights that have been recognized pursuant to the 14th Amendment due process clause. I'm less familiar with the sort of scholarly debate outside of the Supreme Court's rulings.
So will there be new ones in the future?
Senator, I
husband
am
is a
not
sixth
able to
generation graduate of Harvard.
forecast.
I
In
mean, yeah,
every
I'll do it.
case, the Supreme Court is looking at a particular set of circumstances consistent with the Article 3 requirement that the court look only at cases and controversies. So it would depend on what cases came before the court.
So I think that gets at the challenge here that you and I've been going back.
I need
and
some
forth on
water.
over the course of a couple of weeks, because I get the modesty points about being on the district court, but it seems pretty important to understand what the limits might be as a justice. And so I think this morning, again, you stated that I think the quote was that your judicial philosophy is your methodology. But I think that a judicial philosophy of some kind is necessarily an input into your judicial methodology and into every justice's actual jurisprudence on the court. And that's why I think it's important for us to unpack that, because the philosophies that you've outlined for the committee, again, I think yesterday's back and forth that you and I had on Breyer v. Scalia is important, and you wouldn't claim any of those philosophies for yourself. And yet I think the philosophies ultimately instruct judges on the sources and the tools they consult, on how they discern intent, on whether the Constitution is protecting specific, limited, and defined principles, or more general values, and whether modern values can be used to infuse our understanding of the Constitution. So again, when you narrated a bit of the debate between Justice Breyer, I know you've got lots of intellectual inputs in life, but you've credited him as a brilliant jurist and role model before. And the Scalia debates, you didn't really tell us who you thought got the better of the argument. And so I think throughout these 2 days, you've focused a lot on what the Supreme Court has said. And I think that is helpful and important. But I've been also trying to get at what you think the limits might be on what Justice Jackson would be constrained by. So I feel like, I believe we still haven't heard your judicial philosophy. And I wish I'd made more progress with you on that. But what we do know on a personal note is that these committee 3 days have been very long. And I want to thank you, and got to have a nice conversation with your parents earlier, your whole family, for what you've endured, and for spending time with us. And obviously wish best wishes to you and your family. Thank you, Judge.
Thank you.
One more minute.
Thank you, Senator Sass, and Senator Blumenthal is next.
Thanks, Mr. Chairman. Good afternoon.
Good afternoon.
Judge Jackson. I know your birthday, September 14th.
Yes, sir.
You have the happy coincidence of a birthday with Constance Baker Motley.
Yes, sir.
Who just happens to have been born in New Haven, Connecticut.
Ah.
And we're very proud that she is a daughter of New Haven and Connecticut. And she is one of my heroes as well. As you know about her, she was the first Black woman appointed to the federal bench. She is the first Black woman to have argued before the United States Supreme Court. In fact, her record before the court was 10 wins and 0 losses. She was very predominantly responsible for Brown versus Board of Education. Thurgood Marshall got most of the credit, but she did a lot of the work. Probably sounds familiar to you. So why don't you tell us, and maybe tell those folks, particularly women and girls who are watching or listening, why you said at the outset of the hearings here that she was one of those whose shoulders you stood upon as you came here today.
Thank you, Senator. Well, in addition to the fact that we share a birthday, which I discovered when I was in law school and thought, what a happy coincidence in terms of someone who I so admired. And secretly at that point, I was thinking maybe I might want to be a judge. So it was a wonderful, wonderful coincidence. I so admired the fact that she was the first. It's not necessarily easy to be the first, but it is an opportunity to show other people what is possible. When you're the first, it means no one has ever done it before like you. And there may be hundreds, thousands of people who might have wanted that opportunity and thought, I can't do that because there's no one there like me. And so being a trailblazer, whether it's Judge Motley or Justice Marshall or Justice O'Connor, being a trailblazer is really inspiring, I think. And I was always moved by Judge Motley's experience, and think it may even be part of why I moved in this direction.
Well, it is inspiring. And I hope that your very inspiring story will make it possible for a lot of others to think it not secretly, but say it out loud and aspire to it, because it's what this country needs. And fortunately, President Biden has recognized it in the nominees that he's put before us. And we've tried to work with the great leadership of Senator Durbin to confirm people of real merit, the kind of qualifications,
Yeah.
intellect,
So,
character, and depth
someone
and
asks,
warmth
we
that you
heard
bring
any useful
to
testimony
us
today?
today.
Did we?
I want to talk a little bit
I don't
about
really
voting
remember
rights,
anything particularly useful. Do any of
because
you remember
part of the
anything
reason why
particularly
those
useful?
dreams now
Other
are
than the fact that
realities
she
is
really, really likes that
more
one
people
trademark case.
have the right to
That was
vote,
useful.
at least
I have some
until
really fond memories of that
recently.
trademark case, man, but I can't remember any of these CP
In
cases.
fact, there
But let me
has
tell you all about
been
this trademark dispute
a lot of
involving the black
backsliding
the
turning
black
back the clock
Israelites.
on voting rights.
Did we learn anything else useful today?
Gentleman sitting behind you, Doug Jones, our former colleague, whom we very
I
much
mean, you know, I
respect
am an
and
intellectual
admire,
property lawyer,
wrote a tribute
so
to
I can get as excited as the
Vivian
next
Malone
man
Jones,
about a trademark case.
who has
But you
a
know,
rich story as a civil rights
Eh.
lawyer, and who succeeded John Lewis as head of the Voter Rights Project. And he said in a speech that Doug Jones wrote in tribute to her as she was inducted posthumously into the Alabama Women's Hall of Fame,
Nick forgot
I'm
to turn his
quoting,
stream off. That's funny.
"We can best honor her by acknowledging that while
I've done that
most
before
doors
many
are
times.
unlocked today, they are still heavy and so hard to open for so many people in Alabama and the rest of the nation. Let us commit ourselves to do our part to open these doors as wide as possible so that everyone can take the walk that Vivian took." I'm going to ask that former Senator Jones' full speech be entered in the record, Mr. Chairman. Thank you.
Where is this record?
The simple fact of the matter is, Judge Jackson, Congress passed the Voting Rights Act in 1965. It was a source of real power.
Peter wants me to
So
stop
many
singing
people
in
who
Nick's
got the
channel.
right to vote for the first
Peter says
time
stop
in
singing.
practical
I don't know, man.
terms, 'cause it struck
I have a song
down
in my heart. I must
more than
string.
1,000
I must sing.
discriminatory election rules proposed by state and local officials. It opened the ballot box to millions and millions of Americans. And it became regarded as the crown jewel of the civil rights movement. And then, just in the last few years, the Supreme Court has hacked away at it in an exercise of judicial activism that has been historic in magnitude. Judges supplanting their views for the policy preferences and official acts of
Judges
legislatures.
supplanting their views
In
for the
opinions
policy
that were written and
preferences
joined by
and official
only
acts of the
conservative
legislature.
justices. These decisions were about as far from judicial restraint as
Judges
they could possibly
substituting
be
their
now, not even
views
close.
for the policy
And they
decisions of
rewrote
the
the rules
legislature.
of our most cherished and most bipartisan civil rights laws. You know the cases: Shelby County, Brnovich versus Democratic National Committee. In effect, their opinions, including Justice Alito's decision in Brnovich, are completely untethered from the clear statutory text, and they impose a series of so-called guideposts on Section 2 that create unreasonably high hurdles to the exercise of the Voting Rights Act. I hope that you will bring to the court that deliberate, careful methodology.
I'm just going to keep
that you
spamming the link for
described
this
earlier.
video
Very
in Nick's
convincing.
chat because it's just
It is
ongoing.
part of your judicial philosophy in the sense that it's your approach to cases. And it has been very persuasively and clearly articulated to cases. And it has been very persuasively and clearly articulated.
And Nick left his
And I
Nick
think
left his stream on,
if
which
that
means from time to
kind
time
of
I can show my
deliberate and careful
video
methodology
in
had
his
prevailed
stream.
on
So there's
the United
that.
States
I got
Supreme
that going
Court,
for
we
me.
would still have the Voting Rights Act in full right now. And I hope that we can once again return to bipartisan support.
It's nice
of
I'm a
those
mod
rights.
and can drop links.
The most recent exercise of unfortunate decision-making in the voting rights area came just hours ago when the Supreme Court struck down the decision of the Wisconsin State Supreme Court in Wisconsin Legislature versus Wisconsin Elections Commission. What is striking is not only the result, but the fact that it was done as part of the shadow docket. We've talked a lot about it here, and what the people of America should know is there's
Oh, someone's bringing out an
oral
easel.
argument.
Someone's
There's
got a
only
visual aid.
minimal briefing. There are no full opinions of the court. In fact,
You know, I think you're
I'm
just
holding up
wonderful.
a
And here's
per curiam
some painting.
opinion
Here's some paintings
that is
from
about
some
12
school
pages in
children
length.
that were inspired
From
by
the
you.
court.
Here's a picture
We don't
of
know who wrote it.
of you on the bench. This was
And
painted by
there
Molly,
is a
who's 7 years
powerful
old.
dissent.
And she
recommend
she
that
paints you on the bench.
Everyone read it.
Aw. And here's a picture by
Again,
Kyle
use of the shadow
Levin
docket has become
from
increasingly
from
prevalent
my state of
since
Connecticut.
2017. And in
He's proud of
effect,
you
The
too.
United States Supreme Court is shirking its duty. I hope you will bring to the court the kind of responsible and methodical approach to decision-making that will lead to an avoidance of the shadow docket, as well as a return to the Voting Rights Act. And if I can just offer one more piece of advice on the court's workload, I have a chart. I know we're not going by the rules of evidence here, but this chart indicates the signed decisions of the United States Supreme Court over a good part of its history. And I think the pattern here is pretty clear. The court issues fewer signed opinions. In fact, it has declined precipitously since 1972. This little blip at the end here is an increase from 53 to 57, but you can see it's only a fraction of what the court used to do in signed opinions, even from the time when I was a law clerk.
You want the conservatives to
It's
write more
diminished
opinions?
Profoundly. The Supreme Court needs to do its job. It needs to issue signed opinions, not the shadow docket. It needs to take cases and resolve real, fundamental, important
When it comes to the
issues.
Supreme Court, do I think 9 is the right number? I mean,
And
in principle, I
taking
don't know
your
that there's
record,
anything special about 9.
573
I don't know if it's the right number or
opinions
not.
over 9 years.
It's worked for us for 150 years, though, so I have no,
I'm not a math
particular
major,
need to
but
change it.
That's about 64.
I'm reeling some more
opinions a
stuff on,
year. That's a
shilling
lot
some
more
more
than
on
they
his
do,
channel.
all 9 of them. So I hope you will bring the energy that you have demonstrated in this room, the energy and the work ethic to the United States Supreme Court, because clearly you have both. And I think the court is very much in need of it, as it is some of the other great qualities, intellect, character, that you have demonstrated here. Just a couple more points, if I may. You were asked earlier about dissents. I want to ask you about one in particular, the dissent of your mentor and your predecessor on the court, Justice Breyer. I am told, I think I've read, that there is one opinion that he is proudest of. Could you tell us what you recall it being, if you know?
Senator, I'm not able.
He is proudest of was in parents involved in community schools versus Seattle School District.
Nick is still beating me
Uh,
with no content.
I think he said it was the
I just have
opinion
to
that he
say,
was
there's something about that, man.
proudest
It's
of.
like you want your ego checked, man.
And
There's a good
he
way to have your
cited
ego
it
checked. Nick hasn't been
in a
streaming
Harvard Law School
for
symposium about his notable opinions.
hold on.
And he said
How long has
this
it been
dissent
now?
was
Has it been that long?
most notable.
Yeah, about 25 minutes.
I will give you the citation.
And he's still beating me. He's got
when we're
2,000. I've
done.
got 481. He's beating me by 4 to 1
And ask that it be
with
entered into the
nothing.
record, Mr. Chairman.
Without objection.
It's like if you want your ego checked,
It's
that's a good way to
77
go about it,
pages
right?
long. And it's a dissent. It's a dissent
maybe someday.
in the
If I work really,
parents
really
involved
hard, I'll be
case,
strong like him.
which was a 5-justice plurality invalidating public school integration plans in Seattle and Louisville. The plans had been in place for decades.
No, this is true.
Put
This
in
is very,
place
very
by
true.
2 local
Like
school
when
boards
Nick was channel was about as old as mine.
voluntarily
I think
trying to
I think I'm doing better than Nick
school
was
segregation in
at the
public schools in
same
both
time of our
of
channel's
those
length.
cities.
I'd have to double check, but I think I might be doing better
the
than he was at the equivalent
Justices,
time.
conservative justice
So
striking
that gives me some
down
hope.
the school integration plans said in effect they couldn't move forward with those integration plans. You may recall it is the opinion where Chief Justice Roberts said, very famously, the way to stop discrimination on the basis of race is to stop discriminating on the basis of race.
Yep, that'd be great.
Justice Breyer, in dissent, which reminded me of a lot of what you've said here this week, wrote, quote, "I do not claim to know how best to stop harmful discrimination, how best to create a society that includes all Americans, how best to overcome our serious problems of increasing de facto segregation. But as a judge, I do know that the Constitution does not authorize judges to dictate solutions to these problems. Rather, the Constitution creates a democratic political system through which the people themselves, through their legislators, must together find answers. The court should leave them to their work." I think that's the philosophy that you've articulated here today, the judicial philosophy of separate branches of government, as you so eloquently described our constitutional scheme, our federalism that really should have led the court to respect the Wisconsin Supreme Court's decision and the Wisconsin governor's decision, and to stay in its lane, as you have put it so well. The fact is, there has been a lot of progress, and we see it in this hearing room. But there is a lot of work still to be done, and there's a lot of reason for folks to feel even some anger at what we've seen on voting rights and on resegregation in some areas. So I am really excited, as I've indicated, and joyful at the great landmark and the historic accomplishment that your nomination represents and reflects. And I hope, as I've said, that not only will you make the court look more like America, but hopefully think more like America. And I want to thank you for your very hard work, all of what you personally have done, because you as a person have
You
done
are
it.
just the greatest judge.
And
You are
history
so
has given you
great.
this opportunity. Your
Have I
parents
told you how great
have
you are
helped
and
to make it
wonderful, man? You
possible.
are just the best.
Your family story
judge.
is so powerful.
I love you so very, very much.
really
I want
earned
to
it.
clone you. I want
And
none of you on the Supreme
we're
Court.
grateful to you for.
Do you have any
providing all of
kids?
us
Can
that
you
role
help
model.
them be
Thank
more
you,
like you so that,
Thank
that
you,
we
Senator
just have a
Blumenthal.
dynasty
Senator Hart.
forever?
Thank you, Mr. Chairman. Judge, good to see you again.
Good to see you, Senator.
We don't have a lot of time, so let
Good
me
to see
just
you,
get
Senator.
straight
Yeah, I
into
bet.
it. Senator Cruz was asking you at the end of his time in questionings about United
I
States
bet.
versus Stewart. This is the case where Neil Stewart tried to cross state lines to rape another person's 9-year-old daughter. He had 6,700 images and videos.
See,
of
6,700
egregious and brutal child
images at the
pornography. The
CP does seem
government
like a lot.
recommended 97
I mean,
months. The guidelines
that
said
seems like a lot of
97 to
numbers.
121 months. You came in at 57 months. Senator Cruz asked you why. The chairman wouldn't let you answer. I thought maybe you'd like to answer now.
Thank you, Senator. No one case can stand in for a judge's
Wow, it's the
entire
same answer
record.
she gave the other
I
times to
have
Cruz.
sentenced more than
No
100
one
people.
case can stand in, so
a
I'm not going to
variety
explain that
of
case.
Egregious.
I'm not going to explain it.
circumstances.
Now,
In every case.
I will concede
especially
the point that no
cases
one case stands for
that
her.
involve
Great.
the
Are you saying you
kinds of
made a
acts that you're
mistake?
talking about, the kinds of
Are you saying you made a
evidence
mistake in that
that I had to
case?
deal with as a judge?
You know, I've done
In
600
every
cases and I
case,
just made a
I
mistake.
am balancing
shouldn't-
the factors that
You know,
Congress
it just
has
doesn't stand for my
determined
overall
are
beliefs.
appropriate and
You know, I
required
could respect
for
that.
a judge to make a determination. The
Or are you saying
data
you got it
points
right?
that
In which case, it kind
Senator
of does stand
Cruz
for you.
pointed to that you may have in front of you
You know?
don't account for all of the information that was before me as a judge and the authority that you all, Congress, and your
The information you
prior
have before you
confirmation
doesn't
when I
account
was
for
a
all the
district
information I have
judge
before me as a
provided
judge.
for
Well,
me
it
to
accounts for a lot of
exercise
it,
my
to be
judgment,
quite
and
fair.
I treated those cases and every case very seriously and imposed a sentence that was sufficient but not greater than necessary to promote the purposes of punishment.
Would it surprise you to learn that Mr. Stewart's a recidivist? He was warrants issued again for his arrest just 3 years after you sentenced him.
Would it surprise me?
Yeah. Would it surprise you?
You know, Senator, there is data in the Sentencing Commission and elsewhere that indicates that there are serious recidivism issues. And so among the various people that I've sentenced, I'm not surprised that there are people who reoffend. And it is a terrible thing that happens in our system.
Yeah, indeed it is. Let me ask you about the Hawkins case. You and I talked about this yesterday. You've been able to think about it overnight. This is a case where you had an 18-year-old who possessed and distributed hundreds of images of 8-year-olds and 9-year-olds and 10-year-olds, and you gave him, frankly, a slap on the wrist sentence of 3 months.
Senator,
Do you regret it?
I don't remember whether it was distribution or possession. In
It
the
was
law,
both. Do you regret it?
in the law, there are different crimes that people commit.
Judge, you
in
gave
this
him 3
area.
months. My question is, do you regret it or not?
Senator, what I regret is that in a hearing about my qualifications
Ooh.
to be a justice on the Supreme Court, we've spent a lot of time focusing on this small subset of my sentences, and I've tried to explain.
You regret that
Many
we're focusing on your
times-
cases? I don't understand.
No,
your-
no, no. I'm talking about the fact that you're talking about
Child pornography
7
cases?
very serious cases.
I'm glad we agree on that. Don't you think we should be focusing on
Some of which involve conduct that I sentence people to 25, 30 years.
3 months
for-
in this case, Judge. Do you regret it? You haven't answered my question yet. Do you
Senator-
regret this sentence?
Senator, I would have to look at the circumstances. What I'm telling you,
You know the circumstances. We discussed it for half an hour yesterday. There's a 55-page transcript, which I'm sure you've read.
Where is it?
You
I
lived
did
it.
not- I
As
did
you've
not-
emphasized to this committee
Where is the
over and over,
55-page
you've lived
transcript?
it, right? You said that
Please,
you've been
where is
through all
it?
of this.
I
You've
want
looked
it.
at all of the images. You're the one who's had to endure all of it. You gave him a 3-month sentence. I just wonder if you regret it or if you stand by it. I mean, do you stand by that sentence?
Senator, in every case, I followed what Congress authorized me to do in looking to the best of my ability at all of the various factors that apply, that constrain judges, that give us discretion, but also tell us how to sentence. and I ruled in every case
Here, let me go
based
dig,
on
let me
all of the
let me go check
relevant
Pacer again.
factors.
So you don't regret it?
No one case, Senator, can stand in for a
Doesn't
I'm not
answer the
asking that.
entire
I'm asking if
record.
you regret this sentence in this case. And it sounds like the answer is no. But I want to tell you, I regret it. I regret that you gave him only 3 months. Let me read to you what you said about these kinds of cases. In fact, to this defendant, you said, make no mistake, Mr. Hawkins, the children you saw in those pictures were not willing participants in the conduct that you witnessed. They were being forced to commit unspeakable acts of sexual violence for the pleasure of the person who
Sensing
was filming,
memorandum, sensing
and for the
memorandum.
gratification of sick people everywhere, people who apparently have no shred of empathy
Judgment,
for what
reasons
this
not
must be
included.
doing to the children who are being
Minute
abused in
order.
this way. You go on. Some
It's
of
not
the
here.
children you saw in
God
those
damn it.
pictures will never have a normal adult
Where is this
relationship.
55-page transcript?
Some of them will turn to drugs and
I want the
prostitution and
55-page
other
transcript.
vices to try to deal emotionally with the pain that results from the torture that they have experienced. And even those who manage to lead a somewhat normal adult life say they live in constant fear of being recognized. Some people are even unable to leave their houses because once those pictures are on the internet, they are there forever. And the victims can't do anything without worrying that every person that they meet has seen them in their most vulnerable state at the most horrible time in their lives. That's your words, pages 34 and 35 of the transcript. Powerful words, Judge. I just don't understand why, after saying this and believing this, you
55-page
could give this
transcript.
guy 3 months in prison when the probation office that we've heard so much about.
Ron.
Hey, 18
Ron,
months.
I need
Even
help.
The probation
They
office
keep
recommended 18
reading
months.
from transcripts I don't have.
I thought you had all the
Do you have anything to
transcripts.
add?
I don't have the transcripts. No.
No, Senator.
I have the link for
Let me ask you
Pacer.
about your policy of
And there's no
not giving
transcripts on it.
enhancements when there are prepubescent
The sentencing
children like there
memorandum
were in the
itself is
Hawkins
sealed.
case,
There's no
who are
transcripts
8,
at all.
9, 10
I don't know
years
where they're
old,
getting.
when there are
He just said I'm
prepubescent
reading from a
children
55-page
involved. I don't-
transcript.
I'm
Where's the
just
secret
struggling to
transcript?
understand this. You said it. in
Transcripts are
Hawkins.
not
You
always
said that
available
you
on
weren't
Pacer.
going to give him an enhancement.
Okay,
you
yeah,
weren't going
that-
to
or-
make his sentence
yeah.
any tougher, despite the fact that we had
He has
all
it
of these
somehow.
terrible videos that you
I
and
want
I
it.
talked
I want it,
about
Ron.
at length.
I think if you're a
yesterday. This
senator,
is
you might
page
be able to
38
get
of the
it.
transcript, just so that we're all following along. You said, in your case, I don't feel that it
How
is
else is it
appropriate
going?
necessarily to increase the penalty on the basis of your use of a computer, and we've talked about that, or the number of images or prepubescent victims as the guidelines require, because these circumstances exist in many cases, if not most, and they don't signal an especially heinous or egregious child pornography offense. You said the same thing in the Cooper case just last year. This was an individual, Cooper, who was 30 years old at the time of his sentencing. He pleaded guilty to distributing child pornography. He posted between 3 and 4 dozen images of child exploitation to Tumblr, where it could be accessed publicly. The government said, and I'll quote from the transcript in that case, page 37, when his devices were found,
The
including
government
computer,
said is,
within the computer and on an untitled folder were many
I don't trust what the government says about
videos.
anything.
The nature of these videos went well beyond
Yeah, that's one of the
mere
reasons I
child
want the judges
pornography.
to
The government
Like
says, I don't mean to make light
I've
of
got
the
access to
content
the
of any
sentencing
child
memorandum
pornography,
from the
but
parties.
rather to say that the content
You
of
know?
those videos
I've got their
is on the
sentencing
more
memorandums.
egregious or extreme spectrum of the child pornography videos that are encountered in these cases. And yet, when you sentenced him, you said, I'm quoting now from the transcript in Cooper, I'm really reluctant to get into the nature of the porn. And then later, it's very difficult to assess how different Mr. Cooper's images are than those of other similarly situated child pornography defendants, such that I, without going into looking at them, and I'm not an expert, you say. So you say, while I understand the government's arguments, Mr. Miranda, the government's arguments in that regard, I don't find them persuasive from the standpoint of characterizing this as an especially egregious child pornography offense. Help me understand this, Judge. Why is it that what's your policy disagreement with the guidelines treating images, videos, pornographic images that have small children, infants, 7, 8, 9-year-olds? Why won't you give an enhancement for those? Help me understand that.
Thank you, Senator. I'll make 2 responses. First, that's not my policy disagreement. I don't know why you've characterized that in that way.
Well, wait a minute. You say right here in the cases. I mean, this is what I want to get. I want to make sure that we're talking about the
Just
same
look at
thing
her
here.
face.
This in the Hawkins case, I don't feel that it's appropriate necessarily to increase the penalty on the basis of your use of a computer or the number of images or prepubescent victims. And you say the same thing in Cooper.
Senator, two observations. One, I am sentencing in every case. I have policy disagreements with certain aspects of the operation of the guidelines that I lay out in every case as Congress has required and as the Supreme Court permits in light of my experience, not only as a district judge, but also on the Sentencing Commission, which did a report about the operation of the guidelines.
Did they ever release the Sentencing
You've read
Commission
extensively from the
documentation?
government's
No,
argument
I
in
don't
this
think
case.
so.
You've not
They've also been
provided
quoting from
information
transcripts
the
of
probation office
hearings.
or the defense. And when
I
a
don't have the
judge,
probation
But-
office report.
no, excuse me,
Ooh,
Senator.
someone just
the
reminded
probation
him. He
office
got-
provides a
just for this case.
recommendation. There has been information gathered about what a recommendation was given in each one of these cases. I don't have that information here, but what I'm saying is that in every case, the judge is not just hearing from the government. The judge is not just evaluating what the government says in these cases. In every criminal case, a judge has to take into account all sorts of factors, including arguments being made by the defendant, by the government, by the probation office. So I understand that in certain cases, the government may have made an argument, but there are other people in our criminal justice system who make arguments, and the court evaluates everything
Yeah, but it seems
as
like
Congress has directed.
you went well
And no
below
one case can
what
stand
any of
in
them recommended.
for my entire
Because in that
record
one case with
of
the
how
3
I
months,
deal with criminal
as I understand
cases, or
it,
did
the
when I was a
statute says something
district
like 8.5
judge.
to 10 years.
I have law enforcement in
Uh,
my family.
The
I am a
probation
mother
office or
who
pre-sentencing
has
investigation said 2
daughters
years.
who
The government
took these
said, no wait,
cases home with me
the government
at
said
night
2
because
years.
they are
Probation
so
office said,
graphic
I
in
forget, and
terms
you went
of
with
the
3
kinds
months.
of images that you are
So it's like,
describing.
it's a lot of
They
departure.
give you not only the actual videos, which you can ask to see, but they
Ugh,
describe
no, thank
in
you.
the briefs in detail what these videos show. So I am fully aware of the seriousness of this offense
Are you?
and also my obligation to take into account all of the various aspects of the crime as Congress has required me to do, and I made a determination seriously in each case.
What I'm trying to understand is why is it that you say multiple times that just because there are prepubescent victims in Cooper, in Hawkins, that does not signal that this is a heinous or egregious child pornography offense, and you're not going to apply any sentencing enhancements that the government's asking you for? The sentence gets to be less because you say, I'm not going to apply. The government asked for enhancements related to prepubescent children, related to the nature of these images. You say, I'm not going to apply it. But I get what you're telling me is, I guess, that you don't have a policy objection. I mean, why didn't you apply the enhancements as they were asked for?
Senator, I've answered this question many times from many senators who've asked me, so I'll stand on what I've already said.
So you have nothing to add about why these crimes, why these images, in your view, do not signal an especially heinous or egregious child pornography offense. That's Hawkins. You say in Cooper, I understand the government's argument, but I don't find them persuasive, the fact that there were prepubescent children, from the standpoint of characterizing this as an especially egregious child pornography offense. That's page 58. Let me ask you this. Senator Graham earlier today, you were trying to do what's rational, and you didn't do sentencing in these cases, and you didn't think it was rational to sentence
Ron,
people
can you
who
believe
had
it? She
thusins
just sits
of
there and
images
gives him that look like,
I give her all the credit in the world for that.
Guidelines to
Really?
She says she's not going to answer it again.
to the no longer
He asked it again.
discretionary range.
She can
No,
say
Senator,
F
I
you,
said
Screw
the
you.
or she can
guidelines
say it with her eyes or
system
with her lips.
is designed
all right,
to
fair
be
enough. Ron
rational.
has a different
So
take
let
on
me
it,
ask
but
you
fair
this.
enough.
Why isn't it
I'm not
rational
respecting her not answering it.
to
I'm
sentence
respecting her
people who have
once she says
thousands
she's not
of
going to answer it,
images
not answering,
on a
not buckling and
computer
answering it.
to more time
All right, fair enough.
as opposed to somebody who has 1 or 2 pictures in the mail? In other words, the more images there are, why wouldn't you want to sentence that person to more time rather than less? Why isn't that rational?
Senator, I've answered this question and I'll stand on what I already answered.
So, but your answer is what? I mean, refresh my memory.
Senator, I've answered this question. I've explained how the guidelines work and I'll stand on my answer.
But the guidelines are not mandatory. I wish they were, but they're not. The Supreme Court made that determination. I'm trying to understand why you think it's rational not to sentence criminals based on the number of images they have. You say that this is a policy disagreement that you have with the guidelines. This gets to the core of your judicial philosophy. You served on the Sentencing Commission where you recommended changes to the guidelines based in part on this policy disagreement. So I think it's relevant and indeed vital we understand what the policy disagreement is. That's what I'm trying to get at here.
Senator, I previously explained what the policy disagreement is and I will stand on my answer.
So you're not going to answer my question?
No, I've answered your question in my answer.
You
is
haven't
I've
answered my question.
explained-
I'm sitting here asking you and you're declining to answer.
I've explained how the guidelines work. I've explained that the guidelines.
When I'm nominated for the
were
Supreme Court, I'm going to
developed
try this
at a
trick, see if that
time
works
in
for me.
which the commission of this crime was different
You
than it is
already have gotten
today.
past
I've
quite a few
explained
tricks
that
in order to
Congress
achieve
has
that
not intervened to revise or direct the commission around how to deal with the changes in the commission of this crime. And so judges all over the country are grappling with how to apply this guideline under these circumstances. And there's an extreme amount of disparity. And in each case, a judge has to look at all of the factors, not just the guidelines, not just what the government asks for, but the recommendations of the probation office, the arguments of the government and the defense, the nature and circumstances of the offense, the history and characteristics of the defendant, the need for the sentence imposed to promote the purposes of punishment, which include things like rehabilitation. Also, in every case, Congress has authorized judges to impose not only terms of imprisonment, which are a very important part of the consequences for these crimes, but a range of other preventative kinds of measures which courts impose in cases to prevent these defendants from repeating these egregious, this type of egregious conduct. And I talked
Did you hear a beep?
to each defendant, as you have quoted, explaining
was
to them the
something local.
harms that their crimes caused. And I
But then
imposed
maybe that's
not
all his
only a
time?
term of imprisonment, but also all of the other consequences of the offense, to include decades of supervision, restrictions on use of a computer,
Random
and the
unexpected
like.
doorbell noise.
That's my answer. I've answered it many times. Do you have other questions for me?
Yeah, I do.
to answer?
I do, because I want to try to understand when you talk about the guidelines being outdated and outmoded. I understand that they were written, the initial guidelines were written at a time when computers were not common. Everybody didn't have one. Certainly didn't have phones in every pocket like we do now, smartphones. So I understand that. I also understand that the number of images, sexually exploitative images of children on these devices has exploded. And so I'm trying to get at what Senator Coons earlier characterized as a pretty fundamental policy question, which I think is the correct characterization here. I'm trying to understand your view on why it is that while the number of images available on these things has exploded, that sentencing shouldn't track that. See what I'm saying? I mean, you've made the argument, if I understand you right, and I want you to correct me if I'm wrong, you've made the argument that, well, look, the guidelines were written at a time when this stuff was like, it was an individual picture, it was, magazines, whatever. Now, almost every offender, I think this is the argument, so you correct me. Almost every offender, because of the nature of this, they've got tens, hundreds, sometimes thousands. I mean, partly because of the nature of this. My question to you is, wouldn't we want to deter that? Isn't that a reason to impose tougher sentences? I mean,
Senator,
go ahead.
the Congress has every ability to do that. What's happening
didn't
now
they? That's
is that you have a guideline that has gradations in it for the number of
That's, yeah, Congress has the ability to do that,
that
and they did do
ends up
that. And you're
being,
saying
when you
it's
look at the
outdated,
scale,
but Congress has the
something
ability
like
to do it.
the difference
And you're also saying that the
of
black letter law
10
is where
years.
it
I'm
stops,
making,
but it's
I don't know
outmoded, so I'm going to
exactly what
ignore
it
it.
is, but each
I'm so confused,
two-level
Ron.
enhancement is like several years, and the gradations are like zero
I mean, she
to,
literally
and
said,
again, I don't have it in
I
front of
think
me, but it's like
yesterday, at
0
some
to
point, she
50
literally said,
pictures,
you know, if the
50 to
law
100
is
pictures,
clear, that's where you
100 to
stop.
150
I'm like,
pictures,
well,
set
Congress
up
wrote
at a
this.
time in
It's
which the
clear.
mail
Now you're
was
arguing it's
the
outdated,
primary
so we should
mode
ignore
of
it.
possession and
But Congress can
distribution.
change
And
it.
so if
But-
somebody had
but, okay.
50 pictures, they, according to Congress and the commission
I
at
don't
the
know.
time, deserved an extra 10 years in prison. Now, with that scale, everybody's at the top immediately, just because of the nature of the internet. So you're not differentiating using that scale anymore, given the way this crime is committed. And so judges are having to decide, how are we going to deal with the penalties and do our jobs to impose sentences that are sufficient but not greater than necessary under these circumstances.
Yep. Thank you, Judge. I'll just say in closing that I appreciate that answer, and I understand that as a policy matter. I just think we disagree. I think that the more images are there, the more punishment there should be, and I want to see this deterred. And I just think we've pretty fundamentally disagreed. I've enjoyed our exchanges. Thank you for your candor, and I appreciate it. I just disagree with you on the law. Thank you, Mr. Chairman.
Senator Hirono?
Mr. Chairman. Mr. Chairman.
Senator Hirono's turn.
Mr.
Thank you,
Chairman,
Mr. Chairman.
I'm asking to be recognized to make a point to the chairman.
I believe he recognized me. May I proceed?
Mr. Chairman.
Mr. Chairman, I waited my turn on here, and I've been on this committee for 47 years. I think we ought to follow the regular order.
Mr. Chairman, the witness just said that we cannot understand those
I'm
cases
sorry,
without
Senator.
the pre-sentence
I don't want to
reports.
go through this again.
I have a letter that I want to enter into
There
the
are rules
record
in the
that's
committee
signed
that
by
should
10
be
senators
followed.
on this committee. Are you not even going to allow a letter from 10 senators
You
on
wanna
this committee?
send any letter, you can do it. by
This
hand
letter
or by
that is
mail.
signed by 10 senators on the committee addressed to you makes the point that the White House gave you probation information for Democrats that was not provided to the minority on this committee. And just now, Judge Jackson told Senator Hawley, you cannot understand these cases without reading the probation reports. 10 senators on this committee are asking the chairman
Mr.
to
Chairman.
provide those reports so we can do what
How many
Judge
senators are on
Jackson
this
just
committee?
said,
Chairman,
which is
I
to
know
assess
the-
those reports. And
Mr.
here is the
Chairman,
letter.
I know
I
the
ask
ju-
unanimous
know the
consent that it
junior
be admitted
senator.
to the record.
I know the junior senator from Texas likes to get on television, but most of us have been here a long time trying to follow the rules.
Oh, bullshit.
And he could very easily hand you a letter to go in the record. He's saying he's doing this to help Senator Hawley. Senator Hawley could have put it in, and he didn't. But let's get back to regular order.
Senator Hawley
God,
didn't
so-
write the letter. Mr.
Let's get
Chairman, I
back to
ask
regular
unanimous
order.
consent that it be admitted to the record.
Senator Hirono.
Thank you.
Are you denying consent?
Thank you, Mr. Chairman. Aloha, Judge Jackson. Aloha. I'm going
Wow.
to try and spread some aloha.
I don't know if
in
I can.
this room.
I don't know if I can sit here to
I'm
watch her.
taking a lead from.
I'm sorry to abandon you.
No,
but
no,
I-
no, Ron, you can do it. I believe in
sitting
you.
to
You
my
have the
left.
strength within.
Well, at
Pull
least
deep.
you and I are very
Pull deep,
color
Ron.
coordinated
I
today.
believe in you.
She is a
Since
wicked,
2018,
wicked.
I have been asking
stupid-
every nominee
She's
that
wearing a
comes
fun
before
flower
the committees
lapel.
on which I
That's
said the
nice.
two questions.
I'm
that
going to go
I
back
asked
to
you at the
my
start of
Ron,
my
time,
discovery
namely,
responses.
whether or not they have a history of
I'm
I'll be
sexual
back.
assault or
I'll be
harassment.
back.
This is something I started.
Don't you have a
looking to
job?
Make sure that harassment and abuse
I'm on leave, actually.
that women,
No, well,
Jamie, have put
I'll be
up
back.
with since,
All right.
as far as I'm concerned, time immemorial, didn't continue to get swept under the rug. I found these questions to be important for nominees to the judiciary. As Chief Justice Roberts stated in his 2017 year-end report on the federal judiciary, events in recent months have illuminated the depth of the problem of sexual harassment in the workplace, and events in the past few weeks have made clear that the judicial branch is not immune. Here are just a few examples of abusive practices by federal judges. In December 2017, 6 former law clerks and staffers accused Ninth Circuit Judge Alex Kozinski of subjecting them to a range of inappropriate sexual conduct and comments. In September 2019, the 10th Circuit Judicial Council issued an order finding that District Court Judge Carlos Miguel apologize if I mispronounce his last name, had harassed multiple employees over a period of years, including by subjecting them to sexually suggestive comments, inappropriate text messages, and excessive non-work related conduct. In February 2020, former law clerk to the late Ninth Circuit Judge Stephen Reinhardt accused the judge of a months-long
We're talking about sexual harassment in the judiciary.
campaign. And these are a few of the cases that we know about. There are undoubtedly many more we don't know about, both because of the power imbalance between federal judges and their clerks and employees who often rely on connections and recommendations to advance in their careers, and because of the lack of legal recourse available to the judicial employees. Many may not realize this, but federal judicial branch employees are not protected by the foundational federal statutes, such as Title VII of the Civil Rights Act of 1964,
Correct.
that prohibit discrimination and retaliation. And that's why I introduced, along with Chair Durbin and Senators Whitehouse and Murray, the Judicial Accountability Act, which would ensure the more than 30,000 employees of the federal judiciary have strong statutory rights and protections against discrimination, sexual harassment, retaliation, and other forms of workplace conduct. I know you can't comment on legislation, so I won't ask you whether you support the Judicial Accountability Act. Instead, I'd like to hear what you do to make sure your chambers is a safe, inclusive place to
Wow.
work.
Please tell us about your safe space policies.
Thank you, Senator. I, as you know, have been a judge now for almost a decade. And I take my responsibilities not only to hear and decide cases seriously, but also my responsibility as an employer, that I bring law clerks into my chambers. I was a law clerk to 3 wonderful federal judges who were role models for me, and I try to act as a role model to my law clerks. I try to bring in people who have the respect of others, people who come with strong recommendations, people who I think will get along with one another, and certainly people who I think will get along with me. And we create.
Do you ever bring in
a
any
little
conservatives?
Group, a working
Do
group.
you have any clerks who are
And I
conservatives?
think that it's
That'd be an
worked out
interesting
well.
question. Have you ever had any conservative
And I
clerks?
would think that you would make sure that there are no instances of inappropriate
Interesting.
behavior, sexual harassment from any of your clerks or employees.
That's absolutely correct.
During our courtesy meeting, I enjoyed learning more about your background and family. And of the 9 sitting justices of the Supreme Court, only 3, Justices Alito, Breyer, and Kagan, were educated in our public school system. And you would, as far as I'm concerned, make a welcome addition to the court from that standpoint as a public school graduate myself. So public high schools educate people from all backgrounds, and most people go to public schools. Most people don't get to go to private schools. So your classmates probably came from different racial and ethnic backgrounds, incomes, social statuses, academic abilities, athletic abilities, among others. How, if at all, has your public school experience shaped the person you are and your approach to the law?
Thank you, Senator. I was very fortunate to go to public school in Miami, Florida. I had a wide range of classmates, and it was a wonderful opportunity to get to know people who were different than me, and to learn at the end of the day that they were not so different than I am, even if they came from different backgrounds. And I've talked a lot about my debate team. That was one of the activities that I engaged
Just checked
in
out Law
and spent
Self-Defense
a
Stream.
lot
I'm
of
beating
time
them by 70 people.
with my colleagues on the
There's
debate
hope for my
team,
channel.
and with my wonderful coach. and you learn how to support each other, how to speak across difference, how to communicate with different kinds of people. And it was a wonderful experience, and as I've mentioned, in many ways different than the generation before, who in Florida were segregated by law.
So I take it that not only did you have, I would say, a broad experience of encountering people from all different walks of life and backgrounds, but there was still commonality that you had.
Very much so.
And that is very much exemplified in your approach to your work. I also talk with you about the importance of the creative part of our lives, because I think lawyers tend to be very left brain, and I know that you are a very well-rounded person. And so I asked you, what do you do to pay attention to the creative side of your life?
Thank you for the question. I took up, not too long ago, but took up the fiber arts, as they say. My mother
You're a
is
knitter?
an expert crochet artist. She makes beautiful pieces of all kinds, and I always wanted to do that. I always wanted to, and she tried to teach me when I was younger, and it didn't quite turn out. But as I have gone along in my career and wanting to have some sort of a creative outlet, and especially in times of high stress, I started pining for something to do to express my creative side. And I bought a book on crochet. I talked to my mom. I started making hats and scarves, and then I moved to knitting during one of my confirmation hearing scenarios, because I
She's a
needed
crochet
something
knitter.
to keep my mind off of
Okay.
mind off of the stress. So
Can you make me a hat?
I have a
That'd be
basement
a good
full of
question,
yarn.
since you're a
If
Christian. Can you make me a
if you'd
hat?
like to come over.
SCOTUS hat?
I think that's another way that you're connecting to the people who really mean a lot to you.
Don't poke the bot.
The creative outlet is really important to me, because in a changing world, I think it is our ability to be creative in our approaches and how we think about things that will enable us to deal with the rapid changes that happen every day in these days. I view you as a consensus builder. And so I know that in your work with the Sentencing Commission, you really worked hard to come up with some 95% of the time. In this very diverse group, there was consensus in your recommendations. How important do you think consensus is on what I characterized yesterday as a very ideologically split Supreme Court?
Oh, let's see if this works.
I
haven't
think
tried this before.
consensus is very important. It was one of the things that I most admired about having the opportunity to work for Justice Breyer as a law clerk, to observe his process for reaching out to colleagues and trying to collaborate in his thought process about the outcomes of cases. And it's something that I tried to emulate when I was on the Sentencing Commission, which, as you said, is a very diverse body. I saw in that context the importance of trying to reach common ground with respect to your determinations.
Mr. Chairman, thank you very much. To illustrate the kind of broad support that this nominee has, I would like to enter into the record 2 letters, one signed by 1,000 public defenders from all across the country, and another signed by 48 prosecutors from across the country. Judge Jackson, I have very much enjoyed the
Without
privilege
objection.
of talking with you. Thank you, Mr. Chairman. And it will be my privilege to support your nomination.
Thank
Aloha.
you, Senator.
Thank you very much, Senator.
Mr. Chairman,
Senator from
yeah, I have
Iowa.
a letter here signed by members on my side of the aisle I'd like to put in the record.
Without objection. I'd like to comment. I had a chance to review this letter for the first time just a minute ago. There is apparently a concern on your side, Mr. Chairman, about whether you have on your side of the aisle access to all the information that we have on this side of the aisle and all the information that's in the possession of the White House. During a break earlier today, I met with the ranking member, Senator Grassley, his staff, and with White House staff to discuss it. Here's my understanding of what has transpired. Last Wednesday evening, the senator from Missouri selected a handful of Judge Jackson's more than 1,000 district court cases to claim that Judge Jackson, quote, endangers our children, close quote. On Thursday, the next day, the White House contacted Judge Jackson's chambers to request the probation office recommendation in each of the cases. I underline probation office. That probation office provided a chart reflecting these recommendations. This is the sum total of what was provided. They shared with the White House from the chambers. When the senator from Missouri continued to raise questions and request the probation office's recommendation in these cases, the probation office provided this chart reflecting those recommendations, which was shared with the White House. When the senator from Missouri continued to raise questions about Judge Jackson's sentencing record, my staff asked the White House for information about the probation office recommendations. These are just numbers for each one of the cases. That's all that is. The White House and my office didn't have this information earlier because we didn't know the senator from Missouri was going to make this claim in the first place. Once the Republican side requested the same information, my staff shared it within minutes. So now your side, Senator, has exactly what the White House and the Democratic side has. The same chart provided by the probation office. And I might add that some of this had been published in the press, in Washington Post and other places, but it consists in each case of the case number, name, the probation office recommendation for custody, the sentence imposed custody, probation office recommended supervision and release, and the supervision and release imposed. All of that information has now been shared equally. Some information on the other side, on the Republican side, includes frequent reference to transcripts, which we don't have on this side. And the reason being, we didn't anticipate this objection from the senator from Missouri and request that information. Now, the letter also goes a step beyond, which I think is a very important decision for this committee to make. This request for pre-sentence reports from each of these cases. Now, these pre-sentence reports are typically filed under seal. They can contain highly sensitive personal information, not just about the defendant, but about innocent third parties and victims. We've spent a lot of time here reflecting on these terrible crimes. Everyone has acknowledged how terrible they are and how damaging they can be to the victims. We have heard story after story, and I don't question a single word that was spoken in sympathy for these same victims. I would not want it weighing on my conscience that we are turning over these pre-sentence reports to this committee for the first time in history, and that information out of this, or because it was released, would somehow compromise or endanger any victim as a result of it. This information was not requested before. It's never been requested by this committee. And I think we ought to think long and hard about whether or not we even consider going into pre-sentence reports. So I'm going to take this matter up with our side, and I'm sure you will with your side. I have your letter requesting it. As far as this information, you have exactly what we have, no more, no less. In terms of pre-sentence reports, this is a critical policy question, which ought to be carefully weighed. It goes way beyond, I'm sorry, Senator Judge Jackson, it goes way beyond your nomination. And I want to make certain that we don't take a step here that endangers the lives or well-being of innocent people.
Mr. Chairman, since you just responded to the letter that I wrote and was submitted on behalf of 10 senators, I will point out that in Judge Jackson's answer to Senator Hawley, she said that he and this committee did not have sufficient information to assess her sentencing decisions because we heard the arguments of the prosecutors in the transcript, but we did not have the recommendation from the probation office. And what she testified under oath is you can't understand why she issued her sentences without having those probation reports. You are right that there can be sensitive victim information in those reports, and everyone on this side, I'm confident, would agree to redacting out any information that would violate the privacy of a victim. But Judge Jackson has told us it is relevant to understanding those cases, and that's why 10 of us have requested we have those reports, and there's explicit statutory authority for us to do so that is cited in the letter we just submitted.
Senator, I don't know where other members of your caucus stand on the basic question of this nomination. They can decide on their own, and they will, and they should. That is their responsibility. I think I know where you're headed. And I would just suggest that we ought to think long and hard, my friends, about members of the Judiciary Committee endangering the lives of innocent people to pursue this line of questioning. We spent 2 days, 15, 16, 17, 18 hours, and a large part of it on this issue. I don't believe these pre-sentencing reports are going to change anyone's disposition if they're going to vote on this issue. And I do not want it weighing on my conscience that I gave the green light to release this information so that it might endanger the lives of innocent victims. I'm sorry. That's a bridge too far for me. I think the issue before us on sentencing, you each had a chance to hear plenty of testimony on it. And I believe this should be taken up with the individual caucuses on both sides if you wish. But that to me it's gone way too far, way too far. I don't want it on my conscience.
Mr. Chairman, if I might,
Senator,
when I agree with you, I've prosecuted literally thousands of people. I would have to go back and see over 8 years. I can't remember the hundreds of sentencings I was at where we had pre-sentence reports over and over again. There were things in there that were sensitive, sometimes reflecting somebody who were putting their lives on the line to even give a report. Neither the defense counsel nor I as a prosecutor ever thought those would be made public. And we assumed the judges, we had judges across the political stripes who read them, kept the confidence of that. As a result, we knew that the reports were thorough. And a judge has the final say, but as a prosecutor, I might have a recommendation, but I never question a judge who might give a different sentence, because my responsibility as prosecutor, theirs was the sentence.
Senator Lee.
Yeah, might I just weigh in here? I totally understand the concern that you're describing relative to the confidential nature of pre-sentence reports. As a prosecutor and as a law clerk, I reviewed those with some regularity, and I understand the sensitivity of them. Let me suggest a couple of things. First of all, it's not unusual for us as a committee and as members of the United States Senate to review materials that would be inappropriate for public release. I don't think one of us is suggesting that. There are means by which we can review things in a classified environment and treat them as classified. We've done that with significant success in this hearing. Secondly, to the extent that wouldn't provide the level of comfort necessary, we'd also be happy to review them on a redacted basis. These are things that have become relevant in our conversations. We want to make sure that we have the facts, but not one of us wants to endanger anyone or to render public information that is sensitive in nature. There are abundant ways around that.
I would suggest that the information contained in these reports is dangerous to the victims and to the innocent people who are mentioned in these reports, and unnecessary at this point. It's never been requested by this committee, and it's merely a fishing expedition in dangerous territory. Classified settings, redacted versions of the report.
Someone asked about FOIA.
This has never happened in the history of
No,
this
there's
committee.
nothing FOIA.
And I would say
FOIA only
Senator-
extends to the executive branch.
Senator, I
FOIA
will
is
just
not
tell you,
available for
I am not going
the
to be party to
legislative
turning
or
over this
judicial
information and
branches.
endangering the life of an innocent person for a political quest to find more information. We have exhausted this
It
topic.
is the Freedom of Information
We've gone
Act,
to it
right?
over
So
and over again.
Only
I
goes
think
as far
that
as it
this is
goes.
a bridge too far for this committee. That's my personal feeling. I take it that Senator Leahy may agree with me in that regard. This nominee has been before this committee for 18 hours. I don't believe that this information is going to change anyone's vote. You can decide in your caucus what you want to do to go forward. I've told you my position. I want to proceed if I can. I thank the nominee for waiting for this colloquy, and I turn it over to Senator Cotton.
Judge, I want to return to the question of crime and specifically sentencing. In any of the cases where you've sentenced an offender below the guidelines, has that offender gone on to commit another crime after getting released from prison?
Probably.
Thank you, Senator.
I'm not sure that's a fair question.
When judges sentence, they often impose terms of supervised release. And there are times in which when a person is on supervised release, they reoffend. There are also times when they don't. But even after the period of supervised release, the court doesn't continue to have any way of tracking or knowing what happens, because if they were to reoffend, it wouldn't necessarily come back to the same court or the same judge.
So you don't have a factual basis to know whether or not anyone you've sentenced below the guidelines has reoffended in the future?
Do I have a factual basis? I know that there are people who have reoffended while on supervised release. I can't remember whether any of them were guideline sentences, below guidelines, or above guideline sentences.
Okay. I know you've answered a lot of questions the last 2 days about sentences and sex crimes. I just want to be exact about this. In these cases, have you ever sentenced an offender above the guidelines recommendation?
I'd have to take a look at, I know that I have sentenced offenders to the guidelines if in the category of sex crimes in general. I know that I've given 30-year sentences for at least one offender, almost 30 years, 29.5. I've given, I believe, a 12-year sentence for someone at the agreement of all of the parties, which was a sentence that was a part of his plea agreement. I'm not remembering the others.
I understand you've sentenced in a lot of cases. I want to return briefly to the Hawkins case. Wesley Hawkins, as a reminder, was convicted of a child pornography offense in 2013. The sentencing guidelines for this offense called for a sentence of 97 to 121 months, or 8 to 10 years. The prosecutors asked for 24 months. You sentenced him to 3 months. We've heard a lot about this case and your 3-month sentence of Wesley Hawkins, but you got another crack at him in 2019, Judge. In 2019, you sent Wesley Hawkins back under conditions of confinement with the Bureau of Prisons for 6 months with additional restrictions on his computer usage. That's twice the amount of time in custody that you sentenced him to in 2013. What did Wesley Hawkins do in 2019, Judge?
Oh, I don't remember, Senator. I have a lot of defendants who I've sentenced who are on super. That he committed was likely on a very long period of supervision. And during that time, he would likely be under computer restrictions for 10, 20 years or something, where he's not allowed to do certain things with a computer. And a probation officer is monitoring. They put software on the computers of individuals who are who have these kinds of conditions imposed, and that restricts their ability to access certain information on the internet. And so it's not uncommon for a probation officer to report violations of supervised release, not just in this area, but across all crimes. And then the court has to determine how to handle that. And you could, in fact, send someone back to jail for violating conditions of supervised release that are not themselves criminal behavior. It's just, the court says in their supervision order, I'm imposing a 20-year or whatever it is, sentence of supervision. And during this time, you're not allowed to access your computer, et cetera, et cetera. So if he were to do that, it wouldn't be additional criminal behavior, but it would be a violation of my order. And when he comes back to the court on violation, the court has factors that we look at to determine whether or not to treat that essentially as the kind of violation that would require him to go back to jail.
Okay. Judge, yesterday we had an extended conversation of your sentencing of a man named Keith Hodges, a fentanyl kingpin. That sentencing occurred in 2018. You had very detailed recall of that sentence. To my knowledge, that's the only time anyone's asked you about Mr. Hodges' sentence. You've been asked repeatedly over the last 2 days about the Hawkins case. It's been in the news, as Senator Durbin decided, for days on end. This resentencing happened in 2019, and now you're saying you don't have any recollection of it. Let me see if I can refresh your recollection. This is the order you signed, Judge, on April 17th,
This I have
2019,
for all the good it does me.
in USA v. Hawkins. And it says that you concur with the recommendation of the probation office to return him to residential reentry facility for 180 days and to engage in various kinds of computer monitoring and computer monitoring and search. There's your signature over there, Judge. You really don't remember what?
Senator, that is a very, very common thing that judges do. I've sentenced over 100 people, and supervised release, which is the kind of post-incarceration condition that judges ordinarily impose, is something that's done on a standard form, which is what that is.
I understand you've done a lot, Judge, but none of them have been the centerpiece of your hearing for the last 2 days. Do you really expect this committee to believe that you don't remember what happened in this Hawkins case when it came back before you?
Yes, Senator, I do expect you to believe that's my testimony.
Well, I don't find it credible, Judge. It's been in the news for days. Senator Durbin has cited it being in the news for days. You've been asked about it probably more than any other case you've ever had. And I just don't find it credible that you weren't prepared for that matter in 2019. You know what I think? I think he got caught with child pornography again, and he wouldn't have if he had been in prison for the 8 to 10 years the guidelines called for in 2013 when you first sentenced him. Let's turn, though, to your work for detainees at Guantanamo Bay. First off, let me just ask, do you think most detainees at Guantanamo Bay were mostly terrorists or mostly, I don't know, innocent goat farmers?
Senator, it's impossible for me to answer that question. The people at Guantanamo Bay had been accused by the government of engaging in terrorist activities and therefore classified by the executive branch as enemy combatants.
Okay, do you think America would be safer or less safe if we released all the detainees at Guantanamo Bay?
Senator, I'm trying to figure out how to answer that question. 9/11 was a terrible attack on our country, and the executive branch, pursuant to authority that the Supreme Court said it had, designated people as enemy combatants and sent them to Guantanamo Bay. The Supreme Court also said that anybody who was so detained could seek review of their detention. And as a federal public defender, my role and responsibility was to make arguments in defense of the Constitution and in service to the court that was trying to assess, based on the authority given to it by the Supreme Court, whether or not people were adequately classified, what the legal circumstances were, how these habeas petitions were going to be processed. This was a series of legal challenges in a novel environment that federal public defenders and lawyers across the country were engaged in helping the court to evaluate so that we can understand what the Constitution required in this time of emergency.
Okay, so no opinion on whether America would be safer or less safe if we released all the detainees from Guantanamo Bay.
It's a bit of an unfair
Senator,
question.
America
I mean, I'll
would be
sympathize with her.
less
It's an unfair
safe
question.
if we don't have terrorists out running around attacking this country. Absolutely. America would also be more safe in a situation in which all of our constitutional rights are protected. This is the way
See,
our
this is
scheme
this is
works.
right,
This
right?
how
I
the
mean, at least in part,
Constitution
this is correct.
that we all love
I'll give her credit where credit's due.
operates.
You know, as much
It's
as
about
she
making
earns.
sure
But
that the
yeah, you're right. It
government
would be probably
is
safer to keep everyone
doing
locked
what
up
it's
forever, but that's
supposed to
not
do in a
what
time
we're
of
about.
crisis. As Justice Gorsuch
I mean,
said,
yeah, I mean,
the
yeah.
Constitution is not suspended in times of crisis. The government still has to follow the rules.
Yeah, this is the question. The
And
question is
so
unfair because the answer
criminal
is yes,
defense
but
lawyers make
it's
sure
unfair because
that in times of crisis,
it
the
doesn't imply
government
that you
is
should just lock up
following the rules.
because it implies you should
let's
lock
turn to
up
the
everyone
actual
forever
cases. How many
if
of these
there's any
terrorists at
possibility they're
Guantanamo
guilty,
Bay
and that doesn't
did
quite
you represent?
make sense.
When I was a defender, 4 cases were assigned to me in our office. I don't know how many cases came into the office in total, but
You personally had 4.
I was assigned to them along with another defender who worked on the same cases. She was more senior. She did all of the sort of fact gathering related to the cases. And as an appellate defender, I worked on the legal arguments.
Okay. Did you ever represent any of the detainees at Guantanamo Bay when you were not a public defender?
One of the people who I'd represented while I was in a federal defender, his case got spun off and taken up by a law firm. Law firms around the country were also engaged in this work.
I'm well
at the
aware of what
time.
law firms were doing at the time.
Yes. And I left the federal public defender's office. I joined a law firm, and one of the people that I had represented was now at that law firm. They had him as a client.
That's
and
Mr. Al-Salwam.
Al-Qahtani
Al-Qahtani was the one.
Who
Just coincidentally.
My fair
both
weather
he
friend,
and
how are you
went to
doing?
Morrison and Forrester.
Yes, Senator.
Okay.
Believe me, I got
What
stuff
about Mr. Al-Salwam?
I know about.
I
weather
don't
is
know
not
what
so
happened
fair.
to Mr. Al-Salwam.
You were listed as counsel for 2 years during your time at Morrison and Forrester.
What happens is when you leave from any place, firms or government service, you have to let the court know, or their records reflect where you are in the system, and not so much the case in terms of your address.
So to go back to Mr. Al-Qahtani,
Yes.
He just coincidentally, it's a small world, went to Morrison and Forrester at the same time you did, and then you represented him, and you did file multiple motions on his behalf.
So I don't know if it was at the same time. I'm not sure.
But you did file multiple motions for him.
I only
2008 and 2009.
I don't recall whether it was multiple, but he was still at the habeas stage of the process. And I don't know when he came, because the partners who picked up the case were in Los Angeles. I was in Washington, D.C. They contacted me to say, oh, we see on the docket that you had previously represented him, and now you're with our firm. Will you assist us with looking at these briefs, working on these briefs? There were many lawyers who were working on the filings that you're talking about.
After you left the public defender's office, did you continue in your representation of any other client you had at the public defender's office?
I didn't continue my representation of any client. I left the federal public defender's office and then picked up Mr. Al-Qahtani through the circumstances that I talked about, and there were no other clients that I represented in that way.
I have to say, that sounds like continuation. You represented him at the public defender's office, and then you represented him in private practice as well. And you're telling us that's the only person you represented at both the public defender's office and in private practice.
Yes.
So you didn't continue to provide any kind of pro bono work for murderers or rapists or anyone else, but you did continue to represent this terrorist at Guantanamo Bay.
When I got to the firm and they told me that the case was there and they recognized that I was at the firm and had previously worked on the case, and by they I mean the partners in the firm, they asked me as a member of the Supreme Court and appellate group of the firm, which is where what was my practice, if I would help review and work on some of the briefing that they were submitting on his behalf, given my familiarity with the case.
Were you representing him pro bono at Morrison and Forrester?
The firm takes on pro bono representations, which means that the person isn't paying. And
let's turn to your amicus briefs. You had two briefs in Guantanamo cases, one for a think tank, one on behalf of a group of former judges. I think, as anyone who's done amicus work knows, sometimes the client seek out the lawyer, sometimes the lawyer seek out the client. For either of those amicus briefs, were you involved in any way in seeking or recruiting those clients or suggesting the idea for an amicus brief in the first place?
No, Senator.
Were both of those briefs done on a pro bono basis?
Yes, because the Supreme Court and appellate group in a law firm has paid clients and also has pro bono clients. And the briefs that I worked on were on the one brief was 20 former federal judges who wanted to make an argument in the Boumediene case that was in the Supreme Court. And one of them was a partner at my law firm. She was a former federal judge whose idea it was, and she knew the other judges and wanted our group to work on the brief. The other was not just one think tank, it was the Cato Institute, the Rutherford Institute, and the Constitution Project, an ideologically diverse group of nonprofits who wanted to make arguments in another case that the Supreme Court had taken up related to these issues, because all of this was novel and a lot of issues were being evaluated by the Supreme Court regarding the scope of executive authority during this time of crisis.
Okay, so you've done pro bono work for or on behalf of detainees at Guantanamo Bay. Have you ever done pro bono work for the victims of terrorism?
Senator, I'm not aware of any such cases in my law firm. I was in
in
a
her law
group
firm. That could
of lawyers that was often approached to ask, would you file a brief for some group? And I'm not aware that any victims of terrorism asked our firm to participate.
So we've talked a lot about the people you represent. Let's talk a little bit about the defendants in those cases and how you characterize them. I'll remind you that those were the President, the Secretary of Defense, and active duty Army officers. Senator Graham and Senator Cornyn said that you called them war criminals. You disputed that, and Senator Durbin has repeatedly denied it as well. And I'll concede you didn't use those exact words. You didn't say war criminals. But you did say in multiple court filings that they committed acts that constitute war crimes. I'm sorry, but I got to confess, I don't understand the difference between saying someone is a war criminal and saying they've committed acts that constitute war crimes. So can you explain that difference to me?
Yes, I will. Thank you for the opportunity. So when you file a habeas petition under our law, you can't file it against the United States because of sovereign immunity. The way our law works, you have to file it against individual officers in their official capacity. That's the way in which you're able to file a habeas petition. So whoever is the executive at the time becomes the named party in the brief. And a habeas petition is like a complaint in a civil case. It's making allegations to begin the litigation about the person's detention.
But Judge, official capacity, personal capacity, all that is just a bunch of procedural gobbledygook. These are the people that you said committed acts that constitute war crimes.
With respect, Senator.
I just don't understand the difference between calling someone a war criminal and saying they committed acts that constitute war crimes.
With respect, Senator, they were not sued in their individual capacity. We weren't making allegations about those individuals. And in fact, over the course of the case, the
So you were
names
saying the United
changed.
States committed acts of
So
war crimes.
later on, the habeas petition became against President Obama because he then became the executive for the purpose of the habeas
So you're saying the
petition.
United
I'm
States.
well aware the name changed. It probably changed from Bob Gates or from Don Rumsfeld to Bob Gates as well. But they were not the ones in office. They were not the ones who were overseeing the government when you filed these suits and you said they committed acts that constitute war crimes. I don't understand how you expect this committee to believe that there's a difference between saying someone's a war criminal and saying they committed war crimes.
Thank you for the opportunity to explain, Senator. One of the allegations that had been publicly reported with respect to the group of people who were in Guantanamo Bay was an allegation concerning the use of torture. And when you make that allegation, you bring it under laws that themselves constitute crimes of war. That's the way in which the law works. So if you're writing a habeas petition and you say, upon information and belief, Mr. Al-Qahtani was tortured, that allegation is made under a law that says that there was a war crime that occurred as a result of that torture, and you're making that allegation against the United States, but because you can't sue the United States, the actual petition is named in the name of whoever's leading the United States at the time. So later in the course of this, it moved from President Bush, Donald Rumsfeld to President Obama. It's not about the individual. It's about the allegation that that Mr. Al-Qahtani, upon information and belief, had been tortured in the lead up to his detention.
I don't know, Judge. Sounds like a debate about how many terrorists can dance on the head of a pin to me.
Thank you, Senator Cotton. Ask unanimous consent to enter a letter in the record from 9 former national security officials defending Judge Jackson's Guantanamo representation. The signatories include former Attorney General Loretta Lynch, Department of Homeland Security Secretary Jay Johnson, and the former Judge Advocate General of the United States Navy, Senator Booker.
Thank you very much, Judge. After me, only 5 to go. But sit back for a second, because I don't have questions right away.
I have questions. I just want to tell you how great you are and lovely.
This has been
beautiful.
Not a surprise.
I'm only sad that you're married.
Given the history
you're definitely
that we all know,
definitely
not a
my girl.
surprise, but perhaps a little bit of a disappointment.
I'm thinking about leaving the
some of
Senate
things
so
that
that I
have
can
been
be one of your
said in
clerks.
this hearing. The way you have dealt with some of these things, that's why you are a judge and I am a politician, because you have sat with grit and grace and have shown us just extraordinary demeanor during the time.
He drives
when
me more
people were
crazy than
saying things to
Hirono, I'll
you
just
that are
tell you
actually
for me
out of the
personally.
norm. I had to go up dais to ask some of my more senior colleagues about what I feel like is a dangerous precedent. People are taking 1,000 cases you've been over. Is that right? I'm sorry.
He's not wrong. He's not wrong about this.
Something like that.
Something like that. And from what I understand,
I don't like
these
what Cotton
cases
just did.
are often take days, weeks.
You don't think
sometimes
it's fair
months,
to
right?
say, well, these are all the CP cases you've dealt with?
Yeah.
Yes.
And
She
then
doesn't
It's a
choose the
trial
cases.
sometimes, and
What? Huh?
folks are taking any of those cases.
She was
and
with a
just
liberal
trying to
law firm.
pick pieces out.
The
And
liberal-
so my colleague, Senator Hawley, has been doing this all into the lead up and
That
saying
firm-
things, tweeting things.
Oh, as
that
to
I
that,
think
as
a
to
lot
that,
of
I
us, when I
agree
was
with
just
you.
trying to get some advice
as to
here,
as
this
to
is what the new
representation, I
standard
agree
is
with
going to
you.
be.
No, yeah, I agree. That's
That
unfair.
any judge coming before
I thought we were
us
talking about like the
that
cases
has
that she
ever
handled
chosen
as a judge.
outside of the
Oh, no,
sentencing
that's fair
guidelines,
game.
below the sentencing guidelines.
No, the
We're
child
creating
porn.
this environment now where I could make myself the hero.
She's not really
of
being.
people who have been victims of some horrible crime, and suddenly put whatever judge I want
word,
on the defensive by trying to drag out little.
This is what he's
bits
talking about now.
when they have no context to the case.
He's talking about her
Yeah.
work as a judge. Yeah, he's talking about
None of
cases.
the facts.
Holly's question about these 7
They're seeking to exploit
cases.
The thing is to exploit the fact that
of a criminal justice
You're
system.
seeking to
This is
exploit the
why we have
fact
a
that there
third
seems to be
branch of
some very
government.
significant deviations.
I feel bad that there was a judge mentioned by name in this hearing that's from Senator Hawley's state. What is that judge going to think next time they have a complicated sexual abuse case that comes before them?
They might be thinking, "I've
And
already
they know
confirmed
that they could
biatches."
possibly be called out
Well,
if they go
see me
below the sentencing
rolling,
guidelines,
you
which I showed you
hating.
yesterday in my lack of chart. If you remember, I was uncharted. But that you are deciding completely in the norm.
Man has no chart.
70+% in many
Yeah, let's have a poll on
states
whether
are
Booker's
people
going
are
to
doing
cry. That
just
sounds like a
like
good
you
one.
did. But I'm a Democratic senator.
Well,
I've never quoted from this
sure.
very
Cry.
well-respected conservative periodical. This is the National Review. Very well-respected. They're not necessarily something I agree with all
Okay,
the
guys,
time.
put in your bets.
But here's what the National Review, this is the title. Senator Hawley's disingenuous attack against Judge Jackson's record on child pornography. I'll just read the first paragraph. I would oppose Judge Ketanji Brown Jackson because of her judicial philosophy for the reasons I outlined last week. I addressed that in a separate post. For now, I want to discuss the claim by Senator Josh Hawley that Judge Jackson is appallingly soft on child pornography offenders. This is the kicker here. The allegations appear meritless to the point of demagoguery.
Wow, imagine National Review. So consistently conservative.
I got letters from leaders of victims' rights groups. Survivors of assault. All saying sort of the same thing as the National Review. Feel proud about yourself. You brought together right and left in this
3 pages.
In this
All right,
calling out of people that will sit up here.
I see some proto
and try
tears.
to pull out from
See some
cases
proto tears for people in the chat betting yes.
and try
heading
to
that
put
direction.
themselves in a position where they're the defenders of our children. To a person who has children.
Unlike you.
To a person whose family goes out in streets and defends children. I mean, this is a new low. And what's especially surprising about this is it didn't happen last year. You were put on a court that I'm told is the
Most
considered
liberal,
like the second most powerful
hopeless.
court in our land. And you were passed with bipartisan support.
Mistakes were
Nobody
made.
brought it up then. Did they not do their homework? Were they lax? Did they make a mistake? I wonder, as they ask you the question, do you regret? I wonder if they regret that they didn't bring that out. No. Why? Because it was
this is really
an allegation that is meritless to the point of demagoguery.
National Review, thank you.
You are, I don't mean this in any way, because if anybody
I don't
called me
mean this in
average,
any way.
I would be upset, but you are a mainstream judge. Your sentencing, I've looked at the data, falls in the mainstream on everything from child sexual assault to all the other issues that people are trying to bring up. Some of these things that are being cast at you that you called George Bush a war criminal, come on, that is painful. Especially because, as you said, the brief change, these are names that you have to put in. And we're talking about a real issue that goes to the core of our values, torture. Barack Obama was named once Bush left office. There is an absurdity to this that is, it is almost comical if it was not so dangerous.
He's talking about it as being in the Senate, right?
Because the next time a
Is
judge
Senator
comes
Booker
before us
getting
on
off
the
on
right
this?
or the left that has a body of work like you do,
I feel
gosh,
uncomfortable.
One of the
Ooh, he has to talk about her
artists
body?
on our side
Come on, man. Don't make it weird.
could pull out one of the cases
Whoa.
where they were below the sentencing guideline. Say, for example, it was on something like as horrific as rape that we all agree is horrific. And they can suddenly put themselves as the defense. How dare we put someone who's soft on crime? Well, are you soft on crime? God bless America. I got this great text. I've become really good friends with
Holy
the
shit,
folks
dude.
at the FOP from my negotiations. And this was my favorite.
Become an
text.
actor
We
or
all gotta
something,
get this.
man.
I
Come
think
on.
my brother Kennedy might get a kick out of this. He goes, things that are uncountable, stars in the sky,
They're accountable.
grains of sand on the beach.
Also countable.
And the number of times Democrats will mention that the FOP endorsed Judge Jackson in this hearing.
Also countable.
But let me mention it again.
He's like, he's really
people say you're rough on crime.
clown-like, isn't he?
Really want to try to make that stick. You were endorsed by the largest organization of rank and file police officers.
That's a good thing.
You were endorsed by the bosses, the largest organization of chiefs of police. And you were endorsed by Noble, who I hope people find out more about that organization. You got uncles that are officers. You got a brother, not just an officer, who went to serve after 9/11. Your family's not soft on terrorism. He went out there to capture and kill and defend this country from terrorists. I actually sitting back here and finding this astonishing, but then I do my homework. I love that my colleague brought up Constance Baker Motley. You know, when she was getting to the floor of the Senate, they were trying to stop her with outrageous accusations. You know what the accusation was back then? She was a communist. Dragging up stories, trying to throw anything that they might stick. But this is what you and I know. Any one of us senators could yell as loud as we want that Venus can't return a serve. We could yell as loud as we want that Beyonce can't sing.
My God.
We can yell as much as we want that
what
astronaut
this
Major
guy is
didn't go all that high.
He's
But you know
utterly
what?
incapable of having anything even remotely approaching
Dust on his shoulder.
Wow. Let the work I've done.
I'm sorry, what did he say?
For me.
No, he just did this. He did a little
Well,
brush
you
off the
spoke-
shoulder
Oh,
motion.
brush from shoulder.
Yeah, no, he did the third off the shoulder motion.
Watching that man right
And he's
there,
on the Judiciary Committee. He's
Yeah,
on the
yeah.
Judiciary
trying
Committee.
to raise a family
This
and
absolute
study law
ding dong.
while your mama supported
Whoa.
everybody.
Whoa.
This
You spoke in high
video
school.
is
You
going to have to
started
be age
distinguishing
restricted,
yourself.
Ron.
And you know what you said when they told you couldn't go to Harvard?
YouTube doesn't allow me to have porn on the
Watch
channel,
me.
Ron.
I went to law school. I didn't serve on the law review. You did. I didn't clerk at every level of the federal court. You clerked for a Supreme Court justice, one widely respected on both sides, which really shaped you. You left there and you went to private practice, and you know what you found? This is what you told me. That you had those tough choices that working moms have to make, the demands of a private law firm, raising your kids. It just didn't add up. You went before the Senate 3 times in a bipartisan manner. God bless America. We don't do that much stuff bipartisan around here. You went to become a public defender because you wanted to understand all aspects of the law. Who does that? We live in a society
becomes a
that's
public
very
defender? Lots of
materialistic
people.
sometimes, very,
We live in a
very
society.
consumeristic. You went into, do people become public defenders for the money?
Typically
No.
not. Although the federal system doesn't pay too bad.
Your family and you speak to service.
Service.
And I'm telling you right now, I'm not letting anybody in the Senate steal
letting.
my joy.
Letting.
I
See,
told
he
you
is
this.
a man
You've
of
got
the
lots
city.
of joy, that's for sure. You got joys coming out your ass.
I'm embarrassed. It happened earlier today. I just look at you and I start getting full of emotion.
Holy shit, dude. Is he kidding Christmas
I'm
or
jogging
what?
this morning, and I'm at the end of the block I live on, and I get terrified because I put my music on loud when
In
I'm
Newark,
jogging,
right?
trying to block
Right,
out
Corey?
the noise of the heart attack I'm having.
Preach it to me, brother. Preach it to me.
And this woman comes up on me, practically tackles me, an African-American woman. And the look on her eye, she just wanted to touch me because I'm sitting so close to you.
Wow.
And tell me what it meant to her to watch you sitting where you're sitting.
I am sure that she is
And you did not get there
not loving this.
because of some left-wing agenda. You didn't get here because of some dark money groups. You got here how every black woman in America who's gotten anywhere has done, by being
The nominee's crying.
like Ginger Rogers said. I did everything Fred Astaire did, but backwards in heels. And so
Okay.
I'm just sitting here saying, nobody's stealing my joy. Nobody's going to make me angry, especially not people that are called in a conservative magazine demagogic. for what they're bringing up that just doesn't hold water. I'm not going to let my joy be stolen because I know
Holy
you
shit,
and I,
Cory Booker.
we appreciate
Jeez.
something that
Get
we
a
get that a lot of my
room.
colleagues don't. I know Tim Scott does.
Oh, I know Tim Scott
When I
does.
first came to this place, I was the 4th Black person ever popularly elected to the United States Senate. And I still remember a lot of mixed people, white folks, Black folks work here, but at night when people are in line to come in to clean this place, the percentage of minorities shift a lot. And so I'm walking here, first week I'm here, and somebody who's been here for decades doing the urgent work of the Senate, but it's the unglamorous work that goes on no matter who's in offices. The guy comes up to me, all he wants to say, I can tell, is, I'm so happy you're here. But he comes up and he can't get the words out. And this man, my elder, starts crying. And I just hugged him. And he just kept telling me, it is so good to see you here. It's so good to see you here. Thank you, thank you, thank you.
Thank you. Thank you.
I love my brother, Tim Scott. We could write a dissertation on our disagreements. He gave the best speech on race. I wish I could have given a good of a speech. But talking to the challenges and indignities that are still faced. And you're here. I was in the White
All right,
House
those
with
of
my
you who said
Democratic
he's going to
colleagues,
cry,
and
we'll count that.
I'm in my
Yes
joy. I
wins.
can't help it. and the president's asking our advice, who should we nominate and whatever. And I look at Kamala and we have a knowing glance, which we've had for years.
We are the 2 stupidest people in Washington, and look how we're doing.
And then I try to get out to the president what it means.
He is talking, by the way, to a woman who is
what it means.
At least 5 times smarter than he is.
Yeah.
I mean,
and
she's
I want to tell you, when I look at
real.
you, this is why I
She's
get
a real
emotional.
She's exactly what she appears to be.
I'm sorry, you're a person that
exactly
so much more than race and gender. You're a Christian. You're a
he is
mom.
my senator.
You're an intellect. You love books. But for me, I'm sorry. It's hard for me not to look at you and not see my mom.
Oh my gosh!
Not
Is this
see
what?
What was the question exactly?
Mommy? You got mommy issues here now?
Sit behind you.
What was the question?
She had to have your back.
There hasn't been a question here anywhere.
I see my ancestors and yours. Nobody's going to steal the joy of that woman in the street or the calls that I'm getting or the texts. Nobody's going to steal that joy. You have earned this spot. You are worthy. You are a great American. Your hero is Constance Baker Motley. Mine, she has sat on my desk.
She sat on your desk?
Offices that I've held. She's my icon of America. Her name is Harriet Tubman.
What?
There is a love in this country that is extraordinary. You admitted it about your parents. They loved this nation, even though there were laws preventing them from getting together. When they were loving, there were laws in this country that would have prevented you from marrying your husband. It wasn't that long ago, it was last generation. But they didn't stop loving this country, even though this country didn't love them back.
Forget Tubenin.
And what were the
Tubenin
words
is
of
over.
your heroes in
Tubenin
mind?
is
What did
over. We are
Constance
now doing
Baker
book
Motley
ring.
do?
We're in a whole
That
new
she-
level, guys.
This country that she saw insults and injuries. When she came out of law school, law firms wouldn't even hire her because she was a woman. Did she become bitter? Did she try to create a revolution? No, she used the very constitution of this nation. She loved it so much, she wanted America to be America. As Langston Hughes wrote, oh, let America be America again.
Make
The
America
land that
great
never
again?
has been yet, but yet must be the land where everyone is free. Oh, yes, I say it plain. America
Gotta
never
take this
was
call.
America to me, but I
Seriously?
swear this oath, America will be. That is the story of how you got to this desk. You and I and everyone here, generations of folk who came here and said, America, I'm Irish. You may say, no, Irish or dogs need to fly, but I'm going to show this country that I can be free here. I can make this country love me as much as I love it. Chinese Americans first forced into near slave labor, building our railroads, connecting our country, saw the ugliest of America, but they were going to build their home here and say, America, you may not love me yet, but I'm going to make this nation live up to its promise and hope. LGBTQ Americans from Stonewall Women to Seneca. Hidden figures who didn't even get their play until some Hollywood movie finally talked about them and how they were critical for us defying gravity.
Did she
All
answer his
these
question yet?
Love America.
There hasn't been a question in here at
And
all.
so you faced insults.
There's
here.
not been a question.
I was being facetious, I assure you.
But you are here because of that kind of love. And nobody's
Sorry,
taking
Ron.
this away from you.
I kind of missed that one. Went over my
So
head.
you got 5 more folk to go through. 5 more of us.
No, there's only one of
And then
you,
can
Corey.
sit back and let us have all the debates. And I'm going to tell you, it's going to be a well-charted Senate floor because it's not going to stop.
Oh my God.
They're going to accuse you of this and that. Heck, in honor of your person who shares your birthday, you might be called a communist.
She's not a communist.
But don't worry, my sister. Don't worry. God has got you. And how do I know that? Because you're here. And I know what it's taken for you to
She's
sit
dying.
in that seat.
She's not loving this at all.
Harriet Tubman,
I recognize Ms. Tubman.
one of my heroes because
She's everyone's
the more
hero.
I read about this person, the more, she was viciously beaten. For her whole life, she used to fall into spells, cracked skull. She faced starvation, chased by dogs. And when she got to freedom, what did she do? Did she rest? No, she went back. Again and again and again. The sky was full of stars.
The scar was full of
But
stars.
she found one that was a harbinger of hope for better days, not just for her and those people that were enslaved, but a harbinger of hope for this country. And she never gave up on America. She fought led troops in the Civil War. She was involved in the suffrage movement. And as I came back from my run, after being near assaulted by someone on the street, I thought about her and how she looked up. She kept looking up. No
John,
matter
I
what
don't
they
know
did
that
to
I
her,
can
she
help you on
never
that
stopped
one,
looking
man.
up.
Oof.
And that star,
Here it is.
a harbinger of hope.
Harvard year, a harbinger.
Today, you're my star.
Oh my God, this is painful.
You are my harbinger of hope.
This is painful.
This country is getting better and better and better. And when that final vote
USA,
happens,
USA.
and you ascend onto the highest court in the land, I'm going to rejoice. And I'm going to tell you right now, the greatest country in the world, the United States of America, will be better.
So I'm thinking he might be a yes vote.
Thank you, Senator Booker. We're going to take a 10-minute break and come back.
And
and
take a shower.
The last 5 senators ask their question.
Wow, that was
special.
Truly the best speech.
Should we walk through the
Wow.
points, the best points you made there in terms of it's response? Besides, I think citing National Review was a brilliant move. The thing about the National Review that you have to really respect: principled conservatives. These are the principled conservatives, and that's what you get. Principled conservatives. That's what makes America really great. That and Harriet Tubman and the joy. The tears of joy, the harbinger of my tears. The tracks of my tears. Thoughts?
I don't even know where to start, Rod. It's just like I'm trying to put this into my brain. It's just truly the best speech I've heard, maybe ever. I think I'm a Democrat now, and I'm moving to New Jersey.
I think we're all really, at the end of the day, after hearing that, aren't we really all Spartacus? We're all Spartacus. Thank you.
I don't know if I'm fully Spartacus yet, but maybe if I try, I can find the Spartacus buried deep within. Through your guidance, you can be my mentor in this quest.
Your Spartacus mentor?
Yes.
All right. I have responses to petitioners' requests for documents to draft. So
Okay.
I'm gonna go do that.
Just quote Cory Booker back to them and see how confused they get.
Maybe, well, they said it's going to be a 10-minute break. And then he said, then we're going to do all 5 of the remaining senators. You can't.
Well,
does that mean
2
they're going to be
hours.
going all night?
Well, and it's 2 hours worth of stuff and then dinner. And I think they have some testimony tonight after that, right? From random people. I don't know if I'll cover that part. I might cut it after the questioning because I don't know if I need to see random people testifying.
Well, we just did. I guess
this is true.
He's not literally random. Although if you had chosen a random person out of the waiting room of the Newark Penn Station train station that I'm pointing to right now, you couldn't have done a lot worse than what we just heard. All right, catch you later.
All right, thanks. Well, I think we need to start a new poll. We need to start a new poll and see if you guys agree with me or not that this is truly, was, I guess, truly the best political speech of our time. Let's take a poll on that one. See how you guys feel about that. Wow. Brett, are you pregnant after that speech? Yeah. Woo. Oh man, what a good time. Well, my friends, that was a thing. That was the thing that happened. And I hope the only thing I kind of hope for at this point is that at some point in the future, when a Republican nominates someone for the U.S. Supreme Court, that someone will have the balls to just completely steal Cory Booker's speech and just do it again. I do it because I'm an ass. Right? I just literally give his speech word for word and just watch him fume over there. It'd be great. Yeah. Yes, I think this is truly correct. We are all lucky, truly fortunate to have been here together, to have shared this moment of just joy. And yeah, we could watch it again. We could, in fact, watch it again, but I don't know that I am fully prepared to receive that much joy again. I'm worried about a joy overload in my heart because there was so much joy. I mean, he hasn't lost his joy, and man, he apparently has so much joy to just give because my heart is about to overflow with the joy, and I'm just worried right now that if I watched it again, I'd have a goddamn heart attack from the joy. So, yeah. Give the speech to Nick Rekieta. Oh, yeah, Nick definitely needs to cover this. Everyone should bully him in the covering Senator Booker's thing. That'd be good. Wow. He's got the joy down in his heart. Where? Down in his heart. Where? Down in his heart. Got the joy down in his heart. Where? Down in his heart to stay. I don't want to steal your joy. I've got joy to share. Good Logic wants to joy. Good Logic wants to join. Good Logic, do you want to share in my joy? Do you want to share my renewed joy? I'm filled with joy.
I don't understand. I don't understand how those petitioners can expect Ron to answer their discovery demands on Harriet Tubman Brown Jackson Day. This is like, don't they recognize the greatness that is now being confirmed? Don't they recognize the times that we're living in here? How can anyone be expected to work when we have such historic, memorable? We will tell our grandchildren we saw the day that America displayed its greatness.
Yeah.
That's my senator. That's my senator.
Well, I think you're lucky, and I look forward to being. I'm going to move with near you. Do you have like a spare room or something?
Oh,
Because
sure.
I would like to move to New Jersey. I'd like him to be my senator too, because I feel like I need to be around him and surrounded by him, and maybe I can be on a staff or something. I work for free. Be good.
Obviously, who wouldn't? Who wouldn't? Man just gave the greatest speech of our lifetimes.
Yeah.
And that was something to behold. I even doing today. You're 8.5 hours, almost 9 hours into this. Wow.
Yeah, but I've been renewed. I've been renewed with the blood of the Lamb that is Cory Booker.
No,
he's my
you
new
were
Messiah.
crushed. All right.
Yes.
I feel you. You're gonna smear that on your doorpost and
yeah,
you're gonna feel the rapture.
Yeah, I feel rapture.
Yeah. The sad thing is
rapturesque.
He's like, if I ever want to be senator, he's the guy I'd be running against. That's the sad thing, and I would have no chance, like zero chance. It's humiliating if you think about it in those terms. But I would have zero chance trying to run against him. That's the world we're living in here. You know, by the way, yesterday you and I skipped out on watching Maisie Hirono. I don't know if you remember.
Yeah, I mean, I have to tell you, she doesn't drive me as crazy as some of the people do. And I was commenting to Saran, and this was well early in his speech before he went full Cory Booker. But I say, like, Cory Booker drives me crazier than Hirono. And so I don't mind Hirono as much as he does, but yeah. But I stayed and braved it through you. I stayed and braved through whatever that was. So good times.
Because I was watching some clips where she's like, talking about the attacks from the Republicans that who want to investigate everything about her, down to what you got on your LS.
You guys are confused by the poll. You guys were confused by my poll question, Cory Booker, because the only prompt is just Cory Booker, and then it asks yes or no, and they're confused.
I didn't get it either.
Yes, Cory Booker, because I'm all about the Cory Booker. Cory Booker is just the best. Yes, I love him and want to be with him all the time. Or no, Cory Booker, no, not so much with the Cory Booker. So yes, I'm all about the Cory Booker. No, I'm not about the Cory Booker. And I'd like to say that 43% of you are all about the Cory Booker. So nice. I appreciate that.
I checked yes on it.
Yeah.
He's my man. He's my man. He and Kamala Harris having that knowing wink with each other. How uncomfortable must that be? Wow.
They're made for each other.
Room at a table with
made for each other.
Made for yes.
Kamala Booker, 2024.
This is the state of our union. Don't you realize how this is so? If you want to get blackpilled, just look at who our political leaders are, and the future of America. Like, it's just going to get worse and worse each generation. Don't you realize that? By the time my grandkids are voting, it's going to be like. It's literally idiocracy with that president. Yeah. What's his name? That's what we're gonna have. We're so close to that already.
I mean, to be fair, Trump was kind of heading in that direction. I mean, he's got the personality is similar.
That's true. He was more of a boxer than a politician, but
Horatio or something like that was his name in the Horatio, something like that in the movie.
Oh, is that what it was?
Something like that.
I'm sure the audience, I'm sure, is chiming in with that.
Yeah.
So, were there any surprises at all from this hearing for you? One surprise.
Yeah, I mean, I commented on the time when the nominee, after she said I wasn't going to answer that question again, and then the senator basically tried to ask the question again, and she just sat there and gave a look without saying anything. I was surprised by that. I was like, okay,
all right.
Camacho,
I was surprised that she cracked. I was surprised that she cracked when Hawley was questioning her. She was really losing it there. You could see that tongue flicking around in her mouth, where she's like, and her eyes starting to roll.
And then I got really I got frustrated because like she keeps saying, well, I answered the question. I'm like, no, you really didn't. You just keep talking in generalities. Because I still am trying to find these transcripts, by the way. They say there's this 54-page transcript of this hearing. I don't know where the transcript is. It's not on Pacer. So I don't know where this transcript is. I want the transcript. I want to be able to do the independent analysis. Because I don't know. Maybe she's right. Maybe the 3 months for the possession of the 8-year-old kitty stuff is just totally cool. And I'd like to be able to do the analysis independently. But I can't find it.
I actually was reading up. I'm pretty sure it's the same case. I looked up U.S. v. Hawkins because people were talking about, because I saw Tubin was on CNN.
Tubin is no longer a thing. Now it's Bookering, I've decided.
Right. I didn't say Tubining. I said Tubin. So he was talking about how he said, this is a quote from him. I actually I tweeted it out this morning, where he said, people don't realize that when these laws were written, the whole world was very different. There was no internet. The only way that people could acquire this is that they would email, and they would send an email, and then it would be sent to them. And I'm like, if there was no internet, how are they emailing? What does that even mean? What are you talking about? But he's trying to say how they're so archaic. I guess it's not really reflective of how easy it is to get it, that we shouldn't give such harsh penalties or something when these laws were written. The subject laws were written in 1996. 1996 was 11 years after AOL came around and 2 years into Yahoo. It's not like we were living.
AOL isn't that old.
1985.
No way. Really?
I couldn't believe it either. I couldn't believe when I saw that. I looked it up today. And Yahoo came around 1994. So it's not like, the internet was an unheard of thing in 1996. And so I don't know what the hell he's talking about. When did section whatchamacallit?
About that time frame. Yeah, it's about that same time frame for the CDA, Communications Decency Act. It's something like that. It's 96, give or take, something like that.
Yeah, that's what I'm saying. It's like, it's not like the internet was like no one knew about the dangers in the internet. In fact, I think the reason that they passed these laws then was because they saw that the internet could be used as a vehicle for people to exchange really awful, terrible, heinous pornography. So the notion that the left is trying to put out there, change the narrative and say like, oh, these the sentencing periods were meant for a different age, it's crap. It was meant specifically for this age. That's why it was drafted when it was drafted.
But it also doesn't quite flow from the whole logic, which I know that you appreciate, because she said yesterday that if the law is clear, that's kind of where you stop, which is an originalist thing to say, right? It's like, well, if the law's clear, we stop reading. I'm like, great. Right. Then today she says, okay, the law was written 10 years ago. It's outmoded. But you're not saying the law wasn't clear. You're not saying it's a lack of clarity problem. So I had to interpret it differently. You're just saying it's outmoded. But wait a second. I thought you said if the law is clear, we stop. But now you're making an argument that if it's outmoded, it's out of date, so I should ignore it. So what are we talking about?
She's going to do whatever the hell she wants to do. That's what she's saying. And she's definitely an activist. So, and the reason I say she's definitely an activist is because she went to Harvard Law and then became a public defender. Like, you go to Harvard Law, you just earn yourself a few $100,000 in.
I don't know if that's necessarily fair.
Really?
Yeah, I mean, going and being a public defender or prosecutor is a good way to get a lot of experience quick. And if she has a calling, I don't know if that's necessarily fair.
I don't buy it.
Right,
why would anyone? Unless you either have great political aspirations or you're an activist. Those are the only two possibilities. Why would anyone do that? You can go anywhere, literally become anything. You can walk into any law firm and make your nut the day that you come out of law school. Before you even pass the bar, you start making your nut. So I don't know why anyone would do that unless they have tremendous political aspirations or they're an activist. Because you're sacrificing great money to take that role. You're taking much less money to get that role. Why are you doing that? When you just voluntarily encourage so much debt. So that's why I say, if you're a top school, law school graduate, and you're not going to a big firm.
I mean, do you think it's different if you go to Department of Justice?
I think it's political there. I think it's political. public defense is public defender is not the same thing as working for the DA's office. I mean, you think that's the same thing, public defender? What is even a public defender? What does that mean? I don't even know what that really technically means. Doesn't it mean that you're just volunteering to take care of criminal defense work for people?
Yeah.
Like on behalf of the state?
Yeah.
So it's not like you're making the same connections you would make if you work for the DA's office.
Maybe.
Right? I'm just saying, like, would you ever have wanted to do that? Would you ever have thought for a second?
I'll tell you what, right about now, public defender is looking really good because I need a change in my career. So right about now, I'm thinking about throwing an application to the public defender's office. I'll tell you what.
Okay, but you're not fresh out of law school from Harvard. From
This
freaking
is
Harvard.
okay.
I mean, and also as a black female coming out of Harvard. I mean, when did she graduate? Around the same, like what, 98?
She was born 70, so she would have graduated what, about
like 98, around the same time as me, probably.
Yeah,
Right?
I think she said 90. No, she was working in 99. Yeah, so about 94, give or take.
Okay, so you tell me that she couldn't get hired anywhere as a black female coming out of Harvard Law? Come on, she seriously could have written her own ticket. And she
Probably.
chose public defender.
I mean, probably.
That's great sacrifice, and you're sacrificing the money for something. It's either political ambition or you want to be an activist. I respect it. I want to be clear. I respect people who throw away money for a particular thing. It shows the level of their drive. I'm not saying this in a critical way. I'm simply saying I'm not a big believer that someone who displays such heavy activism is consistent with being a good judge. Especially when she's saying that she can basically interpret the law any way she wants. If I go with the originals, I go with that. If the law is more than 3 years old, I call it too old, and now it's defunct. I don't terminology. I'll just go with what I think is right. That's the worst job in the world to have an activist is having to be a judge. If they want to be an attorney for someone, that's a great job for them because you're advocating for one particular position. If you're trying to be fair and unbiased, that's the exact worst place for society to have a judge. But that is exactly where activists want to be, if you think about it, because now they're actually able to make law. So I think she's a wet dream for the liberals. I don't know if I'm allowed to say that on your channel.
Oh, at this point, yeah. Well, as Nick says, we're more than 2 hours in, so nothing matters.
Okay.
Yeah.
I mean, the only good thing from the perspective of someone who's not hardcore left is, all right, so she's taking the seat of Breyer. It's basically substituting one set of liberal decisions for one vote for liberal decisions for another vote for liberal decisions. So, they just replenish the youth of that vote on that seat.
Mm-hmm.
But it's not changing the balance. If you're sitting there and you're conservative, your real concern is, God forbid, something happened to Clarence Thomas. Good God.
Yeah, that's a big concern.
That's terrifying.
Yeah, that's a freak out moment.
Yeah.
Probably get that judge from California and hate our lives. So yeah, I mean, this whole thing is concerning, obviously, and hopefully she'll write more coherent decisions. So that'll be nice because Breyer's writing and his thinking and his questions drive me a little bit crazy. So hopefully I'll get something more coherent.
I doubt that. I don't have confidence in anyone who brags about how they write lengthy decisions. That's not a sign of being intelligent. It's quite the opposite. It's a revelation that you don't know how to condense your thoughts into something that is powerful. You have to just go on and on and on.
Yeah.
So
I think so.
I actually feel like Twitter has helped me become a better writer because I'm forced to condense down to 140 characters.
Looks like are they back yet? What's going on over here? No, they're resuming shortly. I don't know what's going on over here.
You got 5 left?
No, I'm not sad Breyer's retiring, no, because Breyer is way too long at the fair. I mean, yeah, it was not a pretty sight in my view. He needed to go long ago. So, Did Booker actually cry? We're calling it that he did. I think he
Yeah,
displayed possibly every possible emotion. So yeah, I'm gonna go with yes, he cried.
when he's like getting all excited and his voice starts stuttering, I think we could call that crying.
Yeah, I'm there. I'm calling it yes.
Thank you so much.
This is interesting, streaming this much, because I didn't think I'd ever stream this much or this long in one time. And here we are.
You didn't know that they were going to go for 12-hour days.
I didn't really contemplate that, no. I missed that one.
I didn't either. I didn't see that.
Just the coffee?
Just the coffee. Get yourself some coffee. And some hazelnuts, some French vanilla.
I respect that.
Oh, it's really good.
Cory Booker played football at one point, apparently.
Probably. I don't know why it is that my car isn't reading my my thing unless I unlock or lock the doors. Does that mean that my battery is dying on this thing?
Could be. Probably should look into that.
Probably.
Someone asked about the count of her decisions getting overturned. I understood her overturn rate was actually pretty low. Someone was saying 2%.
That's not too bad at all.
No, apparently the average is like 11% in the circuit. So,
no. Well, there you go. I guess that means she's got her finger on the pulse of what the appellate court in her district actually was looking for.
Yeah, she's gonna get confirmed. She's
sure.
She's gonna get confirmed, no problem. She's gonna get. I still think the over/under is at 54.
Yeah, I put her at 55. Except Mitt and Murkowski, Collins, they're all going to be voting with me, voting for her. And I figured one or two others will crack because they'll be afraid of looking like they're racist or sexist or something like that.
Mm-hmm.
So they'll be like a couple hours back.
Yeah, I think that's where we're at. So we got 5 more of this to go, unfortunately, and then there's possibly some testimony, which I think once they're done with the senators are done with questioning, I think I'll kill the stream because I don't really care what randos have to say, or I'll cover it tomorrow or something. And then the Senate, I'm not sure when the Senate is supposed to book a vote on this, but probably soon. I could take a look at see if I can find their calendar.
Which conservatives are left?
I don't know. Let's see if I can find out when this is on the Senate calendar.
How was Kennedy's question?
It was fine. It's fine.
Better than Lee?
Lee wasn't at his best, in my view. This was not Lee's best moment in these hearings, in my view. I've seen better from Lee. I was a little disappointed in Lee.
Mm-hmm.
But this is a personal opinion. But maybe it's because I expect more out of him. So Kennedy, I thought, did fine.
What was he hitting on?
Oh, I can't remember exactly. It's all bleeding together at this point.
Oh, it was more the sentencing on kiddie cases.
Yeah.
I think that more effective than that, because clearly the left doesn't care about protecting children. I think more effective than that is just pointing out how she's all over the place in the way she's approaching it. I mean, she even said that she bases like different styles or whatever, and when she's sitting there saying that she trusts in the law, well, you don't trust in the law when you think it's outdated because it's all 10 years old. Yikes, that was scary. So,
I'm awake-ish, Elena. I'm awake-ish. I'm here.
Yeah, yesterday I had a lengthy day. I after hanging with you for much of the day, I ended up going on to Legal Mindsets channel for a couple of hours, and then Nick took the night off last night, and I was covering this debate, and I literally ran a stream for like 5.5 hours on my own. Yeah. So I was on camera for like 12 hours yesterday.
Wow, that's a lot.
I think people got tired of hearing my voice.
We have 557 people watching right now. Just as a kind reminder, it's actually my first one to stream. If you're not already subscribed already somehow, please hit the red subscribe button. If it's red, you need to hit that button. If you haven't liked already, hit the like button, hit the bell, and for 99 cents a month, you can become an uncivilian and get your name on the stream.
Ooh.
That's fun. Hit the join button, follow the link, all that good stuff. Do the YouTube things.
Yeah. Be a YouTuber. You're here already. Embrace the moment.
I'm embracing it. I'm embracing it. Yeah. I might need more caffeine or something. Or I could just chase. Well, it's a little late in the day for a pro vigil. It's 5 o'clock. She can't tell what a woman is. That's the question I want to ask her, because she says, I know I'm a woman. And I was like, well, how do you know that? How do you know you're a woman? I think it's a good question. If you say you're a woman, how do you know?
What makes you a woman?
Yeah, how do you know you're a woman? I feel like a woman? Oh, so is that's it? So if you feel like a woman, that's it? Oh, okay. I feel like a woman too, Joe. I'm coming out as trans. I feel like a woman. Ugh.
If it can be, if your gender can be as arbitrary as whatever you decide, why can your gender not be as arbitrary as whatever I decide?
Oh, did my screen freeze?
Why can't I decide what your gender is?
No, there's still no. Hold on. What's going on? I'm confused. The Senate is confusing me. It looks like it's over.
What?
They at least on my okay. Yeah, C-SPAN crapped out. So someone said that someone else was back. Let me see if I can find it from the Senate. Yeah. Oh, it is live on the it's live on C-SPAN. Yeah, okay. C-SPAN has apparently crapped out on me completely for some reason.
Those bastards.
That is well, it's partially my fault because C-SPAN decided to crap out on me.
To interpret the law to the extent that somebody argues to the court that there's been a violation of the due process clause of the Constitution, it is within the role of the court to
Can you hear? I don't hear
Yes, I can, at least on my side. Oh, no, it says no. Hold on. Technical issues abound.
Here, let me see if I can.
Oh, there you go. This is the guy I wanted.
It's not the right so much. It's how the right is created. That's why I asked you yesterday whether you think that these unenumerated, unmentioned rights ought to be decided by the people through their elected representatives versus the federal judiciary. Let's take two rights that I talked about yesterday, the right to assisted suicide, the right of a transgender woman to participate in women's sports. I can see how, I'm not predicting that it will, but I could see how the court either through the due process clause or the Ninth Amendment, could find those rights in the Constitution.
Or at least read
as
them
we
in.
talked about yesterday, the Supreme Court has, looks to me like they've adopted the policy of there is no test for a fundamental right. There are several tests. And in Obergefell, Justice Kennedy cited with approval Justice Harlan's dissent in Poe v. Ullman, which says there's no test. We go case by case. And but I know there are tests like, I'll get the language here somewhere. I've got it. I don't want to look it up, but implicit in the concept of ordered liberty. And you've talked about that. Here's a new one that Justice Kennedy talked about in Obergefell. He said, inherent in the concept of individual autonomy. Well, I can see how if the court with 5 votes wanted to say, even though the right to assisted suicide or the right of a transgender woman to participate in women's sports, I can see how somebody, you're smart, you could write an opinion and say that's inherent in the concept of individual autonomy. And maybe, again, it's not the right, it's who's supposed to decide. And that's where the judicial restraint comes in. I mean, don't you think that the values of ordinary Americans and their ability to decide these issues are just as good as those of 5 members of the Supreme Court?
Thank you, Senator. There are policy determinations that are made by vote, and absolutely in the democratic process, people get to decide things. The question and the difficulty is when you have a constitutional scheme of government and you have a constitution that does protect certain rights, and it does so in a circumstance in which those rights, whatever they are, enumerated or not, are might be things that the people have disagreed with. That's the tension. That that although we have democracy as we do, and people vote and should absolutely, we also have a constitution that protects certain rights against the sort of majority will about those things.
But the rub, of course, is I agree with everything.
So she's
you said,
basically
but
saying
rub
screw
is
the people.
These are unenumerated rights.
Yes.
They're read into the Constitution.
Yes.
And what troubles me, I'm not saying I disagree with all the rights that the Supreme Court has created, but I don't think we talk honestly enough about how those rights should be adjudicated. For example, I'm not asking you to comment on this. I think you already have. But when President Biden announced your appointment, or at least shortly before, he talked about, I want a judge that's going to read new rights into the Constitution through the Ninth Amendment. And I'm sure some Americans are saying that's a good thing, but you got a lot of Americans going, hey, wait a minute. Supreme Court isn't elected. A couple years ago, Chief of Staff Ron Klain wrote an opinion piece, and he said he hopes, and I'm going to quote, that, quote, I hope the Supreme Court will intervene whenever the nation's conscience and laws need a jolt in a progressive direction. That's policy making. Do you agree with that statement?
Do I agree with the statement that that's policymaking,
No,
or
did you
I'm
agree
sorry,
with what the chief said?
Senator? That's a political statement made by someone in the executive branch.
Okay.
I'm
I'm not going
Do
to
you
push it.
agree?
Push it. on that. I get it. It's not a good time to make the chief of staff mad, is it? Well, I hope you'll keep this in mind, Judge, if you're confirmed. I mean, this is what judicial restraint is all about. And I think part of the division in our country, America's a big, wide open, diverse, sometimes dysfunctional, but sometimes imperfect, but basically good country. But we have different values. That's part of our diversity. And I think our country works because of our system of federalism. The values in Louisiana may be different from the values in Maine. And if you don't like what's going on in Maine and you like what's going on in Louisiana, you can move. But as our federal government has gotten bigger and bigger and bigger and bigger, what is developed, at least here in Washington, is this managerial elite. And when I say the managerial elite, I mean the entrenched politicians. I guess I shouldn't say entrenched because that's pejorative, but we do have a lot of politicians that have been here a long time. They're members of the media that are part of the managerial elite. They're members of the
He's highly
administrative
intelligent.
state. They're academics that are part of it. There are a lot of corporate phonies that are part of it. And many people in this cabal think they are smarter and more virtuous than the American people. And that they ought to set forth how people should live their lives. People should shut up and just do what they're told. And if they behave, maybe the managerial elite will let them eat meat occasionally. And I think that's part of the division in our country. And I think to some extent, the Supreme Court, I don't want to say contributes to it, but it needs to be mindful of this. I'll give you another example. And this case bothers me. I want you to explain it. I think Lindsay talked to you about it, but I don't know that. I want to hear you explain it. It's Make the Road New York versus McClellan. You remember that one?
I do.
Yeah. Here's the way I read it. Congress, we, in a rare moment of consensus, gave DHS the sole and unreviewable, those are not my words, they're in the statute, the sole and unreviewable right to determine when illegal immigrants should be removed on an expedited basis. The Department of Health of Homeland Security, taking this statute, decided to use its sole and unreviewable authority or discretion to state that we're going to have expedited removal of all illegal immigrants who've been in the U.S. less than 2 years. And you said no. And not only that, but you issued a universal injunction. And I don't understand why. You talked about judicial activism, and I don't see how clearer Congress could have been. Now, the D.C. Circuit reversed you, but I'm going to hear your reasons for issuing that nationwide injunction.
Thank you, Senator, for allowing me to address that decision in that case. The statute at issue.
Okay, well, this is our live now, friends. So we are just watching the Circle of Death. I'd like to welcome you to the Circle of Death.
Damn it. I really want to hear her answer.
Discretion to DHS to determine the amount of time that a person needed to have been in the country.
The Circle of Death giveth and taketh
0
away.
and 24 months in order to be subject to expedited removal, as opposed to the normal removal process in the immigration system. The statute said that DHS had sole discretion, meaning I interpreted, meaning no other agency was to have the authority to make that determination. And the statute said that DHS's determination in that regard was unreviewable, meaning it was final. This is how I'm interpreting, meaning that once the decision was made, it was over. Nobody else gets to review. The court doesn't get to say, no, you're wrong if you pick 12 months, for example, or 16 months or 24 months, as they did in this case. The statute did not speak to whether Congress intended, with that grant of very broad discretion, to exclude another statute that Congress has passed that directs agencies, when Congress gives them discretion, the other statute, the APA, directs agencies as to how they go about making decisions that Congress has given them the authority to make. The APA is a procedural statute. It says to agencies, when Congress gives you discretion to make a determination, you have to do so in a way that's not arbitrary and capricious. You have to use your expertise. In certain kinds of decisions, you have to use notice and comment in order to get information. It's procedural. The claim that was being made in this case, as I read it and understood it, was not that the agency couldn't pick 24 months, because obviously Congress had said in the statute you can pick between 0 and 24 months. The claim that was being made is that the agency picked 24 months arbitrarily, in violation of Congress's direction about how you go about
The APA was violated?
Yes, the claim was an APA violation. So no one was saying that the statute was violated in the sense that the agency did something that it couldn't have done per the statute, picking 24 months. They said the APA was violated because, this is the claim that they were making.
Sure.
Because the agency did no analysis, the agency did no expertise, the agency did not evaluate, okay, if you've been here 6 months, these are the kinds of ties that you have. If you've been here 18 months, right? The agency didn't do anything. Essentially, according to the claimants, the agency heard the president say, we're going to now do 24 months when everybody else, all of the other administrations up to this point.
Because I've only got 2.
Yes, I'm sorry. All right.
What I hear you saying is, tell me if I'm wrong.
Yes.
They didn't follow the APA, in your opinion, which you have to do even though Congress passed the statute?
Well, no, because 2 things. One is the APA under DC, longstanding DC Circuit case law is presumptively applicable to every situation in which an agency is exercising its discretion. So that's the first thing. It's always there as a background rule. So the DC Circuit has said Congress has to be pretty clear when it decides to exclude the APA, when it's saying, I'm giving you discretion, but you can do this arbitrarily, you can do it however you want. And in other places in the immigration statute that sets up expedited removal, Congress says, we are excluding the APA. We're telling you that with respect to this kind of discretion, the APA doesn't apply. So here I had these 2 statutes, and there are canons of statutory interpretation that says that you should try to give effect to all of the will of Congress. You should try to read statutes so that they go together in a way if you have these 2 directives. And there's also DC Circuit case law.
Judge, I got to stop you.
All right.
Because I got it.
And let me just say, I agree that the DC Circuit reversed me. They disagreed with my interpretation, and that's the way that our system works.
Might be fun to look at the DC Circuit's opinion on that one, because her logic tracks.
This is a question about based on your experience.
I assume DC Circuit Court
Can
said the
we
APA
agree
doesn't apply here when they say
that
final
if,
and unreviewable.
I want to emphasize if, cocaine is cocaine, that
Yeah, we'll have to pull the DC Court of
is
Appeals
equal
decision, see if it
in-
makes more sense
in
than what she said.
its danger to powdered cocaine. You with me?
I think so.
One is not more dangerous than the other. If that's true, then the sentencing rules ought to be the same. Okay?
It's a policy matter for Congress. You could make them differently if you
Right.
wanted to.
This one I want to ask you.
Yeah.
Based on your experience, you've
Yeah.
been on the bench a decade.
Yes.
Is crack more cocaine more dangerous than powdered or less or the same?
Senator, that's a policy determination. That's what policymakers do. They look at the evidence related to these things and they decide what's more
But
dangerous.
what have you seen?
What
Yeah.
should
She's seen that
I have
cocaine is a
seen
hell of a drug.
evidence through the Sentencing Commission that the two compositions are chemically similar, so similar as to be indistinguishable. And the commission for very many years as a policymaking body indicated its view that they should be equivalent and lobbied Congress concerning that. And Congress made a determination about, in the policy realm, making it 18-1 instead of 100-1, which is what it had previously meant.
Okay. Thanks, Mr. Chairman.
Thank you, Senator Kennedy. And now Senator Padilla.
Mr. Chairman, before I begin, I know you're being very mindful of the clock. So I just want to say I have two initial, more substantive questions, and then I think two very brief questions, but are very important. So I'll get right to it. Judge Jackson, I am so glad that you take some pride in sharing your family's story, as you should. I know I take pride in sharing mine. My colleagues have heard it, but I never get tired of reminding folks that I am the proud son of immigrants. My parents came to the United States from Mexico decades ago, and through their hard work and determination, they raised three of us. My sister, my brother, and I, we all attended and graduated from college, and we've all found successful careers in public service. Now, it's a story that is shared by hardworking immigrant families across the country. And over the course of generations, families who work diligently each day to create a better life and to contribute to the country. Whether it's as farm workers, short order cooks, celebrity chefs, software engineers, or tech CEOs, as school custodians, teachers, principals, whether they're documented or undocumented, people who migrate to this country seeking asylum, seeking refuge, or a shot at the American dream, all deserve to be treated with dignity and humanity. Now, unfortunately, our laws and our courts don't always do that. Beyond our often cruel and counterproductive choices that we've made over the years when it comes to immigration policy, the language that we use to speak about immigrants can often have dehumanizing effects. For example, in the Immigration and Nationality Act, it's replete with references to quote unquote aliens. And court opinions written by federal judges across the country can be found referring to undocumented persons as, quote, illegal aliens. Now, I know NASA has put a man on the moon, and there are billionaires increasingly exploring space.
You're not going here, are you?
Well, let's be clear. No person is an alien.
Wow.
And no human being can
Wow.
be illegal. So with that context, I read your immigration-related decisions
that. That is
on
so
the district
dumb.
court with great interest.
Wow.
Now, beyond the substance of your opinions,
he can't be
stood
that
out to
stupid.
me
Apparently, he
is
can't
that
be
you
that
seem
stupid.
to have tried to avoid making the same choice as many of your predecessors and many of your colleagues. When not quoting statutes or precedent, your opinions appear not to refer to immigrants as alien or illegal. Instead, use terms such as undocumented and non-citizen.
But But they are alien. That's the term in the statute.
I imagine. I hope that was a conscious choice.
That's the term.
The
It's
language
term
we
in
use
the law.
and the
What Congress
language our
wrote, it's
courts use to describe
alien.
people, whether immigrants, the formerly incarcerated, individuals who identify as LGBTQ, or other historically marginalized people really matters a great deal. Our language matters. It's exactly for that reason that 6 years ago, Congress passed a bill to remove derogatory and offensive references to Black Americans, Asian Americans, and Native Americans from the US Code. And it's why last year President Biden ordered the Customs and Border Protection Agency and ICE to stop referring to migrants as illegal immigrants. With all that said, Judge Jackson, do you agree that the language we use to describe one another and the language used by the bench matters?
Thank you, Senator. As I mentioned earlier in this hearing, judges are the only branch of government who are required to write our opinions, to explain our decisions.
True.
And I have long believed in that capacity that our clarity and language matters. We're explaining the law to people, and people read and understand what the law is, what the rule of law is in this country through the opinions of judges. So they do matter, language.
Thank you. Now I want to discuss with you an issue of law and technology, an issue previously raised by Senator Ossoff earlier today, and I'm excited to talk to you about this topic. Just as an aside, any day that an MIT engineer gets to question a Harvard lawyer, it's a good day. So thank you for indulging. But as you know, the Supreme Court only hears a tiny fraction of all federal appeals. That means that the cases that get to the Supreme Court are typically either new questions of law or very difficult questions of law. And I think the intersection of law and technology is one where many cases are both new and difficult. Over the course of human history, innovation has constantly disrupted our culture and our norms. And for the most part, with good intentions, but societal benefits have not always been the result of innovation. Innovations have challenged us to respond with new means of safeguarding basic rights, whether in the context of privacy, security, competition, employment, just to name a few. And I appreciate that the speed of innovation will always challenge our ability to keep the law up to date with new technologies and their impact. I've grappled with this question as a city council member, as a state senator, as a secretary of state, and now as a United States senator. But clearly, it's also a challenge for the courts, which often have to decide cases during that period between technological progress and the enactment of new laws that seek to account for that progress. Now, new technology alone has given rise to a number of fundamental questions of law, as you mentioned yesterday and earlier, including how the Fourth Amendment applies to new contexts that no founder could have ever contemplated. And likewise, the court has to grapple with questions like how copyright law applies to computer code. And in the coming years, new technologies will present new questions, not just in the context of the Fourth Amendment, but in areas of communications, energy, transportation, healthcare, and many others. So if you can take just a minute, Judge, to discuss the challenges that courts at every level face in addressing cases involving new and emerging technologies, and how you, as a Supreme Court justice, would begin to prepare for these types of cases.
Thank you, Senator. The court does get cases that involve disputes that touch on technological innovation. Whether it is something like copyright kind of case or a patent kind of case or the Fourth Amendment search and seizure, new technologies do intersect with what the law says in the Constitution and in statutes. And at least as far as statutes are concerned, it's certainly much easier for judges who are doing their duty to interpret the law if Congress makes changes that update the statutes to track the modern innovations. What happens with constitutional interpretation is similar to what I described earlier about cases in which the court analogizes back to the time of the founding concerning the principles in something like search and seizure, what qualified as a search that violated the Constitution when those words were written, and then determines whether that same kind of violation is at issue with respect to the technology today. And the court has done that with respect to searches regarding cell phones, police access to GPS data, tracking technology that is put on vehicles, because these disputes do come up. And so, so I'll take this opportunity to encourage Congress to help us by ensuring that new technologies are addressed in statutes that we interpret.
You're absolutely right. Both judges and members of Congress are never done doing more homework and learning, hopefully. Judge, on Monday, which at this point feels like so long ago, I suggested in my opening statement that by the end of these hearings, America would know just how qualified you are to serve on the Supreme Court. And over the course of this hearing, I think the American people have seen that and have gotten to know you as a person. They have heard your family's journey and everything that your nomination represents. Now, I also said on Monday that your qualifications bear repeating over and over again. And so, Judge, with your help, I'd like to remind the committee and the American people once again, just some of your incredible credentials. Yes or no? After law school, did you serve as a law clerk for a district court judge, a court of appeals judge, and a Supreme Court justice?
I did, Senator.
Yes or no? Did you practice law for more than 10 years before becoming a judge?
Yes, Senator.
And did that include time in private practice and time as a federal public defender?
It did.
How many years have you served as a federal district court judge?
I served as a federal district court judge for, I believe, 8.5 years.
And circuit since then?
Circuit since last June.
And as a district court judge, approximately how many opinions did you write? I think we've covered this before.
As a district court judge, I believe I wrote somewhere in the neighborhood of 560.
With a very low rate of having been reversed, if I've done my homework correctly. Look, I can go on, and don't worry, Mr. Chairman, I won't. But Judge Jackson, for 2 days, here's what I've seen. I've seen a number of my colleagues trying to engage with you in good faith on questions about the law, and you've answered them fully, fairly, and thoughtfully in every instance. You've shown yourself to have the keen intellect and legal acumen to serve on the Supreme Court. Now, you've also sat here and politely listened as some of my colleagues have attempted to disparage your judgment and character based on allegations that, even as Senator Booker pointed out, conservative commentators have called meritless to the point of demagoguery. And through that, you've shown clearly that you have the temperament to serve on the Supreme Court. Now, this confirmation hearing has been a reminder, and in some ways, a new Exhibit A, that for people of color, particularly those who have the audacity
People of color, really? That's what we're
to
doing?
try to be the first,
Oh, it's all
often
racism.
have to work twice
It's
as hard
racism.
to get half the respect. Judge Jackson, I offer that with your talent and exemplary qualifications on full display, if my colleagues truly believe in maintaining the legitimacy of the Supreme Court, if they really care about Americans' faith in the judicial system, they will see that even if they may disagree with you on a particular area of the law, that you're exactly the type of judge that should serve on the Supreme Court. You're exactly the type of judge that should receive bipartisan support, not just from this committee, but from the full Senate. And if any senator doesn't, then I hope they'll think long and hard about what it says to the country about the politicization of the Supreme Court.
Really?
That if someone is
Really?
eminently qualified as Judge Jackson
Really?
in all the ways that we've been discussing,
Really?
cannot receive
Kavanaugh?
bipartisan support.
Or even Gorsuch or even ACB? Really?
Judge, I know there's just a couple minutes left, and I'd like to ask you just one last question. Last Friday, in my preparation for these hearings, I took the opportunity to spend some time with a group of students at South San Francisco High School. I went there to speak with them about this historic Supreme Court nomination and to speak with them about you. We had a great conversation about how the court's decisions affect the everyday lives of Americans and about the past and the future of the Supreme Court. But as I was speaking with the students, I couldn't help but be reminded of my own high school experience when one of my teachers discouraged me from applying to MIT because they didn't want me to be disappointed. I turned that discouragement into motivation. Judge Jackson, I know that you too have been doubted on your way to the seat that you find yourself in today. Even over the last 3 days of this hearing, your experience and qualifications have been called into question by some, despite your clear, lengthy record of talent, achievement, and accomplishment. So I want to end my time today by asking you this question. On behalf of the young people I visited with last Friday in South San Francisco, and for the many others across the country who are watching this confirmation hearing today, what would you say, Judge Jackson, to all those young Americans, the most diverse generation in our nation's history? What do you say to some of them who may doubt that they can one day achieve the same great heights that you have?
Thank you, Senator. That was very moving. And I appreciate the opportunity to speak to young people. I appreciate it very much. I do it a lot for the reasons that you have articulated. I hope to inspire people to try to follow this path because I love this country, because I love the law, because I think it is important that we all invest in our future. And the young people are the future. And so I want them to know that they can do and be anything. And I'll just say that
I will tell them what an anonymous person said to me once. I was walking through Harvard Yard my freshman year. As I mentioned, I went to public school, and I didn't know anything about Harvard until my debate coach took me there to enter a speech competition. And I thought, this is a great university. It was basically one of the only ones I'd seen. And I said, maybe I'll apply when I'm a senior. But I get there and whoa, so different. I'm from Miami, Florida. Boston is very cold. It was rough. It was different from anything I'd known. There were lots of students there who were prep school kids like my husband, who knew all about Harvard, and that was not me. And I think the first semester I was really homesick. I was really questioning, do I belong here? Can I make it in this environment? And I was walking through the yard in the evening, and a Black woman I did not know was passing me on the sidewalk. And she looked at me, and I guess she knew how I was feeling. And she leaned over as we crossed and said, persevere. I would tell them to persevere.
Wow.
Thank you, Judge Jackson. You don't have to hope. I'll tell you right now, you do inspire. You are an inspiration. And I will associate myself with the closing words of my colleague and my brother, Senator Booker, that I too refuse to let anyone steal my joy. Thank you, Mr. Chair.
I want to know where they
Thanks,
gave their
Senator
supply of
Padilla.
joy,
Senator
man.
Tillis.
I need more joy
Thank
in
you,
my
Mr.
life. I need
Chair.
some supply.
Judge Jackson, as Senator Booker was providing his closing comments, I could only think, and they were very powerful, that if you like his, how much you're going to like mine on the subject of intellectual property. But before I do that, I know you've been spending a lot of time here. Do you have much experience in matters of copyright protection, patent protection?
Senator, I mentioned earlier that I did a trademark case.
Yeah.
Not
By
that.
the way, I looked up the menu. It looks
Did
like
you?
a really good menu.
I think it's a good restaurant. They had a lot of evidence to that effect.
I haven't done a lot of food or restaurant trademark work, but when I came to Judiciary, fortunately, the former chair and the current chair indulged us in reinstituting the Intellectual Property Subcommittee. And I love that committee because you really have to work hard to be partisan in it. And in fact, it's not partisan. I worked very well with, as the chair, with Senator Coons, and done very well with Senator Leahy and Senator Rono, and working together on things that I think are really
Miranda,
important,
I am
because I think
awake.
one of the things that make
I am in
our
various
country
stages of
great
awake,
is
Miranda.
the founding fathers got it right on understanding the value of intellectual property
I'm very
and how
stages awake, but
it
I'm
could
holding on.
catapult us into the innovation powerhouse that we are today. So I may ask you a few questions about it, but I'm not going to dig
9
too
hours,
deeply.
50
I do want to
minutes
go back
later.
to maybe getting a suggestion from you. I thought, I told you, I don't even pretend to be an attorney, but I am about 30 years into technology. As a matter of fact, I spent 2 years in Boston at Wang Laboratories, and it was no coincidence, having been born and raised in Florida, that I moved one September because I couldn't bear another winter. But I've been in the technical field. I was working on IP, or Internet Protocol, before anybody knew what Internet Protocol was back in the early 90s. And I do think that we should go away and understand the threat. If you've
It's
seen
not
the
9:15. It's
of
9:51.
illicit activities. And for the
Yesterday was
purposes of
13
this
hours.
Discussion, child pornography now. Imagine what it's going to be
9:51.
like 5 years from now.
Hmm.
I was talking with someone in the hallway. They're taking a playbook from drug kingpins, the creators and the aggregators and the distributors are using technology, I think in some cases, to reach out to people and incent them to go to these websites, to infect their computers, to download thousands potentially from a single click. I think that we have to examine these criminal enterprises and put law enforcement resources into cutting the heads off of these people, figuratively speaking. And one of the ways you do that is to provide, I think, more ways to go about prosecute, more technology that we need to cut down the supply. But we still have to deal with the demand. And that's another area where these criminal organizations and others are taking advantage. And, you know, today, if you think about technology 10 years ago, it was a little odd, at least 15 years ago, to see a child. I've got two
Thank you,
granddaughters.
Jan. That's very nice of you.
One is 4 years old, one is 2 years old. They're
He's not said
technologically
anything
savvy.
at all.
As a matter of fact, I love talking to him on
He
the
said
phone. but even
technology
my
is
2-year-old knows
changing.
how to deal with the filters.
He said
which
technology is
make
changing
me
for the
look
last
like
5
I've
minutes
got,
now.
rabbit
Wait for him to
ears
say
and everything.
anything.
They're technologically savvy. There's a real danger there that these horrible
Hey, by the way, did
people,
you
and I
guys know the
genuinely
technology is
believe that
changing?
you
Did
think
you know that?
they're horrible
Did you know the
people,
technology is changing and
are going,
it's changing? Did you understand that?
excuse me,
It's
they're going to
changing?
infect and destroy a lot of lives. And so I don't know, is it with the sentencing commission? How would you, and incidentally, this is a toxic subject in Congress, because if you start talking about better understanding those, most people are going to run away from it. But we do it at the expense of destroying a lot of victims' lives. So I don't, unless you have ideas off the top of your head, I'm trying to get an idea of how we can make people understand. Maybe we could even have a discussion to say that the penalties today are the floor to begin the discussion, just to simply eliminate people from making this so toxic that we don't better understand it and get ahead of it. But how can we even start having an intelligent discussion and a productive discussion where Congress is clearly going to need to act to do what I think everybody in this room wants to do, is just erase it from the planet of the earth, or at least make a lot of progress? Because quite honestly, it has exponentially grown, and there are exponentially more victims today than there were even 10 years ago. Any ideas?
What was the question exactly?
Thank you, Senator. I actually don't. I haven't been working on or looking at or dealing with sentencing policy for a long time now. In my work as a judge, we're looking at individual cases, not systems or crime organizations and policies related to them.
Yeah. Well, I think it's something that we should take seriously. And after we cool the temperatures and have people have legitimate concerns about some of the rulings, I think that we have to clear up some of the complexity and recognize that Congress is a part of the solution. Okay, now on the weighty subject of intellectual property, are you familiar with copyright preemption under Section 301A?
No, I haven't worked with that.
Okay. I wouldn't have expected you to necessarily, but and I won't
that
get
DMCA?
into patent questions. We've got a lot of work that I think ultimately is going to require us getting rid of the shambles of jurisprudence that we have. It's a very complicated field. We've got a lot of mixed signals and current jurisprudence, and my committee's working on that. So it may be something that ultimately works its way up to you all if you're
Yeah,
confirmed.
17 U.S.C. 301.
But
Is
I'm
that-
not going
is
to
it
take
copyright
a lot of
preemption? Is
time,
that dealing with the
particularly
MCA
because
stuff?
the hour is late, and I intend to yield back some of my time.
Or
I do want to go back because I felt like
yeah, is that dealing with the
this
MCA
morning when I went through
stuff?
some of my comments, I mentioned law enforcement. I talked about a couple of your decisions that gave me pause, mainly, excuse me, because law enforcement's under attack. Law enforcement needs to be held to a high standard. I've been involved in this for nearly 22 years, making sure that when I was the town councilman, that we did something audacious and spend a lot of money in getting our law enforcement officers in a small town of only 20,000 people, CALEA certified. That's a national certification to make sure that they understand how to de-escalate, get engaged in the community, and reduce crime. And it worked. But now there are some people that think it's fashionable to attack the police and to defund the police.
It was just making
and quite
all
honestly,
kind of state copyright law die.
That suggests the
Okay,
communities
well,
that are loudest
that's a
about
very
that are
strange
becoming
question
the
to
least
ask.
safe. So I want to ask, you
It's a very
mentioned
strange
several
question to ask.
times, I think yesterday and more today, about your methodology. So is the United States versus Jenkins fresh in your mind, or roughly fresh in your mind? Criminal
bot may
pleaded guilty
hate
to
you, but we'll give you some
assaulting
notice
a
there.
law officer. It was his third conviction in assaulting a law enforcement officer. The government recommended 30 months. The defense recommended 21 months, and you decided to go with an 18-month sentence. So I was trying to, do you recall?
I don't recall. I would want to look at the records and see the probation office's recommendation as well.
Okay. And that, again, is something I wouldn't have access to. So I'm just trying to figure out what the mitigating circumstances were. And there were other ones. And unless you immediately recall it, I'm not going to ask you to go into details. The other one was United States versus Weeks. Similar situation. There was a 24-month request from the government for the conviction on assaulting an officer, and you gave them 12 months. And does that ring a bell, United States versus Weeks?
I think Weeks had a number of different appearances, and there were different aspects to his case, but I'd have to look at the whole file to recall.
That I just feel like again, because I know that you've rendered some 100 sentences over a period of time. I wouldn't expect you, but it is an area that we'll submit it as a question for the record, so that maybe you can refresh your memory and try to get back on that, because it's something that I, for one, think that we need to place a priority on. We've got so many law enforcement agencies across the country now, that we're having a hard time recruiting people and having a hard time retaining people. A lot of people are retiring. And, I know not every police officer is an angel. I was talking with somebody in my office who was talking about her brother. She had a lot of confidence in him. She was here to talk to me about police reforms. And I actually believe that the vast majority of police officers, like your brother and your family members, were good people. And a part of what we have to do is just make sure that when we have these assaults, which are increasing, that we have just punishment, because we need to do that for the protection, not only of the law enforcement officers, but the communities they serve. I'm going to yield back time, because I know we've got two other people talking. And, I thought you've done a great job over the last 2 days. I've tried to be here. I had an emergency and had to leave for about an hour and a half, but I tried to be here for a business emergency. But I thought that you presented yourself well, and there was a lot of pressure. That demonstrates a certain temperament or poise. Can't imagine what's going on inside your head, but at least overtly, you did very well, and you should be proud of that. It's not an easy thing. It's very easy up here to feel comfortable, right? Because there's 22 of us, and it's not like you can,
my friends,
really come at us. So you have an arm tied behind your back.
friends,
I'm sure that there were a number of things you'd like
from
to
me
say,
to you,
but time didn't allow. But
it's been a nice ride.
I just want to commend you, your family, your daughter, who has been glowing every time you talk. And I appreciate your service. Thank you. I yield back, Mr. Chair.
Thanks, Senator
Thank you,
Tillis.
Senator.
Senator Ossoff, you started the day for us.
Judge, good evening. We've come full circle to the end of the dais. Likewise, I don't intend to use all of my time. I do want to echo the sentiments expressed by Senator Tillis. You have conducted these hearings with extraordinary
Oh, is this guy again?
Poise.
Is Georgia boy again?
Strength.
Ossoff?
Grace under pressure. You've had a lot
He might
of
be the person who
poison
irritates
thrown
me
at you,
most. It's possible.
and you've responded with substance and truth, and it's shone through, not just in this room, but across the country and around the world.
Actually, this is a
So I
misconception,
have
my friend. This is a misconception. Guinness is actually one of the lightest,
two
it's one of the lowest
substantive
calorie beers you
questions
can drink.
regarding the First
It's
Amendment.
124 calories per 12 ounces.
One
It's comparable
question,
to like a Michelob
as I
Light or
noted,
something like that.
that I wanted
Because it's only
to,
3.2% alcohol.
address regarding
It
war
is
powers.
and then
I'll
it
be
is
giving
actually a
the remainder of my
surprisingly
time
low calorie beer
to the chair and on to
compared to
Senator
other
Blackburn
beers.
to close.
So yeah, it's a misconception.
We discussed earlier this morning, Judge, the constituent elements of the First Amendment with respect to speech, expression, and assembly. I just briefly want to touch on the free exercise of religion. My great-grandparents came to this country fleeing anti-Semitism in Eastern Europe. Many American stories, including many of the very first American stories, involve flight from religious persecution. Just briefly would ask you to touch upon the constitutional roots and significance in our system of government of the First Amendment protection of the free exercise of religion.
Thank you, Senator. As you mentioned, free exercise of religion and the Establishment Clause, which prevents the government from preferring religion over another, is foundational. It is the principle that many people originally came to this country when it was founded in order to support. It was people who fled from religious persecution and wanted to found a country in which everyone could believe what they wanted to believe and not have the government encroach on, impinge on, burden that right. And so it is a core foundational right. It's in the First Amendment, and your family story is very similar to many families who moved to this country for that reason.
Thank you, Judge Jackson. We discussed in brief earlier today the Sullivan decision, New York Times v. Sullivan, in which the court established a standard by which libel and defamation claims by public figures would be judged. And my understanding, correct me if I'm wrong, is that the standard is that false statements must be made knowingly, that the party making the false statement must know that it is false, and must make such knowingly false statements with malice. Am I correct that that's the standard in the case?
I believe it's knowingly or with reckless disregard for the truth.
She's right.
And that standard is termed or thought of as actual malice. Yes.
She's right.
Is there any generalized obligation in law that you're aware of to accurate reporting or accurate publication?
No.
Where there is not malice or where there is not one of the components established in the Sullivan case?
There's no.
If I understand your
No.
question, I know that the standard related to the Sullivan case does pertain to public figures. And so if a public figure is not involved, there's a different standard in terms of liability for inaccurate or defamatory statements.
Completely right.
Thank you, Judge. And I want to note that the chairman earlier remarked upon the disruptions in the the market in publishing and the dissemination of information that technology has caused in recent years. And I was just reflecting as the chairman spoke that at the time of the invention of the printing press, many of those who previously had centralized control of the production and dissemination of information recognized that it was disruptive and threatening, and that it disrupted power dynamics, and it empowered new participants in public discourse to participate. And I just want to express to you, this is not a question, but express to you my view that it is vital that we in Congress and the judiciary relentlessly defend the principles of the First Amendment and the free expression of ideas, even as new technologies emerge which disrupt these markets and present challenging new particular circumstances to the court. A very brief question on the not lighthearted but important subject of war powers. I reviewed some of the comments that prior nominees have made when asked about questions with respect to the allocation of war powers between the legislative and executive branches. And something that I've seen in some of those transcripts has been a tendency to say, well, these are disputes between the political branches, and questions about those authorities should be resolved between the political branches. I noted in the McCann opinion that you issued, you noted in that case that one of the reasons it was appropriate for the judiciary to consider the claim made by the U.S. House in that case was that where there is a dispute between the legislative and the executive, in that case, and perhaps in many cases, the judiciary is precisely the appropriate forum for the resolution of that dispute. And so it seems to me that the court and you, should you be confirmed, may very well have to entertain cases and controversies pertaining to disputes between the legislative and the executive with respect to war powers, because there is, in my opinion, unsettled law. There's some ambiguity in statute. The Constitution allocates various authorities to the two branches. So not asking you to posit a thesis on this point, but just want to ask you how you will approach such cases. I assume applying the methodology that you have laid out for us consistently throughout these hearings, where war powers may come before the court.
Thank you, Senator. In every case, I applied the methodology that I have laid out in order to ensure that I'm ruling impartially and consistent with my judicial authority. In the part of my methodology that addresses my judicial authority, one of the things that I do, as judges do, is decide whether I have jurisdiction to hear a particular issue. The McGann case was not a war powers case. The McGann case, I determined in that opinion, and Judge Bates had determined in the prior opinion, raised a question of law. The question essentially was whether the subpoena that had been issued by the House had to be responded to by the person who received it, or whether that person had absolute immunity and did not have to respond. That's a question of law that courts answer all the time with respect to the enforceability of subpoenas. In the war powers realm, there may be questions of law that are appropriate for courts to decide, but there may also be political questions. And so it would depend, a political question, if there was a dispute between the legislature and the executive branch over some exercise of authority that was not governed by law, but was in the discretion of either of those branches under the Constitution, where they got to make determinations, something, say, for example, like the exercise of executive authority in war to move troops or do that kind of thing, that would not present a question of law that the court could decide. So it would depend on exactly what the court was being asked to do as to whether or not it had jurisdiction. And under my methodology, that would be the kind of thing that I would have to carefully examine in order to determine whether I could rule.
Thank you, Judge. Let me close with this comment. As I said, you have conducted yourself with extraordinary skill and grace throughout these proceedings.
I hate his
And
hair.
It's in some ways a lonely place for you to sit there under the lights, facing questions, many of them substantive, some of them less so, many of them constructive, some of them mean-spirited and distracting. You've handled it all extraordinarily well. It's been a very long 2 days. I know you know this, but I just want to make sure you do, that throughout this process, and right now, there are millions and millions of people who are watching and cheering you on right at this very moment in homes across this country. There are millions and millions
Well,
of
there's at
people
least 418
inspired
people
by
watching you
you
at
and
this
your
moment.
example who are cheering you on. And not just that, there are people all over the world, who are watching these proceedings and seeing what is possible in America. After some years when there's been some doubt about what this country stands for. That's my opinion, not yours. But people all over the world are watching this and seeing what is possible in America, what is possible in the system of government that we have, what values this country stands
People
for.
even in
And
Ukraine.
I thank you profoundly for the service you've rendered throughout your life and in this hearing. And with 7 minutes remaining, Mr. Chairman, I know you'll remain focused right through the end. I have no doubt that Senator Blackburn has some provocative questions for you. I yield the remainder of my time.
Yay.
Thank you very much, Senator Ossoff. And Senator Blackburn, you're.
Thank you, Mr.
Record.
Chairman. And I know that Senator Ossoff is over there watching your wonderful family and taking notes because he's a new daddy. And if you have time, he'll show you pictures. But indeed, we have all enjoyed
breeded?
hearing about your family and your parents.
He's breeding?
And how hard they worked to open doors of opportunity for you. And look at how you went through those doors and really created such a wonderful life. And I mentioned yesterday that I would hear from friends in Tennessee, and so many of them talk about they like how you have pushed those barriers aside, because a lot of them have had to do the same thing to kind of make their way into careers. And so they've appreciated that very much about you. And I'll have to tell Senator Booker, now I like the fact that he talked about Fred Astaire and Ginger Rogers. And when my daughter was in high school, I actually bought that poster, and I've probably told Senator Klobuchar
What
this before.
are you
But I
talking
bought that
about?
poster of Fred Astaire and Ginger Rogers, and they're dancing, and it says,
What
"I took
are you
every step
talking
he
about?"
Took, but in high heels and backward," just to make the point with her that she was going to have to work hard. And indeed, she accepted that challenge. And I'm really proud of her, like I know all parents are proud of their children. I do want to get to a couple of things, and we do have the vote on the board. Yesterday during our discussion, you had mentioned that you were unfamiliar with some of the statements that I had read back to you, your previous statements and writings, including the statements on child pornography and critical race theory. I was a little surprised by that because I know the White House has worked really hard to prepare you for the hearing. So I wanted to introduce documents just so that we have those in the record, Mr. Chairman. The first document is an article
in which you're quoted as praising the progressive curriculum at Georgetown Day School. The quote appeared in the winter 2019-2020 edition of Georgetown Days magazine. You stated, and I quote, "Since becoming a part of the GDS
Where is this
community
record, by the
7
way? They
years
keep saying I
ago,
want to
I've
submit for the
witnessed
record. Where
the
is it?
transformative
Because I've been hunting
power
around on the
of
Senate
a
Judiciary website and I
rigorous
can't find it.
progressive education."
Can anyone
end quote.
find where this record is for this
Second
hearing?
document is a
That'd be helpful.
transcript of a 2012 hearing
Maybe
before
what I'm
the
looking for is
Sentencing
wherever this
Commission
mystical
at a
place
time when you were
is, this
vice
mystical
chair of the
record.
commission. The topic was child pornography, offending pathways community treatment. You stated during the hearing, and I quote, "I had mistakenly assumed that child pornography offenders are pedophiles." So I went back and pulled that to show that it was a statement and not a question. So, Mr. Chairman, I ask permission to enter those.
Without objection.
Thank you, Mr. Chairman. We talked about abortion yesterday, and I want to go back to that on abortion. I had another question there. Some have argued that bills seeking to protect children who survive abortions are unconstitutional. They say that the right to an abortion includes the right to an effective abortion. So, in other words, does the constitutional right to an abortion include the right to let a baby die if that baby unintentionally survives an abortion? I'd like to know if you agree with that.
Thank you, Senator. Issues like the one that you have raised are in the court system now. And as a result, as a nominee to the Supreme Court, I'm not able to opine about the constitutionality or not of the kinds of legislation that you mentioned.
Well, one of the main factors the Supreme Court is considering is deciding whether to uphold Roe in all of this and with precedent, is if all of this is a settled issue or not. And some of those that are on this about whether it is to an abortion or an effective abortion, and if that constitutional right includes the right to terminate the life of a baby that survives that abortion. So that is an issue that will be decided before you go to the court. But I think it's important to have that discussion. I do want to go back to the issue about the child predators. And as you've heard, Senator Blumenthal and I are working on legislation. Senator Klobuchar's got some legislation that deals with technology. But I want to ask you this because of some of the questioning, and it's just a yes or a no. Do you believe child predators are misunderstood?
Senator, I don't have a context for that. I believe
Well,
they're
I'm going back to the comment on the Sentencing Commission. As you said, that not all child predators were pedophiles.
Senator, I believe that all child predators are dangerous, that the behavior that they engage in is horrible.
Okay.
That it needs to be taken
I
seriously
mean, probably
by the
strictly
court and by
speaking, no, right?
Congress.
Because it's one of those things
in
where
setting the
always, never.
penalties for their behavior.
We've talked about this, right?
So
Always, never
is
are
it
to
your
be avoided. So
position
it's
that child
always true.
pornography offenders
mean,
are
probably
not
not.
pedophiles?
Senator, I believe that the statement that you referenced was a part of a hearing before the Sentencing Commission in 2012.
Right. It was a meeting, yes.
It was a
I've got it
meeting,
right
and
here.
what the Sentencing Commission does is it
Right.
reviews evidence about various things, and I believe I was
Right. And as I said yesterday, the children that are victimized, they don't understand the difference between an offender and a pedophile or a pornographer. And I do think it's a distinction without a difference. Let me ask you about gun rights.
Not quite right.
Violent
In my
crime
view.
is
The reason I say that,
rampant.
by the way, is
We have
because
seen that
the
during
subjective
the last
impressions
year,
of
it's
the
making
victims is
people
obviously
really
not the most
nervous.
dispositive thing,
Pulled some
right? Because victims
stats.
might feel a whole
In
bunch of ways.
2021,
In law, we
27
try to look
major
at things in
U.S.
a more
cities
objective sense. So that's
experienced a
why I say it's not quite right.
44%
She's
increase
like, well, it might mean
in
it's the same to the
homicides
victims,
since
therefore it should be the same as
2019.
sentencing.
Over
Doesn't
a
quite
dozen
flow.
cities set new homicide records in 21.
Whether or not it's the same to
And
the
a lot of
victim or not
families no
doesn't
longer
quite
feel safe. So they're
get you to
buying
the end page
guns,
on the
they're
analysis.
buying ammo, and trying to make certain that they can protect themselves. And in times like this, I think we're really fortunate that the founders
You found the
afforded
transcript? Oh, thank God.
such constitutional
Send it to me in email,
protection
Twitter me,
as
something.
the Second Amendment. So very
My email's uncivillawyt
quickly,
at
walk
gmail.com.
me
Tweet it
through
at me.
what,
Something. Find me a transcript. I'd love
current
it.
Supreme Court precedent says about the
Please.
Second Amendment.
Thank you, Senator. Current Supreme Court precedent
Yeah.
says that under the Second Amendment, there is an individual fundamental right to keep and bear arms in the home, and the opinion focuses on those
Okay, and
circumstances.
so you agree it is an individual right and not only reserved to militias, because there are some that keep trying to say it's only reserved to militias. But if my memory is correct, you base this on District of Columbia versus Heller, that it is an individual
Yes, ma'am,
right.
that the
Okay.
Supreme Court has established it's an
Okay.
individual right.
I wanted to get that on the record because I don't think anybody had asked you that this entire time. Here's another question. I've asked other judicial nominees that are coming to us for the district court and the appellate court, and I've really not gotten a satisfactory answer from anybody. So why is it
Heller is about
constitutionally
the home. Yes.
permissible for the right to
I
keep
can
and
tell
bear
you for
arms,
sure
which the
Heller's about the
Supreme
home
Court has
based on like every
recognized
court of appeals
as a
case, basically
fundamental
ever after
right,
Heller.
and you agree
So
with
yeah, Heller is
that?
very much about the home.
Why is it constitutionally permissible for this right to be subject to the discretionary issuance of a license by a local official?
Thank you, Senator. The Supreme Court is looking at that very issue in a case before it right now. And as a nominee for the Supreme Court, it's important that I not speak to it because the court is deciding this question. It has a pending case. I believe arguments have even occurred
Okay.
related to it.
Yes,
So
yeah.
should other unenumerated rights
And tomorrow
be
is an
subject
opinion day
to
by the U.S.
same
Supreme Court, by the way.
type forbearance?
It has been a while since
having
there's
to
been
get
an
a
opinion
local
day.
license?
It's been
Should
like 3
someone that
weeks since
wants
there's been an
abortion
opinion day.
have to go before
So
a
tomorrow, the
government
Supreme Court's
bureaucrat?
releasing opinions at 10 a.m. Eastern.
Because
So who
the
knows? Maybe
Second
it'll come up
Amendment,
tomorrow and spice
that
everything
right
up.
to keep and bear arms is enumerated in the text of the Constitution. So the question would be, why should it have to have an extra burden?
I understand the question. It's one that the Supreme Court is looking at, and consistent with past practice and the
I'm gonna
need
need more
to
beer. Fortunately, I have
ensure that
plenty.
I'm not speaking to issues that are
Grab.
live.
I'll put these 2 in the trash. Get 2 more. I need to put
Move
my
on.
trash
I
out
want
because
to
it's kind
turn
of
to
full.
some of the sentencing decisions
Yeah.
and
Be right back.
particularly your decision to grant criminal defendants compassionate release. And you've have an unmistakable pattern of releasing criminals with dangerous backgrounds into the community, and the COVID-19 pandemic seemed to exacerbate the trend. To name just a few examples, you use the COVID-19 pandemic as justification to release a fentanyl drug dealer, a bank robber addicted to heroin, a convict who murdered a U.S. Marshal back on the streets. And at a time when violent crimes, including homicide, are spiking all across the country, And we're facing an opioid epidemic driven in large part by the trafficking of fentanyl across our border. How can you stand by your decision that these offenders do not pose a danger to the community?
Thank you, Senator, for allowing me to answer this question. The statutes that govern judges and that allow for compassionate release are policy determinations that Congress has made to permit individuals who are in various circumstances in various stages in the system to seek release. People who are detained after their final sentencing can seek something called compassionate release. People who are detained between when they've been convicted and when they're sentenced can.
Not to cut you off, but time's going to run out. We do have, you know, this is a question that I have been asked so much. People, here's a stack. These are the ones that you sought for compassionate release. There were 1,561 that were detained in DC Department of Corrections. And your statement, and this was in the opinion that you issued, it was U.S. versus Wiggins. You stated, and I'm going to quote you, each and every criminal defendant in the DC Department of Corrections custody should be released because of the COVID-19 pandemic. And in that same opinion, you lamented the fact that you as a federal judge were limited in your ability to order the universal release of criminals back onto the streets. And I am shocked that that would have been your position, because people are so, they are just really concerned about crime in the streets. So do you stand by your position that it would have been the right thing to do to release all of those prisoners back onto the streets?
Senator, that was not my position. In that opinion, United States versus Wiggins, I started off by explaining that given the compassionate release system and the COVID-19 pandemic, it would seem as though
My friend,
that
as I was describing, I've
an
been taking
extraordinary
skin
and compelling
products.
circumstance. But
I've been
two
taking skin
sentences
products. I've been
later,
working, right? The
I
bags under my
say,
eyes are much better
we
already.
can't release everyone.
skin
There are
products
people who are too dangerous
facial
to
tone
release.
issues,
And so even in Wiggins,
facial
I
toner.
decided that he had to remain
I have an
incarcerated,
apricot facial. No, it's
notwithstanding
pineapple.
his
I have a
compassionate
pineapple
release motion.
exfoliator
So
I
the
use.
point, the sentence that I have there,
Yeah.
I did say, but I said it
Grooming.
to lead up to my statement, which was the actual ruling, in which I said, we are not releasing everybody. We're not opening the jails.
And Judge, you know, to lament that you were limited in your ability to order the release of all, that is what causes. That is a judgment issue.
Streambot has an
And
issue
that
with
is what
excess caps because
causes
I tell it to
the-
have an issue
the
with
concern
with excess
that.
caps.
Let me go to the
I
critical race
control the
theory
bot. I set the
issue,
limits.
because
It does it because I
you
tell
were
it
asked
to.
yesterday about a speech you gave in
And it tells you
April
why. Uncivil Law finds it
2015,
distracting because he does.
when
I think all
you
caps is a little bit
had
distracting.
stated, and I'm going
So,
to quote you
you know,
again,
it
that it
monitors for excess
mails
caps.
when you were talking about sentencing, it mails together myriad types
All
of
right.
law,
You sent me a PDF. Cool. Let me check it
including
out.
critical race theory. And you told Senator
promising.
Cruz, I think it was, that when you made that statement, you were
Promising.
talking about decisions regarding sentencing policy. You said, and again, I'm going to quote, I was talking about policy determinations. None of that
Ooh,
relates
promising.
to what I do as a judge. I take that to mean that you don't make policy determinations when you're making sentencing decisions as a judge. So today, in response to a question from Senator Grassley, you said the exact opposite. You said, and I'm going to quote you again, I have at times identified various enhancements that I have disagreed with as a policy matter because the Supreme Court has
Well, at least that
said
sentencing
that that's
commission
the
hearing
authority
transcripts,
of
which is
a
a start.
sentencing judge in our system. So given that you admitted you
Not
make
exactly what I was looking
policy
for, but it's better than nothing.
determinations in sentencing, and you stated that you
Unless it's in
consider
here.
critical race theory
No, it's
in
not, because it was 55
sentencing
pages.
policy. Let me
But
ask
hey,
you
this is
again,
closer.
do you consider critical
Good
race
job.
theory in your sentencing decisions as a judge?
Thank you, Senator. Critical race theory, any academic theory, is not considered in my sentencings. It never comes up in sentencing. It was not what I was talking about in the speech in 2015.
Okay. I appreciate that. I do have one intellectual property question I'm going to submit to you for writing. You've had a long day.
Thank you.
And you've been very gracious. And I think that these are tough questions, but this is part of our doing our due diligence and meeting our responsibility to the people that we represent. And they expect this of us. And as I mentioned, they've been very engaged.
I mean, yeah.
in
I mean,
this.
I just find the caps a little
As
bit
some have
distracting.
said, you know, I
It's
think
just
I
one
would
thing
like
too
her,
much,
I
right?
don't
Because
agree with
usually my
her,
attention's
or I
split
agree
in
on
so many
some
different
things,
places.
but not on
And the all caps I find a little bit
everything.
distracting. So I just like,
But
you know,
they want to know what you're going
can we
to
avoid the caps a little
do
bit, you know?
when you get on the court.
And
Because
yes,
their
I did see
kids
this,
and
and I
their
definitely have to look
grandkids
more into
are
it.
not
But thank you
going
for
to
bringing it to my
have the
attention, renewed attention.
opportunities that you
I'll check
have
out more.
had unless we keep this nation free. So it demands your best, and it demands that you go to the Constitution first. In your opening
The
statement,
bot isn't that
I
aggressive
pulled
on the
this, and
caps.
this
I
is
said
where
I
I'll
did set the
end with
threshold
you.
pretty
You
high.
say, I've been a judge for nearly a decade now, and I take that responsibility and my duty to be independent very seriously. I decide cases from a neutral posture. I evaluate the facts, and I interpret and apply the law to the facts of the case before me without fear or favor, consistent with my judicial oath. I wish you had said consistent with the Constitution.
Well, the
of the
judicial oath
United
includes the
States.
Constitution. That's
Thank
a
you
little
so
unfair.
much,
I mean, it's a
Judge,
bit whatever.
for being with us. Thank you, Mr. Chairman.
Thank you, Senator Blackburn. This concludes our rounds of questions.
Thank God.
And before we recess, a few observations. First, Judge Jackson, you are extraordinary. Your story is a great American story, and I think we've all benefited by getting to know you a little better during the last 2 days. You are exceptionally qualified for this position. I won't read through your resume. It's been read many times, but I think there's no one in the room who in the 2-day period of time has questioned your qualifications. There have been some dissenters. My colleagues promised a fair and respectful hearing. Most, including my Republican colleague, Senator Grassley, followed that admonition. He always does. But there were a few obvious glaring exceptions. I'm sorry for that. But your patience, dignity, and grace in the face of what was frankly some
Why don't you just do one of these
offensive
things?
treatment
You know, be
is a real
faster.
testament to your
Just do
judicial
this gesture.
temperament.
Everyone will know what you
To your
mean.
mom and dad and the Brown family and your Chicago lawyer brother, I thank you for being with us and being part of this historic occasion. Dr. Patrick, I don't know if surgery is any easier than this, but I imagine that you want to get back to it. And I just want to say a word to Layla and Talia, if she's here or she can hear us.
It's not that caps
You got
aren't
a great
allowed.
mom.
You can do caps.
You really do.
You just can't basically do
And-
all caps.
But she's been
The
through in the
threshold's
last
fairly
couple
high.
days. Most people
I mean,
would not
putting
even
in all
consider
caps is
going
just
through
as monotone
1
as no
minute.
caps.
But she is
So
strong.
I mean, the
she's
threshold
caring,
is not meant
she's
to be
kind,
overly punitive.
and you're lucky to have her.
It's just like trying to
And we're
avoid
gonna be
people
lucky
just
to have
yelling
her
all the
on the
time.
Supreme Court. So we've got a little bit of work to do. Incidentally, I could go through the list of all the invitees that have been filing in and out of the room behind you, wanting to be here for a moment to share this history with you. I will let you in on something which you may know. Tomorrow, we're going to announce that you've been rated unanimously well
See?
qualified by the
Like this
American
guy.
Bar
This
Association.
guy doesn't get his
That's the highest
message
possible
censored.
rating.
All right. There's
We're
no problem with
going
that.
to
The bot doesn't
conclude
kick
the
in.
Public portion of this
Right?
hearing.
He's not being overly
Convene
excessive with the
induction
caps. He can use
226
some
for
caps to
closed
express
session
some stuff.
for discussing the background investigation. It should only take a minute or so. And I have discussed this with the ranking member, Senator Grassley, and for the information of all members, the committee will meet in executive session to consider Judge Jackson's nomination to the Supreme Court on this Monday, March the 28th at 3 p.m. And with that, the committee stands in recess. Thank you.
Yay, thank God.
The meeting is right now.
All right. Well, that's the end of that. Thank God. No, we do have one more thing, so don't run away on me. Don't run away on me because we do have one more thing. Or at least I want to talk about one more thing. I guess you guys can do whatever you want. So there was that one opinion Judge Jackson referred to that I sort of said, oh, that makes sense. And then people noted it had been overturned. It surely had. So I thought we could discuss it and actually pull it up and see if it makes sense. Now, what did I do with it? I put it in my stories tab. There it is. Great. Can Firefox open this? I'm issues here. See if I can get this PDF open for you guys. And we'll go through it and see if the court appeals make sense. Great. Okay. It's like my computer decides to have a heart attack right now for some reason. But let's stop that screen. Share a new screen. Share screen. Can I open a tab? Yes, I can. Great. All right. So here's what's happening in this case, at least as it was described to us by the bench. Here's what's happening, at least as this was described to us. All right. There was a statute passed by Congress which gave Department of Homeland Security the sole and unreviewable authority to determine what period of time would be available to deport people on an expedited basis. So this would be like with less hearings and a quicker process, obviously. And Congress said you can pick any number between 0 and 24. Great. So the Department of Homeland Security picked 24, right? So the statute says sole and unreviewable authority. Okay. So Judge Jackson here gets the case as the district court judge. And she says the following, which makes sense to me. And then we're going to review the Court of Appeals and see if it makes more sense. Because that would be a fun thing to do, right? We can evaluate for ourselves who is more right. Because the Court of Appeals for DC could always have its head up its ass, right? I mean, that's always a possibility we can consider, right? So she said, okay, look, this statute to me says sole and unreviewable authority to make this decision. Or sole and unreviewable authority once the decision is made. So once they make a decision, it's sole and unreviewable. The question is, how do they get to make the decision? And she says the APA is a binding policy, which totally makes sense. Totally makes sense from first principles, right? The Administrative Procedures Act is a statute that sits on top of everything for executive agencies. It is your go-to statute on how to make rules for executive agencies. It is your rule on how to make rules. That's what it is. And so the Administrative Procedures Act governs many of the, especially decisions that are outward facing. So decisions that are inward facing, like internally, like changes of structure and stuff like that, that don't impact the public are not usually APA. Decisions that are outward focusing, in some sense imposing on the public in some sense, usually are APA, right? And it goes about how to make these rules. And as she noted in her testimony on this issue, that can often involve notice and comment, right? And we see issues on APA violations all the time. So she says, okay, the statute that Congress passed said sole and unreviewable authority, but didn't explicitly exclude the APA. Okay, APA is also a statute Congress passed. Sure. I'm supposed to read everything harmoniously together. Correct. The APA is sort of a statute that sits above everything, and this is well known, right? And so, since Congress didn't say explicitly, and also she says in other parts of the thing, Congress did explicitly exclude the APA, which goes to show that Congress, when they want to, know how to do this, right? So it's not like it's a secret to Congress. So the fact they didn't do it suggests the APA should still apply. So once they make the decision, fine, but how they make the decision is still APA. Now, that logic completely tracks with me. It completely tracks with me as she described it. But as she noted, she was reversed by the Court of Appeals. So now we'll review the Court of Appeals decision and see if it tracks more. Or maybe she was misleading us as to her ruling or whatever. Like we'll analyze it, see if it makes sense. Who was right? I don't know. But what she said, at least in that respect, made sense. And as always, I, at least on civil law, try to be fair. I always try to be fair. I have many misgivings about her, as we've discussed. But she said this, and I'm like, well, that sounds right to me. Right? So, I mean, I try to be fair, and I just try to call it when I see it. And she says, this is how I analyzed it. I'm like, yeah, that sounds right. All right? So I just say, just call it like I see it. So let's see if the Court of Appeals can convince me that she was wrong. Or whether the Court of Appeals has its head up its ass. That might also be fun. All right, so let's see what's going on here. Okay. All right. Federal law commits to the sole and unreviewable discretion of the Secretary of Homeland Security the decision whether to subject certain individuals present in the United States without documentation to expedited removal. In July of 2019, the Secretary decided to expand the reach of the expedited removal process to its statutory limit, sweeping in all individuals without documentation who reside in the United States for less than 2 years. Three organizations whose members are covered by the expansion filed suit, contending that it violated the APA, the Immigration Nationality Act, the Due Process Clause of the Fifth Amendment, and the Suspension Clause of the Constitution. The district court granted a preliminary injunction against the expansion based only on the APA claims. All right, so the district court says, I can decide this under the APA. I'm deciding it under the APA, so that's the only thing we're reviewing. Fine. We hold the district court properly exercised jurisdiction over the association's case, but because Congress committed the judgment whether to expand expedited removal to the Secretary's sole and unreviewable discretion, the Secretary's decision is not subject to review under APA standards for decision making, nor is it subject to APA notice and comment rules. For these reasons, we reverse and remand. Okay, fine. Congress created the process of expedited removal as part of the Illegal Immigration Reform and Immigration Responsibility Act of 1996. Before this, an individual in the United States without documentation could be considered deportable if, among other things, the person had entered the United States without inspection or at any time or place other than designated by the Attorney General. A determination of deportability entailed a hearing before a special inquiry officer in which the individual had the right to be represented, to examine the government's evidence, and to present evidence on his or her behalf. An officer's determination that the individual was deportable was subject to judicial review. Congress adopted this expedited removal scheme to substantially shorten and speed up the removal process. Expedited removal may be applied to those who are arriving in the United States, as well as to individuals who are not admitted or paroled, which is a weird definition in this context, by the way, and who have not affirmatively shown to the immigration officer's satisfaction there have been physically present in the United States continuously for the 2-year period immediately prior to the date of deportation. It leads the Secretary to designate which groups of individuals who fall within the 2-year statutory range will be subject to expedited removal in a provision we shall refer to as the designation provision. Any such decision about the scope of expedited removal operation within statutory limits is expressly committed to the Secretary's sole and unreviewable discretion, as Secretary may modify such decision at any time. Expedited removal lives up to its name. Under the statute, an immigration officer may determine An individual is inadmissible because she does not have a valid entry document or other suitable travel document, or because she's obtained the visa through misrepresentation. If the individual falls, my voice is getting a little bit sore, by the way, because I've been doing this for 2 days. It's getting a little bit rough. Okay. Absent such indication, all that standard between individuals and removal is a paper review by the officer supervisor. The process is scarcely more involved for individuals who assert intention to apply for asylum or fear of prosecution. Those persons are referred for an interview with an immigration officer who decides whether they have a credible fear of persecution. The interviewing officer prepares a written report of credibility fear determination, including facts relied on and the officer's analysis. If the officer finds no credible fear of persecution, the individual's only recourse is review by an immigration judge. That highly expedited review is meant to conclude within 24 hours. The immigration judge review is final. No administrative or judicial review follows. Because the executive branch's past concerns about expedited removal administratability and accuracy, the Secretary had long chosen to apply those abrupt procedures only to a narrow class of individuals. In particular, the government had expressed concerns that application of expedited removal procedures to individuals already in the United States will involve a more complex determination of fact and will be more difficult to manage. For that reason, the Secretary initially opted to apply expedited removal only to those arriving individuals, defined as those who seek admission to or transit through the United States at a port of entry, or who are interdicted in the international or United States waters and brought to the United States by any means. Yeah. And apparently, this was so tight that it even didn't extend to aliens who had been here for 24 hours. So when they say like entering the border, they mean that kind of literally. So if you made it a day, you're golden. At least under expedited removal. In 2002, the Secretary expanded expedited removal to all unadmitted individuals who arrive by sea and who have been continuously present in the United States for less than 2 years. So we went from one extreme to the other. How about 0? How about 2 years? Okay. In 2004, the Secretary again expanded expedited removal to all individuals not paroled or admitted who were encountered within 14 days of entry and within 100 air miles of any U.S. border. With the exception of expedited removal expansion to Cuban nationals, the 2004 designation remained in place for the next 15 years. All right, so they said, how about all of it in 2002? And then how about 14 days in 2004? Okay. On January 25th, 2017, President Trump directed the then Secretary of Homeland Security, John Kelly, to expand expedited removal to its full limits. Fine. That directive, though, remained unimplemented for the next 2.5 years. Not until July 2019 did the then acting secretary publish an announcement in the Federal Register expanding expedited removal to its full limits so that it reached all covered individuals who've been in the United States for less than 2 years. I'm not sure why it took that long, but okay. This 100 air miles of the border is like 95% of the U.S. population. It's a lot of it. That's sure. That's true. The Secretary cited as basis for his decision the increasing number of individuals who have been detained after apprehension within the interior of the United States. The Secretary also emphasized how fast such expedited removals occur on average within 11.4 days. That's pretty fast. Like all prior expansions, went into immediate effect. Fine. The statute also adopted a web of jurisdictional procedures governing review of both the Secretary's designation and removals. 3 of them are at issue here. The first is a jurisdictional provision that governs the expedited removal program. It provides that no court shall have jurisdiction to review matters related to expedited removal, including procedures and policies adopted by the Secretary to implement provisions. Well, that sounds kind of explicit to my mind, to be fair. That sounds pretty explicit. Second, the subsection bar on judicial review of the expedited removal process is subject to enumerated exceptions. As relevant here, Congress expressly provided that an action may be instituted in the United States District Court for a District of Columbia to review whether any regulation issued to implement it is constitutional, and whether a regulation or written policy directive, written policy guidance, or written procedure issued to Secretary to implement is otherwise in violation of the law. Well, that sounds less explicit now, right? That sounds less explicit. Otherwise in violation of law? That sounds less explicit. That sounds like the APA again. Okay. Third, the subsection bars judicial review of any judgment regarding the granting of relief under the statute's provisions involving denial of discretionary relief and any other decision or action of the Secretary, the authority for which is specified under the subchapter to be in the discretion of the Secretary other than the grant of asylum. The bar on judicial review does not apply to constitutional claims or questions of law upon petition to be reviewed with the appropriate court of appeals. Okay. So based on this so far, it sounds like the district judge is right. I mean, in subsection A, it says no court shall have the power to review it. And then in the exception, it says is otherwise violated by law, which seems to swallow the rule, to be honest. So, I mean, that makes sense and for the district court's determination. That seems loose. So based on that description, I can understand how the district court got to where they want to be. In August 2009, shortly after the Secretary issued the expansion designation, several organizations filed suit on behalf of individual members against the Secretary, the Attorney General, and 3 other federal officials within Department of Homeland Security. The organizations are Make the Road New York, La Union de Pueblo Entrio, and We Count. Each one is a membership organization that advocates on behalf of its members in immigrant communities, and that includes, among its members, individuals directly covered by the new designations. The associations assert multiple claims, including statutory claims under the APA and INA, along with 2 constitutional claims. Specifically, the associations contend Secretary violated the APA by failing to both engage in reasoned decision-making and to promulgate the designation through notice and comment. The associations also allege violations of INI, contending the expansion impermissibly deprived individuals of meaningful pre-removal process and restricted the participation of counsel, due process clause of the Fifth Amendment, and the suspension clause, because the designation deprived individuals of the right to seek judicial review of the removal order. The associations requested, among other things, a declaration that was contrary to law, vacator of the designation, an injunction barring its application to expand a group of individuals. Because the expansion designation took place immediately, the association promptly moved for preliminary injunction. Okay. So regarding jurisdiction, they conclude that. We can skip all this, right? We can skip the district court's analysis. Okay, to overturn preliminary injunction on the question of jurisdiction, we can skip that because the Court of Appeals says it's fine. Jurisdiction. Okay, so they have jurisdiction. All right, fine. I'll deal with that. So they have jurisdiction. Fine. Skip. They need a cause of action. Fair enough. That's where the association's APA notice and comment and reasoned decision-making claims founder. APA provides a limit of cause of action. The cause of action is not available here, where, among other things, agency action is committed to agency discretion by law. Because the APA does not apply to agency action committed to agency discretion by law, The APA exceptions for actions committed to agency discretion by law is read quite narrowly. Yeah, I would think so, or otherwise the APA would basically never apply ever. Restricting it to those rare circumstances where the relevant statute is drawn so a court would have no meaningful standard against which to judge the discretion. But rare does not mean never. The designation provision falls in this restricted mold. There could hardly be a more definitive expression of congressional intent to leave the decision about the scope of expedited removal within statutory bounds to the Secretary's independent judgment. The forceful phrase sole and unreviewable by its exceptional terms heralds congressional judgment to commit the decision exclusively to this discretion. Congress's addition of the phrase "and unreviewable discretion" to sole doubles down on the confinement to one decision maker and one decision maker alone. The natural meaning of the text is that unless the Secretary crosses statutory bounds, no second opinions are allowed. Tripling down, Congress teams sole and unreviewable discretion with additional authority to modify the decision at any time. That statutory judgment confines the judgment to the Secretary's hands, and doing so inescapably seeks to withdraw the decision from APA review. Of course, a statutory grant of broad discretion to an agency does not render the agency's decisions completely non-reviewable under the committed to the agency discretion by law exception, unless the court also determines the statutory scheme taken together with other relevant material provides absolutely no guidance as to how the discretion is to be exercised. If no standards are discernible, it means judicial review is impossible. Okay. The associations are correct that designation is not the type of judgment that's presumptively committed to agency discretion. So the presumption of APA reviewability attaches. Okay. So the question becomes whether the language or structure of the statute provides substantive legal standards to apply. It does not. It only states the Secretary may apply removal to any or all eligible aliens under the statute. Individual exceptions for removal of those who have not been admitted or paroled to the United States and not affirmatively shown the satisfactory of an immigration officer they have been physically present. That's it. Neither statutory text nor procedures provide any other legal standard constraining judgment. The statute only provides the Secretary is authorized to designate groups. That's sole and unreviewable and can be done at any time. Okay. 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 So here's a nice thing. The associations are correct in one respect. Even where an agency is committed to agency discretion by law and is so immune from substantive review, the agency's decision may be still subject to notice and comment rulemaking. But here the statute renders the formal regime inapplicable. For starters, a central purpose of notice and comment is to subject agency decision-making to public input and obligate the agency to consider and respond to the comments. I'm sorry, what? Hold on. Let's see, where were we? The designation provision is explicit secretaries under no duty consider the view of others and expanding the scope. That decision is the sole discretion. Okay. On top of that, the purpose is to expand a record for judicial review. There's no need to create one because it's unreviewable. Finally, the secretary is permitted to modify it at any time, which in this context necessarily means without the time to go through notice and comment. Okay. Hold on. All right. Okay, that makes sense. All right. Here's what I think. Here is my opinion. Based on this analysis, here's my opinion. I think both decisions are reasonable. The Court of Appeals analysis makes total sense. That being said, as the Court of Appeals themselves kind of note, even where it's unreviewable authority, notice and comment can still apply. And they go through analysis of why it doesn't, which makes sense, but this is I think both analyses make sense. It's just a question of which you think is better, in my humble opinion. In my humble opinion, they're kind of even. I don't think one is clearly superior to the other. And so, as to this much, as to Judge Jackson, I'm not going to fault her that much. I mean, I haven't read her decision, but assuming it's sort of the opposite of what the Court of Appeals wrote, it would totally track with basic baseline principles. And also track with the idea that in other places, they expressly excluded the APA and baseline assumptions that the APA applies everywhere and blah, 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 right? So, she might have gotten reversed by the Court of Appeals, but I'm not sure, strictly speaking, that we can say that she's wrong. I mean, it's not the law, but her analysis, if it's the converse of what the Court of Appeals wrote, is totally logical too. And there's even a dissent on this, which, makes total sense. And even without reading the dissent, it makes total logical sense. So it's basically like, which do you think it is? At least in my mind, based on this analysis. And we read it fairly quick, but based on my analysis, it seems right. So, that's kind of what I think. Yeah. Notice in review seems kind of like a joke. Wasn't CDC supposed to do it a bunch of times, but decided not to? Nothing happened to them? I don't know about that. The failure to do notice and comment was part of the reason the CDC thing failed, but not the major reason. So, yeah. So is there any questions about anything? Any questions about anything before I wrap up for the day? And I mean, this is part of the reason why, kind of exactly the reason why I want the underlying materials for these CP cases, because it sounds absurd. And her answers don't bring me a warm, fuzzy feeling. It makes it feel evasive. Senator Holloway's points seem solid. But as always, I want to go back to the original material. Who knows? Maybe we'll learn something. I don't know. But that's one of the reasons I want the original material, so I can make an independent analysis and determine, if the judge, and we could determine maybe the judge's ruling makes sense, or she has her head way up her ass, or whatever, sort of thing we are in between. All that stuff. And, yeah. Jelly Miss says, "Thank you for your stream and your legal insight. You're perfectly welcome. Like you guys may not always agree with me, but I want you guys to believe me when I tell you that I'm trying to be neutral. And I think this shows I'm fair, right? It's like there's a lot. This is what she did in these CP cases seems deeply questionable. Seems problematic at best. I don't know. It seems like an odd conclusion in my mind. But I want to be fair. Maybe they have their head up their ass, and maybe she's just being particularly cautious instead of trying to. I don't know. I want to be able to make a determination for myself, and I can say to you, well, look, this is what the judge's thinking says. This is some idea she has. Maybe there's something here. Blah 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 blah. And so maybe these conclusions somewhat makes sense. I don't know. I mean, it doesn't sound like it. I'm not saying it does sound like it. It sounds like not. But I'd still like to be able to make that determination for myself rather than take someone else's word for it. So, I hope she doesn't get nominated. Well, my friend, to that, you're way too late. You're way too late. So that one, yeah. What do you mean they're about CP? What else is there to know? So many things. It's at least in my mind. To my mind, in my opinion. So many things else to know. I don't think, I mean, at least for my mind, I don't think every CP case is created the same, because I think it's a bit absurd, to be honest. It's a little bit, to my mind, like saying every robbery case is the same, or every murder case is the same, or every sexual assault case is the same. I don't think that makes sense, right? It makes sense to gradiate, even within CP, about degrees of bad, and say some things are less bad than other things, even within a CP context. That doesn't mean that doesn't mean that the least bad things aren't bad, right? It's like saying the least bad murder is still bad. It is, but it's not equally bad to everything. And so we can gradiate, or we can at least think about it. And so, to my mind, for example, it is at least conceivable and arguable that possession of CP isn't the same as distribution of CP, isn't the same as manufacture of CP. To my mind, these things seem differentiable, right? And so, as long as we're differentiating between levels of evil, then I need to know more things. I need to know more things about why she made the kind of decisions she did. Because maybe it tracks in some sort of logic that would make sense. I don't know. But I just think that, like every other kind of crime, it's a little bit reductive to just say, well, it's all equally bad. I think that's problematic. That's sort of what I think. I just think that we need to know more things, and we need to know more things about her logic and what factors are in play, and all the things that are relevant to the decision, to try to track her reasoning, see if her decision makes sense, see whether or not at least we can follow the logic of it, whether we disagree with it or not. I don't know. Try to make a decision that makes sense. No, I agree with this. I agree with this for sure. Nothing shows a reason so far. I agree with that completely. And I think I said as much, right? I agree with this completely. This is part of the reason I kind of want to dig a little bit deeper. But I agree with you completely. Like, nothing we've seen shows any reason. I agree. Like, Senator Hawley's questions and all the other people who asked questions about these things seemed very lucid. Their questions seemed very lucid. Her answers did not provide me any sense of confidence whatsoever, right? But on some level, it seems so absurd. Like, part of the problem is, like, you have this 3-month case, right? And it seems a bit absurd, right? The statute proposes 8 to 10 years. The prosecution recommends 2 years, and you go with 3 months. It seems like a ridiculous conclusion. So it's like, well, I want to track that thinking. Like, how did you come up with that number? At least to my mind, again, my opinion, some of the deviations don't seem that absurd, right? Some of them are a lot closer than others, and this one's way off. And I'm like, well, how'd you get to that number? I like to figure out your thinking so I can figure out if it makes any logical sense. I don't know. So that's just kind of what I think about it. Yeah, and this also is true. This is why story is important, right? She didn't give him a story. She didn't give him a narrative. Correct. This is exactly the problem. She was very evasive and very cagey, which leads me to the conclusion that she has something to hide, which is a perfectly reasonable conclusion, right? It's the most reasonable conclusion in the face of the evidence we have. But as always, the primary source material is going to be better than all that, right? I mean, based on the evidence we have, she seems cagey, evasive. She seems like she's trying to hide the ball. These things don't quite make sense. So I agree that, with all that, it's just like, well, as always, there's the primary source material. Let's go to the primary source material and see if it makes any sense, right? That's just kind of how I think about things. I don't know. So, yeah. Politicians don't think anyone needs to know more. Yeah, I need to know more. I disagree with courts all the time. I disagree with the goddamn Supreme Court. I disagree with them on unanimous decisions. This is not surprising. And I explain my logic for better or worse all the way through. So you guys can follow me. And so I don't know. Maybe she has a point. Yeah, it doesn't sound like it, but I'd like to be able to know. So that's kind of what I think. And also, incidentally, the reason I'm pouring this much effort into it is because it's a Supreme Court nominee. I mean, of course it is. That's the reason I'm pouring so much effort into it, right? I like to know who one of these people is going to be, who's sitting on the court for the next, 30 years or something. I'm pouring effort into it because I care a lot about the Supreme Court, as you guys might have noticed from my coverage on my channel, right? So I'm pouring so much effort into it because this is a major point of contention. It's the most major point of contention. I think we can agree to that much, right? As the hearing we've heard, this is the most major point of contention. I think we can agree to that. It's her weakest spot. I think we can agree to that, right? So I'd like to go examine what seems to be the worst of the worst, and see if it's as bad as they say, and see whether or not it's what it might tell us about her judicial thinking. If she's going to be on the Supreme Court for the next 30 years, I'd like to know a little bit more about her. So I'm trying to, figure out who this is going to be. I'm not thinking she's going to be particularly friendly to the Second Amendment, incidentally, but, I'd like to understand her thinking a little bit more. I'd like to understand her a little bit more. I appreciate, as always, the contribution. All right, so I'm going to sign off for now. Is it all dog and pony shows because she'll be confirmed no more? What's discussed in the session? A little bit. I mean, a little bit, yes. I think the over-under is still at 54. I think the over-under is at 54. Joe said 55. We're not disagreeing by very much, right? So I think she's going to get... I think the over-under is at 54. And it's quite possible she'll get quite a bit more than that. So I'm going to sign off for now, because it's been 11 hours. It's been 11 hours and 15 minutes, and yesterday was a 13-hour day. And we will be back with more analysis because all that good stuff. So, as always, if you're not already subscribed, please subscribe. If you're not liking, commenting, and all the rest of it, do that. Hit the join button, 99 cents to join the channel, support the channel, all the rest of it stuff. I am going to sign off for now. I've been Uncivil Law. I hope you've enjoyed this coverage of our Supreme Court nominee. We will continue to look and see if we can find whatever the hell the senators were quoting from. That would be great. At least we have the Sentencing Commission stuff. That's something. But still, I'd like to know her reasoning in her decisions as judge when she was applying sentencing. Right. So her policy recommendations are one thing, but her actual application is more important, at least in my mind. So we'll continue looking for this mysterious material that seems to be in the hands of some of the senators. And at least for the moment, that brings us to the end of discussion of this stream.